ಮೊದಲಿಂದ ಫಿಕ್ಸ್ ಇದೆ ಕಾಳಗ ಫಿಕ್ಸ್ ಬೇತಾಳ ಬಿಟ್ಟ
ಫೇಮಸ್ ಆಗೈತೆ
ನೋಡಿ ಯಾರು ಫೇಮಸ್ ಆಗ್ಯಾರ
ಆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಬೇತಾಳ ಅಂತಾನೆ ಹೋಗಿರ್ತಾರೆ.
ಅವ್ರು ಗೊತ್ತು ಇವರು ಕೂಗರ್
ಅವ್ರಿಗೆ ಹೇಳಿ ಅಲ್ಲಿ
ಅನ್ವರ್ತಕ
ಇಲೆಕ್ಷನ್ ನಿಂತೇ ಇಲ್ಲ ಮೇಡಮ್. ಕೋರ್ಟಿಗೆ ನೋಟು ಅಲ್ಲ ಅದೇ ಸೇಮ್ ಐತೆ ಅದು ಒಂದೇ ಐತೆ ಅದು. ಹೌದು ಅಲ್ಲಿ ಸಂತ ಮೇಡಮ್
ಮೇಡಮ್ ಸಾಹೇಬ್ರು ಒಂದ್ 2 ದಿನ ಬರ್ತಾರೆ
ಸೀನಿಯರ್ ಮೇಡಮ್. ಕೋರ್ಟಿಗೆ ನೋಟ್ ಅಲ್ಲ, ಕೋರ್ಟಿಗೆ ನೋಟು.
ಯಾರ್ಯಾರ ನಾವು ಜೈ ಹೌದು ನಾನು 7 ಗಂಟೆ ಸಾಹೇಬ್ರು 7 ಗಂಟೆ ತುಂಬ 4:45 बीस को 1 के 4 के 5 6 4 है, इसका 1 को अलग रखिए, मिक्स करो ना ಅವ್ರು ಮಾಡ್ಬೇಕಂತ ಎಲ್ಲ ನಾವು
ಸಾಹೇಬ್ರು ಹೇಳಿದ್ರು ನೀವು ಫಾಲೋ ಅಪ್ ಮಾಡ್ಬೇಕಂದ್ರೆ ಪಾಪ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹೇಳ್ಯಾರ ನೀವು ಫಾಲೋ ಅಪ್ ಅಂದ್ರೆ ಸಾಹೇಬ್ರು ಹೇಳ್ಯಾರ ನೀವು ಫಾಲೋ ಅಪ್
ಅಂದ್ರೆ ಸಾಹೇಬ್ರಿಗೆ ಹೇಳಿದ್ರು ಅದು ಅನಿಸ್ತು ಇಫೆಕ್ಟ್.
ಸಾಹೇಬ್ರು ಸಿಟ್ಟಿಂಗ್ ಅದಾರನ್ರಿ ನೆಕ್ಸ್ಟ್
ಡೇಟ್ ಕೊಟ್ಟಾರ ನಮ್ಮ
ಡೇಟ್ ಕೊಟ್ಟು ಲಾಸ್ಟ್ ಟೈಮ್ ಹಂಗ ಮಾಡಿದ್ರು.
ಎಸ್ಕೆ
firing
take left and right. ಮೇಡಮ್ ಇವ್ರು ಕೇಳ್ರಿ
ಕಾಲಕ್ಕೆ
ಇವ್ರು ಕೇಳ್ರಿ ಅದು 16
ನಾನು ಕಡೆ ಮೇಡಮ್ ಇವ್ರ ಕಡೆ ಕೋಟ ನಂಬರ್ 4 ನಂಬರ್ 4
ವಿಚಾರ ಮಾಡಾಕತ್ತಿರ್ಲಿ
ಏ ನಾಲ್ಪ ಕೋಟ ನಂಬರ್ 4 ನಂಬರ್ 4 ಇಟ್ಟಾರಲ್ಲ ಅಂತ
ಕೊಟ್ಟಿರ್ತಾರ ಇಟ್ಟಿರ್ತಾರೆ
ಮಾಡಿದ್ರಿ
Lord's kind permission. My lord, one matter for 230, my lord's urgency is there. My lord's proposal notice to insert the name of the petitioner in rowdy sheeter is being issued. And my lord,
being issued, how do you know?
my notice is being given, my lord.
Okay.
A proposal notice is given, and now they are precipitating him to attend the parade on Saturday on the reason of session, my lord. 230, my lords, please, my lords.
One matter.
Please, my lord.
230 my lord. The MD of
Pending matter ಯಾವ್ದು ಮೂವ್ ಮಾಡಬೇಡಿ. No pending matters.
MD of
No pending matters.
MD of Milk Union has issued a general body meeting under the chairmanship of the vice president where the matter is pending before this honorable court.
Reserve ಆಗಿರೋದಾ?
ಹೌದು.
Reserve ಆಗಿರೋದಾ?
Again they have issued a notice.
Matter for 230. ಎಲ್ಲಿ ಅವರು?
And
ಹಂಗಾದ್ರೆ ಬರಕ್ ಹೇಳಿ.
ಗಂಗಾಧರ್ ಅಲ್ಲ, ಇದರಲ್ಲಿ ಓನ್ಲಿ ಯೂನಿಯನ್, ಮಿಲ್ಕ್ ಯೂನಿಯನ್.
ಮಿಲ್ಕ್ ಯೂನಿಯನ್ ಮಾತ್ರ.
Please my lord.
Lord, on matter for 230.
Another matter my lord, consent. Consent award in view of the
ಕನ್ಸೆಂಟ್ ಅವಾರ್ಡ್ ಎಲ್ಲ ನಾಳೆ.
Lord,
230 notice
ಇವತ್ತು ನಾಳೆಗೆ ಹಾಕುವ 15th ಇರೋದಾ?
ನಾಳೆ.
ಮೇಡಮ್ ಅದೆಲ್ಲ ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ. ಆಮೇಲೆ ಡ್ಯುಯಲ್ ಪೇಮೆಂಟ್.
ಅಲ್ಲ, one more fresh matter.
ಕೊಡಿ 230
Please.
ತಗೊಳ್ಳಿ.
Lord, 230, my lord. The cooperative election matter, my lord. Lord, the
When is the election, sir?
Lord, the Taluka Agriculture Cooperative Society election.
When is the election?
My lord, 15th, my lord, Monday. My lord, at 2:30. Matter pertains to Bangalore matter. The lordship is granted parole to me, my lord. The government has recommended to me release, my lord.
So
Monday is extension of, I filed the action.
230.
Monday.
It is matter pertains to issuance of enrollment certificate. Enrollment. ಬಾರ್ ಕೌನ್ಸಿಲ್. ಕೊಡಿ. ಮೇಡಮ್ ಸರ್ವ್ ಮಾಡ್ಬಿಡಿ ಮುಂಚೆನೆ. ಅರ್ಚನಾ ಮುಗ್ದು ಮೇಡಮ್.
List number 2 ಮೇಲ್.
ಹಾ?
The petitioner is having the local degree, my lord, wherein the signature of the petitioner itself has been polled. Now they are ready to sell the property, my lord. It is for partition.
ನಾಳೆ tomorrow.
One matter
ಪೆಂಡಿಂಗ್ ಇದ್ರೆ ಬರಲ್ಲ. ಪೆಂಡಿಂಗ್ ಯಾವ್ದು ಮೂವ್ ಮಾಡ್ಬಿಡಿ.
One matter 230 my lord. The government has issued a notification for bifurcation of the cards, my lord. Already my staff is running, my lord.
Bifurcation of
Cards, my lord. Ration card.
Yes,
PDS.
ಪರವಾಗಿಲ್ಲ.
ಇಲ್ಲ ಅಂದ್ರೆ your lordship already
No
since
monopoly there. 230 ಎಲ್ಲ ಇಲ್ಲ ಕೊಡಿ. Yes. Tomorrow we'll see.
day after tomorrow notification is final ಇದೆ ಇದೆ.
Tomorrow, sir.
Please.
Pending matter.
ಇಲ್ಲ fresh matter sir.
Please.
My lord, threat of disposition, proceedings under sir. My lord, the lapse of 6 months, my lord, delay my MEC matters, my lord.
ನೋಡೋದಿಲ್ಲ.
6 months lapse of similar matters,
ಎಲ್ಲ fresh matter.
fresh matters, my lord.
ಏನ್ entry ಮಾಡ್ರಗ?
entry model.
ಬರುತ್ತೆ ಬಿಡಿ ಬೇಡ. Yes.
My lord,
We'll take some matters which can be disposed.
Second list serial number 16, permit to withdraw the infraction.
16.
Please,
Second list,
second list till 16.
seal number 16.
Please,
Yes.
230.
Disposition ತಗೊಳ್ಳಿ 230.
Next week, my lord. Next week, my lord. Next week, any day.
ನೆಕ್ಸ್ಟ್ ವೀಕಿಗೆ ಮೆಮೊ ಯಾಕೆ ಸರ್ ಬೇರೆ ಕೊಡಿ ಅಂದ್ರೆ ಲಿಸ್ಟು ಏನು
Second list.
1 minute, 1 moment sir, 1 moment. ಫಸ್ಟ್ ಅಷ್ಟೇ ಕರೆದ್ಬಿಡಿ ನೋಡಿ.
Next one, serial number 1, being spoken, Sunil Desai.
ಏನಿದೆ?
this locker, my lord, is not been,
ಲಾಕರ್ ಮಿಸ್ಸಿಂಗ್
locker missing and one, my lord, in para number 9. Lordships, on that day, ಅದು clarify ಮಾಡಿದ್ ಬಂದಿಲ್ಲ ಅದು. On the petitioner producing all the relevant documents.
ಹೌದು.
Account details ಅಂತ ಇದೆ. Paper publication ತಗೊಂಡಿದ್ದೇವೆ, mail 50 ಕೊಟ್ಟಿದ್ದಾರೆ.
11 ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಸರಿ ಇನ್ನೇನ್ ಬೇಕು?
ಅಲ್ಲ, ಅವ್ರು ಮತ್ತೆ LRs, ಪ್ರಬೇಟು ಅದೆಲ್ಲ ಅಂತಾರೆ ಅದಕ್ಕೆ.
ಅಕೌಂಟ್ ಡೀಟೇಲ್ಸ್.
Account details ಅಂತ.
The subject petition was disposed by an order dated 26 November 2025. Owing to certain inadvertent typographical error, the petitioner has moved this matter for being spoken to. The error, according to the petitioner, is that the mentioning of the words relevant documents which ought to have been relevant account details. The other is omission, the other omission is mentioning about the not only the account but also the locker that is in the bank. Therefore, the learned counsel for the respondent would admit the omission and has no objection for the correction. In that light, the paragraph 9 shall read as follows. Therefore, the SBI shall, on the petitioner producing all relevant account details, release the entire amount standing to the credit of the account, credit in the account in favor of the petitioner without broking any delay, as also the locker as also the locker on the complete documents being given by the petitioner to the satisfaction of the respondent. Complete document ಮತ್ತೆ ಅದನ್ನೇ ಹೇಳ್ತಾರೆ, ಅದು ತೆಗೆದುಬಿಡಿ. Remove this without amended.
Without
As
breaking
also as also the locker, full stop. The action shall be taken within 8 weeks from the date of receipt of the copy of this order.
Please.
Serial number 2, Anand P. Saudi, R.H. Changdi.
List after vacation. Yes.
Serial number 3, Miscellaneous Naik, F.E. Patil.
I'm appearing for the petition. I'm ready in the matter, my lord.
Tuesday, my lord.
After vacation. Yes. Next.
Serial number 4, Suraj P. Mudor.
ಎನ್ನೇದ ಇದು?
Please, your worship.
But I furnishing not a synopsis.
For what ಹೇಳಿ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಹೇಳಿ.
Please.
But this,
But the respondent number 2 herein was not the appointed on a temporary basis initially. But thereafter was regularized from the service. But during the probation period, my lord, his service came to be, my lord, the terminated. Against that, my lord, he preferred, my lord, the dispute raised, my lord, initially he filed an appeal before the board. But without prosecuting the appeal, my lord, he raised a dispute under section 70 before the jurisdictional joint registrar of cooperative
ಓ
society.
ಇದು ಜಾಯಿಂಟ್ ರಿಜಿಸ್ಟ್ರಾರ್
Of cooperative society.
Ah.
Then he filed, my lord, the joint registrar, my lord, in turn, my lord, after initiating proceedings, he transferred the dispute to the assistant registrar of cooperative society. Assistant registrar of cooperative society, my lord, given a finding that termination is illegal on the ground that no inquiry, no domestic inquiry was conducted. Therefore, directing to reinstate with full back wages. Against that, my lord, we have preferred an appeal. In the appeal, my lord, appeal came to dismiss, confirming the order of, my lord, the authority, our assistant registrar. Against that, my lord, we have filed the writ petition. During the writ petition, my lord, this honorable court stayed so far as back wages is concerned, directing us to reinstate him. My lord, we have
What is
reinstated.
your ground, sir?
But the ground is, my lord, the first ground is already he filed an appeal before, there is a statutory appeal provided under the rules.
You forget that. Next ground.
Next ground is, my lord, he is a probationer. The probationary period, my lord, we have terminated him.
Ah.
We have, during the term of, my lord, probationary period, my lord, we have terminated him. Therefore, my lord,
So,
so the finding, both concurrent finding is not, the inquiry was not conducted, my lord, that is correct.
correct.
Then, my lord, the third ground, our ground is, when the dispute is filed before the joint tester, my lord, under the provisions of the act, my lord, the order passed by the assistant
At the
tester is
relevant
bad
point
in
in,
law.
at the relevant point in time, what was it?
But that is the law. The jurisdictional joint registrar of cooperatives is the competent authority. My lord, as per section 71 of the Cooperative Societies Act.
Contested the proceedings.
Please, my lord.
You contested the
Contested
proceedings.
proceeding, we have to contested the proceedings.
You raised this ground. Anything else?
I'll ask my lord.
Anything else?
Nothing, brother. Oh, no, I am at one, my lord. Reinstated, my lord, the back, so far as, once again, my lord, yesterday I have produced one document to show that we have already, my lord, dismissed him again, my lord, for holding an inquiry. So 2013 up to 2016, my lord, he served. Subsequently, he remained absent, and we have, my lord, after holding an inquiry, we have terminated him, my lord. As of now, my lord, he is not in service.
Your lordships, 2013, after the reinstatement order was there, he has gone, he has reported, he has worked for 3 years.
ಆಮೇಲೆ ಯಾಕೆ ಬಿಟ್ರಿ ಮತ್ತೆ?
They have given him only 50% of the salary. They didn't pay him full salary.
ಅದಕ್ಕೆ other
No,
50%
no,
you are working somewhere
not
else.
that, your lordships. He was totally victimized and he was not able to
What do
work
you
over
mean?
there.
What do you mean victimized?
Like they wouldn't allow him to sit properly, no
Sit
separate,
properly?
no separate table to work was being given, no proper facilities were given for him to perform his work. And especially at that point of time, till 16 he has worked. And he has worked, even though they gave him 50% salary also, he said he has worked. But after that, they have transferred him to various places within a period of 2 months. That is not been
Anyway,
disclosed.
that 6/12/2024 order you have not challenged.
No, till now I have not challenged, your lordships. Now they try to serve that copy to me. So I said, let them send it to my client.
No, that will
Because
never go because ಎಲ್ಲಿದ್ದಾರೆ ಅಂತ ಅವ್ರಿಗೆ ಹೆಂಗ್ ಗೊತ್ತು? 16 ಇಂದಾನೆ
he is there. He is even present before this honorable court, your
Oh,
lordships.
seriously? Yes, but all three grounds.
This, yes, my lord. This is the dismissal order, my lord.
That's all right. That we will only take note of.
Please.
The petitioner. ಅವ್ರು ನೋಡ್ಕೊಳ್ಳಿ ಎಂಟ್ರಿ ಮಾಡಿರಲಿಲ್ಲ ಇವತ್ತು. The petitioner is before this court seeking the following prayer, heard so and so. The facts in brief germane are as follows. The petitioner is appointed on a temporary basis as a diary technologist in the petitioner on 14/9/1994. The petitioner's probation was yet to be declared. At that point in time, owing to certain omissions and commissions, the petitioner, the respondent, which respondent is it?
Two.
The second respondent was terminated from service.
Regularized.
Regularized ಆಯ್ತಾ?
Subsequent, yes, my lord. 15/11/2097. He was regularized.
Oh,
Regularized, your lordships.
on 15/11/1997, the second respondent was regularized in his services or regularized. The 15/11/1997, the probation of the petitioner was declared as being satisfactory or regularized as the case would be. During the probation period, on 6, during the probation period, synopsis.
No, after the probation.
ಅಲ್ಲಿನೂ ಮತ್ತೆ ಒಂದು ವರ್ಷ probation.
The petitioners, the second respondent stood terminated. The termination of which was challenged before the appellate authority on 2/1/1999. Notwithstanding the pendency of the appeal, it transpires that the second respondent approached the Joint Registrar of Cooperative Societies and invoking section 70 of the Karnataka Cooperative Societies Act 1959. The Joint Registrar of Cooperative Societies referred the dispute back to the hands of the Assistant Registrar of Cooperative Societies to hold an inquiry to adjudicate upon the dispute between the parties. The result of the adjudication was that the Assistant Registrar of Cooperative Societies sets aside the order of termination and directs reinstatement with 50% back wages. This is called in question before the Karnataka Appellate Tribunal by the petitioner in Appeal 231 of 2002, which comes to be dismissed by an order dated 14/3/2013. It is this order that has driven the present petitioner to this court in the subject petition. The learned counsel Shuraj Mudol, representing the respondent, would project three grounds that the petitioner during this probation was terminated, and notwithstanding the appeal pending before the appellate authority, the second respondent could not have invoked section 70 and raised a dispute before the joint registrar of cooperative societies. He would further contend that competent authority to adjudicate upon the dispute was the joint registrar of cooperative societies. The joint registrar could not have delegated it to the hands of the assistant registrar of cooperative societies. He would further contend that the petitioner, the second respondent, was reinstated in the year 2013, worked for 3 years, and again remained unauthorizedly absent, pursuant to which an inquiry is conducted and an order of dismissal is passed on 6/12/2024. The said order of dismissal has become final, and the second respondent has not challenged the same till date is his submission. The learned counsel appearing for the second respondent, Sunita P. Kalsoor, while taking this court to the documents, would submit that the petitioner has not raised all these grounds either before the assistant registrar of cooperative societies, before whom the dispute was adjudicated, nor before the appellate tribunal, before whom the appeal was preferred by the petitioner. For the first time, all these grounds are being raised in the petition is what the learned counsel would contend. He would further contend that 3 years he did work, but he was humiliated, victimized, and was forced to leave service. Therefore, he now stands as a dismissed employee. The order of dismissal is not even served upon him. The learned HCGP would also toe the lines of the learned HCGP would submit that the joint registrar of cooperative societies, the assistant registrar of cooperative societies was the competent authority or otherwise is not a question that can be gone into, as the petitioner has not contended all these grounds, urged all these grounds before the competent authority or the tribunal. And I have given my anxious considerations. Therefore, narrated facts are not in dispute. The second respondent, owing to certain omissions and commissions after declaration of his probation, comes to be terminated from service. The termination is called in question by the second respondent before the appellate authority. During the pendency of the appeal, the second respondent thought it fit to raise a dispute under section 70, as it was a dispute between the employer and the employee of a cooperative society. The contention that during the pendency of the appeal, the dispute should not have been raised is noted only to be rejected, as the raising of a dispute is a right of an employee as obtaining under section 70 that cannot be curtailed merely because an appeal is pending before the appellate authority. The next one, the joint registrar of cooperative societies refers the dispute for adjudication to the assistant registrar of cooperative societies. The said reference, correct or otherwise, it cannot now be gone into, as the petitioner has never raised these objections either before the assistant registrar of cooperative societies or when the appeal was filed before the Karnataka appellate tribunal. The assistant registrar of cooperative societies has set aside the order of dismissal, awarded back wages to the tune of 50%, awarded full back wages, and directed reinstatement. This was challenged before the appellate tribunal. The appellate tribunal affirms the order of dismissal but modifies the order of back wages to that of 50%, as against 100% granted by the
full dismissal.
Dismissal. It
Appeal
has
dismissal.
confirmed.
full
totally
back wages ಇದೆಯಾ?
ಹೌದು, it is totally confirmed.
Yes, so ಅದೇನ್ ಮಾಡ್ಬೇಡಿ. The appellate tribunal rejects the appeal filed by the petitioner. The grounds, the learned counsel, the grounds that are urged by the counsel for the petitioner cannot be gone into as observed here and above, as none of those grounds have been urged before the appropriate fora, not once but twice. The other issue is that the second respondent worked for 3 years and again remained unauthorizedly absent for reasons manifold. reasons manifold which need not be gone into in the subject proceedings. What remains is affirmation of the order passed by the tribunal while directing the service of the petitioner to be treated as service only from the date of the passage of the order of the tribunal till the date on which he remained unauthorizedly absent, i.e. up to 2016. With the aforesaid observations, without interfering with the orders impugned, the petition stands disposed.
Monetary benefits 50% ಕಡಿಮೆ ಮಾಡೋದು ಫುಲ್ ಆಗಿದೆ ಅದ್ರಲ್ಲಿ
ಎಲ್ಲಿಂದ ಎಲ್ಲಿಗೆ?
ನೋಡಿ ಫ್ರಮ್ ದಟ್ ಟರ್ಮಿನೇಷನ್ ಟು ಟಿಲ್ ನೋಡಿ reinstatement.
ಟರ್ಮಿನೇಷನ್ ಯಾವತ್ತಂದ್ರೆ?
ನೋಡಿ from the termination order is
Yes, madam,
It is
50%.
full, your lordships. They have been given full. And even opportunity was given by this honorable court to see, they have said like, we are not going to settle the matter. Because the
98
matter was even sent for
ಎಷ್ಟು
settlement.
ಎಲ್ಲಿಂದ
also.
ಎಲ್ಲಿಗೆ?
1998 ನೋಡಿ
1990
98
to
to ನೋಡಿ till reinstatement
ಯಾವತ್ ಮಾಡಿದ್ರಿ?
2013 ನೋಡಿ.
And from 13 till 16, they have given only 50% where he has
full
worked
ಕೊಡ್ತಾರೆ.
fully.
ಅದು ಫುಲ್ ಕೊಡ್ತಾರೆ
ಅದು I will direct. 19 will reduce it to 50%.
ಪ್ಲೀಸ್.
15 ವರ್ಷ free salary. Yes, the
Your
the
lordship,
issue now would be whether the petitioner would be entitled, ಅದು ಚಾಲೆಂಜ್ ಮಾಡಿದಿರ ತಾನೆ? The issue now would be whether the second respondent would be entitled to full back wages as is directed by the ARCS and affirmed by the tribunal. It is an admitted fact that from the year 1998, i.e. the date on which he was terminated, till the date on which he was reinstated in the year 2013, has not worked in the petitioner. Whether he has worked elsewhere or otherwise is not what is projected either by the petitioner or by the respondent before the authorities. Therefore, on the principle of no work, no pay, I deem it appropriate to balance the right of the second respondent as also the financial liability upon the petitioner. Therefore, I deem it appropriate to mulct the petitioner to the tune of 50% of back wages, 50% of back wages as against 100% that is granted by both the fora. The learned counsel for the second respondent submits that from 2013 till 2016, the date on which he remained unauthorizedly absent, he has been paid 50% of the salary. If that be so, the learned counsel for the petitioner submits that full salary would be paid between 2013 to 2016, the date on which he remained unauthorizedly absent, if not already paid. The submission, in the light of said submission and the reasons so rendered here and above, the petition stands disposed without interfering with the impugned orders, except the modification of back wages as indicated here and above.
Your
Sorry,
lordships,
my lord,
the-
one submission, my lord, sorry. So far as full page ಕೊಟ್ಟಾರೆ ಅಂತ ಹೇಳಿ that is incorrect at I have not urged that ground. But orally, my lord, I ground. I mean,
ಎಲ್ಲಿ?
ಇದರಲ್ಲಿ ರಿಟ್ ಪಿಟಿಷನ್
petition, they have not urged the ground regarding the full
But
back.
oral, my lord, I urged at the time of hearing. Sorry, my lord.
ನೀವು ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿದಿರಲ್ಲ?
ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀನಿ.
ಎಂಟೈರ್ ಆರ್ಡರ್ ಚಾಲೆಂಜ್
Yeah,
ಮಾಡಿದಿರ
challenge
ತಾನೆ?
Yes,
ಸರಿ.
please, please.
Yes.
Your lordships, at least the back wages time may be fixed for.
Yes,
The arrears of the back wages from 1998 to 2013, if not already paid as on today, shall be paid
3 months.
within 12 weeks from the date of receipt of the copy of this order.
And
The same goes with the salary of 100% as is submitted by the counsel for the petitioner.
Obliged.
Bill number 5, M. Sidaraju.
Lordship, my client
Your client,
retired from customs office as a inspector in the year 31/1/2009. And afterwards, the sixth pay commission was paid in installments. Then he received the installment, first installment, second installment. In respect of third installment, he has not received.
why?
They told that department has informed that it has been sent, but it has not been credited in his account. That is the reason we have also written letters to the department, and it has been, they say that it has been paid to him. that is the reason we have filed this case. And at present, my lordship, the address what he has given, furnished at the time of retirement, he was settled at Bombay. And subsequently, now he is a native of Bagalkot. But in both the address, I have sent correspondence, that correspondence,
What is the problem with Bombay to Bagalkot?
no, sir, he is a native of Bagalkot.
Petitioner is not reachable
Not reachable.
to their
Oh,
concern.
ಅದಕ್ಕೆ.
My lordship, I have,
ವ್ಯಾಪ್ತಿ ಪ್ರದೇಶದಿಂದ ಆಚೆ ಇದ್ದಾರೆ.
yes, I have sent correspondence to him. And the whatever address what I have sent to Bombay as well as local address Bagalkot also returned. I am unable to contact the party now at
We'll
present.
dismiss it then.
Oh, yes, please.
Oh, yes. Original suit.
My lords,
That is the best way, my
ಅಲ್ವಾ?
lordship. Yes.
ಆಮೇಲೆ ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡ್ತಾರೆ.
No, my lordship, I have tried my level.
You are
best.
also from the customs department,
Yes.
ಮುಂಚೆ?
He was.
ಅಲ್ಲ ನೀವು.
Illa, my lordship. I was working with Mr. MP Kanvi, then government advocate. At that time, this has been filed, this case.
All right. The petitioner is before this court seeking the following. ಕೊಟ್ಟಿದ್ದೀರಾ ಎಲ್ಲ?
ಅಲ್ಲ my lords, ಕೊಟ್ಟಿದ್ದಾರೆ. The only contention is that my lords, even though the check has been issued in the name of the petitioner, it has been received by the petitioner and it has been encashed by the petitioner, my lords.
But
the name of the
ಪೇಮೆಂಟ್ ಆಗಿದೆಯಾ?
payment ಆಗಿದೆ my lords. To that effect,
Petitioner is before this court seeking the following prayer. The learned counsel appearing for the petitioner submits that the arrears as obtaining on implementation of the recommendations of the Sixth Pay Commission was paid in installments to the petitioner. Installments 1 and 2 reached the petitioner. The third did not. Therefore, the present petition is filed. The learned counsel Girish Shulmani submits all the 3 installments have been paid and the checks have been encashed by the petitioner. The learned counsel for the petitioner submits that the petitioner is not reachable. ವ್ಯಾಪ್ತಿ ಪ್ರದೇಶದಿಂದ ಆಚೆ ಇದ್ದಾರೆ. So therefore, he has no instructions as to whether the third is also paid and encashed as is paid and encashed qua 1 and 2 installments. Therefore, the petition is disposed on the submissions made by the counsel for the respondent, ordered accordingly. In the event the amount is not paid, the petitioner is at liberty to revive the subject proceedings. ಅಷ್ಟೇ.
Serial number 6, preemption is 1.
Appearing for respondent number 8, my lord.
Appear for respondent number 6 and 7 here.
Appearing for respondent number 8, my lord, party in person. My lord, I have filed for withdrawal of amount, my lord. The matter is already disposed. My lord.
What amount, sir?
Workmen compensation amount is deposited by the petitioner, my lord.
Why are you party in person?
My lord, my father is working in their company, my lord. It is a partnership firm. The partnership has not dissolved in accordance with the law, my lord.
How can you appear for your father? Oh, party in person,
Party.
that's all right. Partly in person.
No. They preferred a writ appeal also, my lord. That is also dismissed, my lord.
The subject petition stood disposed in terms of an order dated 20th September 2024. The amount ಎಷ್ಟಿದೆ ಎಲ್ಲಿ ಈ ಕೋರ್ಟಲ್ಲಿ ಇದೆಯಾ?
ಈ ಕೋರ್ಟಲ್ಲಿ ಇದೆ.
An amount was deposited at the time of the admission of the petition. The amount is lying in the registry. The the respondent party in person, 8th respondent, the respondent in person has filed an application seeking release of the amount. There is no objection from the hands of the petitioner. Therefore, the registry is directed to forthwith release the amount in favor of the 8th respondent after due verification of the records. Order on IA 1/24, ordered accordingly.
In favor of respondent number 6, 7 and 8.
I appear for 6 and 7 here.
ನಿಮಗ್ ಬೇಕಾ ಅವ್ರಿಗೆ ಬೇಕಾ?
ಅಲ್ಲ ಎಲ್ಲರಿಗೂ ಅದು ಆರ್ಡರ್ ಅಲ್ಲಿ ಎಲ್ಲರಿಗೂ ಮಾಡಿದ್ರು.
6 and 7 is the mother and
All right, release the amount in favor of respondent 6, 7 and 8.
Please, grateful.
Yes.
Serial number 7, S party.
Lord, for petitioner, my lord. May request for next week, my lord.
Why, sir?
But it's concurrent, my lord, long time listing.
AV.
Please.
Monday, my lords, may I request on Monday?
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂದ್ರೆ ಮಂಡೇನಾ? 3 ದಿನ ಇದೆ ಮಂಡೇಗೆ.
My lords, he has only four,
ತುಂಬಾ ಕೆಲಸ ಪೆಂಡಿಂಗ್ ಇದೆ.
my lords, he has only 4 years of service left, my lords. He has been
ಏನ್
removed.
ಮ್ಯಾಟ್ರ್ ಏನು?
Dismissal from the service, my lords, on account that.
Why?
The reason is that, my lords, another person has been taken job under the land losers quota of the same, of the land, my lords. That whatever has been claimed by the petitioner. But in actuality, my lords, the petitioners is having only an ownership to an extent of 1 acre and 6 guntas, and the other person, what they are alleging that is having an he's the owner for another 1 acre and 6 guntas, my lords.
ಸೇಮ್ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್?
Family.
No, my lords.
Brother?
There are different, my lords. There is a
Yes, after vacation.
Please.
Rightly dismissed.
no, my
ಒಂದೇ
lords.
ಫ್ಯಾಮಿಲಿಯಲ್ಲಿ ಎರಡು
No,
ಲ್ಯಾಂಡ್
no.
ಸರ್ವೆ ನಂಬರ್ ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟು ನೀವು ಜಾಬ್ ತಗೊಂಡಿದ್ದೀರಾ ಎರಡು?
No, my lords. It's not that.
ಇಲ್ಲ ಅದ್ರಲ್ಲಿ.
In the inquiry report, my lords, there is a finding that they are from different families. They are not even related by blood relatives, my lords. So this is contrary, my lords. There are certificate also.
After vacation. ತೊಂದರೆನೇ.
8/31, this is Mithun Mart.
Only 3 petitions has become infructuous.
ಹೌದಾ? Eleventh Council appearing for the petitioner
8,
submits that the
8.1, 8.2.
8, 8.1 and 8.2 have all been rendered infructuous. They stand disposed as having become infructuous.
8.3 post along with one more connected matter.
ಕೊಡಿ. ಏನದು?
Promotion malady. Oh, connect matter.
Tag the petition along with so and so, AV.
Next week, take chance.
17th.
17th.
ಅಷ್ಟೇ.
After vacation, my lord, in this connect, ಇನ್ನೊಂದು ಹೊಸದ್ ರಿಟ್ petition 25 ಅದಲ್ಲ objection ಹಾಕ್ಬೇಕು.
ಬರ್ಲಿ ಬಿಡಿ ನೋಡೋಣ. ಅವ್ರು ಬರ್ಲಿ. ದಾರಿಗೊಂಡ್ರು ಕೇಳಿದಾರೆ ಆದ್ಮೇಲೆ ಕೊಡ್ತಾರೆ. Yes.
Cell number 9, GB Patil.
Gopal V. Patil.
Occasion, my lord. Petitioner father, my lord.
Petitioner father.
My lord, hospitalized, my lord, kindly after.
ಅದ ಗ್ರೌಂಡ್. You're telling the act, ಇವತ್ತಿಂದ Eleventh Council for the petitioner seeks time on the score that the father of the petitioner is hospitalized.
Please.
AV. Enter ಮಾಡಿದ್ಯಾ?
ಇಲ್ಲ.
ಇಲ್ವಾ? After vacation.
Cell number 10, FE Patil.
This can be disposed of, my lord.
Serial number 10, my lord, sir. Serial number 10, I beg to appear for my lord, the respondent KIDB in all these cases. A memo has been filed by the petitioners on 6th, my lord, and they are seeking that it should be disposed of. And we need some time to take instructions because it is not covered by Bernard Francis case, my lord, as is being submitted.
2016,
And my lord,
sir. Memo ಯಾವಾಗ ಹಾಕಿದ್ರಿ?
please, my lord. Is ಮೊನ್ನೆ ಹಾಕಿದ್ದಾರೆ 6ನೇ ತಾರೀಕಿಗೆ ಹಾಕಿದ್ದಾರೆ. We
Industrial
have to
area,
take
my lord.
instructions.
Final notification has been, my lord, issued. Lord, corridor project, Lord, there is a limited interference. Now, my lord, we want to see that an award is passed under the new act. That is the only question, Lord.
That cannot be
ಯಾವ್ದು
granted
ನಿನ್ನೆ-
is our submission because, my lord,
ಒಂದ್ ನಿಮಿಷ, ನಿನ್ನೆ ಯಾವ್ದೋ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ರಲ್ಲ, ನಾಟ್ ಕವರ್ಡ್?
No. In favor of respondent, my lord.
ಗೊತ್ತು, ಅದೇ ನಾಟ್ ಕವರ್ಡ್ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಯಾಕೆ ನಿಮಗ್ ಕೇಳಲ್ವಾ ಅದು ಕವರ್ಡ್ ಅಂತ? ಹಂಗೇನೆ.
it is not covered in my submission. And, my lord, there is continuous litigation after the final notification was issued in 2010. And, my lord, in the meanwhile, in some cases, awards have been passed under the land and the general awards have been passed, my lord. And there are interim orders of stay restraining the
No award has been passed.
award.
Lord,
In some
under the new
cases,
act, they have to pass
there
now.
are interim orders.
Where is the synopsis?
My lord, will kindly, my lord, I have filed a
ಹಾಕಿದ್ದೀರಾ?
synopsis. Memo for disposal I have filed.
ಅದರಲ್ಲಿ ಸಿನಾಪ್ಸಿಸ್ ಇದೆಯಾ?
ಅದರಲ್ಲ ಎಲ್ಲ ಹೇಳಿದ್ದೀನಿ ನಾನು.
ಎಲ್ಲ ಹೇಳ್ಬಿಟ್ಟಿದ್ದೀರಾ?
ಹೌದು ಸರ್.
We will file short synopsis.
Total extent, my lord, is 26.
No synopsis?
Lord, the total extent is 26 acres, Lord,
Ready?
which was acquired. Lord, on 23/2, Lord, 2010, Lord, a notification under, Lord, 28/1 was issued. Lord, that was challenged by the petitioners, Lord, because their objections were not considered. Lord, the matter was remanded for reconsideration. Again, Lord, the same mistake was, Lord, done, and Lord, again, Lord, the final notification was came to request. Subsequently, Lord, you will also should kindly Lord, the final notification came to be issued on 8/11/2017, Lord, which is the subject matter of this writ petition. Now, my Lord, your Lordship, because, Lord, this is acquisition is for industrial corridor development, Lord. Therefore, Lord, there is a limited, Lord, grounds for, Lord, assailing the notification. Therefore, we have, Lord, seeking that annexure A, Lord, can't be quashed, and let them pass, my Lord, an award, Lord, under the
New act.
provisions of the act.
New act.
New act.
ಈಗೇನು ಅದೇನು ಪ್ರಾಬ್ಲಮ್ ಅದರಲ್ಲಿ?
ಏನಿಲ್ಲ ಪ್ರಾಬ್ಲಮ್.
ನಿಮಗಲ್ಲ, ಅವ್ರಿಗೆ. ನಿಮಗೆ ಯಾಕೆ ಪ್ರಾಬ್ಲಮ್ ಇದೆ? Shabrat sir.
Can I make submission? Yes, my lord. Awards cannot be passed under the new act because this notification, preliminary notification is dated 23/2/2010. And my lord, the view of the division bench has already taken the view that, my lord, in respect of acquisitions initiated prior to, my lord, 5/4/2022 or at least before 1/1/2014, the provisions of new land acquisition act cannot be made applicable. I have a short request, my lord, to make. Lordship may have these matters on 17th. I will be, my lord, physically appearing on that day. And, my lord, I will enlighten, my lord, assist the honorable court in, my lord, for disposal of the case if it is necessary. And, my lord, from 2011 up to this day, there were continuous litigations, my lord, filed by the petitioners that prevented the authorities from going ahead with the acquisition proceedings, my lord, and they have obtained interim orders in several cases. And, my lord, now they cannot ask for, my lord, the application of the provisions of New Land Acquisition Act and pass awards. And the prayer in the writ petition is that the provisions of section 28(7), 5, 6, 7, 8 and 9 of 6, 7 and 8 and section 29 and 30 of the KID Act are repugnant to the provisions of, Lord, New Land Acquisition Act. That has been answered by this honorable court in Jalaja's case, and this prayer is also covered, my lord, by the decision of the division bench in Jalaja's case. All that I will make my submissions. Since papers were received by me yesterday evening.
We'll take this on 17th. 18th, bada 17th.
17th, your lordship may kindly have. I'll certainly assist, my lords.
Your lordship, one humble submission in this case, your lordship. Own sister of petitioner number 2.
Own sister.
Own sister of petitioner number 2 has filed a impleading application.
You, Niva?
Yes.
Oh.
Lord, filed.
The rights of the parties have
but your
been settled in
lordship,
the civil court.
ಒಂದ್ ನಿಮಿಷ ಸರ್, ಓನ್ ಸಿಸ್ಟರ್ ಬಗ್ಗೆ ಏನು ಹೇಳ್ತಾ ಇದ್ದಾರೆ?
Yes, this sister of petitioner number 2, own sister, filed partition suit, that is 189, OS 189 of 2018, pending before the 4th Additional Senior Division Court, Dharwad. And earlier, prior to that, the brothers only, only brothers kept their sister in dark. They have filed own sister in dark, filed OS number 1 of 2011 at Bylaw Court. They have produced and tactfully made compromise decree. And that case is revoked. That case is revoked after knowing their hidden agenda. Yes, they have filed. They have kept their sister.
ಇವರೆಲ್ಲ brothers?
Yes, they are all playing game and keeping out of this sister and curtailing her legitimate right. That's why, your lordship, her impleading is must in this case, your lordship. That's why that is pleased to be allowed.
You are all own brothers? Purchasers?
No. Purchaser. That is.
Who is your brother here?
Petitioner number 2 is brother.
ಯಾವ್ದ್ರಲ್ಲಿ?
ಈ petition ದಲ್ಲಿ.
ಯಾವ್ದ್ರಲ್ಲಿ?
WP 106527.
ಅದು ನಿಮ್ದಾ? ಪೆಟಿಷನ್ ನಂಬರ್ 2 ಓನ್ ಸಿಸ್ಟರ್?
ಅದರ್ ಕೇಸ್
ಯಾಕೆ ಬಿಟ್ಬಿಟ್ರಿ ಮತ್ತೆ?
ಕೋರ್ಟ್ ನಾಗ ಅವರೇ ಬಂದು ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಈ ಪ್ರಾಪರ್ಟಿ ನಮ್ಗೆ ಅಲಾಟ್ ಮಾಡಿದ್ದಾರೆ. ದಟ್ ಕಾಂಪ್ರಮೈಸ್ ನಾ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀನಿ. ಈಗ ಏನಕ್ಕೆ ಗೊತ್ತು, ದೇ ಆರ್ ರಿಸೈಲಿಂಗ್. ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಆಗಿದೆ, ಸಿವಿಲ್
ರಿವೋಕ್ ಆಗಿದೆ ಅಂದ್ರು?
ಅಲ್ಲ, ಅದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀನಿ.
ಅಲ್ಲ, ಆರ್ಡರ್ ರಿವೋಕ್ ಆಗಿದೆ ಅಂತ
ಆಗಿದೆ. ಬೈಲೊಂಗಲ್ದಲ್ಲ ಆಗಿ ನಡೀತಾ ಇದೆ, ಅದು ನಡೀತಾ ಇದೆ. ಹೊಳ್ಳಿ ಮತ್ತೆ ನಡೀತಾ ಇದೆ. ಅವ್ರದ್ದು ಗೊತ್ತಿಲ್ದೇನೆ ಬೇರೆದಕ್ಕೆ ಸಹಿ ತಗೊಂಡು ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಅದು ಗೊತ್ತಾದ್ಮೇಲೆ ಒನ್ಸ್ ಅಗೇನ್ ಸಚಿಯಲ್ ಅವರೇ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ. ದಟ್ ಈಸ್ ಗೋಯಿಂಗ್ ಆನ್.
ಒಪ್ಕೊಂಡಿದ್ದಾರೆ?
ಅವ್ರ ಬ್ರದರ್ಸ್ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ ಸಾಕ್ಷಿಯಲ್ಲಿ. ನಾವು ಸೈ ತಗೊಂಡಿದೀವಿ, ಗೊತ್ತಿಲ್ದೇನೆ ತಗೊಂಡಿದೀವಿ ಅಂತೆಲ್ಲ ಅದೆಲ್ಲ
ಅದರ್ಸ್ ಗೊತ್ತಿಲ್ಲದೆ ಸೈನ್
ಅಂದ್ರೆ
ತಗೊಂಡಿದೀವಿ.
ಸೈನ್ ಮಾಡುವ ಇಲ್ಲಿ ಈ ಒಂದೇನೋ ಕೆಲಸ ಇದೆ KDB ಲ್ಯಾಂಡ್ ಹೋಗ್ತಾ ಇದೆ ಅನ್ಕೊಂಡು ಇನ್ನೋಸೆಂಟ್ಲಿ ಡಿಡ್ ಸಿಗ್ನೇಚರ್.
ಆಮೇಲೆ ಎಷ್ಟು ಬಂದಿದೆ ನಿಮಗೆ ಕಾಂಪ್ರಮೈಸ್ ಪ್ರಕಾರ?
It is going on.
ಅಲ್ಲಲ್ಲ, ಕಾಂಪ್ರಮೈಸ್ ಪ್ರಕಾರ ಏನು ಬರಲೇ ಇಲ್ವಾ?
That her legitimate share is not allotted for that demarcation is not properly done. That's why that partition suit is still going on in the bilingual court and Dharwad court also. Due to both sides same subject matter ಮೇಲೆ case ನಡೀತಾ ಇದ್ದಕ್ಕೆ section 10 of CPC, this case is stayed and that bilingual case is going on. That is not at all attained finality, your lordship. At this moment, keeping her out is curtailing her legitimate share in this property. That's why her implement is necessary.
It has been in the civil court itself, Lord, compromise has been effected. She is a signatory to that I have produced, Lord. She is also allotted other lands, Lord. That is there, Lord, I have produced.
ಪಾರ್ಟಿ ಆಗಿರ್ಲಿ, ಫೈನಲ್ ದಲ್ಲಿ ಅವ್ರಿಗೆ ಬರುತ್ತೋ ಬಿಡುತ್ತೋ ಕೋರ್ಟ್ ಡಿಸೈಡ್ ಮಾಡುತ್ತೆ. ಈಗಲೇ ಹೊರಗಿಡೋದು ಯಾಕೆ ಅವ್ರನ್ನ?
ಅಲ್ಲಿ ಹೊರಗೆ ಇಟ್ಬಿಟ್ಟಿದಾರಲ್ಲ.
ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಇಸ್ ಗೋಯಿಂಗ್ ಆನ್, ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್.
ಈಗ ನೀವೆಲ್ಲ ಪರ್ಚೇಸರ್ಸ್, ನಿಮಗೂ ಅವ್ರಿಗೂ ಸಂಬಂಧ ಇಲ್ಲ.
627 ಮಾತ್ರ, ಇದು 527 ಮಾತ್ರ.
ಒನ್ ಬ್ರದರ್ ಒನ್ ಸಿಸ್ಟರ್. ಎಸ್ 17th. ಅವತ್ ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಅವತ್ತೇ ನೋಡೋಣ.
ಪ್ಲೀಸ್.
ನೀವು ಯಾರಿಗೆ? ಒನ್ ಬ್ರದರಾ?
They are also claiming as a owner, my lord. They are also claiming as a owner.
I am in 10.2, my lords. My petitioner is, the petitioner in 10.2, as well as I filed implementing application is 10.4.
ನೀವು ಒನ್ ಸಿಸ್ಟರ್ ಒನ್ ಬ್ರದರ್?
No, my lords. I am the original owner of the
Or
property.
one neighbor?
Original owner, my lords.
Earlier owner. He is claiming as earlier owner.
Original owner, my lords. My lords, there is another petition filed by petitioner in 10.2, that is 10.
ಕಾಂಪನ್ಸೇಷನ್ ಜಾಸ್ತಿ ಬರುತ್ತೆ ಇದರಲ್ಲಿ. ಅದಕ್ಕೆ ಎಲ್ಲ ಆಲ್ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಹ್ಯಾವ್ ಕಮ್ ಅಪ್. ಗೊತ್ತಿಲ್ಲದವರೆಲ್ಲ ಈಗ ಒನ್ ಸಿಸ್ಟರ್ ಒನ್ ಬ್ರದರ್. ಕಾಂಪನ್ಸೇಷನ್ ಅಂದ ತಕ್ಷಣ ಬಾಂಡಿಂಗ್ ಜಾಸ್ತಿ ಆಗುತ್ತೆ. ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಸಿಸ್ಟಮ್ ವಿಲ್ ಕಮ್ ಬ್ಯಾಕ್. ಆಫ್ಟರ್ ಅಕ್ವಿಸಿಷನ್, ಅದೇ ಬಿಫೋರ್ ಅಕ್ವಿಸಿಷನ್ ಎಲ್ಲ ಎಲ್ಲೆಲ್ಲೋ ಇರ್ತಾರೆ. ಅಕ್ವಿಸಿಷನ್ ಆದ ತಕ್ಷಣ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಬ್ಯಾಕ್. ಪಾರ್ಟಿಷನ್ ಸೂಟ್ಸ್.
In this case, Lord, I have made an application for initiating contempt proceedings, Lord. Yes, sir.
Against your own sister?
Not sisters,
Then?
Lord.
And
This
10.4
Lord,
only
they
impeding.
claim to be a mortgagers.
10.4.
That mortgage, Lord, in the year 1951 itself
Okay.
has been
I thought
decided.
there is something more than what can be decided straight away in this.
The senior appearance may be noted.
Learned heard the learned ಎಲ್ಲರದು ಹಾಕಿ. FE Patil sir, Archana Magdur madam, ಇನ್ಯಾರಿದ್ದಾರೆ ನೀವು?
My lords, I am the petitioner in 10.2. One more petition needs to be
10.2,
connected.
Then the learned senior counsel Basaraj Shabrad appearing for the KIDB along with Shashank Hegde.
Yes.
Yes.
This petition needs to be connected, my lords. 1091117 of 2019.
ನಿಮ್ದು implementing application.
No, my lords, this is another petition filed.
ಅದೇನ್ connect
for
ಮಾಡ್ಬೇಕಾ? Same acquisition?
same acquisition, my lords. Now, what has happened in this petition, there is a stay order. So not to deposit the award amount, my lords, and there is a stay order. This
Of
needs
the
to be.
same acquisition?
On the same,
Tag the
lords.
tag ಮಾಡದ?
Please, it has to be tagged, my lords.
Tag the petition along with so and so. 17th. Yes, but Sabrad sir, 17th will close
Please,
this.
please, Lord. 17th, Lord, please,
In the fresh matters list.
please. Grateful, my lords.
Yes, sir.
By 11, here Bhavani Shankar.
I appear for petitioners in this case, my lord. My lord, in
Yes,
this
sir.
case, the petitioners are seeking, my lord, direction, my lord. They are challenging the government order, my lord, by which they have been denied the central DA, my lord. They are all retired professors. And, my lord, they retired, my lord, during 2012 to 15, 12 to 16, my lord. My lord, while settling their pensionary benefits, my lord, they were sanctioned the dearness allowance at rates which are applicable to state government employees. Not insofar as the
Differential DN.
how this one differential DA, my lord, which has been granted to the retired judicial officers and the family members of the judicial officers have not been sanctioned to us. We are claiming on the ground of parity.
You are on par with them?
Please, my lord, because IGC, UGC, ICAR, FNGPC and AICT are the 4 pay scales, my lord, which were, my lord, uniformly revised every 10 once in 10 years, my lord. And these the FNGPC retired officers, my lords, were also placed along with us, and all the benefits, my lord, which were related to the pension benefits, my lord, were equally and uniformly revised time and again. But only, my lord, in the year 2010, this government order, my lord, came to be passed, by which, my lord, the FNGPC, my lord, Annexure E can be seen, my lord. Annexure E, page number 112 is a typed copy.
We'll take it later.
Please.
17th, yes. Next.
Serial number 12.
18th. 18th.
All right, yes.
Guest lecture, regularization.
ಗೆಸ್ಟ್ ಲೆಕ್ಚರ್ಗೂ ರೆಗ್ಯುಲರೈಸೇಷನ್ ಎಷ್ಟು ವರ್ಷ ಮಾಡಿದ್ದೀರಾ?
2004 ಇಂದ
ಮಾಡ್ತಾನೆ ಇದ್ದಾರಾ?
Please.
Let's, as of now, my lords, there is no specific instructions in this.
ಗೆಸ್ಟ್ lecturers are appointed year wise.
2004.
Year wise.
Please, on contract basis.
But you've been working without
please, continuously,
without break?
Please,
But my lords, as per the records, my lords, they have not cleared the set, K-set and other qualifications, my lords.
2004 itself.
If they are qualified, you pass orders, otherwise not.
Subject to compliance of that.
They have given representations, you consider in accordance with law.
Consider in accordance.
The application was rejected. On the ground that my earlier application, my lord, it is, my lord.
Regularize ಅಂತ ಬರ್ದು ಚಾಲೆಂಜ್ ಅಲ್ಲಿ ಮಾಡಿದ್ದೀರಾ? ಕ್ವಾಶ್ ಏನ್ ಪ್ರೇಯರ್ ಮನೆ ಕೆಳಗೆ
Consequence. ಅಲ್ಲಿ 6.5 years ಆಗಿದೆ at the date of filing the earlier writ petition. On that ground it was.
No, as on today, you consider in accordance with law and pass.
Please.
The petitioner is before this court seeking the following prayer. The petition heard so and so. The petitioner is appointed as a guest lecturer in the second respondent university to work in the third respondent college in the year 2004. The petitioner continuously worked up to for 7 years, and on 25/2/2011, along with others, in the year 2009, after completion of 5 years of service, along with others, approach this court in writ petition 63264-278 of 2009, seeking the prayer for regularizing his services. While the pendency of the subject petition, the said petition comes to be disposed on 25/2/2011, directing consideration of the cases of these petitioners for regularization. On 2/1/2012, it transpires that on 21/5/2011, two of the persons who had been appointed as guest lecturers along with the petitioner were regularized. This becomes the subject matter of another writ petition in WP 63939 of 2011, seeking quashment of the representations that had been rejected pursuant to the order passed by this court in writ petition 63264 of 2009. Likewise, the case of the petitioner is also turned down, and another representation dated 5/1/2015 also comes to be rejected. Therefore, the petitioner is before this court in the subject petition. The learned counsel for the ಇವತ್ತು ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? Learned counsel appearing for the petitioner submits that he is working as a guest lecturer even today. In that light, he is entitled to be considered for the regularization in the least. The endorsement that is issued rejecting the claim of the petitioner takes the service of the petitioner only up to 2011 and then rejects it. Therefore, there is an error is his submission. The learned counsel Girish Hulmani, though, would defend the order passed by the court, order impugned, by contending that the petitioner is a guest lecturer. At best, he would be entitled to a guest lecturer, which is on an annual basis. If he is still continuing, it is only with a break and reappointing him as guest lecturer. The learned, therefore, cannot claim regularization as a matter of right. The learned HCGP would also toe the lines of the learned counsel Girish Hulmani in seeking rejection of the petition. I have given my anxious note. The four narrated facts are not in dispute. The petitioner joining as guest lecturer in the respondent, second respondent,
Please,
the second respondent, and working till today as a guest lecturer is an admitted fact.
in third respondent college.
Third respondent.
Third respondent college, sir. Third respondent college is an admitted fact. Therefore, the petitioner has, as on today, rendered 21 years of service. Petitioner was relieved, reappointed with an artificial break every year for as a guest lecturer is also a matter of record. The petitioner, along with others, had approached this court in writ petition 63264 of 2009, which comes to be disposed by directing consideration of the cases on 25th February 2011 by the following order. Page 42 to 43. The case of the petitioner itself fell for consideration before this court in WP 63939, wherein following the earlier order, the coordinate bench, the learned single judge, disposed the petition by the following order, 48 and 50, 48 to 50. The claim of the petitioner comes to be rejected.
Let's avoid annexure J, my lords. 6th May 2020, page number 58, my lords.
H and J both, my lord.
On 6th May 2025.
2015.
6th May 2015, by the following order, page 5960. The reason rendered for rejection ostensibly is, the reason rendered on a perusal of the impugned order is that the petitioner had completed on taking the service only up to 8/8/2012, not beyond that. The petitioner today has continued as a guest lecturer and, as observed herein above, has completed 21 years of service. In the light of the petitioner completing 21 years of service with certain artificial breaks, the respondent now will have to consider the entire service in the teeth of the law declared by the apex court in the aftermath of Uma Devi and pass necessary orders thereon in accordance with law. In that light, the impugned endorsement or impugned communication dated 6th May 2015 must necessarily be obliterated. For the aforesaid reasons, the following order. The petition is allowed in part. The order dated so and so stands quashed. The matter is remitted back to the hands of the university to pass necessary orders in accordance with law, bearing in mind the observations made in the course of the order, at any rate within 4 months from the date of receipt of the copy of this order.
Annexure H also, my lord.
H and J, both.
Guest lecturers means they were appointed for hourly basis, your lordship, not full-time basis.
The learned HCGP would toe the lines ಅಲ್ಲಿ. Learned HCGP would, while towing the lines of the council appearing for the university, for the second and third respondent, would submit that the petitioner was appointed as a guest lecturer only to teach on hourly basis and has been continued in the same manner till date.
Regarding continuity of service, my lords, it is the submission of the petitioner.
In accordance with law, I think it is made clear this court has not, except narrating the facts, link in the chain of events and dates, this court has not assessed the merit of the claim of the petition.
Much.
Bill number 13, Girish V. Bhatt, SS Uttal Court.
Petition is not maintainable, my lord.
ಏನಿದು?
The petitioner has challenged the bylaw made by the respond number club.
Which club?
It's a private club, social club.
ಎಲ್ಲಿದ್ದಾರೆ ಇವರು? The petitioner is before this court seeking the following prayer. A perusal at the prayer would admittedly indicate that the petitioner is calling in question a bylaw of social club Hubballi. ಆ ಥರನೇ ಇದೆಯಾ? Social club Hubballi, which admittedly is a private institute, private club. And a bylaw of the private club can hardly be called in question before this court, invoking its jurisdiction under Article 226 of the Constitution of India. Therefore, a private bylaw of a private club is being questioned by a private citizen. Of course, private citizen is being questioned by the petitioner. The petition writ petition wanting in maintainability stands rejected. Yes.
Bill number 14, okay, Nagraju, Dineshim Kulkarni.
After vacation, my lords.
Why?
After vacation.
The
Allegation was for unauthorized absent.
ಎಷ್ಟು ದಿನ?
Inquiry was conducted, it is held and not proved.
For 4 years, my lords.
4 years?
Allegation, my lord, the inquiry was conducted. Inquiry, my lord, held that there is no, my lord.
Exonerated, huh?
Yes, exonerated.
ಮತ್ತೆ?
Thereafter, my lord, they have treated, my lord, 1,800 days as a LWP.
ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ ಈಗ?
ಮಾಡಿದ್ವಿ. In fact, my lord,
What
according
happened to that inquiry? Disciplinary authority accepted?
accepted, it is accepted.
Accept ಆದ್ಮೇಲೆ ಮತ್ತೆ ಇದನ್ನ
They have
ಮಾಡಿದಾರ?
not challenged, my lord, they have not challenged. And my lord, according
ಅದಲ್ಲ.
to me, annexure.
Inquiry officer exonerated you.
Yes.
Disciplinary authority accepted that exoneration?
Yes.
Or disagreed?
They have not taken.
No, there are two things, Dinesh
Yes,
Kulkarni
yes,
sir.
yes,
Once the inquiry officer submits his report, disciplinary authority has two options.
yes.
One to accept it and close it, or disagree and issue a notice and impose separate penalty.
Yes.
What has happened?
My lord, ದೋಷ ಮುಕ್ತರನ್ನಾಗಿ ಆದೇಶಿಸಲಾಗಿದೆ ಅಂತ ಮಾಡಿದ್ದಾರೆ.
ಆದೇಶನೂ ಆಗಿದೆಯಾ? ಆಮೇಲೆ ಮತ್ತೆ ಈ ಆದೇಶ ಹೆಂಗ್ ಬಂತು? Yes.
After vacation, my lords, my
So
statement.
after vacation, open and shut case, you, after accepting, you can't do anything.
Tuesday, my lords.
List on 16th in the fresh matters list.
Say number 15, AP Hegde, John Mani.
So I request my lord, matter may kindly be taken up on 17th.
After vacation.
17th.
After vacation.
Number 16, Sajid Gudwala.
ಇವೆಲ್ಲ ತೀರ್ಮಾನ ಮಾಡಕ್ಕಾಗಲ್ಲ ಜಲ್ದಿ. Yes. Sajid.
Kindly give me password 16.
My lordship, may I seek time, my lordship?
May I grant time?
Please.
Yes. After vacation.
Please.
Bill number 17. Vishwanath Hegde.
Sarthi. ಏನು?
The only point is with regard to the aspect, redesignation from health educator to health educator come lecturer. As per NMC norms, for the post of teaching staffs, qualification as determined under postgraduate. In 2005 itself, the norms made that health educator has to be treated on par with as a lecturer under the regulations. Nevertheless, a notification is issued in 2010. Notifying me as an health educator. I participated and selected. Thereafterwards, along with me, a statistician is also appointed. For her, they have treated on par with a lecturer as per the terms. Nevertheless, in 2017, they considered as per the regulations.
ಅಂದ್ರೆ you are treated on par now.
They have done.
ಈಗ ಆ period ಗೆ ಮಾತ್ರನಾ?
ಆ period ಗೂ ಅಲ್ಲ. They went further extent. Having treated, they passed a resolution, they forwarded to the government for approval. Since the governing council is the authority.
ಇದು ಕಿಮ್ಸಾ? ಮಾಡದೆ ಪರವಾಗಿಲ್ಲ. ಹೇಳಿ.
ಅದರ ಪ್ರಕಾರ ಅವರು ಗವರ್ಮೆಂಟ್ ಕಳಿಸಿದ್ಮೇಲೆ ಗವರ್ಮೆಂಟ್ ರಿಜೆಕ್ಟೆಡ್, one petition is challenged on that. During the pendency of that writ petition, they have considered the redesignated me in 2019. That is on 17/6/2019, they redesignated and the salary has been given. Once again, they have placed it in the governing council.
ಈಗ ನಿಮ್ಮ prayer ಏನು?
My prayer is now, in the last petition, they have withdrawn. That have challenged.
ಈಗ 3 petition ಇದೆ.
3 petition ಇದೆ. ಈ petition ಅಲ್ಲೋ ಆದ್ರೆ ಅದು it is become only academic. It is only academic.
ಅಂದ್ರೆ ಯಾವ petition ಈಗ ತಗೋಬೇಕು ಅದು ಹೇಳ್ಬೇಕು.
10,004, 1,04,876. 104876.
ಅದೇ 17.2.
Yes.
ಅದೇ ಕೊಟ್ಬಿಡಿ. ಇದು ಹಿಯರ್ ಮಾಡಿದ್ರೆ ಬಾಕಿ ಎರಡು ಬೇಕಾಗಿಲ್ಲ.
That has become academic.
ಕೊಡಿ.
For that, I have placed the synopsis along with all documents.
ಇದರಲ್ಲಿ ಈ petition
ಇಲ್ಲ, ಆ petition ಅಲ್ಲೇ ಹಾಕಿದ್ದೀನಿ. Since your lordship has, that is on 21/2/2025.
ಲಾಸ್ಟ್ ಟೈಮ್ ಕೇಳಿದ್ನೆ ನಾನು.
ಹೌದು ಕೇಳಿದ್ರಿ, ಆಮೇಲೆ ಡೀಟೇಲ್ ಇದನ್ನ ಹಾಕಿ ಅಂತ ಹೇಳಿದ್ರಿ, ಸಿನಾಪ್ಸಿಸ್ ಅಲಾಂಗ್ ವಿತ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ದಟ್ ಐ Special Lordship. 2005, as per document number 1, the health educator has been converted into health educator cum lecturer. Page 15, your Lordship. However, in 2010, notification is issued to fill up the post. For the post of health educator, they notified as a health educator instead of cum lecturer. I participated in the selection process. I have been appointed as a health educator with effect from 17/10/2011. Sorry, 20th of April 2010, Annexure C.
Hmm.
Thereafterwards, I have given a representation stating that as per the NMC norms, health educator has to be redesignated to that of a lecturer. However, in 2011 itself, my colleague who is appointed as statistician along with me in the same branch, she has been accorded with a post of lecturer. Nevertheless, I have not been considered. Finally, in 2017,
No, she has been redesignated.
redesignated as statistician cum lecturer.
ಅಸಿಸ್ಟೆಂಟ್ ಪ್ರೊಫೆಸರ್ ಅಂತ ಬರೆದಿದ್ದೀರಾ ಇಲ್ಲಿ?
ಇಲ್ಲ ಅಸಿಸ್ಟೆಂಟ್ ಪ್ರೊಫೆಸರ್ ಅಂತಾನೆ ಮಾಡಿದ್ದಾರೆ ಅವ್ರಿಗೆ ಅಸಿಸ್ಟೆಂಟ್ ಸಾರಿ ಅಸಿಸ್ಟೆಂಟ್ ಪ್ರೊಫೆಸರ್ ಅಂತಾನೆ ಮಾಡಿದ್ದಾರೆ. In 26/10/2017, my consideration has been placed before the governing council. Considering the fact that my colleague is considered as per the NMC norms, and I should also be, a recommendation is made approving the fact that I am entitled for the health educator cum lecturer. That has been passed on 26/10/2017. And after approving the resolution, it has been forwarded to the government for giving effect. Government has issued an order stating that I am not eligible for that. That was challenged before the first writ petition. During the pendency of that writ petition, I have been accorded with the
ನಿಮಗೆ ಯಾವತ್ತು ಕೊಟ್ಟರು
ಅಂದ್ರೆ ನನಗೆ ಡಾಕ್ಯುಮೆಂಟ್ ನಂಬರ್ 87 your lordship, page 87.
ಅಲ್ಲ, that is 5/4/2018.
17/6/2019 your lordship.
17/6 during the pendency.
During the pendency.
Now, so 17/6/2019 you have been redesignated or promoted. ಏನ್ ಮಾಡಿದ್ರು?
ಪದನಾಮಕರಿಸಿದೆ, redesignation.
Redesignation. All right.
And I have also been given the pay scale which is determined for the post.
Assistant professor.
And I have been entitled for that. From that time I was entitled.
ಇದಾದ್ಮೇಲೆ ಏನ್ grievance?
ಇದಾದ್ಮೇಲೆ once again my case has been considered before the governing council for the promotion to others. ಅದರಲ್ಲಿ ಒಂದು resolution pass ಮಾಡ್ತಾರೆ. No, we have given him, but nevertheless, it has to be ratified by the government because since it is an autonomous institution, it is only governing council. So they say that we will forward to the
ಸರಿ, ಗವರ್ಮೆಂಟ್ ಏನ್ ಮಾಡ್ತು?
Government ಕೊಡಕ್ ಬರಲ್ಲ ಅಂತ ತಿರ್ಗಾ ಬರೆಯುತ್ತೆ.
ಎಲ್ಲಿದೆ?
That document number 15, your lordship get it.
Document 15 ಅಲ್ಲ, clause ಏನ್ ಹೇಳಿ?
ಅಲ್ಲ, document number 15 ಅಲ್ಲಿ till government approves that I am now only entitled for a health educator salary ಅಂತ ಮಾಡ್ತಾರೆ. That I have a challenge before this honorable court.
ಆಯ್ತು.
This honorable court granted in interim order.
ಆಯ್ತು.
ಅದಾದ್ಮೇಲೆ ಗವರ್ಮೆಂಟ್ ಇಂದ ಒಂದು ಲೆಟರ್ ಬರೀತಾರೆ ಇವರು.
ಒಂದು ನಿಮಿಷ. ಈ ಸ್ಟ್ಯಾಟಿಸ್ಟಿಷಿಯನ್ ರೀಡೆಸಿಗ್ನೇಟ್ ಮಾಡಿದ್ರಲ್ಲ, ಗವರ್ಮೆಂಟ್ ಕಳ್ಸಿದ್ರಾ?
ಅದು ಕಳ್ಸಿಲ್ಲ. That was not a subject matter before the government. It is only the
ಗವರ್ಮೆಂಟ್ ಕಳಿಸ್ಲಿಲ್ಲ. ಅವ್ರಿಗೆ ಅಸಿಸ್ಟೆಂಟ್ ಪ್ರೊಫೆಸರ್ ಆಯ್ತು, ಅವ್ರು ಮುಂದೆ ಹೋದ್ರು. ನೀವ್ ಎಲ್ಲಿದ್ದೀರಾ? ಅಲ್ಲೇ ಇದ್ದೀರಾ?
ನಾನು ಎಲ್ಲಿದ್ದೀನಿ ಅಲ್ಲೇ ಇದ್ದೀನಿ.
ಸರಿ, ನೀವು ಕೂತ್ಕೊಳ್ಳಿ ಈಗ. ಎಸ್ ಸರ್.
Please. Let's may kindly see page number 28 of the compilation. Thus, this is the notification issued for calling for the posts in the year 2010.
1 minute. ಯಾವ್ಯಾವ ಪೋಸ್ಟ್ ಕರೆದ್ರಿ ಅವಾಗ?
Please, may kindly see page number 28.
ಯಾವ್ಯಾವ ಪೋಸ್ಟ್?
There are several posts.
Which
The
are
tabular
those
columns.
Which are the several? One is health educator.
Tabular column shows the teaching post. The other than tabular column, it is ancillary post, not teaching post.
Now, this health educator is not a
teaching post.
Non-teaching post.
Please. That is clear from the notification at page
The
number
statistician was a teaching post.
Eitherly that was not called for.
ಯಾವ್ದ್ರಲ್ಲಿ?
E-publication, notification.
This Itagmat was not appointed along with the petitioner?
E-notification prakara
Was
appointed.
not appointed along with the petitioner?
No. Idhralli. This is one thing. Let's may kindly see appointment letter at page number 31. This is way back in the year 2010. Appointment
Appointed as
itself is
health educator.
only. Because what was called for is a health educator.
1 minute.
Please.
MCI norms ಯಾವ್ದ್ರಲ್ಲಿದೆ? Page.
That your lordship get it in document number 1, page 10. The relevant pages your lordship get it in page 15.
1 minute. The minimum staff required in the Department of Anatomy, Psychology, Pharmacology, Community Medicine shall be one so and so. ಇಲ್ಲಿ ಟೀಚಿಂಗ್ ಅಂತ ಎಲ್ಲಿದೆ? ಇಲ್ಲಿ Medical Council of India's grievance sanction further Term and postgraduate.
My brother is referring to page number 15.
ಗೊತ್ತಾಯ್ತು, ಅದು ಟೀಚಿಂಗ್ ಅಂತ ಎಲ್ಲಿದೆ ಅಂತ ಅಷ್ಟೇ.
ಹಂಗೆ ಕಮ್ ಲೆಕ್ಚರರ್ ಅಂತ ಇದೆ, ಅದಕ್ಕೆ ಅವರು they are
ಲೆಕ್ಚರರ್ ಅಂದ್ಮೇಲೆ ಟೀಚಿಂಗ್.
that is the reason
Provided
why they are-
further the person in charge of unit shall not be below the rank of first. In charge of the unit, ಅವರು ಬೇರೆ.
Please, this
So one minute, one minute. ಈ ಸ್ಟ್ಯಾಟಿಸ್ಟಿಷಿಯನ್ ಯಾವ್ದ್ರಲ್ಲಿ ಮೆಡಿಕಲ್ ಕೌನ್ಸಿಲ್ ಅಲ್ಲಿ?
ಅದೇ ನೆಕ್ಸ್ಟ್ ಮೇಲ್ಗಡೆನೆ ಇದೆ.
MCI ಅಲ್ಲ.
B statistician, C is health educator. The very same, your lordship. Page 15 ಅಲ್ಲೇನೆ. First is epidemiology cum lecturer.
Yes.
I want.
ಇಲ್ಲ.
It is not their case that I am not teaching staff. Altogether they passed.
ನಾನ್ ಟೀಚಿಂಗ್ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ, ಅದಕ್ಕೋಸ್ಕರ ಕೇಳ್ದೆ. Yes sir.
Please.
Now
Plus the regulation which they are referring to, it commences at page number 13. Plus it says, the regulations may be called the postgraduate
medical amendment regulations.
Postgraduate medical education regulations. This
statistician postgraduate.
This is of the year 2005. What was called for is in the year 2010. 2009 regulation may kindly be seen at page number 17. This regulation which they are referring to is applicable only insofar as the institutes which are running exclusively the postgraduate courses.
ಆಯ್ತು, ಇದೇನು ಹೇಳಿ.
Page number 17 may kindly be seen. This is in the year 2009, which was issued by the very same MCI. Lords may kindly see relevant portion at page number 26.
Health educator.
My lords got it.
Yes.
Clause number 8.
Clause number 6.
Clause number 6.
Health educator.
Page 26.
Page 26, clause 6.
It commences with the clause 8. There it says serial number
Department
5
of Community Medicine.
Adralli serial number 5 may kindly be seen. First tablet.
Correct. Statistician come assistant professor.
There itself it has been specified as statistician come assistant professor.
ಇಲ್ಲಿ health
Here it is only
health educator ಅಷ್ಟೇ.
Even in both rural as well as in the urban training, both are mentioned in page number 26 itself. Please. So subsequent to this, the notification was called for in the year 2010, that is on 5/4/2010. So this regulation is applicable to the present case in hand. This is one aspect. The second aspect, the other side is referring to the resolution.
One more clarification. Now, when did you redesignate her as lecturer?
That is plus the
17/6/2019.
page number
17/6/2019.
Page 87.
It is.
On what basis? On what basis?
Please. This was admittedly.
On what basis?
Please. This was admittedly the health educator come lecturer. There is no sanction post as per 2009.
Post bidi ನೀವು. I am not on post at all. Now, health educator come lecturer is the claim.
That has been withdrawn subsequently.
ಏನು?
This order has been withdrawn subsequently and it was referred to the in the next governing council meeting. It was decided to send it to the FD because it is not a sanction post and it was not a teaching post. The government said as it is not a teaching post and we had not approved it, they passed an order at page number. The initial order is at page number 50. 70. Page number 70. This is the first order passed by the government.
So now there is no order in favor of the petitioner that health educator come lecturer. ಯಾವ್ದಿಲ್ವಾ? There is nothing is in subsistence.
No.
Interim order continue ಆಗ್ಬೇಕು, but order is withdrawn.
Third submission is plus page number 70 is the first order. Second order is page number 7. Page 105 may kindly be seen. This is yet another order passed by the state government. This is even as on today, it has never been challenged by the petitioner before any of the forums. This order may kindly be, I may be permitted to read it. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖಿತ ಪತ್ರದ ಕಡೆಗೆ ತಮ್ಮ ಗಮನ ಸೆಳೆಯುತ್ತಾ 7ನೇ ವೇತನ ಶ್ರೇಣಿ ಆಯೋಗದ ಶಿಫಾರಸಿನ ಮೇರೆಗೆ ಎಐಸಿಟಿ ಅಧಿಸೂಚನೆ 2016 ಪರಿಷ್ಕೃತ ವೇತನ ಶ್ರೇಣಿಯಲ್ಲಿ ಮಾತ್ರ ರಾಜ್ಯದಲ್ಲಿನ ಸಹಾಯಕ ವೈದ್ಯಕೀಯ ಬೋಧಕ ಸಿಬ್ಬಂದಿಗಳಿಗೆ ವಿಸ್ತರಿಸಲಾಗಿದೆ. ಎಐಸಿಟಿ ಮಾರ್ಗಸೂಚಿಗಳ ಪ್ರಕಾರ AICT ವೇತನ ಶ್ರೇಣಿಯು ಆರಂಭಿಕ ಹುದ್ದೆಯಾದ ಸಹಾಯಕ ಪ್ರಾಧ್ಯಾಪಕರ ಹುದ್ದೆಯನ್ನು ನೇರ ನೇಮಕಾತಿ ಮೂಲಕ ಮಾತ್ರ ಭರ್ತಿ ಮಾಡಲು ಅವಕಾಶವಿದ್ದು ಪದೋನ್ನತಿ ಮುಖಾಂತರ ಭರ್ತಿ ಮಾಡಲು ಅವಕಾಶವಿರುವುದಿಲ್ಲ. ಮುಂದುವರೆದು AICT ವೇತನ ಶ್ರೇಣಿಯಲ್ಲಿ
ನೋಡಾಯ್ತು.
there they rejected and they said he is not eligible. This order is not challenged before any of the forums.
This is concerning the petitioner only.
ಹೌದು. ವಿಷಯ subject itself says.
ಈಗ ಹೆಲ್ತ್ ಎಜುಕೇಟರ್ ಈಗ ಪ್ರೆಸೆಂಟ್ ಕ್ವಾಲಿಫಿಕೇಶನ್ ಏನು?
Health educator.
You are qualified to hold the post? Yes, ಅಷ್ಟೇ. Yes, sir.
I request your lordship kindly take page 78 in the very same compilation.
78.
78, document number 10. Medical Council of India Postgraduation Medical Education Regulation 2000, amended on May 2018. Lordship, since your lordship has asked a specific question to my learned friend, why he has entitled from 2019?
That's what.
That your lordship get it in page 83 now, staff requirements. Statistician come lecturer, health educator come lecturer.
ಈ MCI ನು ಒಂದೊಂದ್ ಸರಿಗೆ ಒಂದ್ ಮಾಡ್ತಾರೆ.
ಇಲ್ಲ, ಈಗಲೂ ಇದೆ.
That is
as on today,
this honorable court had
as on today,
had directed the petitioner to implement the NMC also as a party.
as on today, this is the qualification which is prescribed now. Now your lordship has, my learned friend has argued one more point. No, page 105, in which I have not challenged this. I request your lordship, the impugned order is, this 105 is a communication made by the government.
Interdepartment.
It has also been sent to the petitioner also. That is the instructions given.
Please.
In correspondence to that communication, impugned A, annexure A, which has been challenged now in the present petition, has been issued withdrawn.
ಎಲ್ಲಿದೆ ನೀವು ಪೆಟಿಷನ್ ಕಳಿಸಿರೋದು ಎಲ್ಲಿದೆ?
Petition, no, my
105 ಪ್ರತಿ ಕಳಿಸಿರೋದು ಎಲ್ಲಿದೆ?
ಕಳಿಸಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ?
In fact,
ಎಲ್ಲಿ ಇಲ್ವೇ ಇಲ್ಲ ಇಲ್ಲಿ?
No, I have been instructed that it has been sent to the petitioner. I can place that also on record.
It is only a communication, it is not an order.
I can place that also on
record. It is intra-department communication.
What's the use? Annexure A springs from that?
Annexure A is on the basis of that. Your lordship get it in Ulleka of Annexure A. Page 20 in the writ petition.
So now your grievance is that is withdrawn, one though, could not have been. But in the interregnum, MCI had clearly held on which the notification.
And it is subsisting as on today.
No, ಅದು 105 page first ತೋರಿಸಿದ್ರಲ್ಲ.
200.
That is applicable to you?
2005.
2005.
2005, your lordship, except 2009. From there onwards, it has been redesignated, and in all other departments, in all other medical colleges, it has been extended to the health educators. That was also I placed it.
Master's degree, alva? Sociology. Anything else, sir?
My specific submission was that it is a non-teaching post, and insofar as his request is concerned. First governing council meeting, they did not decide that he is entitled. They said if in any other institute, if it is done, it can be recommended to the state government. That recommendation was rejected by the state government.
The petitioner, ಈಗ ಇದೊಂದನ್ನು ಬರೀತೀನಿ.
One more submission. Now in pursuance to withdrawal, as per the direction of the government, what the pay scale which is extended from 2019, they also recovered that.
Recover ಮಾಡಿಬಿಟ್ಟಿದಾರಾ?
Recovered ಮಾಡಿ health educator kurti. In spite of interim order, we have filed a contempt. The honorable court has, since the petition is seized, you are educated.
Recover ಮಾಡ್ಬಿಡಿ.
With extended from 19/6/2021 up to the impugned order annexure A.
Recover ಮಾಡ್ಬಿಟ್ರಾ?
I have no, I'm sorry.
Recover ಮಾಡಿದ್ರು.
The petitioner is before this court. These petitions are preferred by the same petitioner against the same parties. Grievances differ, facts remain the same. Therefore, the learned counsel for the petitioner, V.R. Sarthi, appearing for the petitioner, V.R. Sarthi, submits that if writ petition 104876 of 2021 is decided, the other petitions become academic. Therefore, the petition, the facts obtaining in writ petition 104,876 is made, is noted and considered. The petitioner, and then compilation ಇತ್ತಲ್ಲ, synopsis ಏನು ಅಂತ. The third respondent is Kimsala. Please. Karnataka Institute of Medical Sciences, hereinafter referred to as the Institute for short. An autonomous institution which staffing pattern, payment of salary and other things are under the Medical Council of India regulations and the AICT regulations insofar as the pay scale is concerned. It transpires that on 15/3/2005, the Medical Council of India amended its regulations and in terms of the amendment declared the post of health educator to be redesignated as health educator cum lecturer. Then comes the Medical Council of India regulations of the year 2009, which were depicted minimum requirements for MBBS, minimum requirements 150 MBBS.
The students.
Minimum requirement of MBBS admission regulations. In this, the post of health educator remained in a health educator but did not depict itself to be the health educator cum lecturer. The petitioner was appointed, or the respondent institution called for, sought to fill up the post of, one post of health educator, therefore called for a walk-in interview. The petitioner participates in the said interview, emerges successful, and is appointed as health educator in the Department of Community Medicine at the third respondent on 20th April 2010. After which the petitioner, after the appointment of the petitioner registered a claim that he should have been appointed as health educator cum lecturer, and it was an error. One S.R. Itagmat, who was a biostatistician/tutor at the community medicine department, who was appointed along with the petitioner, was immediately redesignated as assistant professor on 7/10/2011. The same treatment was not meted out to the petitioner. The third respondent then, realizing the said to be, it is the averment in the petition that the institute, realizing the mistake of wrong designation of the petitioner, rectified it and designated the petitioner as health educator cum lecturer in terms of the Medical Council of India regulations. The third respondent then forwards a communication to the state seeking approval of the action of the governing council of the third respondent in redesignating the petitioner as health educator cum lecturer in place of health educator that was all along the petitioner being described of. The government rejects the communication, government declines to approve the action of the governing council, the third respondent, on the score that there is no sanctioned vacant post of health educator cum lecturer. What was available was only health educator, therefore the post stood, the approval was withdrawn. Approval was not granted. On the strength of the approval not being granted, the action of the third respondent began against the petitioner by directing recovery of salary that was paid in the post of health educator cum lecturer from out of the salary of the petitioner, and placing the petitioner back to the post of health educator, redesignating the petitioner back to the post of health educator. All these actions have been called in question in the cases at hand. In the case at hand, and the offshoot of the present petition is what is called in question or preceding actions are called in question in the companion petitions. The learned counsel, the learned counsel V.R. Sarthi, along with Vishwanath Hegde, would vehemently contend that the petitioner had to be appointed as health educator cum lecturer, as the notification was issued pursuant to the regulations of the Medical Council of India, which by then had declared health educator had declared the post to be known as health educator cum lecturer, as the very Medical Council of India regulations described statistician cum lecturer. Therefore, the learned counsel submits it was an error on the part of the third respondent in calling or appointing the petitioner as health educator only in place of health educator cum lecturer. Realizing the mistake, the governing council of the third respondent then resolved to redesignate the petitioner as health educator cum lecturer, which need not have been approved by the state, but a communication is sent for approval and the approval is turned down. The learned counsel, taking this quote through the Medical Council of India regulations then and now, would submit that health educator cum lecturer is the nomenclature that is subsisting today, and would submit that the petitioner should be entitled to the post of health educator cum lecturer, as it is what is found in the MCI regulations. Per contra, contrariwise, the learned counsel Arvind Kulkarni, appearing for the institute, would vehemently refute the submission, contending that the post of health educator was never declared to be a teaching post. It is always a non-teaching post, and therefore there is no question of declaration of health educator to be equivalent to lecturer or assistant professor, as the case would be. The learned counsel would submit that the case of Itagimat was that a statistician was a tutor and a tutor was always a lecturer. Therefore, the designation of tutor, the designation of statistician to be a lecturer was in tune with the regulations. Therefore, the error was rectified right after the appointment of Itagimat. The learned counsel would further submit that the government has not accepted the government has not government has declined to approve the resolution of the governing council which redesignated the petitioner as health educator cum lecturer. Therefore, the institute was left with no choice but to recover the entire amount from the hands of from the salary of the petitioner, as it was an error committed by the institute to hand over the redesignation and all consequential benefits thereon.
2009 regulation.
He would submit that the issue should not be decided only looking at 2005 or 2018 regulations. There are regulations in the year 2009 pursuant to which the recruitment took place or walk-in interview took place. Therefore, in the 2009 regulations, what is found is only health educator and not health educator cum lecturer. The learned HCGP would toe the lines of
Not sanctioned post.
to toe the lines of the council Arvind Kulkarni, but however would submit the state has played its role only in indicating that there cannot be an appointment or a redesignation to a post that is not sanctioned, as health educator cum lecturer was not a post that was sanctioned or available in the institute. No fault can be found with the order, with the communication of the state to the institution. Is a submission of the learned HCGP.
It is
I
not
have given
teaching
my
post.
anxious consideration to the submissions
It is
made
not
known.
teaching post adanda.
He would at the toe the lines ಆದ್ಮೇಲೆ ಎಲ್ಲ ಬೇರೆದು extra line ಅಷ್ಟೇ ಹೇಳಿದ್ದೆ. I have given my source. Therefore, narrated facts are not in dispute. The issue that falls for consideration is whether the redesignation of the petitioner as as health educator cum lecturer is in tune with law or wanting in law. For which it is necessary to trace the history of the regulations of the Medical Council of India and the nomenclature depicted therein, the qualification. The post of health educator carries with it certain necessary qualification. The qualification is one should be a postgraduate in the qualification.
But your lordship, in page 15,
15,
15. This is in 15th March 2005 regulation. 15 page, first.
Qualifications, sir.
Qualifications.
Qualification document. ಈಗ ಯಾವ್ದ್ರಲ್ಲ ನೋಡಿದ್ನಪ್ಪ.
ಈಗಿದ್ರೆ ಅನಕ್ಕೆ
ಪೋಸ್ಟ್ ಗ್ರಾಜುಯೇಟ್ ಅಂತ ನೋಡಿ, ಪೋಸ್ಟ್ ಪೆಟಿಷನ್ ಅಲ್ಲಿ ನೋಡಿದ್ದ.
ಅಲ್ಲ, but the notification
Number
which was
13
issued calling for the application.
Notification.
13.
ಅದರಲ್ಲಿ
I am going on something else. ನೀವು ಹೇಳೋದು ಹೇಳ್ಬಿಡ್ತೀರ, ರೀಸನ್ ನಾವು ತಾನೇ ಕೊಡ್ಬೇಕು. The qualification for health educator is as follows. ಇಲ್ಲಿ flag ಹಾಕಿದ್ದೀನಿ ಮೇಡಮ್. In terms in the cadre and recruitment rules, one should be the health educator is to be filled up by direct recruitment and promotion to the tune of 50% each. One should be a holder of master's degree in sociology or anthropology or psychology or political science or geography or history or economics of a university established by law in India. ಸಿಗ್ತಾ ಅಲ್ವಾ?
ಸಾರಿ,
ತೊಗೊಳ್ಳಿ. ಹೆಲ್ತ್ ಎಜುಕೇಟರ್.
ಸ್ಟೇಟ್ ಸ್ಕೇಲ್ ಅಲ್ಲಿ
ತಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ಇದೆ.
those documents were produced as addition.
Whatever, ನಿಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ಇದೆ.
State scale
ನಿಮ್ಮ
ಅಲ್ಲಿ
ಅಬ್ಜೆಕ್ಷನ್ ನಿಮಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂತೀರಲ್ಲ.
state scale ಅಲ್ಲಿ that was the
Whatever,
requirement.
so and so. The issue, the said qualification that is necessary is maybe for state pay scale. There is no change in qualification in, and even under the Medical Council of India. Now let me consider the regulations of the Medical Council of India notified from time to time. On 15th March 2005, the Medical Council of India makes regulations further to amend the postgraduate medical education regulations 2000. The third respondent is medical college and a research institute is not in dispute. It is a teaching hospital. The qualification, the staff requirements of a teaching hospital is as follows, page 14, 15, in terms of the regulations. Insofar as the Department of Community Medicine in which the petitioner is appointed, there are 3 posts, one epidemiologist, the other statistician and the health educator. To all the 3, the nomenclature is epidemiologist come lecturer, statistician come lecturer, health educator come lecturer. This was the regulations prevailing then. Then comes the regulations of the year 2009. The 2009 regulations were concerning minimum requirements of 150 MBBS admissions annually in regulations. Here, there was nothing said about the regulations of the running a medical college. It was only concerning a 150 MBBS admission. Nonetheless, the post of health educator here also is found. The requirements department wise are noticed here, are noticed in clause 12. In department of clause 8, sorry. In the Department of Community Medicine, what is looked into is, what is seen is the educator, health educator is left as health educator. It is not in the Department of Community Medicine, but it is the staff for Rural Training Health Center, including field work and epidemiological studies. Therefore, this cannot be projected by the institute to say that health educator for a training health center for including field work and epidemiological studies would be taken note of, and not the regulations that prevailed for the purpose of the staff in a teaching hospital. Next comes,
below that there is urban training center ಅಂತ, ಅದರಲ್ಲೂ ಹೆಲ್ತ್ ಎಜುಕೇಟರ್ ಅಂತ.
ಆಯ್ತು, ಅದು ಯಾವುದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ, ಬಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿ. ಎಸ್. Then comes the appointment of the petitioner. The appointment of the petitioner pursuant to walk-in interview is as follows. Page 31. It depicts the petitioner to be a health educator in the department of P&SM andrena? Yeah. In the department, but health educator anta. The petitioner then begins to register the claim that he should be redesignated as health educator cum lecturer. Governing council meets and accords such redesignation. In the teeth of the said claim comes the 2018 regulations of the Medical Council of India. In the 2018 regulations,
Page 83, Your Lordship.
in the 2018 regulations, which comes as an amendment to the postgraduate medical education regulations, the staff requirements in Appendix 2 is as follows. Again, what is found in 2005 regulations is reiterated. The epidemiologist, statistician, and health educator are all considered to be lecturers. As a matter of fact, the statistician appointed along with on the same lines of the petitioner is already accorded a statistician cum assistant professor and has been designated so even today. The plea of the petitioner meets its consideration at the hands of the governing council. Page.
Governing Council.
ನಿಮಗೆ ಕೊಟ್ಟಿದ್ದಲ್ಲಿ redesignation.
Redesignation, page 87, Your Lordship.
The order comes to be passed redesignating the petitioner as lecturer, epidemiologist, health educator cum lecturer. The order reads as follows, page 87, marked portion. This is communicated to the state for its approval. The approval is declined. The approval was sent to the state for its approval owing to an obfuscation by the institute that the health educator cum lecturer was not a post that was sanctioned. The government rejects it on the ground that it was not a sanctioned post. The rejection leads to the impugned order. The impugned order leads the petitioner to be placed status quo ante as a health educator and not as a lecturer. The communication and the order passed as a consequence of a communication from the state are an error for the reason that Medical Council of India from 2005 or 2018 clearly depict the staff requirements to be health educator cum lecturer, ostensibly so as the qualification required is noted herein above. If the qualification is a master's degree and the job of the petitioner is to teach community medicine, it can hardly be said that it is not a teaching post. In the days where physical education is also treated as a teacher, teaching community medicine obviously would undoubtedly be designated as a lecturer. There was no error in the designation for the state to have declined the approval, as it needed no sanctioned post, as it was only a redesignation of the petitioner as health educator cum lecturer. In that light, the impugned orders would suffer from the vice of non-application of mind and leads to its obliteration. The petitioner is entitled to all consequential benefits that would flow from the obliteration of the orders impugned. See, so and so allowed, quashed. Please. In the light of the reason so rendered, in the light of reasons so rendered in the subject petition, the other two petitions need not be considered as they are rendered academic and are disposed as having become academic. Yes, please. ಇನ್ನೇನಿದೆ
ರಿಕವರಿ ಮಾಡ್ತಿದ್ದಾರೆ ಅದೊಂದು.
Consequential ಎಲ್ಲ entitled ಅಂತ ಹೇಳಿ.
All consequential. ಅಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ. ಒಂದು ಪ್ಯಾರಾ ಬರ್ಕೊಳ್ಳಿ. The institute could not have recovered the amount that was paid to the petitioner as the redesignation and the payment were all in accordance with law. If recovery has been done by now from the hands of the petitioner as is contended, the entire amount that is recovered shall be refunded to the petitioner within an outer limit of 12 weeks from the date of receipt of the copy of the order. Outer limit shall be refunded ಅಂತ ಮಾಡಿ ಈಗ operative portion ಬರ್ಕೊಳ್ಳಿ. The writ petition is allowed. The first e-writ petition is allowed. The other two writ petitions are rendered academic and are disposed as having become academic. ಇದು ಮಾತ್ರ allowed. First ಅದನ್ನ ಬರ್ದ್ಬಿಡಿ. Two writ petitions are disposed. The subject petition allowed, impugned order squashed. The petitioner shall, it is declared that the petitioner's designation as health educator cum lecturer was in tune with law, and she shall be continued to be designated as such. All consequential benefits that would flow from the quashment of the impugned order shall flow to the benefit of the petitioner. The recovery, if any, of an amount that is made on the impugned placement of the petitioner's designation status quo ante shall be refunded forthwith to the petitioner, refunded within 12 weeks from the date of receipt of the copy of the order. The compliance with the entire directions also shall be done within 12 weeks from the receipt of the copy of the order. ಇನ್ನೇನ್ ಬೇಕು ನಿಮ್ಗೆ?
She shall be ಅಂದ್ರು, he shall be ಅಂತ rectify ಆಗಿದೆ.
ಶಿ ಅಂತ ಬರುತ್ತೆ.
ಇಲ್ಲ, he ಅಂತ rectify ಆಗಿದೆ.
ಎಲ್ಲಿ ಶಿ ಬರುತ್ತೆ ಎಸ್ ತೆಗೆದು ಬಿಡಿ.
Number 18, Sandhya's category.
Please.
For the petitioner is seeking quashing of annexure G. Petitioner is an industrialist, my lord. Petitioner is an MP industrial engaged in hydraulic and other business equipment of engineering, my lord. I sought for allotment of
No, not at 5.
ಯಾವ ವರ್ಷದಿದು?
18, 2018.
ವೈ ಹಾಕಿಲ್ಲ?
Yesterday, today I have received the information from the office.
Information.
Some information received that these lands are reserved for the government entities.
ಅದಕ್ಕೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬೇಕು ತಾನೆ?
Yes, I will file it. Kindly have it on 18th and I will file 17th.
In fact, that is rejected by the
counsel for the respondent seeks time to file statement of objections. Since the matter is 7 years old, I grant only 7 days time to file objections.
Please,
List the matter
on 17th
list the
I will
matter
file
on
it.
18th in the fresh matters list.
Please.
In the event objections would not come about, it shall be construed that there are no objections to be filed.
The endorsement issued by authority itself is sufficient for rejection of their.
ಹಂಗಾರೆ ಏನು ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ ಅಂತೀನಿ ಬಿಡಿ.
I will file one. I have issued instructions today itself.
Number 19, Srinande Pachapure, Jaitim Kotu Shettar.
Please.
question is, my lords. My lords, 1 day, my lords, difference for a promotion, my lords. His date of entry is, my lords, the respondent number 6, my lords. 24/7/2006, my lords, is the date of entry insofar as petitioner is concerned. In respect of the contesting respondent, my lords, that is respondent number 6, that is on 25/7/2006.
What was the notification?
For the promotion, my lords,
The
from
promotion.
promotion
From what cadre to what cadre?
from assistant master to headmaster.
Headmaster is a promotional post?
Yes, my lords.
Assistant master ಆಗಿ ಜಾಯಿನ್ ಆಗಿದೆ ಯಾವಾಗ?
24/7/2006.
ಅವರು
25/7/2006.
ಹೆಂಗ್ ಜಾಯಿನ್ ಆದ್ರಿ? ಡೈರೆಕ್ಟ್ ರಿಕ್ರೂಟ್ಮೆಂಟಾ ಏನು?
ಅವರು ಅಸಿಸ್ಟೆಂಟ್ ಮಾಸ್ಟರ್ ಅಂತ ಇದ್ರು ನೋಟ್ಸ್ ಬೋತ್ ಅಸಿಸ್ಟೆಂಟ್ ಮಾಸ್ಟರ್ ಆನ್ ಸೇಮ್ ಡೇನೆ ಇದನ್ನ ಮಾಡಿದ್ದಾರೆ.
ಹೆಂಗ್ ಬಂದ್ರಿ ಒಳಗೆ? ಇನಿಷಿಯಲ್ ಅಸಿಸ್ಟೆಂಟ್ ಮಾಸ್ಟರ್ ಆಗಿದ್ದು ಹೆಂಗೆ? ನೋಟಿಫಿಕೇಶನ್ ಹಂಗೆ ಬಂದು ಕರೆದು ಕೊಟ್ರ?
ಇಲ್ಲ, ಬೈ ನೋಟಿಫಿಕೇಶನ್.
ಮತ್ತೆ ಯಾವಾಗ ನೋಟಿಫಿಕೇಶನ್ ಏನು? ಯಾವತ್ತು?
Direct recruitment.
22/7/2006, my lord. It is a aided education.
22/7/2006 notification.
Please, my lord. Appointment date of both the.
ಇಬ್ಬರದು ಅಪಾಯಿಂಟ್. ಇದು ಜಾಯಿನಿಂಗ್.
You're joining the dispute
Anything
ಮಾಡ್ತಾ ಇದ್ದಾರೆ
else, sir?
because of date of birth, my lord. I am the senior.
Well, it's
Anything
what the
else?
notification, the circular says, annexure M, your lords, I'll read lords only one. Length of service is required to be taken into
Of entry
consideration
into service.
from the date of, no, lords, date of entry into the service. Anta ide.
Yes, sir, correct.
Annexure, annexure M, lords.
Absolutely.
Promotion to the post of headmaster or headmistress shall be made on the basis of seniority of a teacher. Seniority being determined by counting the
sir.
total number of years of
That
continuous
is,
service.
that is too rudimentary, date of entry and seniority.
Yes, ma'am. Now what,
ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್ ಇಬ್ಬರದು ಯಾವತ್ತು?
Same.
24/7/2006.
24 ಅಲ್ಲ ಸರ್, 22/7/2006.
ಡೇಟ್ ಆಫ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಸೇಮ್ ಇದೆ, ಇವ್ರ ಎಂಟ್ರಿ ಆಗೋದು ಒನ್ ಡೇ
ಅಂದ್ರೆ-
ಲೇಟ್ ಆಗಿದ್ದಾರೆ. ದಟ್ಸ್ ಓನ್ಲಿ
ಗೃಹ ಪ್ರವೇಶ ಮಾಡಿದ್ದು, ಆಫೀಸ್ ಪ್ರವೇಶ ಮಾಡಿದ್ದು ಒಂದಿನ
ದಟ್ಸ್ ಓನ್ಲಿ ಡಿಫರೆನ್ಸ್.
ಎನಿಥಿಂಗ್ ಎಲ್ಸ್ ಸರ್? The petitioner is before this court seeking the following prayer. Both the petitioners, I heard so and so. The petitioner and the respondent enter the service of the government in the Department of Human Resources on 22/7/2006 pursuant to a selection process and the appointment orders being issued on the same date, i.e. on 22/7/2006. Then comes the claim for promotion to the post of headmaster. Promotion to the post of headmaster is ostensibly on the basis of seniority. The seniority is based upon the feeder cadre. The feeder cadre is the assistant master. In the feeder cadre, the seniority assumes significance for the purpose of calculating the date of entry into service. The petitioner and the which respondent?
Six.
Respondent
Petitioner
number
and the sixth respondent both are beneficiaries of a common even date appointment order, i.e. 22/7/2006. The appointment order ಎಷ್ಟು ದಿನ ಕೊಟ್ಟರು ಜಾಯ್ನ್ ಆಗಕ್ಕೆ? ಜಾಯ್ನ್ ಆಗಕ್ಕೆ ಎಷ್ಟು ದಿನ? 1 week, 15 days?
Usually 10 days. 10 days.
The appointment order depicts that the persons would report to duties within 10 days from the date of said appointment. The petitioner was eager to join immediately, entered the office on 24/7/2006 on the basis of the appointment order dated 22/7/2006. The second respondent took it easy and entered the office on the next day.
Sixth respondent.
A sixth respondent took it easy and entered the office on the sixth day, on the next day, i.e. on 25/7/2006, albeit on the same even date appointment order. The petitioner is before the court on a mistaken notion that seniority would be counted on the date on which they step into the office and not the appointment order. If both the petitioner and the sixth respondent being beneficiaries of a common appointment order, if the respondent had reported duties beyond the period prescribed in the appointment order or under the general recruitment rules, it would have been an altogether different circumstance. Both of them have joined within the time and both of them have joined pursuant to the same appointment order. The sixth respondent is now placed senior in the seniority list for the reason that the sixth respondent is senior in age to the petitioner. Even the said placement cannot be found fault with, as if the seniority list is to be drawn on a common appointment order, it is only a common appointment order, it would be on merit, or if the merit is not the criteria, it would be on the basis of age. Whoever is senior in age will be the senior if it is a common recruitment and recruitment is on the same date, appointment orders are issued on the same date. Therefore, no fault can be found with the action of the state in placing the sixth respondent as headmaster over and above the claim of the petitioner. The petition lacking in merit stands rejected.
Please.
Yes. ನಿಮ್ಮ ಫೈಲೇ ಮುಟ್ಲಿಲ್ಲ ನಾನು, ಅಲ್ಲ ಡೇಟ್ ಅಲ್ಲೇ ಬರೋದು ಅಷ್ಟೇ. ಎಲ್ಲ ಕರೆಕ್ಟ್ ತಾನೆ?
Yes, yes.
Bill number 20, Ramchandravadi, J. Shetty.
Lord, appear for the petitioner, matter relating to my lord, the selection to the post of assistant professor, my lord, in the second respondent university. Lord, selection, my lord, three-stage, my lord, selection on the basis of, my lord, the statutes of the university. As per, my lord, 2010, my lord, UGC guidelines, my lord, which were, my lord, adopted by the university in the year 2017. And, my lord, statutes were published. My lord, first, my lord, 50 marks, my lord, are granted for the purpose of, my lord, academic credentials. 30 marks, my lord, for the written test. And, my lord, 20 marks, my lord, for interview. Your lordship may kindly see, pursuant to the, my lord, this UGC guidelines 2010, 2017, my lord, statute were published by the university. Regarding the interview, my lord, your lordship may kindly take page number 39. Prior to that, my lord, page 35. Academic record and research performance, my lord, 50 marks. Assessment of domain knowledge and teaching skill, my lord, 30 marks. Interview performance, 20 marks. Now, this is, my lord, regarding interview, your lordship may kindly take page 39. What is stated is, my lord, maximum marks, my lord, allotted for the purpose of interview shall be 9.8, my lord, as per the Honorable Apex Court decision, which shall not exceed 12.25. How, my lord, that has to be, my lord, allotted, has been, my lord, given in the statute number 3. Total oral marks 9.8 distributed as follows. Page 39, my lord, I am reading. The candidate shall be required to make a presentation before the board of appointment for a minimum of 10 minutes, which shall be videographed. After the presentation and interaction, the board of appointment shall assess the candidate pertaining to his domain knowledge so and so at the national and state level and the provisions of the Constitution of India. The board of appointment shall award a maximum of 9.8 marks for the oral performance to the candidate, which is I1C above. Out of 9.8 marks that have been assigned for interview, 2.8 marks may be earmarked for presentation and the remaining 7 marks for answering the questions during the interview. On the scale of 1:7 marks, if the candidate is given up to 4 marks or 6 marks or more, it should have adequate recorded justifications. Now, my lord, on this score, 2017, my lord, this recruitment notification was issued for assistant professor, my lord, in the subject of botany. Out of which, my lord, one post was reserved for SC and another for, my lord, 2A category. That was, my lord, again re-notified in 2018, my lord, by notification dated 14/6/2018. Response number 4, my lord, filed application, my lord, pursuant to the previous notification. As on the date of this notification, my lord, she joined a service, my lord, in the government of Karnataka Forest Department. Fourth respondent. My lord, the subsequent notification says that any, my lord, changes in, my lord, the application will have to be updated to the department. Without disclosing, my lord, her appointment in the Forest Department and producing the NOC, my lord, she participated, my lord, in the selection process. Now, my lord, this page number 64. It is mandatory on the part of the, my lord, candidate, my lord, who is already employed with the government or any other department, has to submit application, page 64.
You tell me one thing. As on the date of the application, she was working there?
As on the date of submitting, my lord, application pursuant to, my lord, 2016 and 17 notification, she was not appointed. In the meantime, my lord, on 2017, my lord, September, she was appointed. 2018, my lord, re-notified the, my lord, the post.
Interview agid yavat?
Interview subsequently, 2018 ಅಲ್ಲಿ.
18 ಅಲ್ಲಿ ಆಗಿದೆ.
ಹೌದು. I shall come to that.
Re-notify agid yavat?
2018, that is what.
Where is that?
Annexure D, my lord.
Page.
Sorry. Page number 54, my lord, annexure D1. 14/6/2018.
Page 61, na?
54, my lord.
54.
Fresh recruitment notification.
ಅಲ್ಲ, ಅದರಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ.
ಅಲ್ಲ, ಒಂದು ನಿಮಿಷ. 8/8/2017. Page 51, annexure D.
That is, my lord, 2017 notification.
That is second notification.
Second notification.
Third notification is
Third
my
ಎಲ್ಲಿದೆ?
page number 54. That is
Initially, my lord, they issued
14/6/2004.
ಹೌದು.
ಒಂದು ನಿಮಿಷ. Recruitment notification. 371 ಜೇನ ಇದು?
371J.
This is issue concerning that?
Not regarding that, my lord. This is so far as 371 is concerned, my lord, they have followed the roster and all that.
I'm not on that. Is
371J
the third
post.
notification, second notification?
Yes, my lord, for 371J.
J only.
Yes.
Are you both participants on
Yes,
371J?
both. Yes.
All right. So we'll take this notification
Yes.
as relevant and not the others.
Not.
All right.
Now, this notification is dated, my lord, 14/6/2018.
All right.
As on this date, my lord, she was appointed fourth respondent on 27/9/2017.
1 minute. Where is that appointment order?
My lord, I have produced along with my lord, application for production of additional documents, annexure X, page number 27. That is admitted, my lord.
One minute. Let, ನನಗೆ facts.
Yes, my lord.
Dictation ಕೊಡ್ಬೇಕು ತಾನೆ ಮತ್ತೆ?
Appointment dated 27/9/2017, which is, my lord, well prior to, my lord, issuance of this recruitment notification. Now,
One minute. 14/6/2018 recruitment notification ಗೆ applications were submitted.
Earlier to the, earlier to the.
ಕೇಳ್ತಿರೋದು. Were applications submitted earlier or now?
yes, application was submitted, my lord, pursuant to the earlier.
Which notification?
That is, my lord,
That is, my lord, 2017 notification.
Where do I get that?
that is page number 51, my lord.
8/8/2017.
Yes.
So 8/8/2017 notification ಗೆ application ಯಾವತ್ತು ಕೊಟ್ರು?
That application date.
When did you
My
apply?
lord, the first notification, my lord, is, my lord, 1/1/2016.
ನೀವು ಅದ್ ಬಿಟ್ಬಿಡಿ. ಅದು fresh recruitment notification ಗೆ fresh
ಇಲ್ಲ ಅದೇ
application
2006 ಕೊಟ್ಮೇಲೆ the second notification, your lordship kindly see the, my lord, the page number 51, the condition, your lordship kindly see. Page number 51, item number 3, my lord.
Candidates have already applied.
Yes.
Applied.
Not apply.
Need apply.
But
Only
they are
we have
required,
to-
my lord, to submit, my lord, further information, my lord.
But we'll have to submit relevant
The
information
information
and details in the revised form number 8.
Yes, my lord. That is-
Revised format 8 sets.
Yes, then.
However, need not pay. Fees ಗೆ ಮಾತ್ರ ಬೇಕಾಗಿಲ್ಲ ಅಂತ.
Yes.
All right.
Then,
How,
my
my
lord,
lord,
the
your lord,
Ramchandra, one ನಿಮಿಷ wait.
third notification also, your lordship kindly see, item number 3. That is clause 3, page number 54. There also, my lord.
Who have applied earlier.
Yes, my lord.
ಅಲ್ಲಿ need not apply again, but they will have to submit relevant information.
Yes.
Yes, yes.
All right.
now, my lord, your lordship may kindly come to page
ಈಗ
number,
ಇರಿ ಒಂದ್ ನಿಮಿಷ. Yes.
page number 64, my lord, application.
60?
64, annexure E. Otherly item, my lord, instructions to the candidates, item number 11.
63 ಅಲ್ಲ?
64.
64.
64 ಇಲ್ಲ. ನಮ್ ಕಡೆ ಕೊಟ್ಟಿಲ್ಲ.
My lords, get it, my lord?
64 ಇದೆ.
Yes. Note ಅಂತ ಇದೆ. There are, my lord, several 25 notes, my lord. Out of that, my lord, item number 11.
Male, female ಅಂತ ಇದೆ item number 11.
I am referring to, my lord, this is application, my lord, annexure.
ಇತ್ತಾನೆ 64.
At the next page, my lord, 64. Maybe discrepancy, my lord, regarding pages.
ನೋಟ್ ಅಲ್ಲ.
Note.
ಅಂತ ಹೇಳಿ. ಅದು 66 ಅಂತ ಹೇಳಿ.
Along with the application.
66 eligibility criteria.
Note.
Clause number?
11.
ಅದು.
Yes. Those who are employed should.
66 ಅಲ್ಲಿ. 64 ಅಂದ್ರೆ.
66.
Now, my lord, along with this.
Those who are employed should submit their application through proper channel. However, advance copy may be sent directly.
Yes. Instructions were clear, my lord, in that regard. Now, my lord, totally 19 candidates, my lord, participated for selection, my lord.
Interview ಯಾವತ್ತಾಯ್ತು?
ಅದು ಬರ್ತೇನೆ ಸ್ವಾಮಿ, so that next.
ಆಯ್ತು ಹೇಳಿ.
My lord, written exam, my lord, results were published, wherein this petitioner, my lord, topped the, my lord, written results, annexure F, my lord, she secured 66.
ಯಾರ್ದು? Petitioner 66.
66.
ಎಲ್ಲಿದೆ ಅದು?
Page number 72, my lord, annexure F.
72.
74, my lord.
72 annexure F.
Yes.
ನಿಮ್ಮ ಹೆಸರೇನು?
My lord, petitioner's name, my lord, Srivani, at item number, serial number 4. ಎರಡೆರಡು page number, my lord, page numbers are, my lord. Tabular form ನಲ್ಲಿ ಇದೆ.
Tabular column ಅಲ್ಲೇ ಇದೀನಿ. ಯಾರ್ಯಾರು?
I am referring to this.
ಅದಲ್ಲ.
Next.
ಅದು ಯಾವ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ ಗೊತ್ತಿಲ್ಲ. ಇಲ್ಲಿ annexure yes.
Yes, yeah.
74.
Yes, 74.
Yes. That is the candidates list.
Srivani 66.
66, topper, my lord, in botany. Now, fourth respondent, my lord, secured 62.
ಎಲ್ಲಿದೆ ಅದು?
ಅದು serial number 2.
Item number 2, same.
Serial number?
Item number 2.
2.
Siddheshwari.
Yes, fourth respondent, selected.
This is not on merit, is it?
ಅಲ್ಲ, merit ಅಲ್ಲ, written examination.
Written examination.
Yes. Now, this written examination, my lord, culminated into score card, my lord, preparation at annexure G.
ಅದ್ರಲ್ಲಿ ನೀವೆಲ್ಲಿದ್ದೀರಾ?
Yes. Here, my lord, also the petitioner is topper. Combined merit of the petitioner, my lord, comes to 42.52, serial number 4.
Serial number 4.
4, yes. Selected candidate, my lord, secured 42.40.
Okay.
Now, and the fifth respondent, my lord, secured 31.87.
ಅದು ರೇಸಲ್ಲೇ ಇಲ್ಲ ಬಿಡಿ ಅವರು.
ಅಲ್ಲ ಇದೆ ಅದು ಹೇಳ್ತೇನೆ how it is relevant I said.
Fifth respondent secured
31.87.
39.85.
39.87.
All right.
31.87.
Kavita Sagar.
Yes.
ಅಲ್ಲ 851 your lordship. 851. Kavita Sagar, Dr. Kavita.
ಬರಲ್ಲ ಬಿಡಿ.
Yes. Now, your lordship may kindly see this respondent number 4 and 5, they are, my lord, belonging to SC category. Yes. One post, my lord, is notified for SC, another, my lord, for the general merit. Now, with this, my lord.
You are general merit?
No, 2A category. 2A category.
2A category.
2A category, but general merit.
One second. Now, with this, my lord, the candidates have been invited for interview as per annexure H, my lord, dated 2/9/2018, which was scheduled, my lord, on 5/9/2018. Page number 80.
92.
Otherly one, my lord, instruction, my lord. Latest salary certificate and no objection certificate from the employer as on the date if you are in service is required. Next, if you are found to be ineligible at the time of verification of the original documents, you will not be allowed to appear for the interview and your application for the above post will be automatically rejected. At this stage, my lord, I'll refer to, my lord, the stand of the university as per, my lord, the.
One more clarification. ಇದಕ್ಕೆ latest salary certificate ಕೊಟ್ರಾ?
That is what, my lord.
ಅಲ್ಲ, had she ever divulged that she is working in the forest department?
That's what, my lord, this has not done.
All right.
Yes.
ನೀವು ಕೂತ್ಕೊಳ್ಳಿ. Yes, sir.
Let's see.
Who is the selected
Appear for the respondent number 4.
Selected candidate, sir.
Malad Sahib.
Come on, sir. Yes.
Your lordship kindly see, Malad, 25/9/2017 appointed date in the forest department. Malad, before that, after interview, Malad, in statement of objection, your lordship kindly see the page number 8. Their main objection is that, Malad, I have not obtained the, Malad, the permission from the department to appear for the.
You forget it, sir. ಬೇಡವೇ ಬೇಡ.
Yes.
ನೀವು ಎರಡೇ ನಾನು ಕೇಳ್ತಾ ಇರೋದು.
Yes.
On the date of interview, did you divulge that you were working in the forest department?
Yes, ma'am. Yes. Therefore, statement of objection.
ಆಯ್ತು. You were SC.
Yes, ma'am.
You were selected under SC vacancy or what?
No, because it's
General merit. How did you get into general merit when she was more meritorious?
No. In the interview.
ಅಲ್ಲ interview ನಲ್ಲಿ ಅದೇ that's what I shall come to.
Interview ಕಮ್ಮಿ ಆಯ್ತಾ?
ಅಲ್ಲ ಏನ್ ಮಾಡಿದಾರೆ, my lord, I shall come to that.
I'll say.
ಆಯ್ತು.
Page number 9.
I'll complete, my lord, with
ಹೇಳಿ.
Yes.
87.
Now,
Wait.
with this, my lord, the interview is conducted and result of the interview, my lord, your lordship would find and, my lord, at page number 83, annexure J. 83. This is, my lord, in respect of all the subjects. Your lordship may kindly see on the last, my lord, column total marks nalli no NOC anta ididdu, the candidates, my lord, who had not produced NOC, my lord, who were employed were not allowed to, my lord, participate in the interview, my lord, and their candidature was rejected. Whereas in respect of this, my lord, subject, botany, page number 84. Now what they did?
84.
See, my lord, fourth respondent was granted 8.13 marks, my lord, in the interview out of 9.18, my lord.
ಒಂದು ನಿಮಿಷ ಎಲ್ಲಿ ಓದಿದ್ರಿ? I am at page 84. This
Item number,
serial number 2, my lord, fourth respondent selected candidate.
Siddheshwari.
Yes.
50.550.
50.550.
550. Mine, my lord, 49.350.
Where do you get that?
First, item number 1.
Serial number 1.
49.354.
Yes.
49.3. How, my lord, they have done, my lord, I shall. Now, my lord, as on the date of, my lord, this interview, she was employed, my lord, in the Department of Forest. For this, my lord, your lordship may now kindly take the stand of the university, my lord, annexure R7, my lord, along with my.
Shettrada? Jay Shettra.
Along with, my lord, application filed for production of additional documents.
R4.
ಅಲ್ಲ ನಮ್ದೆ IA, my lord.
R4.
R7, my lord.
R7.
ಅದು my lord, set-
R7.
Yes.
Documents.
This is my lord university which my lord has given my lord.
Krishnadevaraya University.
Yes, very respondent my lord. I sought information regarding whether NOC was submitted by the selected.
NOC not submitted.
Not submitted. Now, the stand of the my lord university at annexure, yes, my lord, next page. This is submitted, my lord, by the Vice Chancellor, my lord, to the Secretary. Your lordship may kindly see, this selection, my lord, has been conducted by the Vice Chancellor when, my lord, his tenure was less than 6 months. Now, I made an, my lord, allegation to the.
Well, yaar selection, no? Whose selection is by the Vice Chancellor?
Allah, Vice Chancellor, my lord, was the chairman of selection committee.
All right.
Yes. This complaint, my lord, was submitted by the petitioner.
Complaint is submitted.
Allah, for that, my lord, he has submitted the report to the Secretary. My case, my lord, I'll read only 2 lines, my lord.
Matra odi.
Yes. Dr. S.V. Prabhakar, SV Clinic at Ballari has stated that Dr. Kaveri Kamble without NOC came for interview and the screening committee members had not entertained her and marks are not allotted in the final scorecard. And at the same time, they have mentioned no NOC. It shows that she has not produced NOC as mentioned in the final scorecard. M. Siddeshwari has also not produced NOC. And in spite of that, selection committee has taken interview and selected her for said post under GM. Now, our response, that is not universities. Yes, it is true that Dr. Kaveri Kamble had come without NOC for interview. As per our rule, we permit the candidates who have not submitted NOC along with their application to come to interview, just to give one last chance to the candidates to submit NOC. If they do not produce the same, even at the time of interview, then we do not allow him or her to interview process. This is well known to all of the candidates. Now, regarding her employment, my lord, what he says is, however, in case of M. Siddeshwari, she has not indicated that she was employed at the time of application, as she was not employed. Therefore, the question of her submitting the NOC does not apply. Now, Dr. S.V. Prabhakar claims that M. Siddeshwari was employed. To the best of our knowledge, she was not employed either at the time of application nor at the time of joining the university. This is what is the stand of the university. In the statement, my lord, what they say.
Vice Chancellor change ಆಗಿದ್ರಲ್ಲ ಅದಕ್ಕೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕೋದಕ್ಕೆ Vice Chancellor change ಆಗಿದ್ರಲ್ಲ.
Statement, paragraph number 3, my lord, of university statement. It is submitted that this respondent appointed to the post of DY RFO and reported to the duty on 25/9/2017. At the time of attending the interview, this respondent has obtained no permission from the forest department.
No permission.
Permission illa. He may not.
Attending interview, this respondent has obtained permission.
Obtained the permission.
Permission, NOC illa. Because my lord, I have annexure R7 I have produced, which is the my lord RTI information issued my lord by the university itself. And their own statement saying that if the candidate fails to my lord produce the NOC at the time of interview, my lord candidate will be declined my lord interview. And there are my lord records to show that the other candidates who failed to submit the NOC my lord were.
ಯಾವಾಗ ಆಗಿದ್ದು ಸೆಲೆಕ್ಷನ್
2018. 2018-19.
2018.
Now, what is my lord harakiri played is this. My lord, I'll read my lord allegation made my lord in the petition, page number 10. Paragraph number 16, my lord. Last 2 lines ninda start. Yet another important aspect, my lords, get it, my lord?
Para 16,
16.
At page 10.
Yes. Yet another important aspect to bring to the notice of this honorable court on the basis of the availability of the record that the Vice Chancellor so-and-so is belong to so-and-so category and also so-and-so, this is my lord, member of the selection committee, belong to so-and-so category. And the selecting the candidates, especially Sri so-and-so, 5th respondent, who is working and pursuing PhD under the guideship of so-and-so, who are belonging to the same category. And thereafter, so-and-so, 5th respondent has secured only 39 point.
Ramchandra.
Yes.
ಇದೆಲ್ಲ ಬೇಕಾಗಿಲ್ಲ.
We
need not go, don't draw cast lines.
Now, my lord, what the my lord candidate who suppressed her my lord employment with the government. Now, appointment order.
We'll consider that. Appointment order. Appointment
annexure,
order.
yeah, my lord. That is also my lord very. Page number, my lord. 93.
7/9/2018.
7/9.
ಸಿದ್ದೇಶ್ವರಿ ಅವರು ಕೊಟ್ಟರದ ಇದು.
Yes. ಅಲ್ಲ ಇದು ಕೂಡ I shall my lord.
ಹೇಳಿ ಓದಿ.
Interview, my lord, process was conducted on 5/9/2018.
Hmm.
Your lordship may kindly take page number 93.
Page number 93.
93,
And
appointment
there-
order.
Hmm.
Yes. Now, 5/9/2018, my lord, interview conducted. 1 day gap. Next day, my lord, syndicate resolution dated 7/9/2018. Therefore, Vice Chancellor's order 7/9/2018. Appointment order issued on 7/9/2018. At the lightning speed, very same date. Now, this appointment order, my lord, was addressed to the fourth respondent. Even, my lord, as on the date of this appointment order, the appointment order condition states, relieving order from the previous institution, if applicable, will have to be submitted.
When
my
did
lord.
she join?
2017 ನಲ್ಲಿ.
ಅಲ್ಲ, ಅಲ್ಲ.
11
ಇಲ್ಲಪ್ಪ, ಈ
11/9
appointment order ಆದ್ಮೇಲೆ ಯಾವಾಗ ಜಾಯಿನ್
11/9/2018.
11/9/2008.
Yes. Now,
ಅಲ್ಲಿ NOC ತಗೊಂಡ್ರ ಫಾರೆಸ್ಟ್ ಇಂದ?
ಇಲ್ಲ ಇಲ್ಲ.
I'll show that. my lord.
ಯಾವತ್ತು ತಗೊಂಡ್ರ?
Interview, at the time of interview itself.
ಅಲ್ಲ, ಈಗ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆದ್ರಲ್ಲಿ ರಿಸೈನ್ ಮಾಡೋದು ಬೇಡವಾ?
ಇಲ್ಲ.
Resign ಮಾಡಿ, ಅದೇ ತೋರಿಸ್ತೇನೆ.
ಯಾವಾಗ ರಿಸೈನ್
I
ಮಾಡಿದ್ರಿ?
will show the document. My lord, she has
Before
resigned.
joining ರಿಸೈನ್ ಮಾಡಿದ್ರಾ?
After, my lord, appointment order was issued, next day, my lord, she submit resignation, my lord, application.
ಇಲ್ಲ, ಅದಕ್ಕೆ ಹೇಳ್ತೀನಿ.
One second, my lord, I shall.
Page, sir.
My lord,
Page number,
I will show the, my lord, the
one second.
objection ದಲ್ಲಿ.
ಹ್ಮ್.
My lord,
Page number, my lord,
R2.
R12, my lord, R2.
First, your lordship kindly tell, my lord, the R2.
It is
Page number 8.
R2.
Is my statement of objection.
A resignation letter
ಅಲ್ಲ,
ಕೊಡಿ
ಅಲ್ಲ.
sir.
Letter, my lord,
Resignation.
along with, my lord,
Next day, Lord.
additional
Next
documents
day,
are
Lord.
produced, R2.
Letter R2 na?
R2, additional documents. Appointment order, my lord, is issued on 7/9. She submits, my lord, resignation letter on 8/9.
ಹೌದು, she is relieved from the.
One second, let me.
ನಿಮಿಷ. Resignation letter
Yes.
ಯಾವತ್ತು?
8/9.
8/9.
Yes.
Appointment order, my lord, is issued on 7/9.
7/9.
As on the date of even appointment order, she was still in service of the, my lord, department.
Correct. Appointment order ಆದ್ಮೇಲೆ ಕೊಡ್ಬೇಕಲ್ವಾ?
My whole case is this, my lord. Now, what they say is, permission has been taken, my lord, is what their contention. Your lordship may kindly take their state, my lord, document. Annexure R2. My lord, the statement filed, my lord, by selected candidate. Page number 8.
ಯಾರು ಮಹೇಶ್ ಒಡೆಯರ್ದ?
Yes.
Yes. Now they claim that this is the NOC.
ಎಲ್ಲಿದೆ ಮಹೇಶ್ ಒಡೆಯರ್?
Page number 8. my lord.
Page number 8.
ನಿಮಿಷ. ಮುಂಚೆ ಬೇರೆ ಯಾರು ಹಾಕಿದ್ರಾ?
ಇಲ್ಲ,
ನೀವೇ ಹಾಕಿದ್ರಾ?
ಇಲ್ಲ, yes.
Page 8.
Yes, ma'am. Annexure R2.
R2, yes sir.
My lord, I have given, my lord, the application to the.
8/9/2018.
Give
Yes,
letter,
my
my
lord.
lord.
My lord, 6/9. Your lordship.
ಅರಣ್ಯ, ಒಂದು ನಿಮಿಷ ರಾಮಚಂದ್ರ ಹೇಳಿ. I'll get back to you.
Yes.
My lord, 3/9/2018. My lord, it is permitted to appear for the interview. Your lordship, next side, my lord, left side, that is in the bottom.
8/9. ಉಲ್ಲೇಖ ಎಲ್ಲಿದೆ ಅದ್ರದ್ದು?
ಇಲ್ಲ, ಇದರಲ್ಲಿ ನಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ ದೇ ಹ್ಯಾವ್ ಪರ್ಮಿಟೆಡ್, my lord. ಪೇಜ್ ನಂಬರ್, ದಿ ಇಂಕ್ ನಲ್ಲಿ ಇದರಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ, ಪೆನ್ ನಲ್ಲಿ.
ಅರಣ್ಯ ಅಧಿಕಾರಿ ಹುದ್ದೆಗೆ ರಾಜೀನಾಮೆ ನೀಡುವ ಬಗ್ಗೆ 8/9 ನೆಕ್ಸ್ಟ್ ಡೇ.
Yes.
ಅಕ್ಸೆಪ್ಟೆಡ್ ಯಾವತ್ತು ರೆಸಿಗ್ನೇಷನ್?
My lord, on same day, that is 8/9/2018, relieved from the.
ಎಲ್ಲಿದೆ?
My lord, your lordship.
Where is the order of relieving?
My lord. Page number, annexure R3, page number 12, your lordship.
R3 page 12.
Yes, my lord.
12 ಅಲ್ಲೇ ಇದನ್ನ ಈಗ.
So and so, ವಿಶ್ವವಿದ್ಯಾಲಯದಲ್ಲಿ after
R2
4
is-
lines.
R2 is your resignation,
ಅಲ್ಲ, R2 is, my lord, getting permission to appear
interview.
for the interview.
ಹಾ.
Then R3, my lord, I will take the, my lord, the page number 12.
ಇದು appears to be given later. ಎಲ್ಲೋ ಇನ್ಸರ್ಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ ಇದು. ಇರ್ಲಿ.
Yes,
ನೋಡೋಣ
8/9/2000.
Yes, sir.
That after 4 line, my lord. ಇದು ಸದರಿ ಉಲ್ಲೇಖ ಪತ್ರ 4ರಲ್ಲಿ ತಮಗೆ ವಿಜಯನಗರ ಶ್ರೀ ಕೃಷ್ಣದೇವರಾಯ ವಿಶ್ವವಿದ್ಯಾಲಯದಲ್ಲಿ ಸಹಾಯಕ ಪ್ರಾಧ್ಯಾಪಕ ಹುದ್ದೆ ದೊರೆತಿದೆ ಎಂದು ನನ್ನನ್ನು ತರಬೇತಿ ಕೇಂದ್ರದ ತರಬೇತಿಯಿಂದ ಬಿಡುಗಡೆಗೊಳಿಸಿಕೊಡಬೇಕೆಂದು ಲಿಖಿತ ಮನವಿಯನ್ನು
ಒಂದೇ ನಿಮಿಷ ಸರ್. ಈ 3/9/2018 ಆರ್ಡರ್ ಮಾಡಿದ್ರಲ್ಲ,
ಹೌದು,
ಅದರ ಉಲ್ಲೇಖ 8/9 ಅಲ್ಲಿ ಇಲ್ವಲ್ಲ? ಅದಕ್ಕೆ ಇದು ಆಮೇಲೆ ಇನ್ಸರ್ಟ್ ಆಗಿರೋದು.
ಅಲ್ಲ ಅದಕ್ಕೆ
ಎಲ್ಲಿದೆ ಉಲ್ಲೇಖ ಇದ್ರದ್ದು?
ಮೌಖಿಕ ಆದೇಶ ಅಂತ ಹಾಕಿದ್ರು.
ಮೌಖಿಕ ಮೌಖಿಕ ಏನಿಲ್ವ? ಲಿಖಿತ ಇದೆಯಲ್ಲ ಇಲ್ಲಿ. ಲಿಖಿತ ಮೌಖಿಕ ಆಗೋಯ್ತಾ?
ಅದೇ, that's permission itself is, my lord.
All right, but ಅದ್ರ ರೆಫರೆನ್ಸ್ ಇರ್ಬೇಕಲ್ಲ. We permitted through proper channel ಅದೆಲ್ಲ. You appear to be very influential. 7 ವರ್ಷ ಕೆಲಸ ಮಾಡಿದ್ದೀರಾ, ಸಾಕು.
Alla, illa.
Let the eligible candidate get it.
Alla, even otherwise.
Yes.
Alla, even otherwise, my lord. My lord, the fifth respondent, my lord, she is appointed in my place. If my lord not succeeded.
Okay, ಇವ್ರು ಅಪಾಯಿಂಟ್ ಆಗಿಲ್ವಾ?
ಅಲ್ಲ, ಆಗಿದ್ದಾರೆ SC category ಒಳಗೆ.
I
My
deliberately
lord, I am
read that.
the highest score.
Dog in the manger policy. ನಿಮಗೆ ಸಿಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರಿಗೂ ಸಿಗ್ಬಾರ್ದು.
ಅಲ್ಲ, SC category ಒಳಗೆ. I am the, my lord, the 3 candidates only, my lord, intrude. And because the board of appointment.
ಅಲ್ಲ ಸರ್.
ಅಲ್ಲ, correct. Board of appointment, my lord.
ಪೋಸ್ಟ್ ಎರಡಿತ್ತು ತಾನೆ.
ಹೌದು, ಎರಡು ಪೋಸ್ಟ್.
One
post is my lord
One
reserved
post is
for
for SC.
Another
is
post
GM.
my lord open for
Even
GM.
if they appointed her as a GM, but so far as SC category, my lord, I am the highest, my lord, the candidate. I am the secure for 59.
Let them do what, but appointment
that's-
should go to the petitioner, no doubt about it. Anything else? 7 ವರ್ಷ ಆರಾಮಾಗಿದ್ದೀರಾ? ಇರಿ. All ಇಲ್ಲಿ public employment is not to be bartered like this. Forest department liದ್ದು ಅಲ್ಲೇ ಇರ್ಬೇಕಾಗಿತ್ತು. Why did you want this?
ಅಲ್ಲ, page number 11 ದಲ್ಲಿ.
Whatever it is, yes.
My lord,
The petitioner.
My lord, I'll
Yes,
rely
sir.
upon one judgment of the, my lord, the Honorable
ಕೊಡಿ sir.
Supreme Court.
Judgment ಕೊಡಿ sir.
Avatar Singh's plot regarding
So far as
suppression.
my lord the interview
ಕೊಡಿ sir.
process is concerned, my lord, I will.
Blatant suppression of all facts. Partisanism throughout.
ಅಲ್ಲ, there is no-
Illegality.
There is no,
throughout.
my lord, there is no suppression at all. My lord,
Yes, I will write it, sir.
no, my lord,
I
because
will write it, sir. No problem.
para
What is
31 to
this?
37, because the modified, selection is a modified ಅಂತ allegation. My lord, I will take the, my lord, the para
I
31.
will not get into malified, sir. ಅದಕ್ಕೆ plead ಮಾಡ್ಬೇಕು, ಯಾರ ಮೇಲೆ ಹೇಳ್ಬೇಕು.
ಅಲ್ಲ,
ಅವೆಲ್ಲ
ಅಲ್ಲ,
ಮಾಡ್ಬೇಕು.
allegation, my lord, your lordship can see, the writ petition itself is not maintained because
sir.
because the board of management appointment constituted under section 53 of the Karnataka University Act. My lord, it has prepared the list after considering all the documents. My lord, it is not, my lord, the.
ಅಲ್ಲ, why
as a-
repetition is not maintainable?
That's why I'm telling you.
Oh, ಹೇಳಿ
Yes. My lord, the board of appointment will constitute under section 53 and we will prepare the list and we will, my lord, the merits of the list. Then, my lord, it will recommend to the syndicate. Syndicate is the final authority to, my lord, approve the, my lord. If there is a difference of opinion, my lord, under section 10, it can be referred. But here, my lord, the syndicate, after considering the, my lord, the board of appointment furnishing the list on the merits, my lord, it has approved the, my lord, then it will send to the, my lord, the chancellor has approved the appointment.
ಅವರೆಲ್ಲ ಮಾಡ್ಬಿಟ್ರೆ ರಿಟ್ ಪಿಟಿಷನ್
No, 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 I'm not saying that, my lord. That is,
Yeah.
therefore, without challenging, my lord, the syndicate resolution, holding that, my lord, because the detailed resolution will be passed.
What, where are you? Appointment is challenged?
Appointment, that is only office order.
Whatever it is, appointment is challenged.
That is,
Everything that led into decision making need not be challenged. If appointment goes, everything goes.
not necessary.
Anything, I will consider all its.
No, my lordship kindly see, my lord.
Maintainability, preposterous submission also I will
No,
consider.
the judicial review is
But-
not, my lord, applicable, my lord, my lord.
My lord,
You are tying the hands of this court under Article 2.
No, that's why, my lord, the selection process.
Thinkable.
No, no, no,
Yes.
selection process may take
So far as-
para 31 to 37. That's all, my lord.
Yes, sir.
That's all, my lord.
Sir, I will give you spade of judgments, illegal appointment. University is a state.
No, state, but the selection process.
University is a state, not an estate.
Yes, ma'am. But the
My lord,
selection
so
process
far-
is not done by, my lord, any one or individual or a chancellor,
ಹೌದು
vice
sir,
chancellor.
selection
But
committee
the
proceedings
committee-
which appeal alva.
That is not challenged, my lord. The
No
selection
problems.
committee is, my lord,
No
as,
problems.
there is a, my lord,
No
modified.
No,
That is not challenged, that's
no
all.
issues. Anything else?
That's all.
Yes.
so I am per the, my lord, the university is
Indians.
concerned. My lord, your lordship may kindly see the, in fact, my lord, the proceedings of, my lord, the board of appointment. So far as, my lord, the
ಏನ್ proceedings, sir?
proceedings, my lord, for appointment, for board of proceedings, my lord, it board of appointment, my lord, has been taken place. My lord, that, my lord, wherein, my lord, it can be seen that, my lord, your lordship may kindly see the. So far as the fourth respondent is concerned, my lord, she secured highest marks. My lord, so far as, my lord, and in view of, my lord, the highest marks, one post is reserved for, my lord, SC, another post, my lord, general. So far as the general candidate, my lord, even though, my lord, she applied under the SC category,
Because of her marks, she went to
because of,
general
my lord, her merit, my lord, she stood in the, my lord, merit list. And she has been appointed on, as a general candidate only. So, my lord, another post is, my lord, left, my lord, it is reserved for SC. That has been given to, my lord, the fifth respondent. My lord, she is, my lord, only candidates available at that.
Well, whoever is petitioner is entitled to under whatever category, it should be given.
My lord, petitioner, my lord, is claimed under category 2A, my lord, though my lord, she is entitled for my lord, general merit, my lord, that is my lord, another aspect.
Category
But
2
so far as my lord,
category
general
2
merit,
ಯಾರಿಗೂ ಕೊಟ್ಟಿಲ್ವಲ್ಲ ಈಗ?
general merit is concerned, general merit is concerned, respond number 4 has been considered.
ಇವ್ರು ಯಾರು? fourth respondent ಈಗ?
Fourth respondent.
So my position,
fourth
my lord, will
respondent,
not
my lord,
change.
You are appearing for Siddheshwari.
Siddheshwari, fourth respondent.
Fourth
So,
respondent. sir.
The contention, everything is against Siddheshwari.
Siddheshwari.
No,
But
my
my
lord,
lord,
so
you-
far as my lord, another aspect, my lord, your lordship may kindly see. What they are saying that at the time of application, they sought for an information saying that at the time of application, kotidara anta heli. At the time of application, where the no objection has been given. No anta helidre.
Correct.
My lord, it's correct. My lord, it is factually also correct because she was not in employment at that relevant point of time. Subsequently, my lord, she was appointed and she joined the duty there.
Sir, it is high
At the time of interview,
high time, these influences should stop and merit should play a role. ಅಲ್ಲಿ ಕೆಲಸ ಇದ್ದಿದ್ರೆ ಅಲ್ಲಿ ಇರ್ಬೇಕಾಗಿತ್ತು. ಅಲ್ಲಿ
now my lord, she will be no
ಕೆಲಸ
more.
ಇಟ್ಕೊಂಡು ಇಲ್ಲಿ
Allah,
ಬೇರೆ ಕೆಲಸ
neither there, here, my lord, it is permissible. My lord. What
I'm not
what
saying
I'm
it's
saying
not
that,
permissible. You should have told that.
my lord, it has
No,
been
no, you have
told.
furnished
It
one.
has been told.
Sir.
My lord, it has been told.
My lord,
My lord, it has been told at the time of interview.
My lord, let them
At
be,
the
my lord,
time
your
of
lordship,
interview,
secure
she-
the
because-
original record. I request your lordship.
My lord, at the,
Yes, sir.
no, no,
Because
at
the
the time,
petitioner-
no, at the time of, my lord, your lordship,
Yes,
at the time of interview, my lord, she has informed the fact of my lord, her appointment, and she has also received, my lord, produced the no objection certificate.
And with the breakneck speed, everything happens. Resignation consider ಮಾಡಲ್ಲ ಗವರ್ಮೆಂಟ್. ಯಾರ್ದು ಮ್ಯಾಂಡಮಸ್ ಕೊಡ್ಬೇಕಿಲ್ಲಿ.
ಅಲ್ಲ ಅಲ್ಲಿ ಕನ್ಸಿಡರ್
24
ಮಾಡಿದ್ದಾರೆ.
hours ಅಲ್ಲಿ ಎಲ್ಲ ಆಗೋಗಿದೆ.
ಅಲ್ಲ ಮಾಡಿದ್ದಾರೆ, ದಟ್ ಅವ್ರದ್ದು ಮಲಡ್ so far as ಮಲಡ್
ಬಹಳ
she was in probation till then ಮಲಡ್ in fact but because ಮಲಡ್ ಬೆಟರ್ ಅಪಾರ್ಟ್ಮೆಂಟ್ ಅಂತ ಹೇಳಿ ಇಲ್ಲಿ ಬಂದಿರಬಹುದು. ಅದು
ತಪ್ಪೇನಿಲ್ಲ.
not what it cannot be find fault.
The petitioner
so far as ಮಲಡ್
is before this court calling in question an office order dated 7/9/2018 issued by the third respondent appointing the fourth respondent as ಏನಿದು ಪ್ರೊಫೆಸರ್ assistant professor in the discipline of botany in the department of botany at the respondent which university is this?
Krishnadevara.
Respondent Sri Krishna Devaraya University, hereinafter referred to as the university for short. Facts enumerated are as follows. Before embarking upon the consideration of the issue in the merit, on this merit, I deem it appropriate to notice the protagonists in the list. The petitioner is an applicant, the petitioner is an applicant to the post of assistant professor in the Department of Botany pursuant to a selection process initiated by the second respondent university. So is the fourth respondent who emerges as the selected candidate. Therefore, the list is between the petitioner and the selected candidate. Facts, ಹೇಳಿದ್ನಲ್ಲ. The petitioner, where is the notification first?
Annexure D, my lord, page number
ನೀವು
50.
synopsis ಏನು ಹಾಕಿದ್ದೀನಿ ಅಂದ್ರೆ ಇಲ್ವಾ? Notifications are issued calling for applications from eligible candidates at various disciplines in the university and the various disciplines in the university. One such discipline, so called, was the discipline of botany, which forms the fulcrum of the list. The recruitment notifications in the case at hand are not one but three in number. The first recruitment notification is in the year 2016.
16/2016.
The second recruitment notification was 8/8/2017. The third recruitment notification, which confined itself to the vacancies arising in the area declared under Article 371J. The third recruitment notification is what is germane for the issue in the list. The pursuant to the recruitment notification of the year 2016, the petitioner and the fourth respondent had submitted their respective applications. Since the subsequent notifications granted such liberty not to, since the subsequent notifications indicated that the applications already submitted, the person should candidates who have already submitted the applications need not submit all over again. For the purpose, this ostensibly was for the purpose of not demanding repeated fee from the hands of the candidates. However, it was indicated that any updated information should be given. The fourth respondent and the petitioner participate in the selection process. The selection process resulted in drawal of the name of the petitioner and the fourth respondent as being eligible to be considered for interview. The fourth respondent and the petitioner were called for interview. Interviews are conducted. Pursuant to the interview, the result is that the petitioner is not selected and the fourth respondent is selected. The fourth and fifth. Fifth NOC ಕೊಟ್ಟಿಲ್ವಲ್ಲ? Fifth select ಮಾಡಿದ್ರಾ?
Select ಮಾಡ್ಯಾರ. She is
Fourth
also-
and the fifth respondent, where is the fifth respondent? ಯಾರು appear
He is not represented.
The fourth and fifth respondents are selected. The fourth respondent is selected. The selection of the fourth respondent is what is challenged by the petitioner. Heard so and so. The learned counsel Ramachandra Mali, appearing for the petitioner, would vehemently contend, taking this court through the documents appended to the petition and the documents that are produced before this court, that the selection of the fourth respondent is marred by illegality, M-A-R-R-E-D, marred by illegality. The fourth respondent at the time of interview or at the time of the application that was submitted for the third time was already appointed. At the time of interview had already been appointed as in the forest department of the government. Such appointment is not divulged. Through proper channel, the applications are not submitted, applications are not updated, permission to attend the interview is not granted by the competent authority through proper channel. Resignation, our contention ಹೇಳ್ಬಾರ್ದೆ? The learned counsel would further submit the no objection certificate that was necessary to attend the interview is not in place, and the merit that the petitioner secured is far higher than that of the selected candidate. If the selected candidate, the response given by the university to the petitioner in seeking information about submission of NOC runs counter to the statement of objection so filed by the university. Therefore, on all these counts, the learned counsel submits that the entire selection process of the fourth respondent is laced with malafides and arbitrariness. Therefore, the petitioner ought to have been selected and not the fourth respondent is the submission of the learned counsel, Ramchandra, counsel for the petitioner. The counsel for the selected candidate, the fourth respondent, would however refute every submission of the learned counsel contending that the application, as on the date of the submission of the application, she had not secured any employment. As on the date of the as on the date when she was called for interview, though she was already working in the forest department, there was the NOC was taken and was placed before the interview committee. The NOC was not written but was oral, and the submission of application.
Oral. That is written.
The NOC
3
was
days permission.
written. NOC was granted on 3/9/2018 for the purpose of attending the interview, and the resignation is submitted the next day after the order of appointment. The resignation is accepted in accordance with law. Therefore, the fourth respondent is more meritorious than that of the petitioner. Therefore, the appointment of the fourth respondent is valid in law. He would submit that even if the petitioner is to be appointed, it cannot be against a post reserved for scheduled castes, which the fourth respondent is. If at all the petitioner has to be appointed, it has to be under the category 2A, which she claims, and therefore submits that the appointment of the fourth respondent must not be touched, but should be affirmed. The learned counsel appearing for the respondent, University J. Shetty, would, though toe the lines of the counsel appearing for the selected candidate, would submit that the selected candidate has been selected in accordance with law after due verification of the NOC that was submitted, NOC that was placed before the interview committee. Therefore, and is found to be more meritorious than the petitioner. Owing to the merit of the fourth respondent, she is selected under general merit category, as she springs to that category, and the vacancy that was left of the scheduled caste is filled with the fifth respondent, and the petitioner has no chance of getting in to those vacancies. The learned counsel submits that the interview and all other things have taken place in accordance with law. He would seek dismissal of the petition. In an area.
In fact, Malad, when selecting committee, Malad found that Malad she is.
And the learned counsel would further submit that this court would not sit as an appeal against the orders against this findings of the selection committee to annul the appointment of the fourth respondent. He would seek dismissal of the petition. Both the learned counsel appearing for the
And
petition.
second thing is, Malad, what he is saying that Malad, it is not the information which has been furnished based on the information sought. Information sought is that whether Malad she is filed an application, no objection at the time of. Malad, it is Malad.
Learned counsel submits that even with regard to the applications or interview being through proper channel is also in order, as the selection committee has found it to be fit. Both the learned counsel appearing for the respondent in unison would submit that this court would not interfere with the wisdom of the selection committee unless it is found to be arbitrary, and there is no arbitrariness in the case at hand, is the submission. I have given my anxious consideration to the submissions made by the respective learned counsel and have perused the material on record. The issue that falls for consideration is whether the selection of the fourth respondent is in tune with law, to which the issue needs to be considered from the date of issuance of the notification. The university issues a notification calling for applications from eligible candidates for the post of, for several posts. One such post called is the post of assistant professor in the discipline of botany. The first application was called on
1/6/2016.
Page
Page number 51, my lord, Anesh Reddy. 1/6/2016.
Oh, the fresh, the first.
Hakilla, but that is referred to, my lord, in the second notification.
The first application was called on 1/6/2016. This is not in dispute. A second notification comes to be issued, terming it to be a fresh recruitment notification. This second recruitment notification, this is in the second recruitment notification or the fresh recruitment notification, clause 3 assumes significance. Clause 3 reads as follows. Clause 3 indicates that the candidates who had applied earlier in terms of notification dated 1/6/2016 need not once again apply, but will have to submit relevant information and details in the revised format in 8 sets. Therefore, it was not that no information should be given, but any relevant updated information should be submitted. This was on 8/8/2017. The third recruitment notification comes on 14/6/2018, which is for the areas coming within within the government order which implements Article 371J. All the candidates who participated in the selection process belong to the said area which come under 371J is not in dispute. In the said notification, the relevant, in the heading ಹಾಕ್ಬೇಕೆಲ್ಲದಕ್ಕೂ, ಈ heading plus. In the said relevant notification, in the said notification, clause 3 again assumes significance. It reads as follows. Clause 3 again indicates that one need not apply all over again, but updated information must be given. The revised application form is also appended to the petition. The application form appends to it a note. Note indicates, note number 11 therein is as follows. Note number 11 indicates that those who are employed should send their application through proper channel. However, an advance copy may be sent directly. ಇದು ಯಾವುದು ಇಂಟರ್ವ್ಯೂ ಇದಲ್ಲ ಅಲ್ಲ
Interview the next ಇದೆ.
ಅಲ್ಲ ಒಂದು ನಿಮಿಷ ಇದು ಯಾವ್ದು ಪೇಜ್ 66 ಯಾವ್ದು ನೋಟ್ ಅದು
64 my lord.
ಆಯ್ತು 64 ಯಾವ್ದ್ರದ್ದು ಅಪ್ಲಿಕೇಶನ್ ಅದು
This is my lord application form, my lord person. Yes.
ಅಲ್ಲ ತಾನೆ
Yes.
ಎಸ್
Eligibility criteria.
ಎಲಿಜಿಬಲ್ ಆಲ್ ರೈಟ್ ಸೊ ಈಗ ಆಸ್ ಆನ್ ಇವರು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಗಿದ್ದು ಎಲ್ಲಿ ಅದು ಫಾರೆಸ್ಟ್ ಅಲ್ಲಿ
Annexure, yes, my lord.
ಡೇಟ್
Date 27/9/2017.
27/9 ಗೆ ಆಗಿತ್ತು
ಅಲ್ಲ 25/9.
25/9/2017 ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಗಿತ್ತು.
Yes.
ಥ್ಯಾಂಕ್ ಯು.
Subsequently interview was.
ನಾನು ಕೇಳಿದ್ದಕ್ಕಷ್ಟೇ ಪ್ರಶ್ನೆ, ಮತ್ತೆ ರೀಆರ್ಗ್ಯೂ ಮಾಡಬೇಡಿ ಅಲ್ಲ. As observed here and above, the recruitment notification for 371J, the third one, was on 14/6/2018. By then, one significant development had taken place. The fourth respondent had applied in the forest department to what post?
Deputy Range Forest Officer.
To the post of Deputy Range Forest Officer. And pursuant to the selection process therein, the fourth respondent had already been appointed on 25/7 to 7 or 9? 25/9/2017, which is admittedly a date that was anterior to the third recruitment notification dated 14/6/2018. The fourth respondent, notwithstanding her employment therein, applies to the post, but the records nowhere divulge that the updated application was preferred by the fourth respondent, that she was already working as a Deputy Range Forest Officer at the time when she applied to the post, at the time when the third notification came. The reason for non-divulgence could be that the application was directed not to be submitted all over again. At the time of the first application, she was not in employment. Be that as it may, the merit list is drawn of the meritorious candidates, including the petitioner and the fourth respondent, to the post of assistant professor in botany. The merit list is as follows. Page 74. At serial number 2 is the fourth respondent who secures 62 marks. At serial number 4 is the petitioner who secures 4 marks more than the fourth respondent.
That is my lord.
That is written examination.
That is written
Qualifying exam.
9 interview ಬಂದೇ ಇಲ್ಲ ಸರ್. More than the selected candidate in the written examination. Therefore, in the written examination, the petitioner was more qualified, but the selection is not on the basis of the written examination. The scorecard is drawn after the assessment prior to calling for interview. The scorecard, insofar as the petitioner and the fourth respondent is concerned, is as follows. Clause 2 and clause 4. ಇದು ಹಾಕ್ಬಿಡಿ 3 and 4 ಅವರು ಇದರಲ್ಲಿ mark portion. The petitioner in the scorecard assessment secures 42.52, whereas the selected candidate secures 42.40. This was also not conclusive, as interview was yet to take place. An interview call letter is issued to all the petitioners, to all the selected candidates. Likewise, an interview call letter is issued to the petitioner and the fourth respondent. The interview call letter of the petitioner is appended to the petition, which certain clauses of which assume significance. Clause 6 and clause 1 of the instructions to applicants. Clause 6 indicates that the latest salary certificate and no objection certificate from the employer as on the date, if you are in service, should be carried to the interview. And if it is found to be ineligible, the candidate will not be allowed to appear for interview to the post, and the post will automatically, and the application will automatically be rejected. The identical communication identical communication is issued to the fourth respondent as well. Interview takes place. In the interview, those who have not secured NOC from the respective departments wherever they were working were not even interviewed. But insofar as the petitioner and the fourth respondent are concerned, but insofar as the fourth respondent is concerned, she is interviewed along with others. The result of interview is as follows, page 84. Here, the fourth respondent secures 50.550, while the petitioner secures 49.354, and the fifth respondent secures no NOC alva.
39.851.
Fifth respondent secures 39.851. Therefore, who is in the race is the petitioner and the fourth respondent on the merit. The selection comes about issuing an appointment order to the petitioner, to the fourth respondent on 7/9/2018. Where is the appointment order?
Annexure M, my lord, page 93.
The appointment order issued to the fourth respondent is as follows. Page 93. Terms and conditions, but it's stuck. The proceedings of the Board of Appointment is for selecting the fourth respondent is 5/9/2018, and on 7/9/2018 the appointment order is already issued. When was it placed before the syndicate is unknown. The proceedings of appointment take place on 5/9/2018. The syndicate immediately meets and ratifies the appointment on 7/9/2018. Vice Chancellor passes the order on the same day on 7/9/2018. Appointment order is issued on 7/9/2018. While appointments being in the hottest haste would not become on the face of it mala fide, what is the icing on the cake is the objections and the information submitted by the university. Adelle no NOC antididu.
My lord, annexure.
The petition yaar keliddidu?
My lord, relative of the petitioner.
Anyway, an application is made under the Right to Information Act as to whether the fourth respondent selected candidate had at the time of interview submitted her NOC. The answer is as follows. R7, page 18.
Application.
At the time of application, whether she has filed answer.
At the time of
That
interview.
was the application.
Details at the time of interview until while.
Not only
Yes,
that, my lord, even
NOC not submitted is what is in. Sir, appeal al ಮಾಡ್ಕೊಳ್ಳಿ ಅವೆಲ್ಲ ಇಲ್ಲ ಯಾಕೆ? Yes.
when forest department says that NOC is not issued, that is also produced. My lord.
1 minute. ಅದೆಲ್ಲಿದೆ?
My lord, annexure P and Q.
ಅದಕ್ಕೆ ಆಮೇಲೆ ಬರ್ತೀನಿ.
Yes.
The response to a complaint or communication made by the by the Vice Chancellor of the university to the Department of Secretary, Department of Education, again assumes significance. The communication reads as follows. The response to a query by the university, by the government, is that fourth respondent has not indicated that she was employed at the time of application, as she was not employed at the time of application. The question of her submitting NOC does not apply. If the clause that called for interview is re-noticed, what would become ostensibly clear is as on the date of interview, the fourth respondent was admittedly a deputy range forest officer in the state government. Working in the state government as deputy range forest officer ought to have submitted her NOC for appearing in the interview, or even submitting an application for the purpose of attending for the purpose of interview, for the purpose of interview. While in terms of the communication, it is not necessary is what is said, while the indication here and above is that it was imperative. Therefore, this is an illegality that cannot be cured as they are facts. Whether the petitioner, whether the fourth respondent has secured NOC from the hands of the forest department is also necessary to be noticed. The forest,
Page number 99 and 100, P and Q.
The forest department, on an information being sought where the fourth respondent was working, also gives information that they have not issued any NOC. The communication reads as follows. What becomes unmistakably clear in the case at hand is the fourth respondent, having secured employment in the state government as a deputy range forest officer, suppresses the entire facts and participates in the interview, as the forest department indicates that they have not issued NOC. The communication indicates of the university vice chancellor indicates that she need not submit NOC contrary to its own communication, but its own communication, and secures employment, notwithstanding the employment that she was in state government. Then comes the drama of resignation by the fourth respondent. The fourth respondent, on the next day of her appointment, when did you report to duties?
Reported to duty.
Report yavat ಮಾಡ್ಕೊಂಡಿದ್ರಿ sir?
The 11/9/2018.
The appointment of the fourth respondent is on 7/9/2018. She reports to duties on 11/9/2018. In the interregnum, a resignation is submitted on 8/9/2018. It is immediately approved on 9/9/2018, and on 11/9/2018, the petitioner, the fourth respondent, reports to duties. In the light of the aforesaid facts, what is discernible is that the fourth respondent, without divulging that she was already in employment and the interview is through proper channel, interview is after seeking permission from the forest department, participates in the interview as if she has not been employed anywhere, and secures the employment that ought to have been offered to the petitioner. The issue is not on the merit of the matter. If on the date of the interview, those other persons who had not secured NOC have not even been interviewed, without the NOC, the fourth respondent is interviewed and selected. It is the opinion of the vice chancellor that the petitioners, the fourth respondent's NOC need not be secured as on the date of the application she was not employed. This, to say the least, is preposterous, as the indication is as on the date of interview. It is too rudimentary that as on the date of interview in any organization, if a candidate participates in that selection process, notwithstanding anybody's employment in a different organization, NOC is a must, as a candidate cannot secure employments in two places and continue employments in two places. Participation in interview and seeking employment is undoubtedly permissible, but with a no objection, as is indicated in the application. The fourth respondent did not do anything of that, but has suppressed everything of that. How much soever defense the fourth respondent wants to project or the university wants to protect, the appointment of the fourth respondent cannot but be held to be contrary to law or laced with malefides. Malefides are of different kinds. Malefides, urging malefides against a particular person, that person has to be made a party. But malefides in a selection process can be gathered from the records, and not necessary that somebody should answer such malefides. Therefore, the malefides in the case at hand are writ large, and the result is the obliteration of selection of the fourth respondent. For the aforesaid reasons, the following order. I'll add the judgments. ನೀವು ಹೇಳಿದ್ದು other judgments.
Para 31 to 7.
ಇಲ್ಲ ಇನ್ನು I will also add some other judgments. Then ಆಮೇಲೆ ಇಲ್ಲಿ ಸೇರಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅನ್ಬಿಟ್ಟು ಅದಕ್ಕೆ ಟೈಮ್ ಇಲ್ಲ ಅದಕ್ಕೆ. So for the aforesaid reasons, the following order. The writ petition is allowed. The appointment of the fourth respondent stands annulled. The appointment shall be offered to the petitioner if the petitioner is found fit in all other traits. The said action shall be undertaken and completed by the university with an outer limit of 8 weeks from the date of receipt of the copy of the order. Yes. Appeal sakala. 30 ದಿನ ತಾನೆ appeal.
Request your lordship. 8 weeks stay.
ಯಾವ stay sir?
ಅಲ್ಲ ಇದನ್ನ
ಏನ್ stay?
Not to malad precipitated by the university till malad.
ಅದು ನಾನೇ ಸರಿ ಇಲ್ಲ ಅಂತ stay ಮಾಡಕ್ಕಾಗುತ್ತೆ. Yes.
Great.
Yes.
Bill number 21, Sunil Desai.
Lord, this is yesterday matter appointment for assistant professor in GIMS. Lord, the appointment is in pursuance of the notification on 1/9/2015. Lord, I have been working in the side post. Now, my lord, in 2016, my lord, the government has passed an order, my lord, reducing the cadre strength of assistant professor in GIMS, taking undue advantages of this, my lord. They are not, my lord, granting a salary of the assistant professor post. Now, my lord, in 2019, my lord, it is appointment.
Will resume it.
Please. Please.
ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಯಾವ್ದಾರು ತಗೊಂಡ್ಬಿಡಿ ಮತ್ತೇನಿದೆ ಆಯ್ತಲ್ಲ ಅವತ್ತೆಲ್ಲ. ಓ ಅದಕ್ಕೆ ಅದೇನ್ ಮಾಡಿ ಸೆಟಿ ಮಾಡಿದ್ರಾ? ಯಾರು ಪೆಟಿಷನ್ ಮಧ್ಯಾಹ್ನ ತಗೊಂತ
Seal number 140. Seal number 149. May I seek Miller's?
ಯಾರು ಟೈಮ್ ಬೇಕೆಲ್ಲ ತಗೊಂಡು
Time not.
Matter at
urgency Miller's. May I take?
ಏಜೆನ್ಸಿ ಕಷ್ಟ
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ? Lordship
Matter at serial 20.
ಬಿಲ್ಸಿ ಎಷ್ಟಾಗುತ್ತೆ ಅಷ್ಟು ತಗೊಂತ.
Lordship has granted interior
ಮತ್ತೆ ನೆನ್ನೆ ತರ ಕೂತ್ರೆ ನಾನು ಕೊಲಾಪ್ಸ್ ಆಗ್ಬಿಡ್ತೀನಿ.
Serial number 170.
ನೋಡ ಬಿಲ್ಸಿ.
My lord, matter at 24, serial 24. May I seek it on Monday? I am
objections for adjournment of
2:30 please.
My lords.
ರೇಟ್ ಕೇಳಬಹುದಾ ಸರ್ ಇಲ್ಲಿ?
105 ಹೇಳಿ. ಡೇಟ್ ಇಲ್ಲ.
After vacation.
After vacation.
Interim order.
Interim order ಇದೆಯಾ?
Interim order after first week of January.
Code officer.
ನಿಮ್ದೆಲ್ಲ
ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟು ಇದೆ? 86 ಅಲ್ಲ, ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಅಲ್ಲ?
ಅಡ್ಲ್ರೆ ಇದು Code officer.
118.
Code officer.
ಹಾ ಹೇಳಿ.
Serial number 30
ಹಾ
interim order extend ಆಗ್ಬೇಕಿತ್ತು.
ಲಿಸ್ಟ್ ಆಫ್ ವೆಕೇಶನ್ ಇಂಟರ್ ಮಾಡೋ ಎಕ್ಸ್ಟೆಂಡ್.
ಆಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ
ಪಟೇಲ್ರೆ
ಅಲ್ಲ ನಾ ಯಾವ್ದು ಕಳ್ಸುದಿಲ್ಲ ಇಲ್ಲೇ ಇಲ್ಲೇ ಇಟ್ಕೊಂಡಿರ್ತೀರಿ. ಅವಾಗ ನೀವು ಹೇಳ್ತಿರಲ್ಲ ಇಲ್ಲೇ ಯಾವ್ದು ನಾ ಕಳ್ಸುದಿಲ್ಲ.
ಪಟೇಲ್ರೆ
ಒಂದು ಶಿವಗಂಧ 131.
Code officer.
Code officer 86 ರೀ. 14 42 ಸರ 86 ನೋಡ್ರಿ.
ಒಂದ್ ನಿಮಿಷ 58. ಲಿಸ್ಟ್ ಆಫ್ ವೆಕೇಶನ್ ಇಂಟರ್ ಮಾಡೋ ಎಕ್ಸ್ಟೆನ್ಷನ್ 154 ನಿಮ್ದಲ್ಲ. ಹಾ ಅಪ್ಲಿಕೇಶನ್ ಇಂಟರ್ ಮಾಡಿಲ್ಲ.
Thank you.
161. ನೋಡಿ ಇದೆಯಾ? ಹೌದಾ? ಇದು ಎಲ್ಲಿ ನೋಡ್ರಿ ಆಯ್ತು. 22.
86 ಡೇಟ್ ಇಲ್ಲ.
22 ರೀಚ್ ಆಕೈತಿ ಬೇಕಂದ್ರೆ ಇಷ್ಟು ಸಿನಿಮಾ ಕೊಟ್ಟಿನ ಅಡ್ಜಮೆಂಟ್ ಬೇಕಾ?
ತಗೋತಾರ ಅದು.
ಈಗ ಅಡ್ಜಮೆಂಟ್ ಬೇಕಾ? ಅದು ಇಟ್ಕೊಂಡಿರ್ತೀವಿ. ಎಸ್ ಕೆ ಹೆಗಡೆ ಅಂತ ಐತ್ಲ, ಎಸ್ ಕೆ ಹೆಗಡೆ ಅಂತ ಐತಿ.
ಅದಿಲ್ಲ ಇದು ತೋರಿ ಲಿಸ್ಟ್ ನಂಬರ್ 1 118. ಎಷ್ಟು
118
ಆಫ್ಟರ್ ವೆಕೇಶನ್
ಅಲ್ಲ ಅವ್ರು ಹೇಳ್ತಾರ
118
ನೀವು ಕೇಳಿ ಲಿಸ್ಟ್ ಆಫ್ ಇದೆಯಾ?
ಇಲ್ಲ ಅಷ್ಟೇ ಇದೆ. ಆಮೇಲೆ 137 ಅದನ್ನು ಹೇಳ್ತೀನಿ. 137 ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಅದರಲ್ಲೂ ಏನು ಸ್ಟೇ ಇಲ್ಲ.
ಡೇಟು ಕೊಡಲ್ಲ ನಮ್ಮಲ್ಲಿ 22 ಲಿಸ್ಟ್ ಆದ 14 ಅಲ್ಲ ನಮ್ಗೆ
ಇಷ್ಟುದಲ್ಲಿ ಅಲ್ಲನ್ನು ಕತ್ತಿರಲ್ಲ ಅವ್ರಿಗೆ ಅಲ್ಲಂತ ಇರಲ್ಲ ಬೇರೆ ಯಾರು ಕತ್ತಿರು
Code officer.
ಕೋರ್ಟ್ ಅಂತ serial number 155 ಇದೆ.
ಅಡ್ಜಮೆಂಟ್ ಹಂಗ ಅದನ್ನ ನೀವು ಹೇಳ್ಬೇಕು. ರೀಚ್ ಆಕತ್ತಲ್ಲ. ನನಗೂ ಊಟ ಮಾಡಕ್ ಬಿಡ್ಬೇಕು ಟೈಮ್ ಆಗ್ತದೆ. ಯಾಕಂದ್ರೆ ನಾನು ಊಟ ಮಾಡ್ಬೇಕು.
Code officer VC ಮೇಲೆ
ಇಲ್ಲ ಹಾಕ ಡೇಟ್ ಕೊಡಲ್ಲ. ನನಗೆ ಗೊತ್ತಿಲ್ಲ, ನೀವು ಕೇಳಿದ್ರೆ ಸಾಹೇಬ್ರಿಗೆ ಹೇಳ್ತೀನಿ. 40 40 ಎಸ್ ಪಟೇಲ್ ಅಪ್ಲಿಕೇಶನ್ ಬೇಕಾ?
Code officer.
ಒಂದು ನಿಮಿಷ ಸರ್.
ಆಯ್ತಾಯ್ತು. ಓಕೆ ಓಕೆ.
ಅವ್ರಿಗೆ ನೀವು ಹೇಳ್ಬೇಕು ನೋಡಿ. ಅಲ್ಲ ಅದನ್ನ ಬರ್ಕೊಂಡಿರಲ್ಲ, ಕ್ವಶನ್ ಮಾರ್ಕ್ ಇಟ್ಕೊಂಡಿರ್ತೀವಿ. ಯಾವ್ದು ಇದ್ರಲ್ಲಿ ಸೆಕೆಂಡ್ ಲಿಸ್ಟಾ? 28 ನೀವೆಲ್ಲಿದ್ದೀರ? ಹಾ. 28, 29 after vacation. ನೀವು ಹೇಳಿ ಆಮೇಲೆ ನಂಗೆ. 3846 ಪ್ಲೀಸ್ ಟು ದ 38 ಯಾರು? ಮತ್ತ
28 ಮತ್ತು 69 ಕೊಡೋಣ ಅಂದ್ರೆ
28 ಅಲ್ಲಿ ಬರುತ್ತೆ, ನೀವು ಅಲಂಗಿತ್ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ ಅವಾಗ ಹೇಳಿ, ರೀಚ್ ಆದಾಗ ಹೇಳಿ ಅಂತ ಹೇಳ್ತಾ ಇರೋದು ನಾನು. ನೀವೇ ಹೇಳಿ, ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
ಸರ್
ಕೃಷ್ಣ ಜಮೀನ್ ಕೊಡಲ್ಲ, ನಾನೇನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಹಾ ಹೇಳಿ ಸರ್, ಹೇಳಿ ಮಲ್ಲಿಕಾರ್ಜುನ್
ಸರ್ ನಂದು ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್
ಹಳೆ ಮನೆ ಸರ್. ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 155 ಇದೆ, ಕಾಲ್ ಲಿಸ್ಟ್ ನಂಬರ್ 1.
ಒಬ್ರು ಮಾತಾಡಿ, ಇಬ್ರು ಮಾತಾಡ್ತಾ ಇದ್ದೀರಾ, ఎక్కువ ಆಗ್ತಾ
ಸರಿ
ಇದೆ.
ಸರ್, ಆಶ್ರಿತ್ ಸರ್ ತಾವು ಮಾತಾಡಿ, ತಾವು ಮುಗಿಸಿ ಸರ್.
ಸರ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 44 interim order extension after vacation.
ಚಿತ್ರ ನೋಡ್ರಿ ಇದೆಯಾ?
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಐತ್ರಿ, ಬಿ ಗ್ರೂಪ್ ಮ್ಯಾಟ್ರಸ್ ಹಾಕ್ಯಾರ.
ಆಯ್ತು ನೋಡ್ತೀನಿ, ಚೆಕ್ ಮಾಡ್ತೀನಿ.
ಆಮೇಲೆ ಸೀರಿಯಲ್ ನಂಬರ್ 52 ಬಳ್ಳೊಳ್ಳಿ ಸರಿಗೆ ನಾ ಇನ್ಫಾರ್ಮ್ ಮಾಡೀನಿ, ಅದು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಇಂಟರ್ಮ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆನ್ಷನ್.
ಹೇಳ್ಬೇಕಂತೆ ಕೋರ್ಟ್ ಆಫೀಸರ್ಗೆ.
ಅವ್ರಿಗೆ ಹೇಳಿರಿ?
ಹಾ ಹೇಳಿ, ಇನ್ಫಾರ್ಮ್ ಮಾಡೀನ್ರಿ.
ಆಯ್ತು ಸರ್, ಓಕೆ.
ಲಿಸ್ಟ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್
ಸೀರಿಯಲ್ ನಂಬರ್ 52 ಸೀರಿಯಲ್ ನಂಬರ್ 52 ಲಿಸ್ಟ್ ನಂಬರ್ 2
ಸ್ಟೇ ಇದೆಯಾ ಸರ್?
ಇಂಟರ್ಮ್ ಆರ್ಡರ್ ಐತ್ರಿ, ಇಂಟರ್ಮ್ ಆರ್ಡರ್ ಐತಿ.
ಹೇಳಿ. ಹಾ ಸರಿ,
ಅವ್ರದಾತ. ಆಮೇಲೆ ಲಿಸ್ಟ್ ನಂಬರ್ 1 ದಾಗ ಸೀರಿಯಲ್ ನಂಬರ್ 30 ಮಾಡಿರಿ. ಈಗ
30 ಆಯ್ತಲ್ಲ ಅರ್ಜುನ್, ಆಯ್ತು.
ಆಯ್ತು ಸರ್, ಆಯ್ತು, ಥ್ಯಾಂಕ್ ಯು.
ಎಸ್ ಸರ್.
ಸರ್ ಹೇಳಿ.
Shall I make a submission? Yes. Serial number 155, cause list number 1 sir.
ಸೀರಿಯಲ್ ನಂಬರ್ 141
155.
141
155 sir. 155.
141 ತೆಗಿತೀವಿ, ಒಂದ್ ನಿಮಿಷ ಅವಸರ ಮಾಡ್ಬೇಡ್ರಿ.
Please. No issues.
141 ಯಾರು? ಅಜಯ್ ಕಟ್ಕೊಳ?
ಅಲ್ಲ ಸರ್, 155. 155.
155.
ಎಸ್ ಸರ್.
ಹಾ ಮಲ್ಲಿಕಾರ್ಜುನ್ ಹಳೆ ಮನಿ. ಹಾ ಹೇಳಿ.
ಹಳೆ ಮನಿ, ಎಸ್ ಸರ್. ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದೆ, ಇಟ್ ಕ್ಯಾನ್ ಮೇ ಕೈಂಡ್ಲಿ ಬಿ ಎಕ್ಸ್ಟೆಂಡೆಡ್. ನಾವು ಆಲ್ರೆಡಿ ಇದನ್ನ ಕೊಟ್ಟಿದ್ದೀವಿ, ಇವತ್ತು ಮಾರ್ನಿಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ ನಮ್ಮ ಕೊಲಿಗೂ.
ಅರ್ಜೆಂಟ್ ಬೇಕಾ?
ಎಸ್ ಸರ್,
ಅಲ್ಲ,
ಅಡ್ಜರ್ಮೆಂಟ್ ಸರ್, ಅಡ್ಜರ್ಮೆಂಟ್.
ಲಿಸ್ಟ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್.
ಎಸ್ ಸರ್, ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಇದೆ, ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದೆ.
ಹಾ ಸರಿ.
ಎಸ್, ಗ್ರೇಟ್, ಥ್ಯಾಂಕ್ ಯು.
ಇಷ್ಟು ಬರೋದ್ರೂ ಇಷ್ಟು ಕತೆ.
Mute.
Court officer, sir. Court officer, sir. Sir, ನಮಸ್ಕಾರ.
ನಮಸ್ಕಾರ ಸರ್, ಹೇಳಿ ಸರ್.
ಸರ್, ಇದು ಜಸ್ಟಿಸ್ ನಾಗಪ್ರಸನ್ನ ಅವ್ರ ಕೋರ್ಟ್ ಅಲ್ವಾ ಸರ್?
ಹೌದು ಸರ್.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ನೋಡು ಸಾಹೇಬ್ರು ಬಂದ್ಮೇಲೆ
ಮಂಡೇ
ಅವ್ರು ಬಂದ್ಮೇಲೆ ಏನ್ ಮಾಡ್ತಾರೆ? ಗೊತ್ತಾಗ್ತದೆ, ನೀವು ಯಾವ ಬಂದಿಲ್ಲ, ಎರಡು ಕಾದು. ಹೇಳಿಲ್ಲ ಮಾಡೇನಿ. ಆ ಸಾಹೇಬ್ರು ಕಲೆಕ್ಟ್ ಮಾಡಿದಾಗ ಏನ್ ಹೇಳ್ತಾರೆ ಗೊತ್ತಿಲ್ಲ, ಒಟ್ಟು ನಾ ಬರ್ದಿಟ್ಕೊಂಡು ಅಕಸ್ಮಾತ್ ತಗೊಂಡ್ರೆ ಡಿಸ್ಪೋಸ್ ಆಫ್ ಮಾಡಿದ್ರೆ ಅದಕ್ಕೆ ನಾ ಒಟ್ಟು ಮಾಡ್ಕೊಂಡು ಅದೇ ರೀಚ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಾನು ಅದು ಬರೋದು ಹಾಕ್ತೀನಿ.
ಜಲ್ದಿ ಹೇಳ್ತಾರೆ, 5 ಗಂಟೆಗೆ ಹೇಳ್ತಾರೆ ಅಲ್ಲಿ ಆನ್
ಸರ್. ಅದು ನಿನ್ನಿನೊಂದು ಏನಾಗ್ತ ನವೋದಯ ನೀನ್ ಮಾಡ್ತೀನಿ ಆಯ್ತು. ನೋಡ್ರಿ ಏನ್ ಖಾಲಿ ಅಷ್ಟು ಹೋದ್ರೆ ಪಟ್ಟಿ ಬಲ್ ಮಾಡಿ ನಾನು ಹುಯ್ಯ ತುಂಬಿಸ್ಕೊಳ್ಬೇಕು ನಮಗೆ ನೋಡ್ರಿ ಸರ್. ಕಾಯ್ದು ಏನ್ ಹೇಳ್ತಾರ
ಹಲೋ
ಹೇಳಲ್ವಾ
ಫೋನ್ ಹಚ್ಚೇನೆ ಟೇಬಲ್ ಫೈಲ್ ಟೇಬಲ್ ಮಾಡಿ ತೋರಿಸಿ. ಮೇಡಮ್ ನಮ್ಮ ಹುಡುಗ ಫೈಲ್ ಕೊಟ್ಟ
ಗೊತ್ತಿಲ್ಲ.
Just clean this table. ಮೇಡಮ್ ಊಟ ಆಯ್ತಾ?
ಹಾ ಸರ್ ಆಯ್ತು ಸರ್.
ನೀರ್ ಏನಾದ್ರು ಬೇಕಾ ಮೇಡಮ್?
ಹಾ ಇಲ್ಲ ಸರ್.
ಸ್ವಲ್ಪ ಕುಡಿಯೋ ನೀರು ಕುಡಿಯಲ್ಲ ಬಂದಿದ್ದಾರೆ, ಸ್ವಲ್ಪ ಗಿವ್ ಅ ಚೇರ್ ಟು ಸಿಟ್ ಡೌನ್. Anyone come, make them sit down. ಇಲ್ಲ ಮೇಡಮ್ ಕೂತ್ಕೊಳ್ಳಿ ಮೇಡಮ್, ನೀವು ಫುಲ್
ಅಲ್ಲ 16 ಅಲ್ಲ ಡೇಟ್
153.
123 16 this corporation 16
ಅದಕ್ಕೆ ಆಮೇಲೆ ಬರುತ್ತದೆ ನೋಡೋಣ. ರೆಸ್ಪಾಂಡೆಂಟ್ ಕರಿಬೇಕು, ಅವ್ರೇನು ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡಿದ್ರು. ಡಿಸ್ಪೋಸಲ್ ಅಂತಿಸ್ತಾರೆ ತಾನೆ ಡಿಸ್ಪೋಸಲ್ ಇಲ್ಲ ಪಟ್ಟಿ ಸೈ ಮಾಡಿದ್ರೆ ಪಟ್ಟಿ ಯಾಕೆ ಹೋಗ್ಬೋದು ನಾಳೆ ನಾಳೆ ಬರ್ಬೋದು ಬರ್ತಾರಂತ ಬರಲಿಲ್ಲ ಒನ್ ವೀಕ್ ನಿಮ್ದು ಯಾರಿದ್ರು ಕೇಮಿಗೆ ಆಗಿತ್ತು ನೆಕ್ಸ್ಟ್ ಕೇಮಿನ ಅದಾವಲ್ಲ ಅಗ್ರಿಮೆಂಟ್ ಕಷ್ಟ ಅವ್ರಿಗೆ ಆಗಿತ್ತು ಅವರೇ ಮಾಡೋದು ಅವರೇ ಆಗೈತಿ ಮುಂದೂ ಅವ್ರಿಗೆ ಆಗ್ಯಾವ ನೀವು ಬರ್ಕೊಂಡಿಲ್ಲ ಕೇಳಿ ಮತ್ತೆ ಅದು ಅವ್ರು ಬರ್ಕೊಂಡಿರ್ತಾರೆ ಆರ್ಡ್ರು ಅಷ್ಟಕ್ಕೊಂದು ಇಲ್ಲ ತಗೊಂಡಿಲ್ಲ ಅಂತ ಅದು ಅಕ್ಕ ಇದನ್ನ ಅದಕ್ಕೆ ಹೇಳ್ಬೇಕು, ಸಾಹೇಬ್ರ ಹೇಳಿದ್ರಲ್ಲ ಅರ್ಜೆಂಟ್ ಆಗಿದೆ ಅಂತ.
ನನಗೆ ಕೇಳಿಲ್ಲ ನಾನು.
ಹೇಳ್ರಿ, ಸಾಹೇಬ್ರ ಹೇಳಿದಾರೆ ಅರ್ಜೆಂಟ್ ಆಗಿದೆ ಅಂತ, ಅದಕ್ಕೆ ಡೇಟ್ ಹಾಕಿ ಕಳ್ಸಂತೆ ನಾಡಿದ್ದು. ಹಾ ಮತ್ತೆ ಬರ್ತ ಅದಕ್ಕೆ ಅರ್ಜೆಂಟ್ ಆಯ್ತು ಅಂತ ಹೇಳಿ.
ಹಲೋ
ಯಾರಿಗೆ ಕಳ್ಸಿರಿ? ವೆನ್ಪಿ ಕಳ್ಸಿರೋ ತೇಜಿಗೆ ಕಳ್ಸಿರೋ? ವೆನ್ಪಿಗೆ ಯಾರಿಗೆ ಕಳ್ಸಿರಿ? ಫೈಲ್ ಕಳ್ಸಿದ್ದು ಅಲ್ಲ, ಯಾರಿಗೆ ಕಳ್ಸಿರಿ? ಫೋನ್ ಹಚ್ಚಿದ್ದು ಯಾರು? ಅಲ್ಲೆಲ್ಲ ಇಟ್ಕೊಂಡ ಮನೆಗೆ ಹೋದ್ಮೇಲೆ ಹೇಳಿದೆ, ಅಲ್ಲಿ ಅನ್ಪೂರ್ಣ ಅಂತಿದ್ದ ಅಪ್ಪ 9 ಗಂಟೆ ನಾನು ಬಂದ ತಗೊಂಡು ಹೋಗ ಹಿಂಗ ಅವೇನು ಬಸ್ ಸಿಗ್ತಾ ಏನು ಸಿಕ್ಕು ಅವ್ರು ಬರ್ತಿದ್ದ ಕಾರ್ ಇತ್ತು ಒಟ್ಟು ಸಿಕ್ತಲ್ಲ ಒಟ್ಟು ಹೋದ ನಾನು ಗಾಡಿ ಅಷ್ಟೊತ್ತ ಆಗ್ತಲ್ಲ ಪೈಲೇ ಈಗ ಬಂದಿತ್ತು ನಂಬರ್ ಹಾಕೋದು ನಮ್ಮ ಮತ್ತೆ 9 ಗಂಟೆಗೆ ಇಲ್ಲೇ ಇದ್ವಿ ನಾವು 8 ಇಲ್ಲೇ ಇರೋದಾದ್ರೆ ಹೆಂಗಾರ ಹೋಗೋದು ನಾವು ಸಿಟಿಗೆ ಹೋಗೋರಾದ್ರೆ 7 ಗಂಟೆ ಮೇಲೆ ಬಸ್ ಇಲ್ಲ ಅದು ಸಮಸ್ಯೆ.
No, serial number 147, Lords. There was a bit urgency.
ಎಲ್ಲ urgency-ನೇ.
Tomorrow there is a date in the trial court, my lords.
ಏನು?
Only recalling of the petitioner's evidence, my lords.
What proceeding?
The family court matter, my lords.
Husband?
A wife, my lords. Husband filed for divorce. Wife's evidence has been taken nil, my lords. I filed for recalling. So, my lords.
I will take it.
Please.
ಈಗಲ್ಲ 4 o'clock.
Please.
Number 149. See, it is a matter wherein I filed a pleading. Will Lordship have declared the interim matter. Tender matter, 90 days period has not been completed ಅಂತೇಳಿ.
ಆಯ್ತು ನೋಡೋಣ.
That is my last, technically my last.
The matters will take. We'll see what is possible. Vijay Kumar sir.
With my lord's kind permission, my lords.
Yes.
My lords have directed me to appear tomorrow in a matter pertaining to RERA, my lords, which my lords had heard in part. My lords, I request permission of my lords to file my statement, my submission, my lords, written submissions tomorrow, my lords. Today, if my lord permit, we'll file it in there. Please.
Please do it, sir. Yes.
Please. Much obliged.
Yes.
My lord, serial number 22. 22 list on serial number 22, my lord. It may be taken on 16th, my lord.
22. ನೋಡೋಣ ಸರ್, ರೀಚ್ ಆಗಬೇಕು. 22 ರೀಚ್ ಆಗಲ್ವಾ?
ಆಗುತ್ತೆ.
ಮತ್ತೆ ಇರಿ. ಆಯ್ತು, ವಿಲ್ ಸಿ. ಅರ್ಜೆನ್ಸಿ ತಗೊಳ್ಳಿ. ಕಂಟಿನ್ಯೂ ಮಾಡಿ.
Serial number 21, Sunil S. Desai.
ಏನೋ ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ ಇದರಲ್ಲಿ?
The appointment of assistant professor in Jeeves, my lord. Now strangely, my lord, they are, my lord, questioning my appointment, saying that there is no appointment at all.
ನಿಮ್ಮ ಅಪಾಯಿಂಟ್ಮೆಂಟ್? ಓ, ಅದು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಗಿಲ್ಲ ಅಂತ. ಈಗ ಸ್ಟೇ ಇದೆಯಲ್ಲ ಇಲ್ಲಿ.
ಇದರಲ್ಲಿ ಈಗ ನಂಗೆ ಇನ್ನೂ ಟ್ಯೂಟರ್ ಪೋಸ್ಟ್ ಅಂತ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಟ್ಯೂಟರ್ ಸ್ಯಾಲರಿನ ಕೊಡ್ತಾ ಇದ್ದಾರೆ 2019 ಇಂಟರ್ನು.
Subject to result, we'll see.
Now your lordships kindly see, my lord. Now they have produced, my lord. Yesterday your lordship has seen, my lord, annexure R6, the appointment which they have produced. My lord, this 19/2015, the same date which they say, they referred it as, my lord, the contract basis. And this even bearing number of the same letter is also now. It is created, my lord, only for the purpose of this case. Other than this, my lord, all the documents refers my appointment letter, the appointment letter which they issue. And my lord, they have not dispute annexure D, my lord. Annexure D, page number 42.
17 ತಗೊಳ್ಳು. We'll see. Interim order ಇದೆಯಲ್ಲ?
But
interim order subsisting will continue to the next date of hearing list on 17th. So many matters finish.
Further hearing.
17th ಇಲ್ಲೇ ಇರ್ತೀನಪ್ಪ, ಎಲ್ಲಿ ಹೋಗ್ತೀನಿ ನಾನು? Yes.
Serial number 22.
I think 19th last working, 19th half day.
Serial number 22, Shri Shai Nilopant.
In fresh matter itself, my lord.
Fresh matter.
Lordship seeking the grant in aid, your lordship.
After vacation.
Please.
Yes.
Number 23, Pallavi Spachapure.
After vacation, urgency will decide. Yes.
24, K.N. Patil.
ಇನ್ನು ತುಂಬಾ ಕೆಲಸ ಇದೆ.
ಸೆಲೆಕ್ಷನ್ ಮ್ಯಾಟರ್
ಅದು ತುಂಬಾ ಇದೆ.
ರಾಮಚಂದ್ರ ಮಾಳಿ ಅವ್ರ ನೋಟಿಫಿಕೇಶನ್, ಸೇಮ್ ನೋಟಿಫಿಕೇಶನ್.
ಯಾವ್ದದು?
ಇದು 24.
ರಾಮಚಂದ್ರ ಮಾಳಿ ನೋಟಿಫಿಕೇಶನ್ ಅಂತ?
This previous matter, my lords, which are serial number 20, which your lordships disposed of, arising out of same notification.
What post is this?
Associate professor in chemistry.
ಅದು ಇದೇ ತರ ಮಾಡಿದಾರಾ?
ಆ ತರ ಇಲ್ಲ, but what has happened is marking is the, insofar as while marking is concerned, they have left out 3 components which are very important. That is 2 patents which I have and 1.
That is, ಅದ್ರಲ್ಲಿ glaring with illegality. This is, we'll have to sit in the armchair of those experts.
It is prima facie apparent. I wrote them a letter saying that objecting to the initial list which they had published. Initially, they excluded me from the zone of consideration itself. I objected, brought myself into zone of consideration. Then again, my lords, I made a request to them saying that, see, the marking system is not proper, because if they include 2 patents, I'll go 10 marks above the contesting respondent. Comparative merit, if your lordships.
City is not made as a, ಇದು ಅವರಿಗೆ ಜೆ ಶೆಟ್ಟಿ ಅವರಿಗೆ ಟೇಕ್ ನೋಟಿಸ್
ಆಗಿಲ್ವಾ?
ಇಲ್ಲ.
Serial
Third
number
unrepresented ಇದೆ.
ಯಾವ್ದು third unrepresented?
ಅಲ್ಲ, ಜೆ ಶೆಟ್ಟಿ ಅವರು he has filed ವಕಾಲತ್.
ಯಾವ serial number 24 ತಾನೆ?
24.
24 ಅಲ್ಲಿ.
Raviraj Patil,
I'm for the contesting respondent.
R5.
The vice chancellor, the VSKU served
Oh,
unrepresented.
ಇದು ಕೃಷ್ಣದೇವರಾಯನ ಇದನ್ನು?
Please, your lordship.
Same notification.
ಅದೇ.
Learned Counsel J. Shetty is directed to accept notice for respondent 2, 3, 4.
It appears Wakalat is filed which is returned with office objection. Ad note ಇದೆ.
Oh, ಇಲ್ಲೇ ಇದೆ. Registry to print the name of J. Shetty as appearing for respondents 2, 3 and 4.
Comparative merit, page 54, if your lordships could kindly
J.
say.
Shetty ಬಂದ್ರೆ compare ಮಾಡೋಣ. 17th.
17th,
Yes.
please.
For 25, Kutundeya, Tata Rangi.
My lords, petitioner.
After vacation.
Petition.
Yes.
Your lordship, one submission, your lordship.
Next.
26, Arjun Agri.
ದರಿಗೊಂಡ್
27, HM Darigon.
ಏನ್ ದರಿಗೊಂಡಿದೆ? Chart matter ಆದ್ರೆ ಹೇಳಿ.
AICT pay scale madna. Not the view of the government order, not extended to the the petitioners. Not there is no the working as the state employee.
Sunil Desai. Christ, Christ.
Allah, demands, my lord.
Demands.
My lord,
Why
their,
ACT?
their appointment itself is under state scale. Notification reflects, and their appointment, my lord, says that. My lord, it can't be, my lord. I have filed my objection. Kindly see, my lord. the
Next year,
notifications.
that benefit has been extended.
2009 ಅಲ್ಲಿ all these people were granted AICT pay scales who were in state pay scales, they were bought under AICT ಅಲ್ಲ? ಎಲ್ಲಿ ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಅದು?
So next year ಏನ್ malad?
ಏನು ಡೇಟ್ ಏನದು?
Malad 13/11/2000, 16/12/2011.
16/12/2000 ನಲ್ಲಿ ಟೈಮ್ ಬಾಂಡ್ ಅನೌನ್ಸ್ಮೆಂಟ್ ಎಲ್ಲ ಇದೆ ಅದರಲ್ಲಿ. ಏನೇನ್ ಕೊಡ್ಬೇಕು ಅಂತ. ಪೇಜ್
16 malad.
ಸುನಿಲ್.
And also demand pass an order as per Annex H, extend that benefit, but the financial benefit not yet released.
No, if that is the case, my lord, he would not have filed. That is earlier director, he has made a mischief, and if that, he would have
Mischief
continued.
ಪ್ರಶ್ನೆ ಅಲ್ಲ. If 16/12/2011 government order permits it, what
Yes.
is the question of mischief?
My lord, the appointment is in 2010.
10 ನಾ? So what? 11 ತಾನೆ?
ಅಲ್ಲ, correct. So ಅವಾಗ states notification reflects of
Appointment
the.
ಇರ್ಬೋದು. ಅಂತ ಕೇಸಲ್ಲೇನೆ 6/12/2011 government order issue ಮಾಡಿ. Look into that.
This is extension, my lord. The order is extension of AICT scale.
Just check and get back.
Yes, my lord.
Same 17.
Yes.
List on 17th.
Seven.
Learned Counsel Sunil Desai to secure instructions with regard to the applicability of the government order dated 16/12/2011 to the case of these petitioners whose appointment comes about in 2010.
28, Manjunath Karganava.
ಇದು ನಿಮ್ದೆ ಸುನಿಲ್ ಅಲ್ಲ?
My lords, these are the Christ universities, my lords. Christ. 5% service weightage in this one.
That is covered.
Covered.
ಸುನಿಲ್. 5% service weightage.
Please, my lords.
Consider it. So in pursuance of the Supreme Court order.
The petitioners are before this court seeking the following prayer. ಈ ಆರ್ಡರ್ ಇದರದಲ್ಲಿದೆ. ನಮ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಅಲ್ಲಿ
ಬಂದಿಲ್ಲ.
ಇದೊಂದೇ ಕೊಟ್ಬಿಟ್ರೆ ಹೆಂಗೆ?
ಇಲ್ಲ ಸರ್, ಅದು ಇಲ್ಲ.
ಅದಿಲ್ಲ ಅಂದ್ರೆ ಇದು ಇಲ್ಲ. You have no judgment, take my judgment, dismissed.
No, we will get it, my lord.
What you will get? List in the first week of January. ನೀವು ಬರೀ SLP dismissed ಅಂತ ಒಂದು ತಂದ್ಕೊಟ್ರೆ covered I think.
ಇಲ್ಲ ಸರ್, ಅದು ಜಡ್ಜ್ಮೆಂಟ್ ಸಿಕ್ಕಿಲ್ಲ.
ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಸೋಮವಾರ ಇಟ್ಟಿದ್ದೀರಿ.
ಸೋಮವಾರ
ಮಂಡೇ ಮಾಡೋಣ.
ಮಂಡೇ
ಇದು ಮುಗಿಸ್ಕೊಂಡು.
ಪ್ಲೀಸ್.
29, AP Hegde, John Mani.
My lord, sir, here for the respondent.
Caste matter. Oh, ಎಷ್ಟು ಇಂಪೋಸ್ ಮಾಡಬೇಕು?
Jagdish, my lord, seeks a little.
Court has formed.
Tuesday, my lord.
Formulated a point for consideration.
My order.
Allala. While granting.
Shri Shyam Prasad.
Hello.
Interim order ಇದೆಯಲ್ಲ?
Interim order.
Just after vacation, interim
ಅಲ್ಲ,
order subsisting.
Tuesday ಅಂತ ಹೇಳಿದ್ರು.
Continue till the next date of hearing. Yes.
30 adjournment. 31, HM Dharwad.
Petitioner seeking mandamus to consider representation annexure M.
For what?
Regarding the appointment of compensation ground, Malad.
Yeah, date of death.
Date of death is 2000, Malad.
2000.
Please, ma'am.
27.
27/2000. Malad, the earlier rejected the Malad claim of the petitioner in the year 2006. On the ground that Malad, at the time of death, Malad is minor. Subsequently, Malad, the similarly situated person granted, given Malad the appointment. And that is Malad made a representation to the Malad the second respondent. Government also recommended my case to the Malad the for consider. Malad, in view of Malad the government order, Malad the second respondent not taken any steps. Annexure M is a representation.
Dayanand Bandi.
Dayanand Bandi.
Ilva?
Let them consider my represent annexure M.
ಎಲ್ಲಿ 25 ವರ್ಷ ಆದ್ಮೇಲೆ ಕಂಪ್ಯಾಷನೇಟ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್.
ಅಲ್ಲಲ್ಲ, similar situation already granted, given Malad there. But the government also recommended my case to the Malad.
The petitioner is before this court seeking the following prayer. The petitioner is said to be the son of a deceased employee who dies in harness on 2/7/2000. The learned counsel appearing for the petitioner submits that the petitioner at the time when he submitted his application was still a minor, and therefore the application comes to be rejected. On attaining majority, he again submits his application seeking appointment on compassionate grounds. The state also is said to have recommended the case of the petitioner for appointment on compassionate grounds. However, the second respondent, the respondents 2 to 4, have not considered the same, despite the situation being the same as projected in the representations. The petitioner thus has submitted a representation all over again, claiming that he is still in a destitute condition, or the family is still in a destitute condition, and and the employment and the necessity of the employment is still subsisting. In that light, the representation is not being considered. The learned counsel for the petitioner submits that if a direction is issued for consideration of the representation, would suffice for the present. In the light of the said circumstance, without entering into the merit of the claim of the petitioner, I deem it appropriate to direct the second response 2 to 4 to consider the representation of the petitioner and pass necessary orders thereon in accordance with law, within an outer limit of 4 months from the 3 months from the date of receipt of the copy of the order, if not earlier, ordered accordingly.
Please.
Bandi Hevde.
Please.
32, Arvind Kulkarni.
That's my request for extension of pay protection was rejected.
Pay protection, why? From where did you come?
HAL, she was working with the HAL in the year.
Date HAL.
She joined the HAL in the year on 13/2/2006.
2006. KPTCL.
Please, that is in the, on 21/2/2015. Annexure.
2015, after 11 years.
Please, annexure.
Applied through proper channel.
Please note. That is not in dispute also. Page number 39 may kindly be seen. They asked me to produce certain documents. I have produced those documents. Annexure Q, page number 21 may kindly be seen. They refer to a order passed in the year 2021. They themselves say it is a prospective in nature. Quoting that order, now they have rejected my.
Where is the appointment order?
Appointment.
In KPTCL.
Accounts office.
HESCOM.
HESCOM. Page number 32.
2015. ಇದರಲ್ಲಿ ಪೇ ಪ್ರೊಟೆಕ್ಷನ್ ಏನ್ ಮಾಡಲಿಲ್ವಾ?
ಇದು ಮಾಡಲಿಲ್ಲ. ಅದು immediately thereafter I requested for them. Annexure M, page number 35. And the order which now.
27th October 2021.
Please Manoj.
ರಿಜೆಕ್ಟ್ ಆಗಿರೋದು 6 ವರ್ಷ ಆದ್ಮೇಲೆ.
ಹೌದು.
ಈ ಶಾಖೆಗೆ ಪ್ರಮಾಣ ಸಲ್ಲಿಸಿರುತ್ತೆ ಮುಂದುವರೆದು ಉಲ್ಲೇಖ 1 ಅನ್ವಯ ಕೊಡಿ ಏನದು?
Please no. This is what they are referring to.
The entire ಅಲ್ಲಿ ರಿಸೈನ್ ಮಾಡಿದ್ರ ಅರವಿಂದ್? ಅಲ್ಲಿ ರಿಸೈನ್ ಮಾಡಿದ್ರ? HAL ರಿಸೈನ್ ಮಾಡಿದ್ರ?
Please no. Resigned. The relieving order was passed. Thereafter they joined the respondent.
ಬೆಳಗ್ಗೆ petition.
See.
Having
the order itself
having
says
admitted fact,
that is
there was a regulation 182 capital A, my lord. This 182A was put forward when in 2000 on 1/4/2006 when new pension scheme came into effect. The matter was placed before the board.
ಇವರು NPS ಕೇಳ್ತಾ ಇದಾರೆ.
Yeah, ಎರಡೂನು ಎಲ್ಲಾನೇ
OPS ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
Page 3 of the memo can be seen. They themselves say orderly, first paragraph. Order, operative portion.
When pensionable service under the board, yes.
They themselves say it is prospective in nature from 2021.
Which
24.
one? The 182.
The one which they are relying upon.
Anything else, sir?
Please.
Achala.
I'm just producing two board orders whereby this regulation 182A, there was a provision earlier. It was not that there was no such provision.
I produced that also. What is it?
May I just take the second
ಯಾವತ್ತು ವಿಡ್ರಾ ಮಾಡಿದ್ದು?
ಇದು 2021ರಲ್ಲಿ ಸ್ವಾಮಿ.
21ರಲ್ಲಿ ವಿಡ್ರಾ ಮಾಡಿದ್ದು.
Please, madam.
ಇವ್ರು ಜಾಯ್ನ್ ಆಗಿದ್ದು ಯಾವಾಗ?
15ರಲ್ಲಿ. The order says it also, just my lord.
Yes.
May I read only relevant part for the purpose of convenience. Second page. Consequent to the formation of KPTCL Pension and Gratuity Trust, wide order dated so and so, the KPTCL and ESCOM's Pension and Gratuity Trust have time and again revised the rates of pension and gratuity contribute payable to KPTCL and ESCOMs as per accrual valuation with effect from 1/6/2002. In order dated so and so, the new defined contributory pension scheme so and so has been made mandatory to all the new recruitments of KPTCL's ESCOMs joining on or after 1/4/2006. Now coming to the point number 5, where he wants to claim the same thing which is extracted in at part 5. In the circular dated so and so, guidelines have been issued as regards to the time limit within which the employee desires to count his previous service of additional years as qualifying service for pension under regulation 182A of KEB ESR needs to submit his request in writing annexure 3. So having discussed that also, why 182A at this moment of time, that is on 2021, was not feasible for the ESCOMs or KPTCL is extracted at paragraph number 11, my lord. May I just request my lordship to move on to 1. Paragraph 11, internal page 3.
Yes, sir.
Please, my lord. They have extracted an illustration that how this thing is showing a financial burden as against the persons who have already contributed to what extent in previous employment and the employment gained in KPTCL or ESCOM as such. So ultimately, the board in its regulation passed a decision so as to delete this particular 182A, whereby all the pending claims and future claims are negative, and the orders to that effect also are negative. So in this background, an endorsement was issued to the petitioner stating that since 182 for the reason stated, which may trace back to this particular resolutions, my lord, which I have forwarded, the petitioner's claim was negative.
11/10/2021 order may kindly be seen. Their own the one which I have passed on, page 3. The operative portion ಅಲ್ಲಿ first clause.
ನಿಗಮದ ಸೇವೆಗೆ
ದಿನಾಂಕ 1/12/2008 ಹಾಗೂ ತತ್ಸಂಬಂಧ ಸೋ ಅಂಡ್ ಸೋ ಎಲ್ಲಾ ಮಾರ್ಗಸೂಚಿಗಳು ದಿನಾಂಕ 24/6/21 ಜಾರಿಗೆ ಬಂದಂತೆ ರದ್ದುಗೊಳಿಸಲಾಗಿದೆ.
ಎಲ್ಲಿ ಓದಿದ್ರಿ?
ಪೇಜ್ 3 ಮಿಲೋಸ್. ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್.
ನಿಗಮದ ಸೇವೆಗೆ ಸೇರುವ ಮುನ್ನ
ನಿಗಮದ ಸೇವೆ ದೇರ್ ಆಫ್ಟರ್ ಪಾಯಿಂಟ್ 1. ಪ್ಲೀಸ್.
Heard the learned counsel, sorry, petitioner, Ashala.
The last two paras of the resolution.
The petitioner is before this court seeking the following prayer. Heard the learned counsel Arvind Kulkarni appearing for the petitioner and B.S. Kamte, Nimmasrakla?
Yes, sir.
B.S. Kamte appearing for the respondent. Facts enumerated are as follows. The petitioner was an employee, the petitioner pursuant to a selection process instituted by the Hindustan Aeronautics Limited, hereinafter referred to as the HAL for short, was appointed as an accounts trainee on 22/3/2007. After about 7 years of service, the petitioner comes about an employment notification issued by the respondent corporation, the respondent Hubli Electricity so and so company, corporation, company for short. The petitioner being desirous of securing an employment in the company applies pursuant to the employment notification dated 23/9/2014 through proper channel, i.e. through the HAL. This factor is not in dispute. The petitioner then participates in the selection process before before the company and is selection ಯಾವಾಗಾಗಿದ್ದು?
Selection 21 to 2015.
And is selected on 21/2/2015. But the nuances of joining the duties was yet to get complete. Therefore, the petitioner submits a resignation before the HAL, and the HAL accepts the resignation on 23/2/2015 and relieves the petitioner. After the relief of the petitioner joins the corporation as accounts officer. Up to this point, there is no dispute. The petitioner, immediately after joining, registers a claim that the appointment order does not render any pay protection, and the petitioner, having applied through the proper channel, is entitled to pay protection and therefore seeks pay protection and all consequential benefits that would flow from such order. The representation is not answered. Plethora of representations are submitted on one not being answered. Finally, a communication comes about on 16th August 2021, rejecting the claim of the petition.
Asking me to produce certain documents.
Reject madilva.
Subsequently, it is rejected.
16th August again madidru.
I have been asked to produce certain documents.
On 16th August 2021, for the first time, a communication is received is sent from the hands of the respondent to the petitioner seeking production of certain documents. The petitioner is said to have complied with the said direction of production of documents. What comes about later is the impugned order dated
27th October 2021.
Impugned order 27/10/2021, rejecting the claim of the petitioner, quoting a resolution and an order of the corporation that the provision that stood available at the time of appointment of the petitioner has since been deleted. Therefore, the case of the petitioner cannot be considered. It is this that has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner, Arvind Kulkarni, would take this court through the documents appended to the petition to demonstrate that his right crystallized the date on which the appointment was made in the year 2015 and the representation submitted thereon. The deletion of 182A was prospective even according to the order that is passed by the company. Therefore, the said order could not be projected as an impediment for grant of the benefit to the petitioner as was sought for. Per contra, the learned counsel appearing for the respondent, B.S. Kamte, would again take this court through the deletion order of 182A to contend that is not there to contend that all pending claims also stood obliterated with the deletion of 182A. The case of the petitioner was pending and therefore it can't be construed to be a concluded claim, and the petitioner was not entitled to the benefit that was sought for. He would seek dismissal of the petition. I have given my notes. The four narrated facts are not in dispute. The issue lies in a narrow compass as to whether the petitioner is entitled to the benefit of regulation 182A, which was subsisting at the time when the petitioner joined the service of the corporation, of the company. The petition, the facts also. The dates, events, and the dates and the link in the chain of events are all a matter of record. The petitioner joins the HAL on 22/3/2007 and secures employment through proper channel in the company, joins the company on 23/2/2015.
13/2/2006, she had joined the HAL. Appointment was confirmed in the year 2006.
13/2/2006. The petitioner joins HAL on 13/2/2006. The appointment therein as an accounts officer stood confirmed on 22/3/2007. 7 years thereafter, the petitioner applies through proper channel for in response to an employment notification by the corporation and gets appointed after applying through proper channel and the resignation in the employer, in the erstwhile employer, and gets appointed on
21/2/2015.
The appointment order did not speak anything about the protection of pay as was available to the employees as on that date. In that light, the petitioner registers a claim immediately thereafter on 7/8/2015
Annexure M, page number 35.
7/8/2015, seeking refixation of the pay of the petitioner. The representation reads as follows. Plethora of such representations come about, but the pay protection did not come about. 6 years pass by. The first endorsement comes about on 27th October 2021, seeking certain documents from the hands of the petitioner. The communication reads as follows. The petitioner is said to have submitted all those documents. What comes about is the impugned order.
Annexure Q, page number 41.
What comes about is the impugned order on
27th October 21.
27th October. ಈಗ ಹೇಳಿದ್ ಯಾವುದು ಒಂದು ನಿಮಿಷ ಅದು 16th August 21 ಈಗ ಹೇಳಿದ್ದು ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಬೇಕಾಗಿರೋದು 16th August 2021. What comes about is the impugned endorsement dated 27th October 2021. It reads as follows. Therefore, the endorsement reads that the petitioner's claim has been turned down on the score of deletion of 182A from the statute book, i.e. the regulations. Therefore, it becomes germane to notice the regulations in juxtaposition to what was present at the time when the petitioner entered service and what is subsisting today. Regulation 182 reads as follows. Regulation.
I have produced along with my page number 5. Along with the memo.
Page number 5.
Look, just now I have passed on.
Ah. 182A reads as follows. 182A permits pay protection of several kinds of employees. One such protection is given to the persons who join the service of the corporation from the local bodies, district boards, municipalities, state railways, or central or state commercial concerns, autonomous body of the Government of India or the state government. The Hindustan Aeronautics Limited is admittedly an autonomous body of the Government of India. Therefore, the protection under 182A was available to the petitioner. The availability of the protection at the date of joining of the petitioner is not in dispute. What comes about later is a resolution of the board. The resolution of the board reads as follows.
Page 2. I have produced.
ನೀವು ಮಾಡಿದ್ದೀರಾ ಇದೇ ಮೆಮೊ
Page 2. please.
When agenda is placed. Probably if my friend has paged agenda also, then that could be.
ಇಲ್ಲ ಇದೆ ಎರಡು ಇದೆ ತಗೊಳ್ಳಿ. The agenda and the resolution read as follows.
Please.
ಇಷ್ಟೊಂದು ಬೇಡ resolution.
ಅಲ್ಲ, the one I have
ಮಾತ್ರ. 182 ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
Agenda discuss.
The one which lots I
agenda resolution ಸಾಕು.
Resolution is the first page, which
the resolution reads as follows. The resolution deletes 182A from the KPTCL employee service regulations, which was bought in terms of circular dated 1/12/2008, and to reject all proposals pending for consideration under 182A requesting counting of past service for the purpose of pension. The government order ಯಾವುದು ಹೇಳಿದ್ರಲ್ಲ ನೀವು?
I have produced along with the memo.
After the resolution dated date and resolution.
Please. This is on 11th October 2021.
ಅಲ್ಲ resolution.
Resolution.
125 was on.
After the resolution comes a government order.
Resolution date is 24th June 2021.
Resolution dated 24/6/2021. A government order springs on 11/10/2021. The government order reads as follows. Hey, government order. The order of the KPTCL comes the government order of the KPTCL. The order of the KPTCL reads as follows. Page. The order of the KPTCL is clear that the deletion of 182A from the statute book is prospective and would not affect the claims that were already penned from the prospective from the date on which it is notified, which is on 11th October 2021. Therefore, the claims that were subsisting before 11th October 2021 admittedly will have to be processed in the teeth of the pendency of the, in the teeth of the subsistence of the regulation in the statute. The petitioner joins the service of the corporate company in the year 2015, at which point in time 182A was still in the statute book. It is deleted only on 11th October 2021. Therefore, it cannot obviously be applied to the case of the petitioner as a case of the petition. If the petitioner was for the first time venting out a grievance after the deletion of the regulation, it would have been an altogether different circumstance. While it is not the case, the petitioner has been agitating the inclusion of pay protection or counting of past service right from the date of appointment. But it is the folly of the company that has not passed any orders till the regulations come, till the regulations stood deleted. It is obvious that the deletion of a regulation cannot take away the rights or even take away the rights crystallized or inchoate that was pending at the time when the regulations were in subsistence. In that light, petition deserves to succeed with the prayer to be granted. For the aforesaid reasons, the following order allowed, quashed, the petitioner becomes entitled to the pay protection of the past services rendered by the petitioner for whatever years it would be in terms of regulation 192A as it was then subsisting.
182.
182A.
182A.
182A. 182 ತಾನೆ ಹೇಳಿದ್ದು? A. 182A. Obliged. Yes, sir.
33, Vijay Srinivas.
Krishna was working as a de-employee, madam. She worked for 22 years, madam.
Regularization.
22 years.
Regularization.
Yes, madam. Regularization.
Consider ಮಾಡಿಲ್ವಾ?
No, madam. Initially, madam.
Who has to consider?
Respondent number 4, madam.
4.
3, madam. 3 and 1.
ಆಗ್ಲೇ ಕೋರ್ಟ್ ಬಂದಿದ್ದೀರಾ?
Please, madam.
ಒಂದ್ಸರಿ ಕನ್ಸಿಡರೇಷನ್ ಇತ್ತು. Earlier round consider ಅಂತ ಆಗಿದೆ.
ಈಗ ಡೈರೆಕ್ಷನ್ ಕೊಡ್ಬೇಕಾ?
Same
Malord.
endorsement has been issued.
Malord.
Same endorsement ಕೊಟ್ಟಿದ್ದೀರಾ?
They gave an impugned endorsement stating that, my lord, impugned order at annexer
page,
ink page, my lord, 23 annexer F, my lord. But relevant, my lord, 24 ದೊಳಗೆ ಲಾಸ್ಟ್ ಪ್ಯಾರಾ ಈ ಮೇಲ್ಕಂಡ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಅರ್ಜಿದಾರರು ಶ್ರೀಮತಿ ಮಂಜುಳಾ ಎಂ ಬೆಳಗಾಂಕರ್ ಡಿ ಗ್ರೂಪ್ ನೌಕರರು ಇವರಿಗೆ ಅವರ ಮನವಿ ಪತ್ರ ದಿನಾಂಕ ಸೋ ಅಂಡ್ ಸೋ ಹಾಗೂ ಸೋ ಅಂಡ್ ಸೋ ಪ್ರಕಾರ ಅವರಿಗೆ ಮಾನವೀಯ ದೃಷ್ಟಿಯಿಂದ ಕಾಯಂ ಖಾಲಿ ಹುದ್ದೆಗಳಿಗೆ ವಿಲೀನಗೊಳಿಸಲು ಹಾಗೂ ಪಿಂಚಣಿ ಸೌಲಭ್ಯಗಳನ್ನು ಪವಿತ್ರಿಸಲು ಯಾವುದೇ ಸರ್ಕಾರ ಆದೇಶ ಇರುವುದಿಲ್ಲವೆಂದು.
As they were continued in the scheme, your lordship.
My lord,
scheme ಆದ್ರೆ ಕಷ್ಟ.
My lord, actually, my lord, initially, my lord, in the year 2000, my lord, 1998, my lord.
No, Sarva Shikshana Abhiyana project.
My lord, in the 1998, my lord, she joined a service, my lord. Thereafter, my lord, when the respondent tried to remove her job, my lord, she approached the KT, my lord, where the Karnataka Appellate Tribunal has granted stay, my lord. Thereafter, my lord, again, my lord, again, my lord, they continued the service, my lord. After continuation, my lord, the petitioner has not passed the petition before KT, my lord. Till fag and my lord, she worked, my lord. Thereafter, my lord, she made several representation to consider regularization, my lord. Thereafter, when they did not consider, my lord, the petitioner approached before this honorable court for necessary direction, my lord. This honorable has
ಅಯ್ಯೋ ಸ್ಕೀಮ್ ಅಲ್ಲಿ ಇದ್ದೀರಾ ಸರ್, ನೀವು ಏನೇನೋ ಹೇಳ್ತೀರಾ. ಪರವಾಗಿಲ್ಲ, ಸ್ಟ್ರೈಟ್ ಅವೇ ವಿಲ್ ಗ್ರಾಂಟ್ ನೋಡಿ. ಸ್ಕೀಮ್ ಅಲ್ಲಿ ಇದ್ರೆ ಕಷ್ಟ.
My lord, ಅವ್ರದೇ ಪ್ರಾಜೆಕ್ಟ್ ವರ್ಕ್ ಸರ್.
Difficult. If you are appointed to the project, ಇನ್ನೂ ಇದೆಯಾ ಇದು?
Yes, my lord. Till today, my lord.
But she is retired, your lordship, now.
You are retired already.
Retired, yes, my lord. 36/2000, my lord. ಅಲ್ಲ ಪೆಂಡೆನ್ಸಿ ಒಳಗೆ
ಒಂದು ಯಾವ್ದೋ ಬರಿತಾ ಇದ್ದೀನಿ, ಅದೇ ತರ ವಿಲ್ ಸಿ ಕವರ್ಡ್ ಅಂತ ಮಾಡ್ಬೋದು. ಲಿಸ್ಟ್ ಆನ್ 17th ಅಷ್ಟು ಪ್ರೊನೌನ್ಸ್ ಮಾಡ್ತೀನಿ.
Please.
Yes. 17th.
Number 34, Umesh Sainapur.
Respond number 3 and 4 also the state authority, my lord. In the last occasion, my lord, this honorable court issued a notice to the penal advocate, my lord.
34.
3 penal advocates are refused.
Desai Patil idaralla?
No, my lord, he is not in panel.
ಯಾರ ಪೇರ್ ಆಗ್ತದೆ?
My lord, 3 and 4 also, my lord, the state authority, my lord.
Yes, government.
The executive is here.
The National Highway Division anta ಇದೆ, Your Lordship. Then National Highway Division doesn't come, Your Lordship. State national ಅಂತಂದ್ರೆ ಅಲ್ಲ, sorry, state highway ಅಂದ್ರೆ ಬರುತ್ತೆ. But that is national highway.
correct ಆಗಿದ್ದಾರೆ.
ಇದ್ದಾರೆ.
State, it's come under the state, my lord. The office situated at Mini Vidhan Saudha.
ಆಫೀಸ್ ಎಲ್ಲಿದೆ ಅದ್ರ ಮೇಲೆ ಡಿಪೆಂಡ್ ಆಗುತ್ತಾ?
But it's come under the
Click ಮಾಡಿ ಮೇಡಮ್.
I will verify, Your Lordship.
The learned HCGP is directed to accept notice for response 3 and 4. The memo of appearance of wakalat shall be filed only after verification whether the third response 3 and 4 are state entities or still the National Highway Authority of India.
Please, Your Lordship.
Date may be fixed.
After vacation, yes.
No, lord. The 10 years regularization, my lord. It may be date.
Teams, sir.
The state admitted that, my lord, the state found that my lord issued notification.
18th.
His name
We'll see on
is,
18th.
please.
Number 35, Shivakumar, Vendigiri.
Please, my lord. The appointment of the post of stenographer by the respondent number V is at challenge. The petitioner is unsuccessful candidate. As the respondent number 2 is a successful candidate.
Oh, typing ಚೆನ್ನಾಗಿತ್ತ ಬೇರೆ?
The short question which is involved is, the requisite condition for the appointment is the PUC, pre-university course, first but the respondent number 2 has not undergone the pre-university course.
ಮತ್ತೆ ಏನು?
It is ITI.
Equivalence.
Equivalent to PUC or not? That is the only issue.
Only issue. And
Now the petitioner has been appointed in Raichur Family Court and he is working since 20. How you agide appointment ಈಗ? Raichur Family Court ಅಲ್ಲಿ now he is working as stenographer.
But that is not a question, my
No,
lord.
no.
ಪರವಾಗಿಲ್ಲ.
ಈಗ ಇವನು 2022 ಇಂದ he is working that second.
ನಿಮಗೂ ಸಿಕ್ಕಿದೆಯಲ್ಲ?
ಸಿಕ್ಕಿದೆ ಆಗಿದೆ. He is working. Yes, sir.
This is about the.
This is Ballari.
This one, Raichur.
Now he is working at Ballari.
ಬಳ್ಳಾರಿ ರಾಯಚೂರು ತುಂಬ. ನಿಮ್ಮ ಮನೆಯಲ್ಲಿ?
He is from Raichur.
ರಾಯಚೂರ?
ಅಲ್ಲೇ ಸಿಕ್ಕಿದೆ.
ಮನೆ ಪಕ್ಕದಲ್ಲೇ ಮತ್ತಿದೆ ಕೆಲಸ?
No, my lord. He is appointed in Ballari.
ಇಲ್ಲ Family Court Raichur.
He belongs to Ballari.
Oh, you belong to Ballari. Ballari ರಾಯಚೂರು ತುಂಬ ದೂರನಾ? ಇಲ್ಲ ಸಿಕ್ಕಿದೆಯಲ್ಲ ಬಿಡಿ.
ಸಿಕ್ಕಿದೆ.
But even otherwise, ITI, SLC equivalent PUC declaration.
This court will also.
Government order is none.
For the.
But only in the situation where they have complied the guidelines of the circular of the 2018, where they have undergone the one language and one subject.
ಈಗ ನೋಡಿ ಮತ್ತೆ ನಿಮ್ಗೆ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಕೊಟ್ರೆ ರೆಸಿಗ್ನೇಷನ್ ಕೊಡ್ಬೇಕು, ಅಲ್ಲಿ ಬರ್ಬೇಕು. ನೀವೆಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಿರೋದು?
ಅಲ್ಲಿ ಇವ್ರು ನಾನಲ್ಲ, ನಾನು ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟ್ಗೆ.
ತಿರ್ಸಿಲ್ಲ?
Gangavati. Millards, on this Millards basis, there are in all 18 appointments are made by the High Court.
We'll set aside everything.
Alla, adke. Poor fellow Millards, since 2022, Millards somehow is earning his livelihood.
ಏನ್ ಟೈಪ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಸಂಬಳ ಬರ್ತಾ ಇದೆ. livelihood ಅಲ್ಲ ಅದು. You're earning salary. ಕಿರಣ್ ಗೌಡ್ರೆ ಬಿಟ್ಬಿಡಿ.
Late to the court.
ಅದನ್ನೇ
That like should be clarified because based on that subsequently similar appointment is being.
Verify ಮಾಡಿದ್ರೆ ಮತ್ತೆ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ.
18 ಜನದ
ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಹೋಗುತ್ತೆ. KPSC ಲೂ ಮಾಡಿದ್ದಾರೆ, ಎಲ್ಲದರಲ್ಲೂ ಮಾಡಿದ್ದಾರೆ.
ಇಲ್ಲ ನಾನೇ ಬರ್ತಿದ್ದೀನಿ. It is our equivalence, but ಅದು ಸ್ಟಾಪ್ ಆಯ್ತು at some point. ಅದು ಸ್ಟಾಪ್ ಆಗಿದ್ದು 2018.
ಕಾಲೇಜ್ ಎಂಟ್ರೆನ್ಸ್ ಗೆಲ್ಲ PUC that ITI has been taken.
This honorable court in similar matter.
I have myself held or ಬೇರೆಯವ್ರು ಬರ್ದಿರ್ಬೇಕು. ಆಯ್ತು ಈಗೇನು ಎಕ್ಸಾಮಿನೇಷನ್ಗೆ?
ಎಕ್ಸಾಮಿನೇಷನ್ ಇದೆ, ಲಾ ಎಕ್ಸಾಮಿನೇಷನ್ ಗೆ ಇದನ್ನ ಮಾಡಿದ್ರು. ಸಾರಿ ಲಾ ಕಾಲೇಜ್ ಗೆ.
Petition for the LLB course it is being considered, my lord, but not for the appointment. It is regarding the appointment.
18 ಜನ. I will not get into the merit. I will say you are also appointed now in Raichur. ಚೂರ್ ಬಿಟ್ಬಿಡಿ.
Please, I'll leave it to the court.
Yes, the petitioner is before this court. ಅಲ್ಲ ಅದು ಕರೆಕ್ಟ್ ತಾನೇ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಗಿದೆ?
ಎಸ್ ಎಸ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡಿದೀವಿ.
ಜಗದೀಶ್ ಪಾಟೀಲ್ ಸರ್ ಹೇಳ್ತೀರಿ ಆದ್ಮೇಲೆ?
ಇಲ್ಲ ನಾನು ಬೆಳಿಗ್ಗೆ ಮತ್ತೆ
The petitioner is before this court seeking the following prayer. The learned counsel appearing for the respondent selected candidate ಇವರಿಗೆ?
I am the appearing for the principal district judge.
Appearing for the respondent before whom the petitioner is now seeking employment, submits that the petitioner himself is now appointed in the court, in the district court
Raichur Family Court.
Raichur Family Court, and is working since
that you lost
is working.
Is working as
Is working. The learned counsel, Iranagowda Kapoor, appearing for the petitioner, though would seek to contend with vehemence that the very appointment of the second respondent is contrary to law, would submit that in the light of the appointment of the, I would submit that he would leave the decision to the court in the light of the petitioner also being appointed at Raichur now as a typist, as a stenographer. In that light, to not to disturb the appointment of the petition of the second respondent, I deem it appropriate to dispose the subject petition in the light of the appointment petitioner also being appointed in the district court at Raichur. To declare all is well that ends well. That's very, very well. Yes.
Grateful.
Much
grateful.
Number 36.
My lord, I'm hearing to the petitioners, my lord. My lord, the petitioners are 20 in number. They are all Adivasis from Madhya Pradesh. They were basically, my lord, brought here as they were Adivasis from Madhya Pradesh. 1 to 12 are seniors. They are elders, my lord. 12 to 20 are minor children. They were brought here, my lord, to work in village Kasnal under bonded labor situation. Thereafter, my lord, they filed a complaint to the authorities. If my lord may please see annexure C at page 56, they reached out to their page 56, my lord, annexure C. This they reached out to this organization in Madhya Pradesh.
Last time ಕೇಳಿದ್ನಲ್ಲ
ಹೌದು ತಾವು ಕೇಳಿದ್ರಿ. My lord,
dispose ಆಗ್ಲಿಲ್ವಾ?
ಇಲ್ಲ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ ಇದು. ತಾವು ಹೋದ್ಮೇಲೆ this matter is coming up for the first time.
ಅವಾಗ ಅವ್ರ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತೋರ್ನಂದ್ರು
Annexure A, I just wanted to point my lords to
ಮಾರ್ಕ್ ಮಾಡಿರೋದು ಹಂಗೆ ಇದೆ ಇಲ್ಲಿ annexure A ಅಲ್ಲಿ.
ಹೌದು.
I have marked this. Visited the place shown to the complaint and 18 adults and 14 children were present on the day. Being inquired, told that contractor Sham paid advance of 20,000. This contrary to law, sir.
Please, my lord, if I can just this memo of citations may please be seen. The definition, my lord. In fact, my lord, the apex court in one of the PUCL cases regarding bonded labor has said, my lord, this kind of, when low rank staff go into these kind of situations, they don't have the sensitivity. My lord may please see the definition of bonded labor. Annexure 2, section 2G, my lord.
Asian Games Village, PUDR 82.
Out, Swami. That is obvious. Bandhua Muktu Morcha. After that, Nirja Chaudhary. All of these say forced labor is, bonded labor is a form of forced labor. Here, my lord, annexure A, the DC says yes, they took an advance. Yes, they are not being paid the minimum wages. But because they are not physically restrained, it is not bonded labor.
In your case only in Bangalore, I wrote one bonded labor there. Which
please,
is that?
Please, my lord. And my lord, may please see section 2G, my lord. Just the definition of bonded labor system, my lord. And then annexure A, if it is seen, it is contrary to this to the law entirely.
You're still working, is it?
Illa, we got rescued and now we've been sent back. But what happens, my lord? My lord may please see annexure K. That is the rehabilitation scheme at page 85. That is my second relief, my lord. Because yes, my lord. So because they have denied, annexure A has been passed, none of the benefits under the scheme has been given to me.
What are the benefits you're entitled to?
My lord, annexure K85, it is monetary benefits, my lord.
What monetary benefits under the scheme? How much?
Please, my lord.
Now, who will identify them for purpose of disbursement?
The Deputy Commissioner, my lord. Under the scheme of the Act, section 12, the Deputy Commissioner, my lord, is the person who is in charge for everything.
No, Deputy Commissioner himself says yes, accepts the fact that they were used as bonded labor and they are sent back now.
No, but my lord, annexure A, page 33. The difficulty comes there. The Deputy Commissioner, he says yes, they were paid an advance. They were paid less than minimum wages, but at the page 35, my lord, he says that this is not bonded labor. So annexure A, if it is set aside.
In page number 34, my lord, second para.
ಗೊತ್ತು ನೋಡಿದ್ದೀನಿ. Further, it was told last 10 days they are working in the farm, they have did not have any problem.
ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿಲ್ಲ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್
ಇದ್ರಲ್ಲ ಎಲ್ಲಾದ್ರಲ್ಲೂ ಸೈಕ್ಲೋಸ್ಟೈಲ್ ಆರ್ಡರ್ ಇದೇನೆ. ಬಾಂಡೆಡ್ ಲೇಬರ್ ಯಾವಾಗ ಬರುತ್ತೆ ಈ ತರ ಒಂದು ಇನ್ಸ್ಪೆಕ್ಷನ್ 10 ದಿವಸದಿಂದ ಫಾರ್ಮ್ ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಿದ್ದಾರೆ, ನಾನು ನೋಡಿರೋದೆಲ್ಲ ಇದ್ರಲ್ಲಿ.
And they were working from November of 2021, my lord, at that time, before they were rescued. So annexure A, my lord, would have to be set aside, and the consequential, my lord, benefits under at page 88, which is a rehabilitation package, my lord, that would have to be given.
Let me see. Heard reserved. ಇನ್ನು ಮತ್ತೆ ಬಂದು ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಬರುತ್ತೆ ಆಮೇಲೆ ಇದೆ.
Most grateful, my lord. My lord, would my lord prefer a synopsis, my lord?
Yes.
Grateful, my lord. I'll give that. By Monday,
That would make my job easy.
Most definitely, my lord. Grateful, my lord.
Yes.
Kaki Sawain, Sangram Kulkarni.
My lord, the petitioner had challenged annexure D, my lord. Petitioner had participated in the auction for transformers, my lord. But there were two transformers. The first transformer that was lifted, it contained less quantity of copper, my lord, and therefore he gave a representation to the respondent to hold a joint inspection. That was not considered, and therefore a writ petition came to be filed before this honorable court, my lord, where a submission was made that the representation would be considered, my lord. Subsequently, they refused to hold a joint inspection, against which a writ petition was filed. My lord, the second writ petition was filed challenging the rejection of the representation, my lord. In the year 2021, the writ petition filed by the petitioner was allowed with a direction that the petitioner should pay the remaining balance amount and lift the transformer, my lord. Thereafter, the petitioner gave an application to deposit the amount. That application has been now considered, and they have now passed an order saying that the EMD amount that was paid is to be forfeited, and additional charges have been levied, my lord. That has been challenged before this honorable court, saying that EMD amount.
EMD forfeited?
But they are not lifted within time, my lord. And since 2010 till today, he has not lifted. There is a provision. Oh, there is a disputed question. This honorable court dismissed the writ petition, page 20, as there is a arbitration clause. ಇದು ಮತ್ತೆ ಅವ್ರ ಅಮೌಂಟ್ ಕೇಳಿದೀವಿ ನಾಟ್ ವಿ ಹ್ಯಾವ್ ಆಸ್ಕ್ಡ್ ದೆಮ್ ಟು ಪೇ ದ ಸರ್ಟನ್ ಅಮೌಂಟ್ 1 crore.
Arbitration ಆಗಿಲ್ವಾ?
Arbitration ಹೋಗ್ಬೇಕು. Not within 1 month we will conclude the arbitration process. Instead of that, 10 years he is proceeding in the case here. Since 2010.
Case where?
But here itself 2010 ದಿಂದ prosecute ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
Only grievance is
I will direct the arbitrator to conclude the proceedings within 2 months.
My respectful submission is, it is only regarding the forfeiture of EMD amount, my lord.
No.
If we are ready
it is only forfeiture of EMD, I will consider it.
Yes, my lord, it is only that amount.
Yes, forfeiture of EMD ಯಾಕೆ ಸರ್?
ಇದರಲ್ಲಿ ಪೇಜ್ ಇಂಪ್ರೂವ್ಡ್ ಆರ್ಡರ್
ಒಂದು ನಿಮಿಷ ಶಿವರಾಜ್ ಮಗಲ್.
ಪೇಜ್ 29 ದಲ್ಲಿ ಕ್ಯಾಲ್ಕುಲೇಷನ್.
ಒಂದು ನಿಮಿಷ. Yes.
Yes, my lord, as per clause 5.5 of the special terms and conditions. Page 29.
29. These are all the calculations.
One minute. The additional charges which have been levied are at serial number A, B, and D, my lord.
As per clause A,
clause A, clause 5.4, clause 7.3, and 5.5, my lord.
Clause A, B,
serial number A, B, and D.
C illa.
My lord, we are only aggrieved regarding the forfeiture of the.
That is in terms of clause 5.5.
Yes.
Collected from so and so. In case failure to pay the balance of sale value, including tax so and so, operative banks.
Lord,
where is the power to, on what circumstances EMD can be forfeited?
But if he failed to lift, my lord, then there is
reject madilva inna?
No, he has not lifted. Since 2010, transformer is with my lord.
ಆಯ್ತು. ಈಗ EMD forfeit ಮಾಡಿರೋದು because he has not lifted, is it?
Yes, my lord.
ಇವತ್ತರೆಗೂ ಲಿಫ್ಟ್ ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ, ಯಾಕಂದ್ರೆ ಅವ್ರು ನಮ್ಮ ಕಡೆಯಿಂದ ಪೇಮೆಂಟ್ ತಗೊಂಡ್ರೆ ನಾವು ಲಿಫ್ಟ್ ಮಾಡ್ತೀವಿ. I have to make the payment.
So 15 ವರ್ಷದಿಂದ ಅಲ್ಲೇ ಇದೆ.
Yes, my lord. But page 27 my lord,
ಎರಡು
correct.
ತಿಂಗಳಲ್ಲಿ ಕಂಪ್ಲೀಟ್
Yes.
ದಿ ಆರ್ಬಿಟ್ರೇಷನ್ ಕ್ಲೋಸ್ ಇಟ್. ಇಲ್ಲ ಅಂದ್ರೆ 2035 ಆದ್ರೂ ಇಲ್ಲೇ ಇರುತ್ತೆ.
ಇಲ್ಲೇನಾ?
My lord, in case this order is also.
No, I will uphold the EMD for future if you have not lifted. Straight away.
My lord,
I will uphold the EMD for future.
but a time may be fixed for making the payment and we'll lift, my lord.
ಬರೋದಿಲ್ಲ.
Yes.
ಆಯ್ತು, ಈಗ 2 months ಅಲ್ಲಿ ಲಿಫ್ಟ್ ಮಾಡಕ್ ಹೇಳ್ತೀನಿ. ವಾಟ್ ಎವರ್
ಚಾರ್ಜಸ್ ಗ್ರೌಂಡ್ ರೇಟ್
ಅದೇನಿದೆ ಅದೆಲ್ಲ ನೀವು ಡಿಸೈಡ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಈ
ಆರ್ಬಿಟ್ರೇಷನ್ ಕ್ಲಾಸ್ ಯಾವ್ದ್ರಲ್ಲಿದೆ ಕೊಡಿ.
Lord, as per this order, my lord, if 2 months' time is granted to us, we will pay the amount and lift the amount, transformer immediately.
Pay the amount
arbitration
ಅಂತ
clause my lord, page 12 my lord, arbitration.
sir, he'll pay the amount and lift it ಅಂತಲ್ಲ.
ಅದೇ will furnish him a calculation amount my lord, let them pay that amount my lord. He is not
This
ready to
amount
pay.
as per annexure
ಅವ್ರು 2000
D. As per annexure D, my lord.
10 years back the amount ಕೇಳ್ತಾ ಇದ್ರು my lord. Till today my lord the ground rate
ಎಲ್ಲಿದೆ ಇದು?
my lord, page 12 my lord, statement of objections my lord.
ಯಾವ್ಯಾವ ಪಿಟಿಷನ್ ಗಳು ಪೆಂಡಿಂಗ್ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ?
Statement of objections I have filed my lord.
ಕ್ಲಾಸ್ 12
Page 12 my lord.
ಆರ್ಬಿಟ್ರೇಷನ್ ಕ್ಲಾಸ್ 9.
9.0 please my lord. Let them will conclude the arbitration.
ನೀವು ಲಿಫ್ಟ್ ಮಾಡೋದು ಅದೆಲ್ಲ ತೀರ್ಮಾನ ಮಾಡಿ.
ಎಲ್ಲ ಬರ್ತದೆ.
Consequential EMD for future will be dependent on that. If they don't, you revive this petition.
Yes.
The
But the
petitioner
most
is
part,
before.
my lords may not blacklisting ಒಂದು ಮಾಡಿದ್ವಿ. That may be we lords.
Blacklisting notice ಮಾಡಿದೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇಲ್ಲ ಅದು ಸ್ಟೇ ಆಗಿದೆ.
Same order ನಲ್ಲಿ there.
ಅದನ್ನ
Petitioner is before this court seeking the following prayer. The petitioner is a participant in a tender notified by the respondent. The issue does not relate to the tender, but the material relating to the tender is dumped in a particular place and has not been lifted by the petitioner. In the light of the said action, the respondent corporation has not paid EMD or has forfeited the earnest money deposit which the petitioner had deposited pursuant to the tender. The issue is languishing since 15 years, as the petitioner is fighting for his EMD for the last 15 years and has now suffered an order of blacklisting as well. Therefore, the petitioner is before this court in the court seeking the aforesaid prayers. Insofar as the order of blacklisting is concerned, it is an admitted fact that there was no notice issued to the petitioner prior to the passing an order of blacklisting, as it is a common order of blacklisting and forfeiture of EMD. Therefore, the said order of blacklisting could not have been passed at the outset, issuing a notice, as the order of blacklisting involves civil and economic consequences. In the light of the order of blacklisting being in violation of principles of natural justice, I deem it appropriate to obliterate that portion of the order which blacklists the petitioner. Insofar as the forfeiture of EMD is concerned, the learned counsel Shuraj Mudol submits that the entire blame should be laid upon the petitioner, as he has not lifted the material and still lying dumped in a particular area for the last 15 years. In that, the learned counsel also submits that the agreement between the parties also envisaged an arbitration to be the mode of resolution of a dispute in terms of clause 9. Clause 9 of the agreement reads as follows. Clause 9 of the agreement directs arbitration to the method to be the mode of resolution of a dispute between the parties of any kind that arises out of the contract. The present dispute undoubtedly has arisen out of the contract. In that light, I deem it appropriate to dispose the petition with a direction to the respondent corporation to appoint an arbitrator on consensus and close the arbitration proceedings, or adjudicate the dispute and close the proceedings with an outer limit of 8 weeks from the date of receipt of the copy of this order. The consequent action would be a grant of EMD or otherwise, and from the hands of the respondent to the petitioner in terms of the award of the arbitrator. For the aforesaid reasons, the following order: the petition is allowed in part. The impugned order, insofar as it blacklists the petitioner, stands quashed. The impugned order, insofar as the forfeiture of EMD is concerned, is now remitted back to the hands of the arbitrator, who shall enter upon the dispute, adjudicate the same, and pass necessary orders thereon in accordance with law, within an outer limit of 8 weeks from the date of receipt of the copy of the order.
Meanwhile, we are ready to deposit the amount, my lord. We may be permitted to
ಅದಲ್ಲೇ
deposit.
ಕೇಳ್ಕೊಳ್ಳಿ, ಮುಗಿಸ್ಕೊಂಬಿಡಿ.
My lord, because as far as this order is concerned, my lord, we are ready to deposit the amount.
Allon barkoli. The learned counsel for the petitioner is also submits that he is ready and willing to deposit the amount and lift the material. The same shall be considered by the arbitrator as well. Yes. Ordered according.
Number 38, Sarvasappa ki Vasati, MS Sarvi.
This is respect of the selection of assistant law officer post in the respond corporation in respect of. Yes, assistant law officer post selection.
Yes, next.
Number 39, DM Malli.
Next week.
My lord, appearing for the petitioners, my lord, this is this is the matter of the Hubli Dharwad railway station, my lord. Those workers.
Oh, yes.
My lord had heard this. The only thing that has happened in between is the interim order that was granted, my lord. There was an interim order granted that 52 of the workers should be given their work. That was challenged by the contractor before the division bench. Division bench has dismissed. Dismiss agide avardu. So now, my lord.
Yes.
Lord, all contentions were kept open to be urged before the writ petition. Yes, my lord, I had filed the writ petition because writ appeal. I am sorry, my lord, because this court had directed me to take 50 more workers, and my lord, I am holding a tender.
So, now it's rejected, alva.
No, the tender, my
the
lord,
writ appeal is rejected.
Writ appeal, my lord, is disposed of,
contractor's term is
stating that
over.
the contentions may be taken up in the writ petition and theli madidru. And my
Yeah.
term is over. My lord, now only question would be, my lord, for the next contract which is already awarded, and there is a new tenderer, my lord, who has come into.
My lord, one submission, my lord had heard all of this on the last date, and my lord actually had also indicated that matters could be dictation could be made. I have also filed my synopsis in this, my lord. If my lord will please see, on 10th of February.
And your lordships had also indicated that the present contractor would not be touched upon, and the subsequent anta tav helidri. My lord, now the subsequent contractor also has come and is taken over the work. Now my bills are not being cleared because of the pendency of this writ petition, my lord.
ಐವತ್ತು ಜನ ತಗೊಂಡ್ಬಿಡಿ ಎಲ್ಲ ಸರಿ ಹೋಗುತ್ತೆ.
At time hoyt Swami, unfortunately. My learned friend is also not in the driver's seat.
Yes.
My lord, the direction is being sought to the railways. The relief is being prayed against the railways.
We'll dispose it on 17th. Synopsis ಹಾಕಿದ್ದೀರಾ? Synopsis, Clifton.
Yes, my lord. My lord, may please just take the synopsis that I filed, my lord, 10th February.
17th, yes.
My lord, this was an activity outcome.
17th will decide.
My lord, can it be at 2:30? Can it be at 2:30 on 17th, my lord?
Yes, sir.
My lord, at 2:30 on 17th, please.
ಬೇಡ fresh material ಇರಲಿ ಬೆಳಗ್ಗೆನೇ.
Fresh matter. Okay, fine, my lord. That's grateful, my lords.
Withdrawal. Thank you. Withdrawal in terms of memo. 40. Next.
41, Adachandi.
Yes, Pranav.
Please, my lord. My lord, petitioners are challenging the order of Deputy Commissioner, my lord, declaring their land as burial ground. They have been cultivating the land since 1990, my lord.
Why, sir?
They are not their land, my lords. It's the government land. They filed application for regularization.
Regularization. Unauthorized occupant.
Unauthorized occupation.
That was filed in 1990, my lord. It is pending consideration.
AVIO, yes.
Alla, adu stay my dispose mandamus.
42.
Intermediate idea.
Sunil
Please.
Desai. Number 42.
After vacation, ಇಲ್ದೇ ಆಗ್ತಾರೆ. IO ಇದ್ರೆ IO. Next.
43, KL Patil.
Instructions to make a submission.
44.
ಎಲ್ಲ after vacation ನಾವು. ಯಾರಿಲ್ಲ ಅಂದ್ರೆ better. Gayatri.
Here for petition, my lords. This is day before yesterday's matter, that resignation matter, my lords, withdrawn before the.
Yes, Raghavendra Gayatri.
My seniors held up in by service day in Court Hall 6. My seek for one accommodation
Service
till
day?
Tuesday.
ಆತರ ಬೇರೆ ಇದೆಯಾ?
In Court Hall 6, my apologies, my lords. They have allotted.
All right.
That's the reason. Till Tuesday.
Yes, ನಾಳೆ.
Obligement.
ನೀವೇ ಮಾಡಿ.
Not ನಾಳೆ ಅನ್ಕೊಂಡು. I've read the file, my lords, but not tomorrow, my lords. Tuesday, if may. subject to their
There are
convenience.
2, 3 judgments you got seen.
Please, Manoj.
2, 3 judgments on the issue. Nodilva?
Noted then, Manoj, one more thing in this case is non-compliance of section 97.
7, correct.
Yes,
97 requires approval.
My lords,
correct.
that,
Manoj,
that is done, my lords.
reading of section 97, attestation and 2 things are mandatory, Manoj.
There is one judgment, Balram Gupta versus Union of India.
Manoj, there is one judgment by this honorable court on the point of section 97. Not the, if the.
No, in general, whether resignation can be withdrawn, there are 2 circumstances.
Correct.
Once resignation is given, it can be withdrawn on 2 dates. One before acceptance, one before the intended date of relieving.
Correct.
See, you say, I want to retire on the 30th of January by giving on 1st of January. Before 30th of January, you can withdraw it.
Can withdraw.
Even if you even if it is accepted. So in a contract that is not permissible, under a scheme, if voluntary retirement scheme, it is accepted, it is closed. This is not a scheme.
Correct.
This is resignation which you can withdraw. That's why, apart from 97, you should bring in these judgments. Right, Balram Gupta, 1987.
The allegation of the petitioner is that, Manoj, resignation is forced. The reason is this, Manoj.
Forced is a different, you forget about forced, those are all realm of disputed questions of fact. Then we will not be able to go into. It's a plain and simple legal argument.
the
that
earlier
whether
to-
it can be withdrawn or not.
Yes, earlier to resignation, on 20th, I submit a representation to the DDPO stating that the management is forcing me to resign. After that, Manoj, on 23rd, on typed copy, a signature is taken. On the top of the resignation letter, Manoj, the date is mentioned, it's 23/11/2025. On the signature, Manoj, wherein I have signed.
All this is considered by the apex code. 97 effect Allah, but the general principle, general law is discussed in all these cases. One is Balram Gupta, 87 supplement, I think 538 or something, and Srikanta, Bemel versus Srikanta, the 2008 4 SCC. Everything you find in that.
Great.
Whether it can be withdrawn prior to the indented date. We'll take it tomorrow, just look into it. 97
It's
you have
not-
Kodi.
It's not tomorrow, my lords,
97.
Tuesday, may I check?
Section 97 ಯಾವ್ದು
Yes.
ಹೇಳಿದ್ರಲ್ಲ?
But so far as section 97 is concerned, that should be read with 2006 rules, my lords. Because 97(2) does not say who is the competent authority.
However, section 8 explains who is the competent authority under the Education Act.
ನಿಮ್ಮ ಅಪ್ರೂವಲ್ ಇಲ್ಲದೆ ಮಾಡ್ಬೋದಾ ಇದೆಲ್ಲ?
She
ಆಗಲ್ಲ
herself
ಅಲ್ವಾ?
has given your lordship resignation.
No, even if you say 97, section 97 ಪ್ರಕಾರ government has to put its seal ಅಷ್ಟೇ ಅಂದ್ರೂ, without that it won't come into effect at all.
Allah, there is section 97 mandates notice to governing council. That is not.
My lords, it may not be so. It may not be so, my lords.
Ah.
For this reason, rule 15 of the
Correct.
2006 rules appoints,
ಆಯ್ತು,
my lords.
ಅದು ಯಾವ್ದು ಕೊಡಿ, ಸೀನಿಯರ್ ಬೇಕಾಗಿಲ್ಲ, ನೀವೇ ಮಾಡಿ. Yes.
My lords. May I
Tomorrow.
seek for on Tuesday, my
You
lords?
be
Not
ready.
Tuesday, my lords.
Yes. No sir.
Bless. I'll be, no.
Yes.
I'll be.
You be ready, enough. ಅವ್ರಿಗೆ ಸ್ವಲ್ಪ ರೆಸ್ಟ್ ಕೊಡಿ.
Bless. I'll be ready.
Yes.
Sir, I'll be ready.
Yes.
Number 45, Mr. Mittal Court.
After vacation.
46.
ಮಿತ್ತಲ್ ಕೋಡ್ ಯಾವ್ದು ಏನಿದೆ?
Yes, I am here, sir.
You
Yes.
are ಮಿತ್ತಲ್ ಕೋಡ್.
Yes.
Yes. What is the case?
This case, the civil matter in arrest is pending before the Honorable High Court.
ಈ
It is
ಪ್ರಾಬ್ಲಮ್
pursued-
ಏನಾಗಿದೆ ಇಲ್ಲಿ?
After this, what they are doing is, police entered in land and they with bulldozers with parties. So that was,
ಏನು?
and thereafter, my lord.
ನಿಮಿಷ ತಡಿ.
My instruction.
ಪೊಲೀಸ್ JCB ಇಟ್ಕೊಂಡಿಲ್ಲ.
They are not interfering. I report is also, I secure the report.
Yes, after this
Sir,
order.
ಇಲ್ಲ ಅಂತ ಹೇಳಿದಾರಲ್ಲ, ನಾನು ಮಾಡಿದ್ದೀನಿ ಆಲ್ರೆಡಿ.
ಮಾಡ್ತಾ ಇಲ್ಲ.
There is an order here.
Yes.
The learned AGA on instruction submits that there is, the police are not interfering in the affairs of the land belonging to the petitioner and would undertake
Yes,
that
yes,
police will not
yes.
interfere
Yes,
in
madam.
future unless situation warrants. The submission is placed on record on the said
They
undertaking, the
are
petition stands
calling the
disposed.
party station, asking them to threaten their dispossess. Jameen biಟ್ಟು ಕೊಡ್ರಿ ನಿಮ್ದೇನಿಲ್ಲ and they are doing it in police station.
Judgment.
ಅಲ್ಲ, they are calling parties, you give the land to them, dispossessing.
Calling parties give the land.
No, that.
ಅಲ್ಲ, ಅವರಿಗೆ they are calling it police station, threatening them to dispossess from the land. That's
They
it.
will not call the police station, don't worry. Yes, undertaking given.
Yes.
Interim order will continue. ಎಲ್ಲದರಲ್ಲೂ interim order ಇದ್ರೆ, ಇಲ್ಲದೆ ಇದ್ರೆ ಅದೇ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
Number 46, Balbi Patil.
After vacation. Yes. Interim order ಇದೆಯಾ?
47, Jagdish Patil.
Petitioners.
Short
Flood
point-
affected areas.
short point ಇದ್ರೆ ಹೇಳಿ, ಇಲ್ಲ ಅಂದ್ರೆ after vacation. ತುಂಬಾ ಇದೆ ಮಾಡಕ್ಕೆ.
Noted, yes. Immediately after vacation.
Just immediately after vacation. There I will not be
For
able
your
to leave.
observation also, they have not found, on 17/11, the lordship observed the
ಅಂತದ್ದೇನಾದ್ರು ಇದ್ರೆ
direction ಕೊಟ್ಟಿದ್ರು ಅವ್ರಿಗೆ, verify ಅಂತ. Last
ಕೊಡಿ,
3-4 times they have taken time.
ಬನ್ನಿ, ಏನದು ನೋಡ.
Whether the allotment has, 17/11 your lordship, that is. Seek instructions ಅಂತ ಹೇಳಿದ್ರು.
List the matter on Monday in the fresh matters list. In the event no instructions come about, this court would be constrained to allow the petition. Yes.
48, Sukumar Ispatvadi.
Like to appear for the petition.
Departmental inquiry.
Case of suspension.
Suspension.
Let's have stayed it.
Stay ಇದೆಯಾ?
Let's have passed an order of interim order on the last.
Any order is it?
ಹೌದು.
2023 ನನ್ನ order.
ಹೌದು. ತಾವೇ ಮಾಡಿದ್ last.
Interim order is there.
Let's, while passing the order of interim order dated 4/9/2023. Let's, it's a case of, let's, malafide exercise done by the
Detail order.
ZP. Yes.
Yes. ಮತ್ತೆ ಬಂದಾಗ dispose ಮಾಡಿ.
ಅಲ್ಲ, 2 ನಿಮಿಷಕ್ಕಿಂತ ಜಾಸ್ತಿ ಆಗಲ್ಲ ಅದಕ್ಕೆ.
Yes.
Let's, the petitioner, let's pursuant to annexure A order. Direction was issued to the petitioner to consider representation pass orders. Let's say she has written, the petitioner is a Panchayat Development Officer. Let's say she written in a letter to the, let's the Taluk Executive Officer stating that, let's the appointing authority is ZP, not the Panchayat PDO, to appoint any employee to the Gram Panchayat. But the Executive Officer, let's insisted you have to pass an order in pursuant to the order passed by High Court. Let's Gram Panchayat passed resolution and they have appointed. Said appointment was refused by the person who approached the sample court. Let's see, correspondence was taken place between, let's the Taluka Executive Officer, Jilla Panchayat and petitioner. Lastly, let's the Jilla Panchayat CEO passes an order holding that, let's the conduct of the petitioner is against section 10 of, let's KCSR rules. That is totally, let's
Dereliction of duty.
yes.
Panchayat has passed the order, your lordship, R3. We are.
Interim order ನೋಡಿದಿರಲ್ಲ? ನೋಡಿಲ್ವಾ? ನೋಡ್ಬಿಡಿ ಸರ್. ಇದಕ್ಕೆ solution ಕೊಡೋಣ. B group ಅಲ್ಲಿ ಹಾಕ್ಬಿಡೋಣ. Post the matter in B group. Interim order subsisting will continue till the disposal of the petition.
Now by virtue of, let's the suspension order, case is not considered for next promotion. That's the reason, let's.
Oh, DPC ಯಾವಾಗಿದೆ? The petitioner is at liberty to move the matter in the event the departmental promotion committee would meet for consideration of the case of the petitioner for promotion. ಅಥವಾ ಹಿಂಗ್ ಮಾಡೋಣ. The learned counsel appearing for the petitioner submits that the case of the petitioner is not considered will not be considered. Charge sheet issue ಮಾಡಿದಾರಾ?
Charge sheet ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೊಟ್ಟಿ
We have given reply also.
ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ ಇಲ್ಲಿ.
ಇಲ್ಲ, ಅದನ್ನ charge sheet minutes, they have issued articles of charge. We have submitted reply.
Is that under challenge here?
No, suspension is under challenge.
ಅದೇನ್ ಮಾಡಿದ್ರಿ?
ಅದ್ರ ಮೇಲೆ ಏನು ಆಕ್ಷನ್ ಆಗಿಲ್ಲ, ಅಷ್ಟೇ ಇದೆ.
ಮತ್ತೆ ಅದು ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕಲ್ವ? ಕಷ್ಟ.
We will file it.
ಹೋಗೋದ್ರೊಳಗೆ ಮಾಡಿದ್ರೆ ಮಾಡ್ಬೋದು ಅಷ್ಟೇ. ಟ್ಯಾಗ್ ಮಾಡ್ಬೇಡ. Yes. Same, post the matter in B group. The petitioner is at liberty to move the matter in the event of need. The need would be if the case of the petitioner is not being considered for promotion on the strength of the pendency of the subject petition.
Number 49, Sadikin Gudwala.
Petitioner.
Annexure B, my lord, authorization was given in favor of.
Interim order ಇದೆಯಾ?
Interim order ಇದೆ. In view of this, my lord, regard to monopoly and locus standi.
Alternately,
Para 11, my lord, this honorable court took a view that it should not be a monopoly or should.
ಅದು ಗೊತ್ತು 500 800
Lordship may say that, my lord, annexure B was given to, my lord, some society. That I challenged it.
ಸ್ಟೇ ಇದೆಯಲ್ಲ
ಇದೆ.
ಮಾಡಿದೆ ಕಂಟಿನ್ಯೂ ಆಗಿದೆ.
All in view of this is the dispose ಮಾಡಬೇಕು.
Petitioner ಅವ್ರು ಹೇಳಿದ್ರೆ ಕ್ಲೋಸ್ ಮಾಡ. Petitioner is before this court seeking the following prayer. The coordinate bench, owing to the fact of illegality prima facie projected in the order, had passed an interim order which reads as follows: 22/9/2023. Later, another coordinate bench in identical circumstances has passed the following order. The learned counsel appearing for the petitioner submits that the issue in the list stands completely answered by what the coordinate bench has held. The learned AGA is not in a position to dispute the findings of the coordinate bench as it is in tune with the PDS control order. The coordinate bench has directed that in terms of the PDS control order, the fair price shops in the rural area should be at 500 and the urban area should be at 800. That is drawing from the PDS control order 2016. Therefore, I deem it appropriate to follow suit, i.e. by following the judgment of the coordinate bench in so and so, by granting the same relief to the petitioner, ordered accordingly.
50, Yogesh Manohar Desai.
I am appear for petitioner this case, my lord.
Yes. Next.
Monday, my lord. Monday post, my lord.
ಏನಿದು?
Nando ಮತ್ತು grant a permission under section 197 of CRPC, my lord.
Sanction?
197 permission ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
ಆಯ್ತು after vacation.
Monday, please, my lord.
No, sir. ಮಾಡ್ಲಿ ಯಾರು? Yes, next.
51, C.R. Bhaskar.
After ಇಲ್ಲದೆ ಇರೋದನ್ನೆಲ್ಲ
for the petitioner, my lord.
Interim ಮಾಡಿದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿ. Yes.
There is no interim order, my lord.
That will also continue.
Did become infectious, my lord. Since
Why, sir?
Did become infectious, my lord.
Why, sir?
The petitioner has challenged the appointment of fourth respondent, my lord. Petitioner has challenged the appointment of fourth respondent, my lord. Already fourth respondent is retired.
Right.
Appointment challenge ಮಾಡಿದ್ದಾರೆ, promotion.
ಅಲ್ಲ, Dean, our director of the KIMS.
Income director. The petitioner is before this court seeking the following prayer. The learned counsel appearing for the respondent submits that the challenge in the case at hand is to the appointment of the petitioner, appointment of the
respond number 4.
Respond number 4 as the income director of
respond number 5 institution.
Of the respond number 5 institution. The learned counsel for the respondents in unison would submit that the income director has retired from service on attaining the age of superannuation. Yes. In the light of the said subsequent development, the challenge to the appointment of the fourth respondent to the fifth respondent institute has become academic. Therefore, the petition is disposed as having become academic or infructuous as the case would be.
Please, much.
Kind lordship, may I make my submission, my lord? It was my persistent prayer to the honorable court and continuously, even the observation made at page dated 20th September 24 itself may be looked into. How the illegal appointment was continued. And my second prayer was to issue the necessary mandamus to the respondents to appoint me as the income director in violation of the C&R rule as well as the bylaw of the institute. The fourth respondent was clandestinely appointed. My eligibility has also been recognized by the fourth respondent himself. Please, my lord,
eligibility returned back under document ado.
ಅಲ್ಲ ನನ್ನ ಎಲಿಜಿಬಿಲಿಟಿ ಇದೆ ಅಂತ ಅದನ್ನೇ ಒಪ್ಪಿದ್ದೇನೆ ಕೂಡ, ಬಟ್ ಸ್ಟಿಲ್ ಹಿ ವಾಸ್ ಕಂಟಿನ್ಯೂಡ್. ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್,
ಈಗ ಒಂದ್ ನಿಮಿಷ, ಈಗ ರಿಟೈರ್ ಆದ್ರೆ ಏನ್
ಅಗೇನ್ Yes, yes, this is why, this is the reason why I had persisted, my lord, before kind lordship, several times it was taken up, for around 7 times it was matter was taken up on board. My lord,
What
please
can be
look into the memo dated 19.
What can be done?
New incumbent has, my lord, my submission with the liberty may also be accorded, at least my liberty be accorded, because, my lord,
Liberty for
99,
what?
2024,
Liberty
for
for what?
challenge, new person has been appointed as a in charge, my lord. A new person has been appointed in the place of court respondent as in charge.
If you want to challenge, sir.
My lord, see, there is no notification as such. The very notification issued was for appointing the applicants who had
If the new person is appointed, please challenge it if you want to challenge. Yes.
Please, ma'am.
Next.
My lord, I have not been invited. See, my lord, the procedure adopted by them is that, my lord, the interview was supposed to be conducted, notification was annexure B was issued. That conditions themselves was violated by the fourth respondent in collusion with this. Then still they have not yet appointed any of the candidates as a permanent income director. Now again the new incumbent, that's one Dr. Purnima, has been appointed on the basis of in charge. So once she is being continued even until today as in charge. But bylaw says hardly for 6 months a candidate can be appointed. But in violation of that as well, so far the bylaw is concerned, they are continuing.
New dean, my lord. New dean is appointed already.
Alala, she's a party here.
No, not my lord.
Yes. Next. Court has no time to waste.
Please, my
Yes,
lord,
next.
in order to enable me to challenge that, at least liberty may be
Next,
accorded, I will
please.
challenge that appointment as well.
You want whatever you want to do. Yes.
Ramesh P. Chigri, 52.
Please, my lord, please.
Lordship, here in this case, my lord, I am for respond number 5. My lord, I have filed, my lord, before the tribunal with respect to, my lord, for a maintenance. That was, my lord, I have made a
Senior citizen.
senior citizens.
ಏನಾಗಿದೆ ಈಗ?
Now, my lord, he is on a deathbed. Nobody is taking care with respect to
Why,
that.
what has happened?
Now, my lord, in this case, my lord, interim order is passed against the order of a deputy commissioner. Respond number 2.
What is the deputy commissioner done?
The deputy commissioner order is that, man, setting aside the gift deeds passed, my lord, gift deed with respect to, my lord, the petitioners.
Correct. Gift deed ಹೋಗ್ಲಿ ಬಿಡಿ.
That against that order, interim order is passed by the
Correct. Supreme Court covered ಏನ್ ಮಾಡಕ್ಕೆ?
covered, but he has given a lot of police complaint to the with respect to that, because at the time of a paralyzed stage, my lord, they went.
Adella will consider. Will direct maintenance to be given.
Now he is on a deathbed. Nobody is
Correct. He will
taking
take care, sir. ಇಲ್ಲ ಅಂದ್ರೆ gift deed annul ಮಾಡ್ತೀನಿ. Will reverse the order ಅಂತ ಹೇಳೋಣ. But ಬರ್ಲಿ ಅವರು. There is no representation. We have the petitioner list tomorrow in the fresh matters list.
Please.
Number 53.
In the event there would be no representation, appropriate orders would be passed.
Please, my lord.
ಅಲ್ಲ, interim order would get automatically vacated ಅಂತ ಮಾಡಿ. Yes.
53, regarding my lord's appointment to the post of library supervisor.
Regularization.
Alla. Appointment, fresh appointment. One of the criteria that the candidate should have library science certificate. I have a master's in library science, page number 26.
ಸರಿ, ಏನು ಹೇಳಿ?
The private respondent who does not have a library science certificate have been selected. And I have been placed in the second preference.
Lordship, in this, Lakshman T. Matagan is no more longer the panel member for Jilla Panchayat.
Paralla sir, who has to defend the action?
Private respondent number 7.
ಯಾರು? ನೀವು ಅಪಾಯಿಂಟ್
ಅಲ್ಲ, they have been selected. Appoint ಆಗಿಲ್ಲ ಇನ್ನು.
ಮತ್ತೆ ಅಪಾಯಿಂಟ್ ಆಗಿದ್ದು ಯಾರು?
ಇನ್ನು ಅಪಾಯಿಂಟ್ ಮಾಡಿಲ್ಲ. This is a selection list I have challenged.
Objections he has filed.
Objections consider ಮಾಡ್ತಾರೆ.
ಅಲ್ಲ, objection ಎಲ್ಲ ಹಾಕಾಗಿದೆ ಅದರಲ್ಲಿ.
ಅದೇ
ಮಾಡಿ
objection
final list
consider
ಮಾಡ್ತಾರೆ.
With that observation,
Petitioner is
it's a
before
prima
this
facie
court
illegality.
seeking the following prayer. The petitioner is before the court calling in question a provisional select list so notified in which the name of the petitioner does not figure but name of
my name is figures in the second priority.
The name of the petitioner figures below the candidate who does not have the qualification.
Library science.
Qualification of library science. The post advertised is for the of the library supervisor, to which the qualification is bachelor and master's.
Certification course in library science.
Certificate course in library sciences. The petitioner claims that he has, and the candidate who is at serial number 1 does not have. Therefore, the selection should go in favor of the petitioner. The selection is yet to come about. The petitioner has only filed his objections. The respondent stated it is Needless to observe that the respondent state will consider the objections of the petitioner and notify a select list after the select list as the allegation is the person at serial number 2 does not, the serial number 1 does not possess the certificate in library sciences hyphen a requisite qualification for appointment to the post of library supervisor. With the aforesaid observations, the petition stands disposed.
Grateful.
Well, earlier, another candidate challenged the same order. The honorable court has disposed of it with the direction that final list should be prepared.
You prepare agidya?
Agila.
Consider the objection
Agila.
same order.
That is between the final, before the selection committee, not before the honorable court.
Final list honorable court ಅಲ್ಲಿ ಇರುತ್ತಾ selection committee.
No, observation.
ಇದು
it
same
should be kept
observation. Yes,
open.
next, please.
Grateful, my lord.
Lords, based only on the direction from the joint director to the institution, my lord's institution has withheld my salary, my lord started recovery
Yeah, yes, sir.
from 2013, my lords. My lords, kindly annex.
From 2000 May.
2023 October.
Yes, madam, salary ಕೊಟ್ಟಿಲ್ಲ.
The time of training period, payment has been done. Your Worship.
Terminated ಆ?
Training
period.
time ಅಲ್ಲಿ ಕೊಟ್ಟಿರೋ salary ಅದು.
ಆಮೇಲೆ ಕೊಟ್ಟಿಲ್ವಾ?
ಅಲ್ಲ, that subsequently, Your Worship, I will verify, but
Learned
at the time.
HCGP to secure instructions with regard to non-payment of salary list on Monday in the fresh matters.
Please.
Yes, next.
55.
My lord, I undertake to appear for the respondent in this matter, my lord.
My lord, so I'm for the petitioner. There's a petition for appointment of an arbitrator.
ಏನ್ ಕ್ಲೋಸ್ ಮಾಡದ?
My lord,
Consensus candidate ಇದರ? Yesterday you appeared on VC.
Yes.
Same
Not
matter,
on,
is it?
not on VC, my lord. I had come here last week.
Oh, sorry.
And-
Same matter, is it?
Yes.
undertake to
You're from
appear for
Bombay.
the respondent, my lord.
Ah.
Lord, I do not have the benefit of the file. It may be, a date may be fixed, my lord.
Don't worry, sir, you take the benefit of the order.
My lord, a very simple issue that two work orders. An arbitration clause is identical in both the work orders. I'm requesting for appointment of an arbitrator.
We'll do it. You ready?
Lord,
We'll take it tomorrow then. Or Monday.
Monday.
You appear online, no issue.
Yes, much obliged. Much obliged.
Bombay to Belgaum is not far, but anyway.
Yes,
appear
yes.
online.
But yes, it's a part of education to be in front of your honor. So
Oh,
I would
yes,
love to. Much obliged.
List on Monday in the fresh matters list. Yes. We'll close it. EMP stay.
Yes, I would be grateful. Yes.
Here for petitioner, not the petitioner and respondent 4 and 5 joint owner of the property bearing ceremony 650. ಅಲ್ಲ ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಮಲಾಡಿ when suit is pending, objection is pending, the third respondent release entire amount in favor of the fourth respondent. Title dispute is there. Acquisition made by the third respondent. Acquisition ಮಲಾಡಿ India
Accusation ಅಲ್ಲ, acquisition.
Acquisition. ಮಲಾಡಿ India 2023. Suit ಮಲಾಡಿ 2023.
Acquisition first, suit first.
ಅಲ್ಲ suit in the secondary, but they filed objection. Suit for partition. They are joint owners.
Family members.
Family members.
Acquisition ಆದ ತಕ್ಷಣ family members.
There after filing the objection.
ಒಬ್ಬರನ್ನೊಬ್ರು ನೋಡ್ತಾನೆ ಇರಲ್ಲ.
ಅಲ್ಲ ಒಬ್ಬರಿಗೆ ಎಂಟೈರ್ ಅಮೌಂಟ್ ರಿಲೀಸ್ ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ.
ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ ಸರ್? ನೀವು ಸೂಟ್ ಮುಂಚೆನೆ ಹಾಕ್ಬೇಕಾಗಿತ್ತು ಪಾರ್ಟಿ.
ಅಲ್ಲ ದೇವರ ಅಬ್ಜೆಕ್ಷನ್ ಮಲಾಡಿ ಟೈಟಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆ.
ಟೈಟಲ್ ಡಿಸ್ಪ್ಯೂಟ್ acquisition ಆದ್ಮೇಲೆ ಬಂದಿದ್ದಲ್ಲ. After vacation, yes.
57. In so far fourth respondent is concerned, notice ಮಲಾಡಿ not.
R4 ಏನು?
R4 is a contesting respondent.
Notice ಆಗಿಲ್ಲ.
ಅದೇ ಏನು ಗೊತ್ತಾಗ್ತದೆ.
Emergent notice to the fourth respondent returnable by the 9th of January 2026. Yes. Iದೇನು office objection accepting the submission of the council, que office objections overruled. Yes. ಅದೇ ರಿಲೀಫ್ ಇವತ್ತು.
57.
Writ of mandamus 57 filing report my lords as per the
ಏನ್ ರಿಪೋರ್ಟ್?
order was passed. By order dated my lords 27/3/24 this honorable court directed
charge sheet ಹಾಕಿದ್ದೀರಾ? The petitioner is before this court seeking the following prayer. The learned independent agency charge sheet ಹಾಕಿದ್ದಾರೆ, ಆಮೇಲೆ ನೋಡೋಣ. The petitioner cyber police ಯಾಕೆ?
Online fraud will of 40 lakhs is online.
The learned counsel, learned AGA on instructions would submit that the that the police have filed a charge sheet before the concerned court and when the matter is pending acceptance before the concerned court. Yen marriage? Oh, marriage fraud.
No, my lord.
ಇನ್ನೇನು
Online,
ಶಾದಿ.com
40 lakh rupees of online fraud.
ಶಾದಿ.com ನೀವು ಶಾದಿಗೆ ಮುಂಚೆನೆ 40 ಕೊಟ್ಬಿಟ್ರೆ ಇನ್ನೇನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? 40 ತಗೊಂಡು ಮರೈನ್ ಇಂಜಿನಿಯರ್ ವೆಂಟ್ ಆಫ್ ಮರೈನ್ ಸಿಗ್ಲೇ ಇಲ್ಲ ಆಮೇಲೆ. ಶಾದಿ.com ಅಲ್ಲಿ ದುಡ್ಡು ಕೊಡಕ್ ಮುಂಚೆ ಕರೆಕ್ಟ್ ವೆರಿಫೈ ಮಾಡ್ಬೇಕು. ಬ್ಲೂ ಟಿಕ್ ಬಂದ್ರೆ ಮಾತ್ರ ವೆರಿಫೈಡ್. ಎಸ್
DAG ವಿಜಯ್ ಕುಮಾರ್
ಏನದು?
ವಿಜಯ್ ಕುಮಾರ್ ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್.
ಓ ಬಂತ? ಎಸ್ ಎಸ್ ಇದು disposed with therefore in the light of the charge sheet being filed before the jurisdictional before the competent court before whom the matter is pending, reserving liberty to the petitioner to avail of such remedy as available in law, the petition stands disposed.
So 60, SM Kalwar.
Next week. Just after vacation, please.
Seeking writ of mandamus, my lord. Acquisition proceedings already been dropped, my lord. To that effect.
To be dropped.
Dropped. No, they have,
already dropped.
SLU has written letter to the.
Verify, my lords, next week.
Vacation.
So next week, my lord.
Yes, next.
So the 61, Vijay Kumar, PB.
After vacation, yes. Next.
62.
Request on next week, man. Next. Pension benefits.
Yes.
It pertains to pension benefits.
Maybe, yes. Next.
62, Sima Isnaik.
Regard to the compassionate appointment, your lordship, in the previous occasion, your lordship asked us to verify whether this reported judgment of this honorable court is applicable to the central act also, your lordship. There is no bar.
They had relied on some judgment.
Reported judgment.
Passed by the court and bench, whether a dependent brother can be given a compassionate appointment.
Dependent brother.
Can be given, your lordship. There's reported judgment in the previous occasion also, your lordship.
Family ಗೆಲ್ಲ ಕೊಟ್ಬಿಡೋಣ.
Allah, ಅವ್ರಿಗೆ
Reported
ಕೊಟ್ಟಿರೋದೇ
judgment ಇದೆ.
the wife was given.
Let me submit it. I'll take 2 minutes, your lordship.
Yes.
His lordship
We
was
have been
asking-
college mates and mooters together, your lordship.
Mooters. Oh, mooters. Sorry.
Same college. Your lordship, I'll wind up in three minutes, your lordship.
You moot it off, madam. Yes.
Lordship, there's an reported judgment of Justice Suraj Govindraj, your lordship, where it says, I have already produced it in the
That
last
brother
occasion.
also can be given.
Yes, it can be given, provided he takes an undertaking, your lordship, in the judgment, your lordship, para 8. In that view, if I am of the opinion that petitioner number 2, having undertaken to take care of petition number 1, the mother, the application of petition number 2 for appointment on compassionate basis ought to have been considered by the respondent in a proper prospect.
Unmarried brother, family definition ಏನಿದೆ?
ನಮ್ದ್ರಲ್ಲಿ settlement ಇದೆ. In settlement, if the deceased was unmarried, then dependent brother had a right.
He was unmarried.
No,
married.
Israel married. She was given
Died
employment after
issueless,
the
your
death of
lordship.
husband.
Died issueless, your lordship, and in view of this reported judgment of the honorable court, your lordship, Justice Suraj Govindraj had asked us to file affidavit of the mother and the petitioner here in your lordship by order dated 4/9/2024, and we filed an affidavit on 23/09/2024.
ಎಲ್ಲಿ ಕೇಳ್ತಾ ಇದ್ದೀರಾ ಇದು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಇಲ್ಲಿ?
ಇದು this is a central government undertaking, HL. Hindustan Latex Limited.
ಅದರಲ್ಲಿ ರೂಲ್ಸ್ ಏನಿದೆ?
Rules ಇಲ್ಲ. There's a settlement arrived at between the union and the millets.
All right. What are the terms of settlement?
The terms of settlement says, if a deceased, if your lordship sees, I have produced a copy of the settlement, page 33 millet. In that, dependent brother or dependent unmarried sister would be eligible only in case of unmarried deceased employee. Now she was married after the death of husband. Husband was working with us. After his death, she was given a compassionate appointment. Now she passed away, her brother claims.
And she died issueless, your lordship.
ಇದು ಸೆಕೆಂಡ್ ರೌಂಡ್.
ಹೌದು. 12(3) minutes, one settlement is arrived under section 12(3) of the ID Act. It is binding on the parties. Unless that is, let's challenge in the manner known to law. Since it's a settlement, they can't challenge it.
If the employee had died unmarried, ಅವಾಗ brother comes in.
Yes.
ಈಗ ಈ ಕಂಪಲ್ಷನ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಇದು ಇಶ್ಯೂಲೆಸ್ ಈಗ ಅವರು ಇಲ್ಲ.
Our issue, Allah, in terms of the award, deceased should have been unmarried. Then brother was entitled to.
ಇದು ಐಡೆಂಟಿಕಲ್.
please, your lordship. Yes, your lordship.
ಅದು
Para
ನಮ್ಗೆ
six.
apply ಆಗಲ್ಲ. There was, it's
ಆಗ್ತೈತಿ.
KSRTC.
No, no, there's no separate law, union law, central law for compassionate appointment, your lordship. Para 8, your lordship, page number 5. Reported judgment says it can be given.
ರಿಪೋರ್ಟ್
your
ಗೊತ್ತು
lordship.
ಮೇಡಮ್, ಸರಿ ಹೇಳಿ.
Can be given, your lordship. And then there's a proviso in their act, it's in
Judgment
their
is a
settled.
judgment, whether it is reportable or non-reportable, yes.
This is a cause for me, your lordship, not a case.
Cause?
This is a cause for me. This
No
person
action.
this person has suffered bomb blast with 76% leg injury, your lordship. Most
No,
of my.
sympathy cannot give
Allah,
appointment.
ashte,
Compassion can give you, but
Please,
not
your lordship,
sympathy.
in their scheme, your lordship, all that they say is, if there is an undertaken given, your lordship, for, it can be considered in their objection, page 33, your
Not
lordship.
agreeable. ಒಂದ್ಸರಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಕಂಪ್ಯಾಷನ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್.
That closes, your lordship. This is a new.
New
Because, all the terms and conditions are different for the new employment, your lordship.
Oh, no.
Some consideration, your lordship. Judicial activism is what.
Activism, I don't want to be active.
Judicial compassion is what she can.
No, sir. ಕಷ್ಟ ಮೇಡಮ್. ಅದಕ್ಕೆ ಜನವರಿ 5th ಹಾಕ್ತೀನಿ.
Date bad, your lordship. We'll move the matter.
ಜನವರಿ 5th ಡೇಟ್ ಬೇಡವಾ?
ತಾವು ಇದ್ದಿದ್ರೆ I would have said.
ಸುರತ್ ಸಾಹೇಬ್ರು ಬಂದ್ರೆ.
Lordship can reserve, your lordship.
ಓಯ್ ಬಿಡ.
What more better judgment I would have got, your lordship, other than
See,
from your part.
compassion appointment, correct.
ಅಲ್ಲ, ತಾವು ಮಾಡಿದ್ರು, I think I leave it to your lordship.
Difficult, we'll see. ಮಲ್ಲಿಕಾರ್ಜುನ್.
I tried, there's no, it's
ಏನಾರು ಆಗುತ್ತಾ?
ಇಲ್ಲ, ನಾನು ಕೇಳಿದ್ದೀನಿ. She had requested me twice, I spoke to the management. There's no possibility.
Classmates.
Before this.
No, he's younger to me by 10-12. He's my younger brother's
10-12
classmate.
years.
I went to law college very late, your lordship.
The college ಅಲ್ಲಿ ಅಷ್ಟೇ, but otherwise she is my young.
He's senior to me in college, but 12 years younger to me in school. His father and my father are
ಕೇಸ್ ತೀರ್ಮಾನನೇ
childhood.
ಮಾಡಕ್ಕಾಗಲ್ಲ. Peculiar facts, ಇದು ಅರ್ಥನೇ ಆಗಿಲ್ಲ ನಂಗೆ.
No, I requested.
Senior to you in college, younger to you by 12
I
years.
was in Delhi preparing for civil services. I was 35 when I became a lawyer, your lordship. They were very young. They were 22 when they became lawyers. So my younger brother, schoolmate and classmates, your lordship.
ನಿಮ್ಗೆ
So I requested, I chewed his brain also, your lordship, do something.
do something.
I said, ask, talk to your party, I told him.
There's no possibility. I tried.
Because I feel, your lordship.
There's no provision.
Government
to
is
enable
never
us-
against the people, your lordship. It is a bureaucratic wrong where we come to the court. I said, speak to your bureaucrats. You could, when I was a government pleader, I've done enough exercise with the bureaucracy, your lordship. And they do budge, your lordship. They do budge.
Enough exercise with
I
this.
come from a political background. I know the government is never against the people, your lordship. Your lordship may do, take it as part heard, your lordship. Part heard, your lordship. Tamminda bandre, anything is amruta. I don't know if I have to tell you, your lordship, my adoptive father, Justice MNV, has praised you so much, your lordship. He was so much of praise for your lordship. Apart from this, your lordship may take it as part heard, your lordship. Whatever.
ಅಲ್ಲ, I did not say anything. Please.
Part heard, madam. Part heard, madam, your lordship. Again, this tension continues for much. 63. Much.
Respond number 2 and 3. Get the instruction and file my objection. 63.
64, Ramchandramani.
Appear, my lord. Petitioner. This is my lord, promotion from the post of associate professor to professor. My lord, in the Department of Plastic Surgery in the secondary.
Jimsa.
KIMS. Now, my lord, he, as on the crucial date of my lord DPC 13/3/2024, he was the only associate professor, my lord, and one post of my lord the professor was vacant as on the date of my lord DPC.
His, my lord, credentials were, my lord, placed before the DPC. DPC assesses, recommends my name, my lord, for promotion, puts a rider saying that financial department approval has to be obtained for the purpose of, my lord, issuing the
Vacant post ittu ತಾನೆ?
vacant
Cadre post ತಾನೆ?
cadre post, sanctioned post.
Finance department ಯಾಕೆ ಬೇಕು?
That is what, my lord, DPC puts a rider only in respect of these two cases.
No, why? ಆಮೇಲೆ
My lord, as many as 45 departments, my lord, DPC was conducted.
What happened to the rider?
Rider, my lord, Kim submits to the government saying that since DPC has required finance department approval, it may be granted. Government says, why are we asking this approval only in respect of this petitioner? Why are you treating this differently in respect of the petitioner? Your lordship may kindly take the government, my lord, correspondence.
ಆಯ್ತು ಹೇಳಿ ನೀವು ಅದೇನ್ ಬೇಡ ಹೇಳಿ.
So this is, my lord, only with a view to victimize. Now what it does is, subsequently after 1 year, my lord, again conducts a DPC in respect of these two petitioners, now gives promotion 2025. Whereas in respect of 2024 DPC conducted with that rider, those who were, my lord, recommended along with me, they got promotion since 2024. Only in respect of these two petitioners, deliberate attempt of, my lord, victimization.
ಅಷ್ಟೇನಾ? No adjournment.
No, some other advocate is appearing for.
No passover.
No, my lords. My senior name may kindly be deleted, my lords.
ಅಷ್ಟೇನಾ ಸರ್? ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ?
GB Patil is appearing now.
ಗೋಪಾಲ್ ಬಿ ಪಾಟೀಲ್ ಎಲ್ಲೋ ಇದ್ರಲ್ಲ ಎಲ್ಲೋ? ಅರವಿಂದ್ ಕುಲಕರ್ಣಿ ಇಲ್ವಾ?
Not appearing.
The petitioner is before this court seeking the following prayer. Heard so and so. The petitioner secures employment in the Karnataka Institute of Medical Sciences and Research Center, initially as an assistant professor. Having regard to his qualification, experience, and in terms of the guidelines of the Medical Council of India, Medical Council of India gets promoted to the post of associate professor. The next higher cadre to the post of associate professor is, for the post of assistant professor is, professor guy,
Professor.
Is professor. Professor in the department of
Plastic surgery.
Plastic surgery. Owing to the eligibility and seniority of the petitioner, the departmental promotion committee meets. The departmental promotion committee considers the case of all the persons, finds this petitioner also eligible to be promoted to the cadre of professor, but adds a postscript. The postscript is in the nature of a rider which says that the concurrence of the finance department is necessary to grant promotion to this petitioner. The same was the shara indicated in Que, another post. In the light of the DPC indicating that the that the concurrence of the finance department would be necessary, the file is then placed before the state government. The state government appears to have expressed shock that only these two posts are referred to the finance department while others are not, and declines to comment on the same. By this jugglery of correspondences between the institute and the government, a year passes by. Another departmental promotion committee meets in the year 2025, considers the case of the petitioner, now grants promotion, now recommends for promotion to the post of professor without any rider. The petitioner thus gets promotion in the year 2025, notwithstanding his eligibility and entitlement of the year 2024. The promotion in the year 2024 is denied only on the score of a postscript added as a rider that the finance department's concurrence was required. If it was not required in 2025, it is ununderstandable as to why it was required in the year 2024. The government having not interfered with the very rider of the finance department's concurrence to a finding of the recommendation of the departmental promotion committee, unless exceptional circumstances exist, is outlandish. The learned counsel Gopal B. Patil is not present to defend the action, which prima facie is indefensible. List the matter tomorrow in the fresh matters list.
Great.
For 65U, SM Karnataka.
After vacation, ಇಲ್ಲರದಲ್ಲ ಆಗ್ತದೆ.
Seeking direction to the respondent number 2, my lord.
ಕಾರಣ
The termination already stayed by this honorable court, my lord.
ಸ್ಟೇಡ
Stayed by.
ವೆಕೆಟ್ ಮಾಡ್ಲಾ?
Allah, in person to that, my lord, she is given representation to for reinstatement that application not been considered.
ಏನ್ ಅಪ್ಲಿಕೇಶನ್ ಸರ್?
In person to the stay of the termination order, my lord, she has given an application for reinstatement, my lord.
For reinstatement.
Termination has been ordered, my lord, without holding any inquiry.
ಸರ್ ಟರ್ಮಿನೇಷನ್ ಸ್ಟೇ ಆಗಿದೆ.
Stay.
ಆದ್ಮೇಲೆ ವಾಪಸ್ ಯಾಕೆ ಕರ್ಕೊಳ್ಳಿಲ್ಲ?
4/10/2024 it has been stayed. Several representation has been.
Date.
4/10/2024, my lord.
4/10/24.
2024.
The petitioner is before this court calling in question an order of termination. The termination of the petitioner was without any inquiry. Therefore, the coordinate bench has granted an interim order on 4/10/2024. Notwithstanding the order of termination being stayed, the petitioner is not being taken to duties, is the allegation. The learned HCGP to secure instructions as to why the petitioner has not been taken back to duties despite the order of termination being stayed, as the action of the respondent would fringe on the borders of contempt if they would not take the petitioner back to duties by the next date, 17th fresh matters. ಈಗ ತಗೊಂತಾರೆ. Consider the presentation ಅಂದ್ರೆ ಮತ್ತೆ
wherein it was stated. I will clarify. Your
Already this is
I will clarify, Your Lordship, but in my objections, we have stated, we have already reinstated, but I will get
earlier she was
clarification and.
terminated.
If not already reinstated.
Please.
If not already reinstated, pursuant to the interim order dated 4/10.
Please, Your Lordship.
No, till date she has not been in.
I will.
ನಿಮಗೆ
clarify.
ಹೇಳಿರಲ್ಲ
Please.
ಸರ್, ನಿಮಗೆ ಫೀಸ್ ಬಂದಿದ್ಯಾ? ಅಲ್ಲ ರೀಇನ್ಸ್ಟೇಟ್ ಆಗ್ಬಿಟ್ಟಿದ್ರೆ ಬರಲ್ಲ ಅದಕ್ಕೆ. ಏನ್ ಸರ್ ಇದಕ್ಕೆ ಅರ್ಜೆಂಟಾ?
Urgent ಅಂದ್ರೆ.
ಈಗ ಅರ್ಜೆಂಟ್ ಮ್ಯಾಟರ್ಸ್ ಯಾವ್ದಿದೆ ಹೇಳಿ?
ಇಲ್ಲ ಅದಲ್ಲ, ಇದು ಒಂದು ಮ್ಯಾಟರ್ ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್.
230 ಮೂಡ್ ಮ್ಯಾಟ್ರಾ?
ಅದಲ್ಲ, ಇನ್ನೊಂದು ಫ್ರೆಶ್.
ಯಾವ್ಯಾವ್ದು ಅರ್ಜೆಂಟ್ ಇದೆ ಹೇಳಿ?
Lord,
66, my lord, 66, my lord.
My lord, 66, my lord.
150.
No, my lord, 66.
ಆಯ್ತು, 66 ಅರ್ಜೆನ್ಸಿ. ಒಂದು ನಿಮಿಷ.
ಮೆಮೋ ಜೊತೆ ಒಂದು ಇಟ್ಕೊಡಿ. ಸ್ವಲ್ಪ ನೋಡಿ. ಮೆಮೋ my lord, next page. Next page.
ಏನು?
101, my lord.
ಇದೀನಪ್ಪ.
ಗೊತ್ತಾಯ್ತು ನೀವು ಇದೀರಾ ಅಂತ. ಆಫ್ ಮಾಡಿ ಸರ್.
ಶ್ರೀನಿವಾಸ್ ಅಲ್ಲ
ಯಾಕೆ?
9 advocates.
ಯಾವ್ದಕ್ಕಿದು?
ನಾಳೆ ಇದು ಧಾರವಾಡ ಹೈಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಅಸೋಸಿಯೇಷನ್ ಎಲೆಕ್ಷನ್.
ಏನಾಗಿದೆ ಈಗ?
10 advocates already.
ನಾಳೆ ಫ್ರೈಡೆ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಯಾಕೆ ಸಂಡೇ ಮಾಡಕ್ಕಾಗಿಲ್ವಾ?
ಯಾರು ಬರಲ್ಲ ಸರ್.
Advocates Association.
That is a difficulty in Dharwad. 10 ಜನ ಮಲೋಡ್ ರಿಸರ್ವ್ ಮಲೋಡ್ ಟಿಕೆಟ್ಸ್ ಮಲೋಡ್ ಉಜ್ಜಾಯ್. Their flight is from
8 ಗಂಟೆಗೆ ಮಾಡ್ಬೇಕಾ?
ಏನಿಲ್ಲ ಮಲೋಡ್, I am not taking.
ಯಾರು? ಹೂ ಇಸ್ ರಿಟರ್ನಿಂಗ್ ಆಫೀಸರ್?
ಕಾಯ್ಕಮಠ್.
ಎಲ್ಲಿ ಕಾಯ್ಕಮಠ ಕರ್ಕೊಂಬನ್ನಿ.
ಕರ್ಕೊಂಬರ್ರಿ.
One member.
ಅಲ್ಲ ಇದೇನು 8 ಗಂಟೆಗೆ ಮಾಡ್ಬೇಕದ್ ಮಾಡ್ಲಿ.
ಅಲ್ಲಿ ತಾವು ಮಾಡಿದ್ರೆ ಮಾಡ್ತಾರೆ, ತಾವು ಆರ್ಡರ್.
ನಾವು 10 ಜನ ಕೊಟ್ಟು ಹೋಗ್ತೀವಿ. ಆಫ್ಟರ್ ಇನ್ ದ ಈವ್ನಿಂಗ್ ಲೆಟ್ ದೆಮ್ ಕೌಂಟ್.
ಆಯ್ತು, ಕೌಂಟಿಂಗ್ ಚೇಂಜ್ ಏನಿಲ್ಲ, ಬರೀ ಬೆಳಗ್ಗೆ ಮಾತ್ರ.
ಅದೇ ಬೆಳಗ್ಗೆ ಮಾತ್ರ.
8 ಗಂಟೆಗೆ ಸ್ಟಾರ್ಟ್ ಆಗ್ಲಿ ಬಿಡಿ. ನ್ಯಾಷನಲ್ ಎಲೆಕ್ಷನ್ಸ್ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ, ನಿಮ್ದೇನ್ ಪ್ರಾಬ್ಲಮ್?
ಅವರಿಗೆ ಚೇಂಜ್ ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತಂದು
ಐ ವಿಲ್ ಡೈರೆಕ್ಟ್. ಇದು ಬಂದಿಲ್ಲ, ಪೆಟಿಷನ್ ಇದೆಯಾ ಇಲ್ಲಿಗ? ಮತ್ ಪೋಸ್ಟ್ ಆಗೋದು ಯಾವಾಗ? ತರ್ಸಿ, ಅಲ್ಲ ನಂಬರ್ ಮಾಡಿಸಿ. ಈವನ್ ಇಫ್ ಇಟ್ ಇಸ್ ನಾಟ್ ಹಿಯರ್ ಐ ವಿಲ್ ಪಾಸ್ ದಿ ಆರ್ಡರ್. ನಂಬರ್ ಒಂದು ಮಾಡಿಸಿ, ನಂಬರ್ ಮಾಡಿ ಲಿಸ್ಟ್ ಮಾಡಿಸಿ.
ಕಾಯಕ್ ಮಾಡ್ರಿ ಕರೀರಿ.
ಕ್ಲೋಸ್ಡಾ? ಎಲ್ಲಿ ಇವ್ರು ಕರೀರಿ, ತಗೊಳಕ್ ಹೇಳಿ. ಗೆಟ್ ದಿ ರಿಜಿಸ್ಟ್ರಾರ್, ಆರ್ಜೆ ಕರೀರಿ, ರಿಜಿಸ್ಟ್ರಾರ್ ARJ ಕರೀರಿ.
ಫೈಲಿಂಗ್
ಅಲ್ಲಿ ARJ ಹೇಳ್ತೀನಿ.
ಫೈಲಿಂಗ್
ARJ
ಪ್ಲೀಸ್.
Serial number 187.
157, my lords, 157.
230 ಮೋಡ್ ಮ್ಯಾಟರ್ ತಗೊಂಡ್ಬಿಟ್ಟು ತಗೊಳ್ಳ ಒಂದೇ ನಿಮಿಷ.
Please. Serial number 1.
ಸದಿಕ್ ಕೊಡ್ವಲ್ಲ.
Please, my lord.
ಏನಿದು?
My lord, proceedings under my lord, this honorable court directed. My lord, your lordship may direct Girish Ulliman need to take notice and will list it on Monday.
ಗಿರೀಶ್ ಹುಲ್ಮನ್ is directed to accept notice. ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು?
My lord, kindly see annexure H. my lord.
ಗಿರೀಶ್ ಮಂಡೇ ಹಾಕ್ತೀನಿ.
Please, my lord. Please, my lord.
ಕಾಪಿ ಮಂಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್. ಎಸ್.
Please, my lord. Serial number 12.
ಶಿವಾನಂದ್ ಮಾಲ್ಶಿ. ಶಿವಾನಂದ್. Election.
No, here, the delegation is been withdrawn without, my lord, the substantive reason.
ಯಾವತ್ತು election?
Election is on, my lord, Monday, 15th.
ಯಾರು? withdrawn by whom?
Withdrawn by the, my lord, the sixth respondent.
Who appears?
Lord, notice has to be ordered for sixth respondent.
ಅಲ್ಲಿ ಸರ್ವ್ ಆಗಬೇಕಲ್ಲಪ್ಪ.
ಅಲ್ಲ, ಯಾಕಂದ್ರೆ here what happens is your lordship kindly.
Why
see-
is it withdrawn?
No, that is what the reason. Lord, reason what they say is that Lord, this petitioner is not cooperating with the Lord, the sixth respondent. Your lordship kindly.
Cooperating?
Howdo, 44, page 44, the resolution is at page 45.
What do you mean cooperation?
Means that, Lord, he is not, Lord, he is not, Lord.
Not what?
Lord, he, your lordship kindly see, ಕಳೆದರು TAPMs ಇಂದ ನಮ್ಮ ಸಂಘಕ್ಕೆ ಹಾಗೂ ಸಂಘ ಸದಸ್ಯರಿಗೆ ರೈತರಿಗೆ ಗೊಬ್ಬರ ಅವಶ್ಯಕತೆ ಇದ್ದಾಗ ಹಾಗೂ ಇನ್ನಿತರ ಹಲವಾರು ಸೌಲಭ್ಯಗಳನ್ನು ಒದಗಿಸಲು ಇವರು ನಮ್ಮ ಸಂಘಕ್ಕೆ ಹಾಗೂ ನಮ್ಮ ಸಂಘ ರೈತರ ಹಿತಾಸಕ್ತಿಗೆ ಧಕ್ಕೆ ಉಂಟು. ಹೌದು.
The petitioner 1, 2, 3, 4 AGA.
Please.
ಕಾಪಿ ಉಂಟಾ?
Copy, sir.
I've served the copy.
AG's ಆಫೀಸ್ ಅಲ್ಲಿ ಇಲ್ಲಿ
ಅಲ್ಲ,
ಕೊಡಲ್ಲ.
ಇಲ್ಲ,
230 ಅಂದ್ರೆ ಕೊಡಲ್ಲ ಅಂತ. Yes. 6, 5 and 6 hand summons. Serve ಮಾಡಿ ಇವತ್ತೇ.
Please.
We'll list it tomorrow. The impugned order of cancelling the delegation of the sixth respondent shall remain state till the next date. ನಾಳೆ, tomorrow at 4 PM.
May I request hand delivery of the
order and delivery memo.
I'll
ಕೊಡಿ. ನಾಳೆ ಸರ್ವ್ ಮಾಡಿದ್ರೆ ವೆಕೆಟ್ ಮಾಡ್ಬಿಡ್ತೀನಿ.
Today itself file.
Serial number 3. Rohit Nagesh Latu.
My lord.
ಕೊಡಿ ಮೆಮೊ. ಏನ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಬರೋಲ್ಲ?
ಇಲ್ಲ, my lord. My lord, proposal notice to insert the name of petitioner in rowdy sheeters in violation of guidelines of this court in BS Prakash case.
Yes, AG.
Annexure A, B and C need to be stated, my lords. 3 petitioner, my lords.
ಮೂರ್ ಇದೆಯಾ?
Petitioners are 3.
Petitioners 3. List the matter on Monday in the fresh matters list. Learned AG is directed to accept notice and secure instructions. The orders shall remain stayed subject to the conduct of these petitioners.
My lords, one submission. Not even a single case is pending against
Nimsha,
them. Please.
Subject to the conduct of these petitioners. List Monday fresh matters.
Please. My lords, annexure A, B and C.
A, B and C. ಮೂರ್ ಜನದ separate.
Please.
Yes.
Obligement.
Madam Shivali.
The senior exam.
I appear for the petitioners council, my lord.
Copy is not served, my
respondent.
There is a chief executive.
Hello, who has issued notice now?
Or he has been put under such a
Copy is
pressure
not issued.
that initially he called for co-opting, treating my post as vacant. That was stayed by this court. He called a meeting ignoring me. That was also stayed by this court.
Sir, ಒಂದೇ ನಿಮಿಷ. Yes, one moment, sir. One moment. ಶೀಲ್ವಂತ್ ಎಲ್ಲಿದ್ದಾರೆ? ಅದ್ಯಾರು? ಸಾದಿಕ್ ಯಾರು ಮೂವ್ ಮಾಡಿದ್ದೀಗ? ಅಲ್ಲ ಕೆಳಗಡೆ ಫೈಲಿಂಗ್ ಕೌಂಟರ್ ಹೋಗಿ ಕೇಳಿದ್ರೆ ಆಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಂತ. ಎಸ್
157 on Balkota.
ನಿಮಿಷ ಇವ್ರಿಗೆ ಮುಗಿಸ್ಬಿಡ್ತೀನಿ. 230 ಮೂಡ್ ಮಾಡಿ. ಎಸ್ ಸರ್.
Please, my lord. The first respondent.
ಇದು ರಿಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ ಅದೇ ತಾನೇ?
Please, my lord.
ಎಸ್. They heard the learned
ಅದರಲ್ಲಿ
senior
ಈಗ
counsel.
ನಾವು
I am staying it, sir. 1 minute. I heard the learned senior counsel Jaykumar S. Patil appearing for the petitioner. The writ petition, a number in madam adu?
Please,
Reserve
ma'am.
ಮಾಡಿರೋದು.
This is the
The subject, the writ petition so and so is heard and reserved for its orders. Even before the order is pronounced, the first respondent is now wanting to flex its muscles by issuing a notice to the petitioners, which would undoubtedly amount.
not issue the notice to the
without issuing notice, he calls for a meeting.
Flex.
Annexure A,
one ನಿಮಿಷ. During this, before the order could be pronounced, the first respondent has now called for a meeting without issuance of any notice, which would undoubtedly fringe on the borders of contempt of the orders passed by this court and the matter being matter pending pronouncement of its judgment. Therefore, there shall be an interim order as prayed for. List the matter on Monday. Pronounce ಮಾಡುವ.
Please.
And delivery back.
Please.
95 Lord.
Now ಈಗ ಹೇಳಿ ಒಂದೊಂದಾಗಿ.
Serial number 16. Emergent note.
Page wise.
Emergent notice to respondent number 192, my lord.
192 emergent notice. Petitioner shall also serve by way of hand summons
Yes.
to 192 and file an acknowledgement by tomorrow. List the matter on Monday in the fresh matters.
Please.
Yes.
Lordship, page number 69.
ಈಗ ಎಲ್ಲಿದ್ವಿ ನಾವು? 60?
68, it was last ಮುಗಿದಿದ್ದು. 69.
68
ಅಲ್ಲ 69 matter, Your Lordship.
ನಿಮಿಷ 65. 65 after vacation. 66. ಮುಗಿತಾ? 65 ಮುಗಿತು, ಸರಿ. 66 after vacation. ಏನಪ್ಪ?
Lordship, about to dictate the order.
About to dictate. ಈಗ ಮಾಡಿದ್ನಲ್ಲ after vacation.
Time, my lord, respondent. Respondent took the time, my lord, day before yesterday, my matter was dictated.
ಏನ್ ಮ್ಯಾಟ್ರ್ ಏನು? ಏನ್ ಮ್ಯಾಟ್ರ್ ಅಂತ ಹೇಳಿ.
But compassionate appointment, my lord.
Compassionate ಯಾಕೆ? ಅಲ್ಲ ಯಾಕೆ
My lord, my lord, the application was rejected on the ground that adopted sons are not entitled.
Adopted son, the Monday fresh matters.
Please.
Also ಇಲ್ಲ ಆಮೇಲೆ ನೋಡಿ. You don't file ಅಂದ್ರೆ ನಮ್ಮ ಆರ್ಡರ್ ಪಾಸ್
This
ಮಾಡ್ಬಿಡ್ತೀವಿ.
is 8th time, my lord, so he said.
Monday
Before
ninth
your
time.
lordship only. True, my lord. ಅಲ್ಲಿ order sheet ನೋಡು.
ಅಲ್ಲ ಅವ್ರು ಲಾಸ್ಟ್ ಟೈಮ್ 4 ಅಂತ ಹೇಳಿ. Monday, yes. 67. Yes, after vacation. Next.
60. Appear for petitioner, my lords. Inquiry report is not furnished to the petitioner. Punishment is imposed.
Without inquiry report?
Yes.
Tomorrow. ಅಷ್ಟೇ, we'll send it back.
Yes.
ನೀವು ಗವರ್ಮೆಂಟ್ ಎನ್ಕ್ವೈರಿ ರಿಪೋರ್ಟ್ ಯಾರು? ಭೂಷಣ್ ಕುಲಕರ್ಣಿ.
Bhushan Kulkarni.
HDMC.
HDMC.
HDMC ಅವ್ರು ಕೊಡಲ್ಲ ಬಿಡಿ, ಆದ್ರೆ ಸೆಟಿಸ್ಫೈ ಮಾಡಿ ಕಳಿಸ್ಕೊಳ್ಳೋಣ. ಎಸ್, ಟುಮಾರೋ ಫ್ರೆಶ್ matters.
69, Your Lordship, that the light unauthorizedly
After
absent, Your
vacation.
Lordship. Better. Unauthorizedly absent, Your
403
Lordship.
days.
Petition is given.
Please,
ಕಿರಣ್ ಗೌರ ಕಬ್ಬೂರ್.
please, Your Lordship, because they have filed contempt also, Your Lordship. ಅದು
ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
Please, Your Lordship.
67, 60,
69, Your Lordship.
69 tomorrow.
69.
Please, Your Lordship.
Day after.
Tomorrow, day after tomorrow? Tomorrow, yes. 70 after vacation, yes.
71.
Madam, ಎಲ್ಲೆಲ್ಲಿ? I see. Entry ಮಾಡಿದ್ರೆ ಎಲ್ಲಿದೆ? 70 AV. Yes, Rupa madam, ಏನಿದೆ?
71, my lords. It's a service tax, my lords. It's on the limitation, my lords. It may be taken today or.
My lords, proceedings has been initiated on the basis of 26 years, my lords. It can be disposed of in terms of the Chinmay trust judgment, my lords, if the
My
petitioner
lords,
agrees.
no, my lords, because it is barred by limitation, my lords. The shoka is not.
Then
Then,
tomorrow.
my lords, then objection needs to be filed, my lords. My lords, tomorrow, my
My
lords.
lords, from last
Tomorrow, my lords,
3-4 occasions, there.
ನೋಡೋಣ ಗಿರೀಶ್, ನಾಳೆ ಹೇಳಿ. Yes.
Please, my
Fresh
lords.
matters.
ಅದೊಂದೇ, ಓನ್ಲಿ ಫ್ರೆಶ್ ಮೇಡಮ್, ಬೇರೆ ಯಾವುದು?
Please, my lords.
After vacation, yes. 73. What 10 years? ಏನ್ ಮಾಡ್ಬೇಕು ಅದಕ್ಕೆ? ಸ್ಯಾಲ್ರಿ 10 ವರ್ಷ ಕೊಟ್ಟಿಲ್ವಾ? ಯಾವ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್? Who appears?
Served on representative.
Tomorrow fresh matters, yes. 74. 73 ಆಯ್ತಲ್ಲ. 74
74,
after vacation.
75, Angada, this is scary.
After vacation.
After, ayo, thank you, sir. After vacation, yes. 76. ESCOM ಮಾಡೋದು ಹೆಂಗೆ? Monday fresh matters, yes. Anil Kale,
Anil Kale,
AV, next. Kalwad AV,
78, SM Karnataka,
AV, SK Hegde, after vacation.
59, SK Hegde,
ಎಲ್ಲ after vacation. Entry ಮಾಡಿದ್ರೆ continue ಮಾಡಿ.
80, Manjunath Torgal.
My lords, tomorrow 10:30, my lords.
Why?
Petitioner is eligible to appoint under state pay scale, my lords. Library, my lords.
It was heard, your lordship, last occasion also. I have objected, your lordship, but state scale he is entitled.
He is eligible.
Monday ಹಾಕೋಣ?
Please, your
Monday fresh matter. State ಗಾದ್ರೆ ಕೊಡ್ತಾನೆ.
Lords, 10:30, my lords, because it is fifth time it is not being reached.
Monday it may reach. Have hope, sir. Yes. 81.
81, Ramchandramani,
ಎಷ್ಟು ವರ್ಷ ಡಿಲೇ ಆಗಿದೆ? After vacation. After vacation. Yes, next.
82, Dinesh Kulkarni.
After vacation. Granted,
Getting stay in the file. Since it's covered by judgment.
17th fresh matters. Yes.
Please.
83,
Stay ilva? Stay ilva? Why? Monday fresh matters.
84,
Right. Yesterday's matter, he considered for allowing the petition yesterday, Mr. Bundy.
BWSS.
Allah, the KWSSB, Murad.
Water supply. What is this?
Yes, to trace out the documents and Murad make payment. That matter, Murad. Yesterday he was there.
Where is he? Dayanand Bandi. Nale.
Please.
Fresh. Yes.
85,
Tender. Tender. Stay ಇದೆಯಾ? Interim order ಇದ್ರೆ Monday ಹಾಕಿ. ಇಲ್ಲ ಅಂದ್ರೆ after vacation. Yes, next.
86, Arjuna.
87,
Ramchandramani,
after vacation. Yes. Interim order continue.
88,
My lords. My lords, appearing on behalf of respondent, my lords. Counsel on record is unwell, my lords. He had brain
After
stroke
vacation.
after vacation.
ಏನಾಯ್ತು?
9, Gayatri Sir,
My lords. My lords, entire recruitment process is completed, my lords. On merits, it would be taken up
List the
after
matter.
vacation.
Immediately after vacation. Yes.
Please.
Gayatri,
Gayatri Sir,
after vacation. Interim order continues.
Serial number 90. 91. Serial number 90. So yesterday's matter, Murad, sir. Ex parte order by the authority, Murad, under section 78.
Then we will send it back.
That it has to be, Murad.
ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು?
Government, Murad, sir.
AG. Thanks, sir.
I'm ready to submit the books of accounts, Murad, and they have invoked section 74. There is no fraud, Murad. They have to invoke 73 and Murad consider.
Monday fresh matters.
Please.
91, my lords, land of the petitioner being acquired with the National Highway Authorities, no compensation being paid.
Immediately after vacation. Yes.
Please, notice has to go to respondent.
Notice ಆಗಿಲ್ವಾ ಇನ್ನು?
10 to 13, my lords. Others already.
Emergent notice to respondents 10 to 13.
Please, my lords.
Yes, next.
92, MS Survey,
After vacation. 93. ಇದು ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅಂತ ಹೇಳಿದಲ್ಲಿ ವೆಯ್ಟ್ 93 ಒಂದು ಇಟ್ಕೊಂಡಿರಿ ಫೈಲ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್. ಸರಿ, ಆಮೇಲೆ ಎಲ್ಲ ಬರ್ದಿದೀವಲ್ಲ ಎಲ್ಲದ್ರಲ್ಲಿ ಗೌರ್ಡ್ ಅಂತ ತಗೋಬೋದು ಯಾರ ಹತ್ರ.
94, P. Munja,
ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಏವಿ ಎಲ್ಲ
95,
My lord, 95, after the interim order is passed, they have stopped the payment, my lord, to the ASHA workers.
What payment? What payment?
The
Government.
monthly payment, salary, my lord.
Yes, government.
Already, and they have removed also, my lord, some of the workers despite the stay order. Could it be, my lord, disposed of? Otherwise, my lord, the pendency is being utilized to remove the workers.
List on
Saying that-
17th fresh matters. Yes.
Great.
17th fresh matters. Next.
99 also, my lord, same matter.
Wait. 96 after vacation.
96 regularization.
After vacation. Yes. Next. 97 after.
97 tomorrow, please, your lordship.
97 tomorrow. Karana.
Challenge the arbitrary action of the.
Mike sir, ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
Challenge the arbitrary action of selective suspension of employee.
ಯಾಕೆ ಎಲ್ಲಾರನ್ನು ಮಾಡಿಲ್ವಾ ಸಸ್ಪೆನ್ಷನ್?
Show cause notice issued 7 people. Only petitioner is suspended.
Depending upon, my lords, the role they have played in, my lords, that misappropriation, my lords.
But so same charge sheet is filed. Same charge sheet is filed.
Suspension is revoked.
Suspension is removed.
ಸಸ್ಪೆನ್ಷನ್ ರಿವೋಕ್
ಅಂದ್ರೆ ರಿವೋಕ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. But 3 ತಿಂಗಳ ತನಕ without any blemish, she suffered a lot. Other people, those who have recipients,
ಕೆಲಸಕ್ಕೆ ತಗೊಂಡಿದ್ದಾರೆ. ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದೀರಲ್ಲ?
ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
3 ತಿಂಗಳ ತೀರ್ಮಾನ ಅಲ್ವಾ?
Yes.
Matter requires deeper consideration. List the matter in B group. Yes.
Monday, please.
Monday B group ಇಲ್ಲ sir, ಬರೀ fresh matters.
Please.
Yes.
28.
After vacation. Yes, next.
99.
Same, 99, 17.
It's connected with 95, my lord.
95 and 99 together.
Interim orders may be extended.
Stay ilva?
ಇದೆ interim order may kindly be.
ಅದರಲ್ಲೇ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
Yes, ma'am.
ಯಾವಾಗ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಗಿರೋದು?
2009 onwards, my lord, there are people working.
What is the ground ಏನು? What is the ground?
Ground is yesterday was 3 grounds.
Yesterday's ground ಅಲ್ಲ. ಇವತ್ತು ground ಏನು?
She is not the resident of that revenue village.
ನೀವು BA BEd ಅವರು? ನೀವು ಆಫ್ಟರ್ ವೆಕೇಶನ್. ಡಿಸ್ಮಿಸ್ ಯಾಕೆ ಮಾಡಿಸ್ಕೊಂತೀರಾ ನನ್ನ ಕೈ? ಓವರ್ ಕ್ವಾಲಿಫಿಕೇಶನ್ ಕೊಡೋದೇ ಇಲ್ಲ ಅಂಗನವಾಡಿಗೆ. ನೀವು ಮಕ್ಕಳು ನೋಡ್ಕೊಳ್ಳೋದೇ ಇಲ್ಲ.
ಅಲ್ಲಲ್ಲ. She is not the respondent. She is appointed.
ಅಲ್ಲ, are you BA BEd?
ನಾನು MA ಮಾಡಿದ್ದೇನೆ.
BA ಗೆ ಕೊಡಲ್ಲ.
required qualification.
Required qualification PUC.
Secondary PUC.
ಅಲ್ವಾ?
ಹೌದು.
ನೀವು PUC ಇದೆಯಾ ಹೇಳಿ.
PUC ಆದ ನಂತರ ಡಿಗ್ರಿ ಮಾಡಿದೆ ಇಂಟರ್ನಲ್.
ಅದಕ್ಕೆಲ್ಲ ಕೊಡಲ್ಲ. ನೀವು PUC ಇದ್ರೆ ಮಾತ್ರ ಕೊಡೋದು.
ಅದೇ PUC ಇದೆ. PUC ಇದ್ರ ಮೇಲೆ ಹಾಕಿದ್ದೇನೆ ನಾನು ಡಿಗ್ರಿ.
ಯಾಕೆ ಸಪ್ರೆಸ್ ಮಾಡಿದ್ರಿ BA BEd ಆಗಿರೋದಲ್ಲ?
ಯಾವ್ದನ್ನ?
BA BEd ಎಲ್ಲ
ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ದೇನೆ, ಬಟ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಇದು ಕೇಳಿಲ್ಲ. ಅವಳದ್ದು ಆಗಿದೆ. She is also completed, if I am correct.
ಏನು MSc ಮಾಡಿದ್ದೀರಾ? ಆಫ್ಟರ್ ವೆಕೇಶನ್.
ಪಾರ್ಟೆಡ್ ಆಗಿರೋದ್ರಿಂದ ಮಂಡೇ ಅವರು ಟ್ಯೂಸ್ಡೇ.
ಪಾರ್ಟೆಡ್ ಆಗಿದ್ಯಾ?
ಹೌದು. In fact, it is yesterday your lordship has expressed matter
expressed to be what?
Posted for dictating orders. Yesterday matter was heard.
I list on 9th January. Further hearing.
Further hearing.
Parted. ಇಲ್ಲ ಅಂದ್ರೆ 9th January ಆಗ್ತೀನಿ ಬೇಕಾರೆ.
Further hearing.
For further hearing ಅಂತ next week ಇಡಬಹುದು. Any day.
ಅಲ್ಲ, ನೆಕ್ಸ್ಟ್ ಬಂದ್ರೆ ನೀವು ಮಾಡ್ಕೊಡಿ.
Sorry.
ನೆಕ್ಸ್ಟ್ ಬರೋರ ಹತ್ರ ನೀವು ಮಾಡಿ, ತೊಂದರೆನೇ ಇಲ್ಲ.
Further hearing 9th is the.
Yes, I will not grant. Over qualification I will not permit at all. ಸುಮ್ಮನೆ you will be taking somebody's livelihood who is correctly PUC. ನಿಮ್ಗೆ ಎಲ್ಲಿ ಬೇಕಾದ್ರೆ ಕೆಲಸ ಸಿಗುತ್ತೆ, ಟೀಚಿಂಗ್ ಕೆಲಸ ಮಾಡಿ ಹೋಗಿ.
ಇಲ್ಲ, ಅದಕ್ಕೆ ಇಲ್ಲ ಅವಳದು ಕೇಳಿ.
ಎಲ್ಲೂ ಸಿಗ್ಲಿಲ್ಲ ಅಂತ ಅಂಗನವಾಡಿ ಕೈ ಹಾಕ್ತಾ ಇದ್ದೀರಾ?
ಅವ್ರ ಕ್ವಾಲಿಫಿಕೇಶನ್.
If you are incapable of getting a job elsewhere for MA, MA, PhD and you want ಅಂಗನವಾಡಿ on PUC ಗೆ, ಇದಕ್ಕಿಂತ no sir, I will not permit all such. Over qualification ಆಮೇಲೆ ನೀವು ಏನು ಮಾಡಲ್ಲ.
I kindly after vacation.
After vacation. Yes. After vacation. Yes.
Number 100, 100.
100. 100 ಅಂದ್ರೆ ಏನು ಪೊಲೀಸ್ ಕರೆದಂಗೆ ಕರೀತಾ ಇದೀರಾ? Yes.
Seeking for mandamus to consider the request.
Mandamus to
consider the request of the petitioners wherein
Manoli. ಏನ್ ರಿಕ್ವೆಸ್ಟ್ ಸರ್?
My lord, wherein service rules have been amended.
After vacation, yes. Next.
101, case 40.
Appear for petition. Yesterday's matter.
Project Director, Karnik and Nirmiti
Project
Kendra.
Director Nirmiti Kendra, my lord.
Tomorrow, fresh matters.
May I request modes? May I request modes? After vacation.
No, sir.
My lords may treat it. Of course, my lords have heard this.
Lord, he is illegally being continued, my lord, on the same.
There was genuine reason for my
I
absence.
know, that's there.
Otherwise, I would not have.
I'm portal ಹೇಳಿದೆ.
Is illegally being continued, my lord.
We will not be
ಅಲ್ಲ
absent.
ನಂದು ಒಂದೇನಂದ್ರೆ ಗವರ್ಮೆಂಟ್ ದವರು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿಲ್ಲ ಬಿಕಾಸ್ ಇಟ್ ಈಸ್ ಫಾರ್ ದೆಮ್ ಟು ಡಿಫೆಂಡ್ ಅನ್ನೋದಕ್ಕೆ ತಾವು ಪಾರ್ಟ್ ಮಾಡಿಬಿಟ್ಟು
List the matter on 9th January for further hearing.
Please.
Objections, if any, by the respondent, all the respondents by then. In the event the objections are not filed, it shall be construed that there are no objections to the contentions of the petitioner.
Please.
Yes.
Interim order model.
Interim order subsisting will continue till the next date.
Please continuing from the last 6 months.
New year on Marbury.
Please.
102, Pranam Umesh Padgi.
My lord, I am appearing for the petitioner, my lord. The approval of the appointment of the year 2012 in the granting and institution, my lord. Matter is covered by the I mean permitted.
After vacation, yes, next.
103.
N short point. N Pranav idu.
Publicity.
Huh? After vacation, immediately after vacation. Yes, next.
103, Rajshekhar Gunjali.
Writ of mandamus, my lord, have it, my lord, Monday, my lord. Since, my lord, there is a, my lord, field channel is there, existing. But without using that, my lord, they are creating the, my lord, diverting the flow of water.
Immediately after vacation. Photo nodak time back. Yes. After vacation. Next.
They are already issued them so-called notice to.
14%.
104, 14%.
Vishwanath Hegde. ಅಯ್ಯೋ ಆಫ್ಟರ್ 14% ಯಾರು? ಬೈ ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಇದನ್ನ ಅಲ್ಲಿ ಹೋಗುತ್ತೆ ಬಿಡ್ತಂದ್ರೆ. List immediately after vacation, interim order subsisting will continue to the next date of hearing.
105, Adjudication. 106.
106 plus I appear for the petition. Suspension order, it was, dictation was.
ಎಲ್ಲ ಡಿಕ್ಟೇಷನ್ ಗೆ ಅಂತೀರ. ಏನ್ ಸಸ್ಪೆನ್ಷನ್ ಆರ್ಡರ್?
Suspension order based on the newspaper cuttings, the.
Yes, Monday, fresh matters.
107, Adjudication. 108.
My lord, the tax matter, my lord, which was heard on the last date, levy of capital gains tax on agricultural land, my lord.
ಅದು ಬರದೇ ಇಲ್ವಲ್ಲ ಟ್ಯಾಕ್ಸ್?
ಅದನ್ನ ಅವ್ರು ಟ್ಯಾಕ್ಸ್ ಹಾಕಿದ್ದಾರೆ ಅದ್ರ ಮೇಲೆ. This was
Simulation, ರೂಪಾ ಮೇಡಮ್ ಅಲ್ಲಿ. ರೂಪಾ ವರ್ಸಸ್ ರೂಪಾ. ಎಸ್.
My lords, it may be sent back, my lords.
ಕಾಸ್ಟ್ ಅಂತ ನಾನು ಹೇಳ್ತಿದ್ದೀನಿ. Notice may be cost, my lord. ಯಾಕೆ send back?
ವಾಶ್ ಮಾಡಿ ಕಳ್ಸೋದು ಮತ್ತೆ ವಾಪಸ್.
ವಾಶ್ ಮಾಡಿ ವಾಪಸ್ ಕಳ್ಸಿ and let them file the reply, my lords.
You file your return of.
Filed a reply. We've already filed a reply. No, but that is
Consider
not.
and pass orders ಅಷ್ಟೇ.
Yes, my lords.
I'll operative portion ಬರ್ಕೊಂಬಿಡಿ. Heard the learned counsel, Rupa for the petitioner, Rupa for the respondent. The petitioner is before this court seeking the following prayer. The reasons I will continue. The petition stands allowed. The impugned notices stand quashed. The matter is remitted back to the hands of the respondent to consider the reply already submitted to the show cause notices so issued. Or time limit and medal.
No, my lords.
All procedure, it is for the respondent authority to regulate its procedure on such remand, ordered accordingly.
Good.
Reason I will fill it and give it, yes.
109.
Tirumalesh and Rupa alva? Rupa madam. Tirumalesh and Rupa. ಇಲ್ಲ ನಿಮ್ಮ ಒಬ್ಬರದೇ ಹಾಕ್ಲಾ?
ಹೇಗೆ ಪರವಾಗಿಲ್ಲ.
109, my lord.
109.
Challenge the suspension order.
109?
Challenge the suspension order.
Challenge.
Based on, my lord, the criminal petition filed after lapse of 24 years.
ಅದು.
ಎರಡು connected.
ಇದೆಲ್ಲ ಕನೆಕ್ಟ್ ಆಗಿದೆಯಲ್ಲ ಅದು?
ಎರಡು.
ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ಕನೆಕ್ಟ್ ಆಗಿಲ್ವಾ?
ಅಲ್ಲ, criminal petition listed on, my lord, 16th.
ಅದೇ 15th ಅದ್ರ ಜೊತೆ
16th.
List on 16th fresh matters.
My lord, order may be.
Interim order will
My lord,
continue. Interim order ಇದೆಯಾ? After vacation.
ಇದರಲ್ಲಿ ಇದೆ.
My lord, these two matters are concerned, my lord, that they have an alternative remedy under the Education Act, my lord.
ಏನು ಸರ್?
ಅಲ್ಲ, here, submission.
Yes, all right. 16th fresh matters.
Please.
110.
My lord, extension of parole, my lord. Petitioner is in custody for 19 years, 3 months. 60 days granted.
60 days, yes. Extension allowed 60 days.
Obliged.
Next. 111 after vacation. ಏನ್ ಇಶ್ಯೂ ಏನು? ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಗೋಗಿದೆಯಲ್ಲ ಈಗ, ಮತ್ತೆ ಇಂಟರ್ವ್ಯೂ ಮಾಡಲ್ ಕೊಡಕ್ಕಾಗತ್ತೆ. ಎಸ್, ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಫ್ ದಿ ಸೆಲೆಕ್ಟೆಡ್ ಕ್ಯಾಂಡಿಡೇಟ್ ಶಲ್ ರಿಮೈನ್ ಸಬ್ಜೆಕ್ಟ್ ಟು ದ ರಿಸಲ್ಟ್ ಆಫ್ ದ ಪಿಟಿಷನ್. ಯಾವ ಸೀರಿಯಲ್ ನಂಬರ್? 111. 11 ಅಷ್ಟೇ. Appointment of the fifth respondent shall remain subject to the result of the petition. Next.
112.
Post immediately after service of. ಈಗ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ? Fresh matters Monday. Yes. 112 fresh matters Monday.
113.
After vacation, interim order continue ಮಾಡಿ.
114 on Monday, my lord. It's a service of weightage is not considered. Petitioner is near to service of weightage. Appointment of teachers in Muraji this school.
Covered ಅಲ್ವಾ ಅದು?
Covered.
ಸುನಿಲ್ ದೇಸಾಯಿ ಇಲ್ಲ?
Sunil Desai.
ಸುನಿಲ್ ದೇಸಾಯಿ ಕವರ್ಡ್ ತಾನೇ ಅದು? Monday fresh matters. Yes. ಅದೇ ದಟ್ ನಿಂಗಮ್ಮ.
114 ಅರ್ಜುನ.
Yes.
115.
115, I'm led by a senior counsel, my lords. Mr. Harish is online.
My lords, 115.1, 2 and 3, I appear for the petitioners. My lords, there's some urgency in the matter because.
Wow, sir, no time, sir. Yes.
My lords, even if it's on Monday or Tuesday, my lords, there is some urgency because there's an order that is passed that is fairly patently illegal. It will take about 10 minutes, my lords, for your lordships to hear this. It's a straightforward matter. Anytime next week, my lords.
17th, sir. The only time is 17th. Yes.
Obliged.
116.
Fresh matters, my lords, 17th. Yeah.
Oh, only fresh matters, sir. Yes.
Very well, my lords. Very well. Much obliged.
Yes.
116. Shokar Kalyan City.
86 years old. Only pay difference of pay scale. Now he is 86 years old. My lord, he was already principal. Grade 2, my lord, the college had strength of more than 1,000. That aspect is not considered by the appellate authority. The second time, my lord, the matter is coming up. 2 times, my lord, appeal was filed. Earlier writ petition filed. I was asked to, my lord, approach the appellate court. Appellate authority remanded the matter. On second time, my lord, they rejected it. And third time also, they have rejected without considering, my lord, that he was already the principal and student strength was more than 1,000. He is entitled for, my lord, difference of the pay scale.
Have you summoned the officers? The police officers ಕರೆಸಿದೀವಾ ಯಾವ್ದ್ರಲ್ಲಾರು? ಹಂಗಾದ್ರೆ have you summoned the officers? ಅಲ್ಲ police officers ಕರೆಸಿದೀವಾ? They will take it. Why is the SP waiting?
Well, JDPA also has recommended, sir.
Wait. What is the matter? 180 correct. What is the matter?
My lord,
No, why have you summoned the superintendent of police?
He's the commissioner of police.
Sorry, commissioner of police. Sorry.
But the one matter, my lord, the learned advocate general is there.
Appearing for the.
Today matter is listed, serial number 180.
Which is that matter?
I am appearing for the petitioner, my lords. This is a petition where I have challenged the rejection of application seeking permission to hold a protest.
Yes.
It is the protest being conducted, being held by the students, my lords.
For what, sir?
My lords, there are about 3 lakh backlogs in the government official, my lords.
3 lakh backlog in?
Lords, across multiple posts, my lords, there is no call for being done. Because of which, my lords, the upper limit that is set, there is an age limit of 33 years for some posts, my lords. Students have already crossed that. There was assurance given by the government officials that they would extend it, but there is no action being taken.
Let me ask you one thing.
Yes.
If you protest, they will extend the age limit, is it?
My lords, in the previous protest, my lords, they had given an assurance that would be conducted. Previously, my lords.
What kind of assurance?
That they would consider our representation for extension of the from 33 years. They would extend it, give a relaxation of about 5 years.
People should permit what is the political assurance got to do with the rules that are there? If the rules do not permit extension, where is the question of extension?
Milords, that is
ನೀವು
not the,
protest ಮಾಡಿದ್ರಿಂದ ಏನಾಗುತ್ತೆ ಹೇಳಿ?
ಅಲ್ಲ,
Is it not going to create problem to general public? Is it not going to create problem everywhere? Are you going to sit at one place and protest?
no, Milords, that is one proposal that I
No,
can,
are you going to sit at one place and protest? I will permit you. But if you are going to cause problem to general public for this purpose, where it is impossible to do anything out of a protest, ನೀವು 33 years ಇದ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ, we will have to do it. Rules should permit, sir.
true,
If
Milords,
the rules don't permit, what kind of protest can bring about any change?
that is one such, Milords, I absolutely agree with your lordships.
Yes.
That is one part of it, Milords. As regards students who are now eligible, after about 1 or 2 years, Milords, their upper limit they will also cross the upper limit. So that needs to be considered. At least they'll start calling for, Milords, is our request. Our representation is only with that.
What is the problem?
Milords, now, if I may suggest, Milords, if
Advocate General Sahib.
My lord, we
Now,
had
what
granted
is the
permission. I'm sorry, my
We are
lord, my
placing the
apologies.
statement of
My
objection
apologies.
also, Milord.
My apologies, your
No
lordship.
problem, ಹೇಳಿ.
My lord, we are
placing
granted
statement of
permission
objection to
to
this
protest, my lord, earlier, 1 month back itself, my lord. In total violation of the permission granted to them, my lord. In the location of the protest they are sought for, we are given the location, number of people. They are caused total disturbance to the residence of the people. There are institutions, colleges, my lords, which has caused havoc, my lord. Your lordship may kindly
No,
statement.
I will not, though it is your right to protest, everything is correct. Yes. But it is always hedged with conditions.
Certainly.
Conditions that you will not disturb the peace in the vicinity, the day-to-day life of the public.
Yes.
Or other, you are protesting for your own cause.
Certainly,
correct?
Milords.
So that should not result in any kind of, you protest at one place and leave it.
Milords, that is what I wish to submit. If at all there is an issue with the route that I have suggested a 2-kilometer distance, Milords, from Srinagar Circle to DC office. If I may be permitted to complete my submission, Milords.
All right, complete.
Milords, it's a very, Milords, if at all there is an issue with
When is this?
Milords, I'm 15th, Milords, I'm proposing. 15th, which is on Monday, Milords. They'll have, there is 2 more days, Friday, Saturday and Sunday, 3 days of time with them and with us as well, Milords. We are ready to give an undertaking that we will not cause any kind of hindrance to the general public at large.
What has happened? I have the identical protest earlier.
Same organization. ಇವರೇ ಮಾಡಿ
ನಾವೇ ಮಾಡಿರೋದು.
ಇವರೇ ಮಾಡಿ 2,000 ಜನ ಬರ್ತಾರಂದು 25,000 ಜನ ಜುಬ್ಲಿ ಸರ್ಕಲ್ ಬ್ಲಾಕ್ ಮಾಡಿ 4 hours ಬ್ಲಾಕ್ ಮಾಡಿ. It's already happened,
we will not permit another, see, we will not permit, what forbid, we will not permit any kind of stampede to happen, any kind of.
Page 26,
no.
page 26 ತಾವು ಒಂದ್ಸಲ ನೋಡಿ. Page 26 photo ನೋಡಿ.
Milords, I have submission to that as well.
Page 26 ದಯವಿಟ್ಟು ಒಂದ್ಸಲ ನೋಡಿ. Photograph ನೋಡಿ.
For that, Milords,
You may sit at a place, protest. You want your voice to be heard by the government.
Certainly, Milords.
Your voice to be heard by the government need not be on a violent lines or need not be on the lines that you are saying. If the voice is to be heard by the government, it should be heard by the government in any manner that you do it.
Milords, that is what I'm proposing now.
If you are proposing now, you at a place you sit, turn mode of that place. You can't cause any problem to general public, sir. Whatever kind of protest it is,
Milords,
and whoever it is.
I am ready
or
to give.
These protests are having political overtones. We don't know.
From our side, Milords, it may be taken on record as an undertaking that we will not cause any disturbance.
May I make one suggestion?
One minute. You may say it's a mob or protest. It's not by one. 25,000 people come and somebody becomes unruly. Who is going to?
Milords,
and citizens' lives are at stake. Who is going to be responsible later?
Milords, they are saying that 25,000 people were there, but that was not the case. There were about 5,000 people. That is, Milords, Milords.
2,000 5,000 ವ್ಯತ್ಯಾಸ ಇಲ್ವಾ?
True, Milords, we will restrict on our side. We will, Milords, on all, if possible, if necessary, Milords, we will tell all the students association to ensure that not more than 2,000 should be there. And Milords, at starting point, there will only be 100 to 200 students. As and when we proceed on that road, since libraries and other educational institutes fall on that road, slowly and steadily they'll gather.
Slowly and steadily.
And it's hardly a 2-kilometer stretch. Now, Milords, if
I am asking,
they can
I am
propose
asking every unemployed youth who wants to participate in this or who is asking, if you protest,
yes,
the 33 years will be increased without the rule being like that. Will that happen? Will that happen? And courts have clearly held that you can't force the state to call for applications or whatever it is. If there is a petition filed, we can answer, we can issue a direction, we can get the compliance of those direction. What is the use of protest in this?
Milords, we are going to submit a memorandum now.
Submit.
If that is not
Submit a
considered,
memorandum.
if that is not considered, we'll have to inevitably come to the courts.
That is why, see, those things you will have to agitate by filing a petition.
On two.
You, no problem, sir. You protest, we will not come in the way of your protest. But the protest at any kind should not be in deviation of law, not disturbing peace anywhere, not disturbing anybody's life.
That already the first occasion they've done it, my lord. Kindly see page annexure R4.
We'll take it tomorrow morning. We'll take it
The
tomorrow morning.
petitioner is
Who is the
association.
petitioner?
All Karnataka
All
state
Karnataka State Students
Can I make one
Association.
request,
He is the
my lord?
president of the association.
You are the president.
He is the president. He is representing the petitioner society.
Aitu,
But
yes.
I just asked him if he is going to sit in one place and protest. He is agreeable to it.
Can I make one request?
ಕೂಗು ಸರ್ಕಾರ ಅಯ್ಯಾಜಿ ಸರ್ ಹೇಳಿ.
My lord, let my learned friends give a representation, my lord, giving the details as to how many people, location, whatever. Independent of that, my lord, your lordship may have it on Monday or Tuesday. We'll consider their application and place it before your lordship. Allah,
One minute, I'll
not
tell
that, my lord, because we are given.
One moment. What's your name?
Kant Kumar.
Mr. Kant Kumar.
Kant Kumar.
Yes.
Kant Kumar avare. Now, you, what is your grievance, tell me?
Sir, in government, there are 2,76,386 posts, vacant posts, sir, are there, my lord. Last 5 to 6 years, there is no recruitment in Karnataka.
ಸಂಬಳ ಕೊಡಕ್ ದುಡ್ಡಿಲ್ಲ ಇರೋರಿಗೆ. ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಹೇಳಿ. ಅಲ್ಲ, government doesn't have money to pay salary to the existing people. I'm getting petitions every day.
My lord, lakhs of aspirants, dreams are killing by government. Actually, 5 to 6 ಲಾಸ್ಟ್ 5 ವರ್ಷದಿಂದ ಸ್ಟೂಡೆಂಟ್ಸ್ ಪರವಾಗಿ ಒಂದು ವೇಕೆನ್ಸಿ ಫಿಲ್ ಮಾಡಿಲ್ಲ ಮೇಡಮ್, ಮೈ ಲಾರ್ಡ್. ಲಾಸ್ಟ್ 2.5 years ಒಳ ಮೀಸಲಾತಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಲಾಸ್ಟ್ 1.5 year ಇಂದ ಒಂದು ವೇಕೆನ್ಸಿ ಫಿಲ್ ಆಗಿಲ್ಲ ಮೇಡಮ್.
ಕಾಂತ್ ಕುಮಾರ್ ಅವರೇ, ಒಳ ಮೀಸಲಾತಿ ಮಾಡ್ಬೇಕು ಅಂತಿರೋದು ಪರ್ಸ್ಯೂಯೆಂಟ್ ಟು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ಸ್ ಡೈರೆಕ್ಷನ್.
ಎಸ್ ಮೈ ಲಾರ್ಡ್.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ ಅದು ಮಾಡದೊರ್ತು ಮಾಡೋಂಗಿಲ್ಲ ಅಂತ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳಿದ್ದಾರೆ. ನೀವು ಪ್ರೊಟೆಸ್ಟ್
ಮಾಡಿದ್ರೆ ಮೈ ಲಾರ್ಡ್ ಆತರ ಏನ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆತರ ಹೇಳಿಲ್ಲ ಮೇಡಮ್, ಮೈ ಲಾರ್ಡ್.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಡೈರೆಕ್ಟೆಡ್ ರೀಡೂಯಿಂಗ್ ಆಫ್ ದಿ ಎಂಟೈರ್ ರಿಸರ್ವೇಶನ್ ಪಾಲಿಸಿ.
ಮೈ ಲಾರ್ಡ್, ಮೈ ರಿಕ್ವೆಸ್ಟ್ ಈಸ್ ಒಳ ಮೀಸಲಾತಿ ಒಳಗೊಂಡಂತೆ ನೇಮಕಾತಿ ಪ್ರಕ್ರಿಯೆ ಪ್ರಾರಂಭ ಮಾಡಿ ಅಂತ ಹೇಳಿ ಮೈ ಲಾರ್ಡ್. ಅದ್ರ ಜೊತೆಯಲ್ಲಿ 56% ದಟ್ ಈಸ್ ಆಲ್ಸೋ ನಾಟ್ ವ್ಯಾಲಿಡ್ ಇನ್ ದ ಲಾಸ್ಟ್ 9 ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ಅದು ಇನ್ಕ್ಲೂಡ್ ಆಗಿಲ್ಲ ಮೇಡಮ್, ಮೈ ಲಾರ್ಡ್.
ಅದೇ ನೀವು ಪ್ರೊಟೆಸ್ಟ್ ಮಾಡಿದ್ರೆ ಆಗತ್ತಾ ಅಥವಾ ಪಿಟಿಷನ್ ಹಾಕ್ಬೇಕಾ ಹೈಕೋರ್ಟ್?
ಮೈ ಲಾರ್ಡ್, ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಪೆಟಿಷನ್ ಇದೆ ಮೇಡಮ್, ಮೈ ಲಾರ್ಡ್. ಆಕ್ಚುಲಿ ಲಾಸ್ಟ್ 1 year ಇಂದ ಕಂಟಿನ್ಯೂಷನ್ಸ್ ಇದೆ ಆಗ್ತಾ ಇದೆ. ಅಸೆಂಬ್ಲಿ ಡ್ಯೂರಿಂಗ್ ಸಮ್ಮರ್ ವಿಂಟರ್ ಸೆಷನ್ ಅಲ್ಲಿ.
ಇದು ವಿಂಟರ್ ಸೆಷನ್ ಇದೆ ಅಂತ ಪ್ರೊಟೆಸ್ಟ್ ಮಾಡಬೇಕು.
ಎಸ್ ಮೈ ಲಾರ್ಡ್, ವಿಂಟರ್ ಸೆಷನ್ ಅಲ್ಲಿ ನಮ್ಮ ಒಂದು ಏನು ಸ್ಟೂಡೆಂಟ್ಸ್ ಇಶ್ಯೂಸ್ ಇದೆ, ಕಾನೂನು ರೀತಿಯಲ್ಲಿ ಏನೇನು ತೊಡಕಿದೆ ಅಷ್ಟು ಸಮಸ್ಯೆಗಳನ್ನ ಬಗೆಹರಿಸಿ ಒಂದು ಬಿಲ್ ಪಾಸ್ ಮಾಡಿ ಒಂದು ಆಕ್ಟ್ ಮಾಡ್ಬೇಕಂತ ಹೇಳಿ ಮೈ ಲಾರ್ಡ್. ಮೈ ಲಾರ್ಡ್,
ಟೈಮಿಂಗ್ ಗೋಸ್ಕರ ಮಾಡಿರೋದ ಇದು?
ಎಸ್ ಮೈ ಲಾರ್ಡ್.
Yes, all right. We'll see. Tomorrow we'll take it. But Kant Kumar, you should know, you appear to know the law also. You should know that ನಿಮಗೆ ಒಂದು, that nobody can force the government. Of course, ನೀವು ಪ್ರೊಟೆಸ್ಟ್ ಮಾಡಿ ಇದಕ್ಕಲ್ಲ. ರೂಲ್ ನ ಚೇಂಜ್ ಮಾಡಕ್ಕೆ ರೂಲ್ ಚೇಂಜ್ ಆಗ್ಬೇಕು ಹೊರತು ಇರೋ ರೂಲ್ ರಿಲ್ಯಾಕ್ಸೇಷನ್ ನೀವು ಪ್ರೊಟೆಸ್ಟ್ ಮಾಡಿದ್ರೆ ಸಿಗಲ್ಲ. ಕರೆಕ್ಟ್, ನೋ ಪ್ರಾಬ್ಲಮ್. ಯು ಪ್ರೊಟೆಸ್ಟ್, ಬಟ್ ಇಟ್ ಶುಡ್ ನಾಟ್ ಹಾರ್ಮ್ ಎನಿಬಡಿ.
ಶೋರ್ ಮೈ.
ನೀವು ಅದು ಎಲ್ಲಿ ಕೂತ್ ಪ್ರೊಟೆಸ್ಟ್ ಮಾಡ್ತೀರಾ ಅವ್ರಿಗೆ ಪೊಲೀಸ್ ಕಮಿಷನರ್ ಅವ್ರು ಕೊಡಿ. Will representation ಕೊಟ್ಮೇಲೆ he will examine. I will take this tomorrow. Tonight itself he will give you a representation. Look into it, where they want to do it. If it is feasible, you come to. I'll take this at 2:30 tomorrow. You report to the court as to the feasibility of the place and the people that are going to participate.
If at all.
My request is let them all the information sought for by the commissioner may be given so that can be.
No, the commissioner is here. The commissioner is
here. I requested him to be there, my lord. I requested so that he may assist your lordship for any information.
Since we want to give a representation to the deputy commissioner, my lords, right in front of his office there is a huge open ground which can accommodate 2,000 people easily. We will sit there and we are ready to agitate there.
Kindly give the representation. We'll definitely consider by tomorrow by 2 o'clock.
You do one thing. You give a representation now to the commissioner.
Yes, ma'am.
Commissioner is here.
Yes,
he will look into it, and tomorrow he'll take it at 2:30. We'll resolve this issue tomorrow at 2:30. All right?
As your lordship suggested, sit in one place and agitate, my lords. We are agreeable to it.
You don't. ಮತ್ತೆ ನೀವು commissioner office ಒಳಗಡೆನೆ ಮಾಡಬೇಕು ಅಂತ.
ಇಲ್ಲ.
ಅದಕ್ಕೆ ಅದು ಮಾಡಬೇಡಿ.
We'll suggest 2 places, my lords. They can.
ಆಯ್ತು, ನೀವು ಕೊಡಿ representation.
We'll do it.
Kant Kumar, give the representation.
Thank you, my lord.
Your name, sir? Shashi Kumar, correct. Shashi Kumar sir is here. He will look into it, and tomorrow at 2:30 I will take it. We'll take it at 2:30 and try to resolve this issue.
Statement of objection, my lord.
ಆಯ್ತು, ಅದನ್ನ ನೋಡ್, ಅದಕ್ಕೋಸ್ಕರ ನಾಳೆ
ತಾವು
ಹಾಕಿದ್ದೀನಿ.
ದಯವಿಟ್ಟು ಒಂದ್ಸಲ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್
ಖಂಡಿತ ನೋಡ್ತೀನಿ, ನೋಡ್ಬಿಟ್ಟು ನಾಳೆ ಹೇಳ್ತೀನಿ.
If you just see that, my lord, they are not really entitled for anything, sir. It is the other motive there behind the strike. Kindly go through the statement of objection.
ನಾನು took a bird's eye view, don't worry, I saw it.
Please, grateful.
ಅದಕ್ಕೆ there are other overtones in this. Don't disturb the peace of the people by other overtones.
Please.
We'll take it tomorrow.
Thank you.
Your cause may be genuine, but the problem is all the persons are not under your control. Anybody may, anything may happen from any quarter. You will be held responsible. Yes. You protest. You should take everybody together and protest, even the police. Right? Yes. Tomorrow at 2:30.
Tomorrow at 2:30.
Yes, tomorrow at 2:30. ಇವತ್ತೇ ಕೊಡಿ ಅವ್ರಿಗೆ.
We'll do it. Grateful, my lords.
Annexure K, my lords, page 56.
Annexure K na. Serial number
116. ಅದ ಕೇಳಿದ್ವಲ್ಲ ಅದಕ್ಕೆ.
ನೀವು ಸಡನ್ ಆಗಿ annexure K ಅನ್ಬಿಟ್ಟು ಅಲ್ಲ ಪ್ರೊಟೆಸ್ಟ್
ಅಲ್ಲ ಅವ್ರು ಬಂದ್ರು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಆ ಕಡೆ ನೋಡಿದ್ರು. Sorry, my lord. 56 JDP, my lord, this thing. The post was already on with the page 56, my lords. Annexure K, last 3 sentences. It was in, my lord, it was with effect from 2/8/96 itself. The pay scale had come into effect, and he was promoted in 95. My lord, retired in 97. Annexure K make last sentence, 3 sentences.
Retired in 97. Filed the petition in 25.
Pay scale, other difference as a matter of right, because this the JDP admits.
25 ವರ್ಷ ಏನ್ ಮಾಡಿದ್ರಿ? 28 ವರ್ಷ ಏನ್ ಮಾಡಿದ್ರಿ?
ಅಲ್ಲಲ್ಲ, ಅದು ಆದ್ಮೇಲೆ ಅವ್ರಿಗೇನಪ್ಪ ಅಂತಂದ್ರೆ ಅಪ್ಲೇಟ್ ರಿಟ್ ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡಿದ್ವಿ, ಅಪ್ಲೇಟ್ ಹತ್ತಿರ ಹೋಗಿ ಅಂತ ಅಂದ್ರು, ವಿದೌಟ್ ಕನ್ಸಿಡರ್ ಡಿಲೇ ಅಂತ ಹೇಳಿ ಅದನ್ನ ಅಲೌ ಮಾಡಿದ್ರು. ಅಲೌ ಮಾಡಿಬಿಟ್ಟು ರಿಮಾಂಡ್ ಮಾಡಿದ್ರು ಟು ಕನ್ಸಿಡರ್ ದ ಹೋಲ್ ಥಿಂಗ್. ನನ್ಗೆ ಇಂಟ್ರೆಸ್ಟ್ ತಮ್ಗೆ ಗೊತ್ತಿದ್ದಲ್ಲ, ಇಂಟ್ರೆಸ್ಟ್ ಏನ್ ಬೇಕಾಗಿಲ್ಲ.
ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಫೈಲ್ ಕಳಿಸಿ. ಈಗ 180 ಆಯ್ತಲ್ಲ, ಈಗ ಅದನ್ನ ಫೈಲ್ ಇಲ್ಲಿ ಚೇಂಬರ್ ಕಳಿಸಿ. ಅಬ್ಜೆಕ್ಷನ್ ಎಲ್ಲಿ ಅದು? AG ಅಡಿಷನಲ್ ಅಡ್ವೊಕೇಟ್ ಕೊಟ್ಟಿದ್ದ ಅಬ್ಜೆಕ್ಷನ್ ಎಲ್ಲಿ? ಫೈಲ್ ಚೇಂಬರ್ ಕಳಿಸಿ ಈಗಲೇ. ಎಸ್,
ಹಿಂದೆ WP ಹಾಕಿ ಅಪೀಲ್ ಹಾಕಿ, ಅಪೀಲ್ ಅಲ್ಲಿ ರಿಮಾಂಡ್ ಮಾಡಿ, ಅದು ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ಮತ್ತೊಂದ್ಸಲ ಅಪೀಲ್ ಹಾಕಿ, ಆಮೇಲೆ ಇಲ್ಲಿ ಬಂದಿದೆ.
ಮತ್ತೊಂದ್ಸಲ ಕೇಳ್ಬೇಡ ಬಿಡಿ, ಆಫ್ಟರ್ ವೆಕೇಶನ್. ಎಸ್, ಆಫ್ಟರ್ ವೆಕೇಶನ್.
ಅಲ್ಲ, ಯಾವತ್ತು ಹಾಕ್ಬೇಕು?
ಆಫ್ಟರ್ ವೆಕೇಶನ್.
ಅಲ್ಲ, ಅದು ಇಷ್ಟೇ ಪಾಯಿಂಟ್ ಇರೋದು. ಅವರು ಅನೆಕ್ಸರ್ K may kindly be seen
immediately after vacation. Yes. Next.
One submission regarding
17118 adjourn ಆಗಿದೆ madam.
No, they have not informed me before taking the adjournment, my lords.
ಸಂಜಯ್ ಚಾನಲ್ ಏನ್ urgency ಏನು?
Urgency, there is no interim protection, my lords. Land acquisition matter, my lords.
What kind of protection you want?
Not to carry any excavating activities in my land.
Why? Acquired ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ, only under preliminary notification. No final notification.
Madam, preliminary notification ಯಾರಾದ್ರೂ ಮಾಡ್ತಾರೆ ಮೇಡಮ್?
No, they have already constructed in my started constructing in my neighboring land, my lords.
ನೀವೆಲ್ಲಿ US ಅಲ್ಲಿ ಇದ್ದೀರಾ?
ಹಂಗಲ್ಲ.
ಅಲ್ಲ, ನೀವೆಲ್ಲಿ ಅಲ್ಲಿಲ್ವಾ ಪಕ್ಕದಲ್ಲಿ? ನೀವು ಅಮೆರಿಕಲ್ಲಿ ಇದ್ದೀರಾ?
No, my lords. ಅಂದ್ರೆ
ಎಲ್ಲಿದ್ದೀರಾ ಮತ್ತೆ ನೀವು?
In Bag.
No, ಇಲ್ಲಿದ್ರೆ ಸಾಧ್ಯವೇ ಇಲ್ಲ ಅದಾಗಕ್ಕೆ.
ಅಲ್ಲ, we have filed the objection, they did not consider it.
ಆಯ್ತು, we'll take it on Monday.
Previous matter
118 Monday.
ಅಲ್ಲ ಸಾಹೇಬ್ರೆ,
ಅದ ಇದು ಕಲ್ಯಾಣ್ ಶೆಟ್ಟಿ ಸಾಹೇಬ್ರದ್ದು ಅವತ್ತೇ ಹಾಕಿ ಮಂಡೇ.
ಅಲ್ಲ, ಪ್ರೀವಿಯಸ್ ಮ್ಯಾಟರ್ 86 87 ಇಯರ್ಸ್
ಹೇಳಿ ಸರ್ ಮಂಡೇ ಅಂತ.
119, my lord. Compensatory job, my lord. 3 compensatory job, my lord. Compensatory apartment, lord.
After vacation.
No, my lord, 3 daughters are.
Unless you tell properly, after vacation.
No, my lord. Compensatory apartment.
After vacation. Yes.
Compensatory apartment. Compassionate apartment.
Monday fresh matters.
Right, sir.
120. All of you should.
Petitioner has attained superannuation in the year 2023, my lord.
ಯಾವುದು ಸರ್?
120, my lord.
ಏನಾಯ್ತು?
Leave encashment and time bound increment payment are not received, my lord.
Immediately after
ಅಲ್ಲ,
vacation.
only mandamus,
ಸರ್.
mandamus, my lord.
ಬೇರೆ ಎಲ್ಲ ಬಂದಿದೆ ತಾನೆ?
ಇಲ್ಲ, ಬೇರೆ ಏನಿಲ್ಲ. Mandamus, page number 14, annexure C, my lord. Only mandamus. Government has to consider, my lord. Application is forwarded by.
Fresh matters.
Please, much.
121, me and Moolimani.
Guest lecturer after vacation, yes. Hirangoda Kapoor after vacation.
123, 124 again. 125.
Appear for petition, Mulats. I had filed an affidavit. I had filed an affidavit, Mulats.
Sachin.
In terms of,
Lord, filing objection Malad, for the affidavit.
Affidavit objection na.
Yes, my lord.
Yen problem nimge ಹೇಳಿ.
My lord, there is outstanding is more than 3 crore 80 lakhs rupees.
2 crores is already paid. In terms of the
Monday,
interim,
fresh matters.
interim order.
Monday, interim order will continue till the next day.
Great.
126, Sarsteshai.
My lord, there is some urgency, my lord. My lord, election matter, my lord, in view of the interim order passed by this honorable court, my lords, we have, my lords, cast there our votes. Now respondent is directed to consider our representation, my lords, last 23rd, my lord, that was considered Monday, my lords, if they have produced.
Monday, fresh matters.
Please, my lords, much.
127.
My lord, so regarding officiating allowance,
After vacation. Objection ಬೇಕು.
kindly my interim prayer may be considered.
Interim prayer ಅಲ್ಲಿ final prayer ಕೊಡಕ್ಕಾಗುತ್ತಾ madam?
ಇಲ್ಲ, final
After
ಏನಿಲ್ಲ.
vacation. ಎಲ್ಲ ಒಂದೇ ನಾನು ನೋಡಿಲ್ಲ.
At least any date may be fixed.
After vacation?
No, next week.
No. Right. Yes, yes.
128.
After vacation.
After.
Interim order.
Thank you, sir. Interim order ಇದೆಯಾ?
Plus
AVIO, yes.
plus 129 plus senior reserve. Plus
129
senior reserve.
I'm sorry, my lord, my apologies to your lords once again, what happened earlier.
ನಿಮ್ದು ಯಾರು ಫೋನ್ ಮಾಡಕ್ ಹೇಳ್ದವ್ರು ಅವ್ರಿಗೆ? ಯಾರು ಎಲ್ಲಿದ್ದೀರಾ? ಮತ್ತೆ ಅದಕ್ಕೆ ಅವ್ರು ಇದೀನಪ್ಪ ಅಂತ ಹೇಳಿ.
I'm sorry, my lord, my apologies. My lord, your lordships have granted an interim order.
After vacation, AVIO, next.
ಇಲ್ಲ ಇಲ್ಲ, ಒಂದೇ ಒಂದು
ಮಾಡಿ ಆಮೇಲೆ AVIO.
ಅಲ್ಲ, ಕ್ಲಾರಿಫಿಕೇಶನ್ ಅಷ್ಟೇನೆ. ಅವರು ಯೂನಿಟ್ 1 ಗೆ ಬೆನಿಫಿಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಯೂನಿಟ್ 2 ಕೊಡ್ತಾ ಇಲ್ಲ, ಅಷ್ಟೇನೆ ಕ್ಲಾರಿಫಿಕೇಶನ್, ಇನ್ನೇನಿಲ್ಲ.
ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು?
Shabajan Hussain.
Your lordship, I appear for the respondent number 2 SLDC, your lordship.
Yes, madam. Unit 2 ಕೊಡಲ್ವಾ?
Your lordship, ಈ ಕೇಸಲ್ಲಿ interim order ಇಲ್ಲ, your lordship. ಈ ಕೇಸಲ್ಲಿ the direction was restricted to the fact that we will not collect the SLDC charges. It will be collected.
List the matter on 17th in fresh matters. Yes, next.
Please, ma'am.
Obliged, your lordship.
Lords, in this matter, lords, during COVID-19, lords, surgical instrument to the tune of rupees 2.5 crores were supplied to the government, lords. They had even sought a report. Lords, let them release only an admitted amount, lords.
Admitted amount ಎಷ್ಟಿದೆ?
2.5 lords, 48 crores.
Admitted amount ಅದು.
ಅಷ್ಟೇ. Page 25, lords.
Monday, we'll dispose it on Monday, fresh matters, yes.
Great.
121 Arjuna.
132.
132.
After vacation, yes. ಒಂದ್ ನಿಮಿಷ, ಇದು ಹಸ್ಬೆಂಡ್ ಕೇಸ್ ಸ್ಟೇ ಇರುತ್ತೆ. 132 ಯಾರಿಲ್ವಾ?
134 Uday Gachimmat.
Yes.
134, 133.
132 ಆಯ್ತಲ್ಲ? 133 ಅಡ್ಜನ್ ಆಗಿದೆಯಾ? 133.
133 is a matter where my lords were going to issue general directions in respect of interference by the police in recreation clubs.
ಮಾಡಿದ್ದೀನಲ್ಲ?
ಅಲ್ಲ, ಇದು ಡಿಸ್ಪೋಸ್ ಮಾಡ್ತೀನಿ ಅಂತ ಅಂದಿದ್ರಿ, that matter that time.
ಸಿನಾಪ್ಸಿಸ್ ಹಾಕಿದ್ದೀರಾ?
ಅದೇ my lord said
list Monday fresh matters.
Please. There is an undertaking on the last occasion given that has been.
No, it will cut down litigation, will do something.
Please.
After vacation 134.
No, 134 lords, suspension order. He honored.
ಹೇಗಿದೆಯಾ?
Stay there, lords. It will not take more than 5 minutes.
ಏನು?
He honored somebody, my lords. That is the allegation. That is why he
honored somebody.
ಅದೇ ಯಾರೋ RT activist ಬಂದಿದ್ರು, ಅವ್ರನ್ನ ಆನರ್ ಮಾಡಿದ್ದಾರೆ, ಅದಕ್ಕೆ ಇವರು ಸಸ್ಪೆಂಡೆಡ್ ಅಂತ ಹೇಳಿ.
ಅಷ್ಟೇನಾ?
ಅಷ್ಟೇ.
Monday fresh matters.
Great.
ಅಲ್ಲ ಅಷ್ಟೇ ಆದ್ರೆ
ಅಷ್ಟೇ, ಈಗಲೇ ಹೇಳ್ಬಿಡ್ತೀನಿ.
ಸರಿ, ಅಲ್ಲ ನಾನು ಈಗಲೇ ಮಾಡಕ್ಕಾಗಲ್ಲ, ಮಂಡೇ ಮಾಡ್ತೀನಿ.
135.
135 interim order may be extended. Notice may be ordered, my lords. I have served a hand summons, but they are not.
Emergent notice to the respondent, interim order subsisting would continue to the next date. Yes, next.
136.
My lords, 136 can be posted after vacation.
Will be posted, sir, after vacation. Yes.
137 Arjuna. 138.
My lords, Monday, my lords, 138.
Karana?
My lord's wife has filed for maintenance. My lord, she's a second wife. She has no other means to maintain herself.
Second wife has no other means.
My lord, she has taken care of. It is the first wife who has helped in getting marriage of the second wife because she is not having any children, my lords. First wife is not having any children, so she consented for the second marriage, my lords.
Second wife has?
Even she has no children, my lords.
ಅಲ್ಲ ಆಮೇಲೆ ಇನ್ನೊಂದು ಆಫ್ಟರ್ ವೆಕೇಶನ್ ತಗೊಂತೇನೆ.
That's Monday.
ಆಮೇಲೆ ಥರ್ಡ್ ವೈಫ್ ನೋ ಚಿಲ್ಡ್ರನ್ ಫಾರ್ 1 and 2 ಅಂತ ವಿಲ್ ಕಮ್.
That is may be
Yes.
taken on Monday, my lords.
Hmm?
Monday, my lords.
No, after vacation. Yes.
139.
My lord, State Bar Council, Bundelkhand University, that degree
141.
certificate, my lord.
Oh.
Criminal prosecution has been ordered.
ಬಂಡಲ್ಖಂಡ್ ಎಲ್ಲ ಏನಿಲ್ಲ.
Degree certificate, not the law certificate, my lord.
After lapse of 23 years, my lord, he has started with a BA degree, my lord.
ಹೌದಾ?
12 years, 12 years, more than 12 years. Yep.
PUC has completed in the year 1994.
94 PUC ನಾ?
Degree 2017. he
17.
ಏನ್ ಮಾಡಿದ್ರಿ ಅಷ್ಟು ದಿನ?
And when we have sought for the address of residential
ಇಲ್ವೇ
address
ಇಲ್ಲ
of,
ಅಲ್ಲಿ ಅಷ್ಟೇ.
He has joined law, man.
ಅದೊಂದೇ ಸಿಗೋದು ಎಲ್ಲ 20 ವರ್ಷ ಆದ್ಮೇಲೆ. ಆ ಕಾಲ ಹೋಯ್ತು ಸರ್.
With great difficulty, he has passed the exams.
Yes.
Criminal prosecution has been ordered.
ಕರೆಕ್ಟ್ ಆಗಿದೆ. ಅದ್ಲೇನ್ ಡೌಟ್ ಇಲ್ಲ. Such people should not be spared. ಅದೊಂದಿತ್ತಲ್ಲ ಯಾವುದು? ನಾಳೆ ಇದೆ, ಸರಿ. So we'll dismiss this. Dismissed.
Yes, my lord.
140. Practicing certificate.
Huh?
Tax matter. Delay in filing.
After vacation, yes.
Kindly wait on Monday. 141.
GM Police.
My lords, item 141, I seek to assist on behalf of the petitioner, my lords.
ಅದೇ ಇದು ಗ್ಯಾನ್ ಕೊಟ್ಟಿದ್ದಲ್ವಾ? ಸೊ ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ವೆಕೇಶನ್. ನಾವು ಒಬ್ಬರೇ ಯಾಕೆ, ಬೇರೆಯವ್ರಿಗೂ ಕೊಡಿ. Yes.
No, my lords,
Yes,
consider.
next.
My lords,
Interim order subsisting will continue to the next meeting.
no, there is no interim order in that matter.
Yes, next. ಏನು ಇಲ್ವಾ ಆಫ್ಟರ್ ವೆಕೇಶನ್? ಎಸ್.
142 adjourned. 143.
143, my lord. For petitioner, my lord. My lord, respondent 5 to 10 were refused to accept hand summons.
Refusing?
Respondent 5 to 10 were refused to accept hand summons, my lord. We are filed.
Affidavit ಹಾಕಿದ್ದೀರಾ?
Yes, my lord.
The learned counsel for the petitioner submits respondents 5 to 10 have refused hand summons. Therefore, is filed an affidavit. In the light of the refusal, respondents names of respondent 5 to 10 be shown as served.
Kindly show emergent notice, my lord.
ಆಯ್ತು, ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಟು ರೆಸ್ಪಾಂಡೆಂಟ್ 5 to 10. ಶೋನ್ ಅಂತ ಹೇಳಾಗಿದೆ, ಮತ್ತೆ ಹಾಕ್ಬಿಡಿ. ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ದೀರಾ ಇಲ್ವಾ?
Yes, my lord.
ಸರಿ, ಏನ್ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಬೇಡ. ನೆಕ್ಸ್ಟ್.
144.
Lords, respond number 6, my lords. They have not accept the hand summons, my lords. I have filed affidavit, my lords.
Same order. Yes.
Consideration interim prayer, my lords, Monday.
Interim prayer. ನಿಮಗೆ ಯಾಕೆ ಇಂಟ್ರಿಮ್ ಪ್ರೇಯರ್?
ಅಲ್ಲ, interim
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿದಾರಾ?
ಇಲ್ಲ, ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿಲ್ಲ.
ಮತ್ತೆ APMC ಗೆ ಯಾಕೆ?
ಇಲ್ಲ, ಇದು PDS matter, my lords. Food grains supply, my lords. I have the till today, my lords. I have supplying the food grains, my lords.
Status quo way, the cards be maintained till the next date of hearing.
Please.
Yes, next. Affidavit ಹಾಕಿದ್ದೀರಾ ನೀವು? ಆಯ್ತು, yes.
145. Madhavi Mar.
After vacation.
146.
Same.
My lords, it's tax matter, my lords. Account is freezed, my lords.
Immediate 5th January. Yes, next.
147.
My lords, this one is a wife's petition, my lords. Family court matter.
Yeah, respondent here.
Respondent, my lords, is a cavator. I have served him, my lords.
Not appeared?
Not appeared, my lords. He has filed.
List on Monday in
My
fresh
lords, my lords,
matters
there's
list.
urgency because tomorrow's is a date, my lords. And
ಒಂದ್ ನಿಮಿಷ. List on Monday in the fresh matters list. Further proceedings before the concerned court shall remain stayed.
please.
Yes.
Hand delivery, my lords.
Yes.
Please, interim order.
IVIO, next. Sunil, this is
Yes,
149.
Timeline 90 days is the fixed tender notification. Timeline is not been.
ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಸ್ವಾಮಿ, 90 days ಮೇಲೆ ಫ್ರಮ್ ದ ಡೇಟ್ ಆಫ್ ಲಾಸ್ಟ್ ಟೆಂಡರ್ ಕಾಲಿಂಗ್ ಆಫ್ ದಿ ಅಪ್ಲಿಕೇಶನ್ ದಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಕ್ಯಾಲ್ಕುಲೇಟೆಡ್ ಫ್ರಮ್ ದಟ್. ಹಂಗ್ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿದ್ರೆ 2 months 6 days ಆಗ್ತದೆ. ಬಿಕಾಸ್ ಆಫ್ ದಟ್ ರೀಸನ್ ಮಿಲಾರ್ಡ್ಸ್ ಎಂಟೈರ್ ಮಿಲಾರ್ ಪ್ರೊಸೆಸ್ ಅಲ್ಲ.
ಒಂದ್ ನಿಮಿಷ. ಟೆಂಡರ್ ನೋಟಿಫಿಕೇಶನ್ ಡೇಟ್ ಏನು?
18/11.
18/8.
18/8.
Please. 2025.
2025.
Yes.
Please.
All right. ಅದರ ಲಾಸ್ಟ್ ಡೇಟ್ ಏನಿತ್ತು?
That's last date.
Date, my lord.
ಡೇಟ್ ಹೇಳಿದ್ರೆ ಅನಕ್ಷರಿ ಅಂತ.
Let's space 60 minutes. Last date is 18/9/2025.
18/9.
Receipt of tender.
2025.
2025.
Yes.
All right. ಟೆಂಡರ್ ವ್ಯಾಲಿಡಿಟಿ ಪೀರಿಯಡ್ ಎಷ್ಟಿದೆ?
90 days.
ಯಾವತ್ತು ಮುಗಿಯುತ್ತೆ?
Let's as of my
ಯಾವತ್ತು ಮುಗಿಯುತ್ತೆ?
My lord, it is 19/11.
19/11/2025.
Yes. And most importantly, my lord, even has circular timeline, technical bid is also not, my lord, open till today.
ಈಗ ಎಂಟ್ರಿ ಮಾಡಿದೆ ಅಲ್ವಾ?
ಇದೆ.
ಏನ್ ಅರ್ಜೆನ್ಸಿ ಸರ್?
ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಫೈಲ್ ಮಾಡಿದ್ರೆ
ಮಾಡಿ ಅದ್ರಲ್ಲಿ ಏನಿದೆ?
bid is open.
Copy.
ಅಲ್ಲ ಇದು ಡೇಟ್ಸ್ ಕರೆಕ್ಟ್ ಆಯ್ತು?
1812 as per my the
ನಿಮ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಅಲ್ಲ, ಈ ಡೇಟ್ಸ್ ಕರೆಕ್ಟಾ?
from the notification I'm telling that date of last date and timing receipt of tender is 18/9. From 18/9 if calculation is 90 days.
18/9 90 days ಅಂದ್ರೆ it is 1912 ಆಯ್ತು.
ಹೌದು. ಅದಕ್ಕೆ they are taking date of notification in the paper publication. That is not so in the notification.
Yes, 1912.
1912.
Now kindly see, that is why I said circular.
ಸ್ಟೇ ಆಗಿದ್ದು ಯಾವತ್ತು?
Stay 24/11.
sir.
24/11. Anything else, Sunil Desai?
No, timeline, my lord, even technical bid has prescribed in the timeline is not been, my lord, adhered.
Yes.
Can you see the circular, my lord? Lordship says,
Anything else?
nothing has been done in the tender, my lord. They are kept quiet for all.
The petitioner is before this court seeking the following prayer. The file kudiyadu.
Lord, take note, my lord, page number 63, my lord.
Dates are stubborn.
No, I know. Can you see, but your lordship says in, my lord, the other matter has held that, my lord, if it is 90 days, the timeline prescribed in the schedule is to be, my lord,
ಇವಾಗ ಹೋಲ್ಡ್ ಮಾಡ್ತೀನಿ.
In this case, nothing has been done. It is contrary to the circular. My lord, 89. Yes.
One minute.
Please.
Nothing has been done because of you.
No, not
24/11 ಗೆ 1912 ಗಿತ್ತು ಸರ್ ಡೇಟ್.
ಅಲ್ಲಲ್ಲ,
ಇನ್ನು 1912 ಬಂದೇ ಇಲ್ಲ ನಾವು.
ಅದು ಎಕ್ಸ್ಪೈರಿ ಗೆ, ಅದು 90 days expiry ಗೆ.
ಪರವಾಗಿಲ್ಲ.
Kindly see page number 61 for a moment.
No problem.
61 for a moment.
Yes sir.
61. It says, my lord, evaluation has to be start on or before 30th day.
ಈಗ ಮಾಡ್ತಾರೆ ಈಗ ಅದೆಲ್ಲ.
ಅಲ್ಲಲ್ಲ.
That timeline,
2 months, more than 6 months.
The interior timeline, that is the timeline within the timeline is directory. I will write, no problem. ಅದೊಂದು ಇವತ್ತು ಇದು ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ಇವತ್ತೇ ಮಾಡ್ಬೇಕು.
Kindly see, my lord, as per the page number 60 for a moment.
ನಿಮ್ದೇನ್ objection comment?
Page number 60.
Kindly see, in page number, my lords, in page number 7 of my objections. My lords, he has participated in the technical bit.
Now let them say, my lord, I have produced this status report.
You have not participated, huh?
Okay, kindly see this 63.
Yes sir, no.
No, as per my information, party has.
It's a very smart way of telling.
So that is why I asked, my lord, to take out the evaluation status of as on the date of filing of a writ petition.
That's all right.
Kindly see page number 63.
Petitioner.
My lord, 60 for a moment, 63 may kindly be. Page number 63. Okay, what technical?
Timeline ತಾನೇ ನೀವು ಹೇಳ್ತಿರೋದು.
ಅಲ್ಲ 63. ಅದು ಟೆಂಡರ್ ನಲ್ಲಿ this is, my lord, as on the my lord, before filing 2023 is the status.
Technical
that is what, my lord.
Para 10 of my objections.
ಯಾವಾಗ
ಈಗ ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
Let me see. ಅಲ್ಲ I heard.
ಈಗ ಕೊಟ್ಟಿಸಿ ಈಗ ಸರ್ ನಾಳೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್.
ನಾಳೆಗೆ ಆಗುತ್ತೆ ಅಲ್ಲ ಅಕೌಂಟ್ ಕ್ಲೋಸ್ ಆಗಿ ನೋಡೋಣ ಬಿಸಿ ನಾಳೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್. ಬಟ್ ಕಷ್ಟ.
ಅಲ್ಲ ಬಟ್ ಅದು ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಆಗಿದೆ.
Will write now. The timeline within the timeline is directive.
No, but it can't be, my lord, more than, it should not be more than, my lord.
Sir, more than 90 days ಆಗ್ಲೇಬಾರದು. That doesn't mean ಒಂದು ವಾರಕ್ಕಿದು 15 ದಿನಕ್ಕಿದು. We can't hold them like that.
No.
They should complete it within 90 days.
Yes, my lord. But 60 days nothing has been done.
That we'll see. Yes. ನಾಳೆ.
Yes.
Fresh matter.
Fresh. ನಾ ಇರೋದೇ fresh.
Interim order. Interim order may be.
Interim order continues. Yes.
I am for the petitioner, my lord.
150?
I am for the petitioner, my lord. Husband's petition.
After vacation.
Grateful, ma'am.
ಇದು ಏನಿದೆ ಮ್ಯಾಟರ್?
Husband's, it is been posted for judgment, my lord. PW1 ಗೆ
interim maintenance.
Interim maintenance. Please, my lord.
ಎಷ್ಟು ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ?
ಇವ್ರು ಕೇಳಿದ್ದಾರೆ 10,000 ಬಟ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ 12,000, my lord.
ಓ ಪರವಾಗಿಲ್ಲ ಬಿಡಿ, ಏನ್ ತೊಂದ್ರೆ. ಸ್ಟೇ ಇದೆಯಾ?
ಪ್ಲೀಸ್ ಮಾಡ ಸ್ಟೇ ಇದೆ.
After vacation, yes. Next.
Madam, interim may kindly be extended, my lord.
That will continue. Passport. Monday fresh matters. Yes.
152. Please, lord.
What judgment?
My lord, it's Tuesday, my lord.
Covered ಯಾವುದು?
152 I'm.
ಏನ್ ಕವರ್ಡ್?
Covered ಆದ್ಮೇಲೆ ಅಂಗನವಾಡಿ teachers workers helper.
ಏನ್ ಅಂಗನವಾಡಿ?
I am the appointed as ಅಂಗನವಾಡಿ helper. The promotion as ಅಂಗನವಾಡಿ.
Oh, that matter. Stay ಇದೆಯಲ್ಲ? Yes, AVIO. Next.
Allowed on submission. Already
ಇಂಟ್ರಿ ಮಾಡಿದೆ ಸರ್. Yes.
tomorrow madam.
ನೀವು ಕಂಟಿನ್ಯೂ ಆಗ್ತಾ ಇದೀರಾ ತಾನೆ?
ಇಲ್ಲ ನಾ ಪ್ರಮೋಷನ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿಯರೇ. ಪ್ರಮೋಷನ್ ಆರ್ಡರ್ ಮಾಡಿಲ್ಲ. Because of that reason only I am.
ಈಗ ಆಗಿದೆಯಲ್ಲ ಮೇಡಮ್? ಈಗ ಆಗಿದೆಯಲ್ಲ? ಪರವಾಗಿಲ್ಲ. ಈ 2 ತಿಂಗಳು ತಾನೆ? ಈಗ ಆಗಿರ್ತಾರೆ. ಈಗ ಆಗಿದ್ದೀರಾ?
ಇಲ್ಲ ಆಗಿದೆ. In identical matter the same contention and same fact madam. Page number.
Guidelines, earlier guidelines.
ಕೊಡೋದು ಸರ್. ನಾಳೆ ಆಗುತ್ತಾ?
Page number 31 my lord.
ಮ್ಯಾಟರ್ ಬರಕ್ಕೆ.
Page number 31 my lord.
ಆಗುತ್ತಾ? ಲಿಸ್ಟ್ ಕ್ಲೋಸ್ ಆಗ್ಬಿಟ್ಟಿರುತ್ತೆ ಅಂತ.
Page number. Page number please ma'am. Tomorrow.
ಆದ್ರೆ ಇಲ್ಲ ಅಂದ್ರೆ ಮಂಡೇ ಫ್ರೆಶ್.
Please. Entry ಮಾಡು. Please.
153 Omkar Lakshman Desai.
After vacation. After vacation.
4.
My lords, covered by decision, your lordship, page number 38.
After vacation. Yes.
My lords.
ಯಾರಾದ್ರೂ ಮಾಡ್ತಾರೆ.
155 adjacent.
ಅದಕ್ಕೂ ತೊಂದರೆ ಆಗುತ್ತೆ ನಿಮಗೆ? ಇಲ್ಲ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಕವರ್ಡ್ ಬೈ ಇದ್ರೆ ತೊಂದರೆ ಆಗುತ್ತೆ.
The building permission, my lord, 3 meters land to be relinquished.
Yes.
Next.
156 for the petitioner lords. This case punishment transfer of the KSRTC driver cum conductor, wherein on 6/12/2025, the very department has partially recalled the transfer order. Who has not appeared, approached this honorable court, those persons has recalled and reinstated in the same place.
ಪ್ರಶಾಂತ್ ಬರ್ಲಿ.
ಯಾವ್ದು ಮಾಡಿದೆ? ರೀಕೌನ್ಸಿಲ್ ಹೋಗು.
Please.
ಜೂಮ್ ಮಾಡಿ.
Please.
Next.
157. Kumar.
After vacation. Advocates Association ಬಾಗಲಕೋಟೆ.
Advocates Association.
ನಾಳೆ ತಗೊಳ್ಳ? ಎಲ್ಲಿ ಏನಾಗಿದೆ? ಏನ್ ಮಾತಾಡಿದ್ರಾ?
Allah. We are filing affidavit, my lord. So committee members have not published that.
So what happened is, your lord.
Now affidavit ಆಗ್ತಾ ಇದೆ.
So let them file the affidavit. No, I just want to bring certain facts on record. Without serving the copy
of affidavit.
Allah, not affidavit, of the removal order. It has been, Lord, circulated to other members and other members have circulated,
You want
Lord,
a
in the
judicial
WhatsApp.
order noticing that it cannot be done and all, I'll pass an order. Not a problem. Don't worry about it.
No.
If they have filed an affidavit, if you want to, ಇವ್ರೇನ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ರೆ ಏನಾರು ನಿಮ್ಮ ಮೇಲೆ?
ಇವರು before they are, my lord, they have filed a complaint. ಅವ್ರ ಕಮಿಟಿ ಮೇಲೆ ಹಾಕೊಂಡಿದ್ದಾರೆ. ನಾನು ಅದು ಬೇಡ, ಎನ್ಕ್ವೈರಿ ಬೇಡ ಅಂತ ಇದ್ದೀನಿ.
ಆಯ್ತು, ನಾಳೆ ಮುಗಿಸು.
ಮಂಡೆಗೆ ಹಾಕೊಂಡ್ಬಿಡಿ.
ಮಂಡೇ ನಾಳೆ ನಿಮ್ ಎಲೆಕ್ಷನ್ ಇದೆ.
ಅಲ್ಲ, ನಾಳೆ ಇಲೆಕ್ಷನ್ ಇದೆ, ನಮ್ದು ಇಲೆಕ್ಷನ್ ಇದೆ.
ಅದೇ ನಿಮ್ದು ಎಲೆಕ್ಷನ್.
ಅದಕ್ಕೆ ಮಂಡೆಗೆ.
ಮಂಡೇ ಫ್ರೆಶ್.
Please.
Interim order may continue.
Interim order will continue, but Monday will close it, Srinivas Naik. What order you want to protect your honor, we will do it. Don't worry about it. But that what they have done is incorrect.
ಇಲ್ಲ, ಇವ್ರು ಮಾಡಿಲ್ಲ. ಇವ್ರು filing affidavit.
ಯಾರೋ
some advocates have done it.
No,
not this person.
I'll tell you, mudslinging should not happen before the bureaucrats. That's all.
Because how come, Lord, the order had gone to the hands of the other members without reaching me? I am the affected person.
ನಿಮಗೆ ಬಂದಿಲ್ಲ?
ಬಂದೇ ಇಲ್ಲ. And through WhatsApp, I came to know that, Lord, such a order is been passed. ಹೌದು, removal order.
It was placed on the notice board, my lord. All advocates have taken.
No, it was never placed on the notice board.
Monday.
ನಾನು ಹೇಳಿದ್ದೇನೆ, affidavit ಅಲ್ಲಿ ಹೇಳಿದ್ದೇನೆ.
Please.
Monday fresh matters.
Please.
158.
For petitioner, separate award. Mandamus.
Monday fresh matters.
159 Omkar Lakshman Desai.
After vacation. Ella after vacation. 160 after vacation.
161
after vacation.
163 Asifram Galgali.
After vacation.
164.
163 my lords, interim orders.
Interim order will continue.
164.
Retirement.
72 years, my lord, 72 years, my lord, arrears of pension.
ಯಾಕೆ arrears?
Lord, his, my lord, date of retirement was, my lord, 12/11/2015. Somebody gives complaint that his date of birth is something. My lord, I am compulsory retired from it. I am seeking for retirement benefits for 4 years by university.
Yaar university?
Mr.
KL Patil.
KL Patil, sir.
Patil, sir.
Yes, ma'am.
Hello, Marbonma.
Monday.
Monday ಮಾಡೋಣ. Monday fresh matters, yes.
165 adjourned.
Hmm.
166.
In this, I filed application for vacating. Election process is stayed.
ಯಾವ್ದ್ರಲ್ಲಿ?
166.
Ah.
Election process is stayed.
What has happened?
I
There was a
filed
defect in the election list. I filed a petition before DRCS. He stayed it. Afterwards, my lord, after 2 days, he got a discussion with some all the officers. He's a society, he's a society.
ಒಂದ್ ನಿಮಿಷ.
It
We'll
is
set
the
it aside,
government who
send
has-
it back.
Yes.
My lord, the
No, interim order restore ಮಾಡಿ, ವಾಪಸ್ ಕಳಿಸಿ, ತೀರ್ಮಾನ ಮಾಡಕ್ direction ಕೊಡಿ.
Halal, the special officer is appointed for verification of the voters list. He has called for objections.
No, once he has
Published.
passed the order, how did he even recall it?
My lord, afterwards he took the instructions and thereafter he has vacated.
ನಮ್ಗೆ ಗೀರೆ ಮಾಡ್ಲಿಲ್ಲ.
ಅಲ್ಲ, ಯಾರ ಇನ್ಸ್ಟ್ರಕ್ಷನ್?
ಅಲ್ಲ, here ಮಾಡೇನೋ ಕೊಟ್ಟಿಲ್ಲ.
ಯಾರ ಇನ್ಸ್ಟ್ರಕ್ಷನ್? What kind of instruction?
I will submit. They filed some objections regarding voter list. There is some irregularity.
ಎಕ್ಸ್ ಪಾರ್ಟಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಕೊಟ್ರು, ತೊಂದ್ರೆ ಇಲ್ಲ. ಯಾರನ್ನ ಕೇಳಿ ವಾಪಸ್ ತಗೊಂಡು ಅವ್ರನ್ನ ಯಾರು ಕೇಳಿದ್ರ? ನೀವು ಪ್ರೈವೇಟ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೊಂಡ್ಬಿಟ್ರ?
ಅಲ್ಲ, ಸ್ಟೇ ಕೊಡ್ಬೇಕಾದ್ರೂ ಯಾರನ್ನು ಕೇಳಿಲ್ಲ.
ಕರೆಕ್ಟ್.
Nobody was heard. Only on the
ಸ್ಟೇ
objection.
ಕೊಡ್ಬೇಕಾದ್ರೆ ಯಾರನ್ನು ಕೇಳಿಲ್ಲ ಅಂತ ವೆಕೆಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಯಾರನ್ನು ಕೇಳಬಾರ್ದು.
Andre, not special officer is appointed for verification of voter list. He has called for objections. Let them place before him. He will take decision.
I will
The
set
present-
aside the recalling order,
Yes.
restore the interim order, send it back with a direction of timeline to close it. That is the best order you will get, otherwise AVIO.
No, my one submission. It is to be verified by the election officer only, not by the any officer. Voter list to be.
Accordance
Therefore,
with-
I made a
ಒಂದ್
complaint.
ನಿಮಿಷ, dispute ಅಲ್ಲಿ ಇದೆಯಾ ಈಗ?
ಇದೆ.
Whatever you want, you can urge before the DRCS.
Yes.
ARCS, he will pass an order.
He cannot, my lord, declare the valid voters list. It is the election officer before whom, my lord, let them place material. He will take decision.
So he has not taken that,
ಅದು
therefore I
election-
went there.
ಯಾಕಂದ್ರೆ ಎಲೆಕ್ಷನ್ ಆಗ್ಲಿ,
Please.
ನೀವು ಎಲೆಕ್ಷನ್ ಅಗೇನೆಸ್ಟ್ ಇದ್ದೀರಾ?
Against ಅಲ್ಲ ನಾವು ಅದಕ್ಕೆಲ್ಲ.
ಅಲ್ಲ,
My lord, in that list. there
The
are, my lord,
opportunity will be given
about,
to
my lord,
them.
500 to 600 members are dead persons.
Let-
My lord,
let
about
it be-
500 to 600 eligible voters. I have given my lord list saying that these are the persons, you delete them and hold election.
Lord, kindly see, my lord.
I am not seeking stay
Statement.
of election.
The-
I am seeking only, my
ಒಂದ್
lord,
ನಿಮಿಷ, ಈ ಡೆಡ್ ಪರ್ಸನ್ ವೆರಿಫಿಕೇಶನ್ ಅವರೇ
My
ಮಾಡ್ಬೇಕು,
lord,
ಅಲ್ಲೇ ಮಾಡಿ.
let them make,
ನಾಟ್ ದಿ ರಿಟರ್ನ್.
returning officer ಅಂತ.
one officer is appointed
ನಿಮಿಷ.
for scrutiny of the voter list.
ಒಂದ್ ನಿಮಿಷ ಸರ್, ರಿಟರ್ನಿಂಗ್ ಆಫೀಸರ್ has drawn 500 dead names and
Yes. No, no.
ask him only to do it?
Kindly,
Never.
kindly
That's the
see.
difficulty,
Lord,
my lord.
two
We
officers.
will ask the independent authority to do it. Now
My
it
lord.
is before the ARCS. He will do it.
My lord, he is a private person.
No, no,
It
he
is
will-
government
No, no.
who has to say
No,
it.
no.
Kulkarni
He
sir.
is a society.
He will do it. ARCS himself will verify it.
Yes.
I will not permit the returning officer to do it. Illa andre I will stall everything now.
Please, my lord.
Lord, kindly see, my lord, annexure
A
R3.
man who has drawn 50 dead names.
No, it is
we will-
false. my lord.
Allegation.
It is false. Kindly see the
No, a
reply
man who,
submitted by.
one minute. A man who has drawn 500 dead names.
It is wrong, my lord.
No,
It is
that
wrong
is the
submission.
allegation. And I permit him only to count those dead names?
No, not that
No,
person,
sir.
not that person.
No,
It
my
is
lord,
not
he
that
is a
person.
private respondent. It is the government who has to say it. How did he recall that order?
Please, my lords. Ex parte
Comment
interim,
stoic silence ಅಲ್ಲಿ.
Yes.
ex parte interim orders passed, my lords, after hearing both the parties.
Both
this
the parties.
order- But in the order,
Let him file affidavit, my lord. Or
After
affidavit
hearing
affidavit.
both the parties, it is
Yes,
recalled
yes.
ಅಂತ.
please, in the order, it does not depict so, but
ಅಲ್ವಾ? ಅದಕ್ಕೆ
I've
ಆರ್ಡರ್
sought the
ಏನಿದೆ ಲಾಸ್ಟ್
instructions.
ಎರಡು ಲೈನ್ ನನ್ನ ನೆನಪಿದೆ ಸ್ಟೇ
ಚರ್ಚಿಸಿ.
ಕೊಟ್ಟಾಗ.
I've seen.
ಬೇರೆಯವ್ರ ಜೊತೆ ಚರ್ಚಿಸಿ.
ಅಲ್ಲ, ಬೇರೆಯವರೊಡನೆ ಚರ್ಚಿಸಿ.
ಚರ್ಚಿಸಿ.
ಅಲ್ಲ,
ಆರ್ಡರನ್ನು ರದ್ದು
ಬೇರೆಯವರೊಡನೆ-
ಆದೇಶವನ್ನು ಹಿಂಪಡೆಯಲಾಗಿದೆ.
ಬೇರೆಯವರೊಡನೆ ಬಲ್ಲವರೊಡನೆ.
As-
Lord, what
as per
happened is.
ಚರ್ಚೆ ಇದೆ ಅಲ್ಲಿ.
ಚರ್ಚೆ
Please,
ಅಂತ
my lords, but
ಹೇಳಿದ್ದಾರೆ.
as per instructions,
ಇಂಟ್ರಿಮ್
both
ಆರ್ಡರ್
the parties were
ಕೊಟ್ಬಿಟ್ಟು
present.
ಇಟ್ಸ್ ಲೈಕ್ ದಿಸ್.
Please,
ಸಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಕೊಟ್ಬಿಟ್ಟು ಆಮೇಲೆ ಹೋಗಿ ಯೋಚನೆ ಮಾಡಿ ಬೇರೆಯವ್ರ ಹತ್ರ ಫೋನ್ ಮಾಡಿ ಮಾತಾಡಿದ್ ಕೊಡ್ಬೋದಿತ್ತ?
ನೀವು ತಪ್ಪು ಮಾಡಿದ್ದೀರಾ ಅಂತ.
Not like that. Lord, annexure.
ಅದೇ ಮಾಡಿರೋದು, ಬೇರೆಯವರೊಂದನೆ ಚರ್ಚಿಸಿ.
Annexure R1 may kindly be looked into. We have, the concerned officer has given the details of the voters list. After satisfying that,
ಅಯ್ಯೋ, ಎಲ್ಲ ಕುಲಕರ್ಣಿ ಸರ್, ಐ ಆಮ್
let
ನಾಟ್
them
ಆನ್
consider.
ದಟ್.
Lord, let them consider the voter list. I have no objection.
ಅಷ್ಟೇ ಹೇಳಿ.
ಆಯ್ತು. Time limit.
ಇಷ್ಟು ಚರ್ಚೆ ಬೇಕಾಗಿರ್ಲಿಲ್ಲ.
Whether he is,
ಅಲ್ಲ, the issue revolves around ಚರ್ಚೆ ಬೇಕಾಗಿಲ್ಲ.
whether he is, my lord, empowered to scrutinize, that is the problem.
Who?
The officer.
What is the choice?
Once, my lord, election process is.
That's, what is the choice? Tell me. In peculiar facts make peculiar orders. Can't help.
Let him verify, my lord, within time limit.
ನಾಳೆ. ಇದು ಡೇಟ್ ತಗೊಂಡ್ಬಿಡಿ ಎಲ್ಲ, ನಾಳೆ ಲಿಸ್ಟ್ ಮಾಡಿ ಮಾಡಿಸ್ಬಿಡಿ, ಆಮೇಲೆ ಸೈನ್ ಮಾಡ್ತೀನಿ ನಾಳೆ. ನೀವು ಎಲ್ಲೋದು
ಮಲೋಡ್ ಸೀಲ್ ನಂಬರ್
ಇವರು
167.
ಚರ್ಚೆ ಮಾಡಕ್ ಹೋಗ್ಬಿಟ್ರೆ ನಾ ಎಲ್ಲ ಅನ್ಕೊಂಡೆ.
ಇಲ್ಲ ನಾಳೆ.
ನಾಳೆ
167.
167, my lords. I seek, but on Tuesday, my lords, is urgency in the matter.
ಏನ್ ಅರ್ಜೆನ್ಸಿ?
I need to secure
That is
instructions.
appointment order, appointment, already they were appointed, my order has not issued.
No appointment
Subsequently, I
order.
challenge with this
Nothing is.
honorable court. Subsequently, see, Sanskrit University, Mr. Anup Deshpande is appear.
ಓ ಸಂಸ್ಕೃತ್ ಯೂನಿವರ್ಸಿಟಿ, ಎಸ್ ಮಂಡೇ
yes,
ಫ್ರೆಶ್
yes.
ಮ್ಯಾಟರ್ಸ್.
Monday, madam, Tuesday, my lord.
ಟ್ಯೂಸ್ಡೇ ಯಾಕೆ ಮಂಡೇ ನೀವು ಇರಲ್ವಾ?
Fresh matters, my lord.
ಸೀನಿಯರ್ ಇಲ್ಲ, ನೀವಿದ್ದೀರಲ್ಲ. ಮಂಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್.
Half of the trust
No,
members,
no,
I need to
ಓದ್ಕೊಂಡ್ ಬನ್ನಿ. ಶಿ ಇಸ್ ದೇರ್, ಓದ್ಕೊಂಡ್ ಬರ್ತಾರೆ, ಸುಮ್ಮನೆ ಇರಿ.
Please, please, my lord, please.
secure instructions on behalf of the trust, my lords.
ವೇಟ್ ಎಸ್
Please.
168, Sajid Ahmad Gudwala.
My lords, Mandam is seeking reinvestigation in CC number 1554.
I filed
Last
objections. I filed objections, Matla.
Wherein,
Day
my
before
lords,
yesterday.
accused has been arraigned as witnesses, my lords.
Yes, the 3-4 notices are given. He has refused to come to for investigation.
ಅಕ್ಯೂಸ್ ನ ವಿಟ್ನೆಸ್ ಹೆಂಗ್ ಮಾಡಿದ್ರಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅವ್ರ ಮೇಲೆ
ಮಾಡಬಾರ್ದು ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ.
ಮಾಡಬಾರ್ದು ಅಂತಲ್ಲ, ಅವ್ರ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಇತ್ತು ಸಮ್, ಇಲ್ಲ ಅಂತಲ್ಲ. ಫಾರ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ he never turned up.
17th ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್. ಎಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಎಲ್ಲಿದೆ?
ಹಾಕಿದೆ ಆಲ್ರೆಡಿ.
ಹಾಕಿದೆ.
Already
ಕಾಪಿ ಕೊಡಿ ಮತ್ತೆ.
169, Sunta Kansu.
ಕೆಲಸದಿಂದ ತೆಗೆದಾಕ್ತಾ ಇದಾರೆ. 130
ಯಾವಾಗ ಡೇಟ್ ಕೊಟ್ಟಿದಾರಾ?
ಕೆಲಸದಿಂದ
ತೆಗೆದಾಕಿದಾರೆ, ತೆಗೆದಾಕ್ತಾ
ಇಲ್ಲ, ತೆಗೆದು ಹಾಕ್ತಾ ಇದಾರೆ.
ಇನ್ನು ಹಾಕಿಲ್ವಾ?
ಹಾಕಿಲ್ಲ.
ಏನ್ ಮಾಡೋಣ ಈಗ?
Kindly have it Monday, man.
ಮಂಡೇ, ಎಸ್ ಮಂಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್. ಯಾರು ಇವ್ರು ತೆಗಿತಾ ಇದಾರೆ? ಎಸ್
170,
Blood is covered. Two of them have left out, my lord, same order.
ರೆಗ್ಯುಲರೈಸೇಷನ್.
Yes, regularization.
ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು?
Government, my lord, and I have given him the
ಅವರು
copy.
ತುಂಬಾ ಚರ್ಚೆಲಿ ಇದ್ದಾರೆ.
ಇದರಲ್ಲಿ 2 ಮಂದಿ ಬಿಟ್ಟು ಹೋಗಿತ್ತು ಅಷ್ಟೇ. The same order, on the same application space.
ಯಾರು ಎಜಿ ಏನ HCGP?
ಇಲ್ಲ, he himself has.
ನೀವು ಚರ್ಚೆ ಮುಂದುವರಿಸಿ ಅವರದಂತೆ. ಇದು ಇಬ್ಬರದ್ದು ಬಿಟ್ಟೋಗಿತ್ತು, ಸೇಮ್ ಆರ್ಡರ್, ಇವ್ರದ್ದೇ ಸೇಮ್ ಆರ್ಡರ್. ರೇರ್ ಕೋಟ್ ಮಾಡಿ ಸೇಮ್ ಆರ್ಡರ್. ಡಿಸ್ಪೋಸ್. ನೆಕ್ಸ್ಟ್
171,
My lords, covered by judgment, my lords. Connected matter is disposed of. It is a covered by judgment.
ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಯಾವ್ದು ಸರ್?
It is already disposed of.
ಪೇಜ್ ಅಥವಾ ನಂಬರ್ ಏನಾದ್ರು ಒಂದು ಕೊಡ್ಬೇಕಲ್ಲ.
Proxy counsel, my lords.
ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಡಿಸ್ಪೋಸ್ ಆಫ್ ನಂಬರ್ ಅಂದ್ರೆ ಪ್ರಾಕ್ಸಿ ಕೌನ್ಸಿಲ್. ಮಂಡೇ ಫ್ರೆಶ್.
172,
That's matter pertaining to freedom fighters pensions, my lords.
After vacation.
Please, my lords.
Next.
173,
Farmers petition, your lords, we are ready for the consent. This under the UKP project. It is a government policy, your lords. The similar matters are listed tomorrow, it seems, your lords. Where we are ready for the consent, whatever the amount, that's the similar matters. Vidyavati madam, you know.
ಇದರಲ್ಲಿ ಲರ್ನೆಡ್ HCGP accepts
1, 2, 3 and 5.
ಅಲ್ಲ, ನಾಳೆನೇ ಕೊಡ್ತೀನಿ. ಇವಾಗ ಏನು ನೋಟಿಸ್ ಆಗೋದು ಇಲ್ಲ, ನಾಳೆ ಪೋಸ್ಟ್ ಮಾಡ್ತೀನಿ.
Yes, your lords.
173. All right. 174.
174, Palestine.
174. Petitioner was a teacher, my lords. During the service, he has suffered a stroke, paralysis, my lords. Government has not released the amount. Even the state commission under the
In medical reimbursement.
medical, no, my lords, he has suffered a stroke, paralysis of.
ಏನು ಅಮೌಂಟ್ ರಿಲೀಸ್ ಮಾಡಿ?
Lords, as per the state commission order, lords, his salaries have been not released.
ಕಮಿಷನ್ಗೆ ಹೋಗಿದ್ರ ನೀವು, ಸ್ಯಾಲರಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ?
State under the Disability Act, my lords, 2016.
ಡಿಸಬಿಲಿಟಿ ಕಮಿಷನ್.
Disability commission.
ಕಮಿಷನರ್, ನಾಟ್
Please, state commission.
Yes, sir.
So 2012, my lords,
Monday, fresh matters. Learned HCGP is directed to accept notice for the respondent. We'll close it on Monday. Yes.
175,
I appear for the petitioner, my lord. Mandam is seeking, my lord, notice has to be issued, my lord.
Learned AGA is directed to accept notice.
No,
for
my lord,
Hey,
1, 2, 3, MB conviction.
ವೆಂಕಟೇಶ್, ನೀವು ಯೂನಿಯನ್ ಆಫ್ ಇಂಡಿಯಾ ಆಗಿದ್ದೀರಾ ತಲೆ? DSGI ವೆಂಕಟೇಶ್ is directed to accept. ಎಲ್ಲಿ ಇವರು DSGI ಇದ್ರಲ್ಲ, ವೆಂಕಟೇಶ್ ಕಾರ್ವಿ is directed to accept notice for the respondent. Petition.
1 to 3, my lord. 4 to 6, CV Angadi sir appears.
4 to 6 CV Angadi. Yes, after vacation. Next.
176, Sunil Patil.
Seeking a compassionate appointment, my lord. Kindly, MB Kanvi may be directed to
Senate
take
Council
notice.
MB Kanvi is directed to accept. MB Kanvi ಯಾವುದಕ್ಕೆ?
HESCOM either. And previous writ petition, he was appeared to put.
Learned MB Kanvi is directed to accept notice for the respondents, both ಎರಡರಲ್ಲೂ.
That's it. The next one is the also compassionate appointment, my lord.
ಅದೇ ಎರಡು ಸೇಮ್.
ಇಲ್ಲ, ಇದು government has direct to take notice, my lord.
Learned
1 to 5, my lord.
1 to
5, my lord.
1 to 5 HCGP after vacation. Next.
Externment order, my lords, covered by your lordship's decision.
Externment Surat Sab's order disposed.
Please.
Next.
179.
Appear for petitioner, my lord. We are seeking remand in this matter, GST matter. We have challenged the ex parte non-speaking order, my lord.
Ex parte non-speaking, Monday fresh matters.
Stay illa, my lord.
Lordship's order 105.
Indiana.
Page number 105, Lordship's order.
ಯಾಕೆ? State government or government of India?
ಇದು 1, 2, 3 is a government, my lord. 3, 4 and 5 Girish Ulmani.
Impugned order pass ಮಾಡಿರೋದು ಯಾರು?
State, my lord.
State. Page
105 interim order, my lord.
Tag with 105 same order. Next. After vacation. Next. My protest ಆಯ್ತಲ್ಲ 180.
1, 2, 3 government, my lord. And 4, 5 Girish Ulmani.
ಅದರಲ್ಲಿ ಏನ್ ಮಾಡಿದೆ ಅದೇ.
6 Venkatesh.
ಅದರಲ್ಲಿ ಏನ್ ಮಾಡಿದೆ ಅದೇ. Yes. Next.
Lordship Monday.
No. After vacation. Next.
182.
So, 181 Monday.
182.
181.
Tell me.
Lords, 182. The attachment issued under the in the EP, my lords, in execution petition.
You are the owner of the vehicle?
I am owner of the vehicle. No notice is served. My vehicle is also not standing in my name.
ಯಾವಾಗ ಮಾರ್ಬಿಟ್ರಿ?
No, sir. No, sir. The address is entirely shown as wrong. No notice. Lords, now the attachment has been issued.
The petitioner, owner of the vehicle, is before the court calling in question an order of attachment by the concerned court without even issuance of a notice to the petitioner. The learned counsel submits that the vehicle involved is not his, and there is no notice of any proceeding held. Therefore, there shall be an interim order of stay of the order of attachment. It is made clear the proceedings before the concerned court are not stayed. Yes.
Serial number 181. 181 notice has to order. 181 will also.
Emergent
notice has to order.
Notice ordered. Yes. 183.
It's 183, 185, 186, and 188. Identical matters are listed on Monday. My lords, covered matter where differential GST has to be paid by my lords, the department. VAT and.
That Justice Krishna Kumar or order.
Notice ಆಗಿಲ್ಲ ಸ್ವಾಮಿ. So identical matters are listed on Monday.
ಆಯ್ತು ಮಂಡೇನೆ ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರ್ಯಾರಿಗೆ?
My lords, 183 and 186 my lords AGA, 185 and 188 ಸಂಜಯ್ ಚನ್ನಾಳ my lords.
ಆಯ್ತು
ಅದು ಕೊಡಿ.
So
please. Pleasure.
My lords, vehicle release order, my lords, deputy commissioner has
learned AGA is directed to accept notice for the respondent list on 17th.
My lords, vehicle is there in the custody
since when, sir?
Since June, my lords.
June. ಈಗ ಏನ್ ಸೀಸನ್ ನೋಡಿದೆ, ಈಗ ರೈನಿ ಸೀಸನ್ ಆಗಿದೆ, ವಿಂಟರ್ ಮುಗಿಸ್ಕೊಳ್ಳೋಣ.
Monday, my lords.
ಇಲ್ಲ, ವೆಡ್ನೆಸ್ಡೇ.
Please, my lords.
Let it see all the seasons.
My lords, I have paid the entire amount.
ಲಾರಿನಾ?
No, my lords, car, my lords.
ಕಾರಲ್ಲಿ ಏನ್ ಸಾಗಿಸ್ತಾ ಇದ್ರೆ?
It is alleged that I was fertilizer ಸಾಗಿಸ್ತಾ ಇದ್ದೆ ಅಂತ allegation ಇದೆ, my lords.
ಕಾರ್ ಬೂಟಲ್ ಫರ್ಟಿಲೈಸರ್ ಹಾಕಿದ್ರಾ?
Yes,
ಆ ಕಾರ್ ಯೂಸ್ ಮಾಡಕ್ ಆಗದೇ ಇಲ್ಲ ಬೇರೆ ಏನಕ್ಕೂ.
My lords, that is a false allegation.
ಅಲ್ಲೇ ಇರೋದು ಒಳ್ಳೇದು.
ಎಲ್ಲ ವೆಡ್ನೆಸ್ಡೇ.
ಆಯ್ತು, ವೆಡ್ನೆಸ್ಡೇ.
Please, my lords.
187.
Petitioner will deposit 3 lakh rupees on or before.
ಮಾಡಿದೀರಾ?
ಮಾಡ್ತೀವಿ. ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ
ಆನ್ ಆರ್ ಬಿಫೋರ್ ಎಲ್ಲ ನನ್ನ ಆರ್ಡರ್ ನೀವೇ ಹೇಳ್ಬಿಟ್ರಲ್ಲ. ಎಷ್ಟಿದೆ ಮನೆನಾ?
19 lakhs ಇದೆ.
ಮನೆ
ಮನೆ
ಮಳೆ
ಮನೆ ಮನೆ
ಮನೆ
ಮನೆ.
ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು?
ಬ್ಯಾಂಕ್ ಆಫ್ ಬರೋಡಾ ಎಮರ್ಜೆನ್ಸಿ ನೋಟಿಸ್.
ಯಾರು ಬ್ಯಾಂಕ್ ಆಫ್ ಬರೋಡಾ?
ಇಲ್ಲಿ ಕೌನ್ಸಿಲ್ ಸೀನಿಯರ್ ಬೆಂಗಳೂರಲ್ಲಿ ಇರ್ತಾರೆ.
ಹೆಡ್ ಆಫೀಸರ್.
ಹೆಡ್ ಆಫೀಸರ್.
ಬ್ಯಾಂಕ್ ಆಫ್ ಬರೋಡಾಗ ಪೇರ್ ಆಗ್ತಾರ ಅವರು. The petitioner is before this court seeking the following prayer. ಅಲ್ಲ ಬೇಡ, seeking ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ?
Criminal miscellaneous order dated
calling in question an order of the learned magistrate passed under section 14 of the SURFACE Act. The learned counsel submits that in terms of the order, the amount in due is 90 lakhs and the property involved is a residential property in which the petitioners are staying. In that light, there shall be an interim order of stay of further proceedings subject to the condition that the 30 lakhs na?
3 lakhs.
3 lakhs. ಔಟ್ ಹೌಸ್ಗೆ ಹೇಳಿದ್ರೆ ನೀವೀಗ ಮನೆಗೆ ಹೇಳಿ.
ಅಲ್ಲಿ 19 ಲಕ್ಷ ಇದೆ, 5 ಲಕ್ಷ.
ಎಷ್ಟಿದೆ ಬಾಕಿ?
19.
90 ಅಂದ್ರೆ 19 lakhs.
19.
19 lakhs. In that light, there shall be an interim order stay of further proceedings subject to the condition that the petitioner would deposit 5 lakhs in the next 4 weeks. List the matter on 16th January. In the 16th Sunday. January. 19th January. 19th January. In the event the deposit is not made, the interim order would get automatically vacated and the petition also would get dismissed.
Petition dismissed.
But petition also would get dismissed. Yes. Next.
188, Suraj Espalole.
You say ma?
183.
ಯಾವ್ಯಾವ್ದು?
183, 186, 183, 185, 186 and 188. ಅಲ್ಲ 189 is more further hearing matter.
189 further ಅದೇ
189 ಕರಿತೀನಿ. 189.
ಕರೀತಾರೆ ತಾಳಿ.
ಅದರಲ್ಲಿ synopsis ಹಾಕಿದ್ದಾರೆ, it can be disposed of.
Senior counsel.
I am for the respondents in this.
ಯಾವ್ದಿದು this?
Tax matter. Dr. Ravishankar.
Raghuram sir.
Mr. Ravishankar used to appear.
ಅದಾ ಇದು?
ಹೌದು ಸರ್.
ಇದು ಅವಾಗಿಂದ ಫರ್ದರ್ ಹೆಂಗ್ ಆಗಿದೆ? Yes.
Synopsis ಹಾಕಿದ್ದಾರೆ.
ಹಾಕಿದ್ದಾರೆ. We'll reserve it. I'll reserve. Yes.
Objections maybe.
Objection ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೀವಿ.
Yes.
190, Rakesh Satyakati.
ಏನಿದು ಮೇಡಮ್?
Birds Act, my lordship.
Birds Act.
I have given a citation, it is covered, my lordship. Only Birds Act offences can be quashed, not IPC.
Yeah?
Please, ma'am.
I will post it on Monday, fresh matters.
Grateful, ma'am.
191,
My lords, I appear. This is that pygmy agents, my lords, pygmy agents commission.
Bangalore
Matter.
9th January at 2:30 p.m.
My lords, my lords. One, I'll just
take it.
Here it's, yes, my lords. Only one
Yes,
thing
yes,
I need to
Bangalore.
show your lordships. Page
Yes, sir.
186, my lords, may kindly see, the petition says, even if the pygmy agents get the payment as commission, the government of India has clarified it will remain salary for the purpose of Income Tax Act. So
Last time ತೋರಿಸಿದ್ರು.
yes, yes, I'm
Last
sorry,
time.
I'm just reiterating. I'm just reiterating.
Just on 9th January for the hearing at 2:30 p.m. ಒಂದು ನಿಮಿಷ.
Deeply.
ಕೊಡಿ. ಇದು ಎಲ್ಲಿ? ಸಾದಿಕ್
Sadiq Gudwala.
ಎಲೆಕ್ಷನ್.
My lord, petitioners are my lord, advocates practicing at Dharwad bench. Kindly turn to my lord annexure B. My lord, ink page.
The petitioners, advocates practicing before the bench at Dharwad have submitted a representation to the returning officer. Kayak Mat. ನೀವೇ ಅಲ್ವಾ?
In fact, I'm not here to deprive anybody,
Yes.
but this election date has been announced.
I will permit, sir. Don't worry. Yes. Calendar of events 9 ಟಿಂಕರ್ ಮಾಡ್ತಾ ಇಲ್ಲ. 8 ಗಂಟೆಗೆ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
8 ಗಂಟೆಗೆ we got some practical difficulty because all the way ಎಲ್ಲಾನು ಕರ್ಸ್ಕೊಂಡು 8 ಗಂಟೆಗೆ commence ಮಾಡ್ಲಿಕ್ಕೆ we got practical difficulty. We cannot commence at night.
ಎಷ್ಟೊತ್ತಿಗೆ ಮಾಡಿದ್ದಾರೆ?
9:30 ಮಾಡಿದ್ದಾರೆ. 9:30 ಇದೆ. At the most we can prepare for another half an hour earlier ಮಾಡ್ಬೋದು.
8:30.
8:30.
8:30 or 8:45.
8:30 it is, because we have to reach 12:45 at Goa.
ಆಯ್ತು 8:39. Yes.
One submission your lordship permits, will file, I'm pleading application. Our only grievance, we are not opposing our seniors.
She is not a member of this association. She can't file it.
I'm a member of this association.
Which association member?
Member ಇದ್ರೆ ಏನಾದ್ರು ಮಾಡಬಹುದು.
ಅಲ್ಲ ರಂಜಿತಾ is not a member.
Not a member.
For a moment, your lordship. I'm the member, but I'm not eligible for voting, your lordship, because since it's been 8 months, my grievance, I'm not, sorry, your lordship, that is the senior
ಹಂಗೆಲ್ಲ
submission.
Don't-
ಇಲ್ಲ, that is the senior submission. I'm not opposing any seniors, your lordship. My submission, were only grievance, it may be extended to all the eligible voters, ಅಷ್ಟೇ.
All the eligible, ಏನ್ elections ಆ?
ಅಲ್ಲಲ್ಲ, 8:30ಗೆ.
ಇವರು 10 ಜನಕ್ಕೆ ಅಷ್ಟೇ ಮಾಡಬೇಡ, ಏನು ಜನರಲ್ ಅಂತ ಹೇಳಿ. ಅಲ್ಲ,
ನಾನು 10 ಜನಕ್ಕೆ ಏನ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಇಲ್ಲಿ. ರಂಜಿತ್, I am not doing it for 8
10
members or 10
petitioners
members.
before this court.
Representation ಅದಿರ್ಬೋದು, but I cannot pass an order 10 ಜನಕ್ಕೆ ಮಾತ್ರ separate vote ಮಾಡಿ ಅಂತ.
ಇಲ್ಲ ಇಲ್ಲ.
Yes, that is enough,
Yes.
because will
But
not.
why did you say she is not a member?
She is not a member.
she is not a voter, she is a member of.
ಮತ್ತೆ
ನಮ್
ನಾಟ್ ಎ
seniors-
ವೋಟರ್ಗೂ ನಾಟ್ ಎ ಮೆಂಬರ್ಗೂ.
ನಮ್ ಸೀನಿಯರ್ಸಿಗೆ ಅಪೋಸ್ ಮಾಡಷ್ಟು ದೊಡ್ಡವ್ರು ಇಲ್ಲ ನಾವು.
Because she takes advice from me because she is telling like that.
Take it easy. Don't worry. ಆಗ್ತವೆ ಇವೆಲ್ಲ. Yes.
ಯಾಕಂದ್ರೆ my hands were tied. I cannot suo moto, cannot change that timing.
ನಿಮ್ ಹ್ಯಾಂಡ್ಸ್ ಅದೇ ತರ ಇದೆ ಅದಕ್ಕೆ
ಅಲ್ಲ,
ನಿಂತಿರೋದು ಹಂಗೆ
I'm
ಹ್ಯಾಂಡ್ಸ್ ಟೈಡ್ ಅಂತ
folded- ಅಲ್ಲ,
ನಿಂತ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದೀರಾ.
I'm with folded hands before this court.
No, sir. Don't worry. Yes, the petitioner association, ಅಲ್ಲ ಯಾರಿದು? Petitioners are before the court seeking slight tinkering of the date of the timings in the election on the score of the difficulties projected in the representation submitted to the returning officer. The returning officer says his hands are tied, obviously so, as the election dates are announced and the calendar of events are announced and the election dates are also announced. Therefore, the petition is preferred. The only relief sought is change in the timings by preponing the time of election from 9:30 to 8 o'clock. The returning officer submits that 8:30 would pose a great difficulty. Therefore, to give a quietus to the issue, I deem it appropriate to direct the elections to commence at 8:30 AM.
8:45. ಸ್ವಲ್ಪ ನಾನು 8:45.
ಇಲ್ಲ ರೀ, ಅಲ್ಲ ನಾವು 3 ಗಂಟೆ ಒಳಗೆ ಹೋಗ್ಬೇಕು. 12:45 ಟೈಮಿಂಗು ಹಾಕಿದ್ದೀನಿ ನಾನು.
ನಾನು ಹೇಳಿದ್ದು
ಎಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು?
We have to reach Goa, my lord. We are going to Ujjain. Ujjain. There is a flight. From Goa there is a flight. I had to catch that flight.
ಅದೇ ಹೇಳ್ಬೇಕಾಗಿತ್ತು. We have to go to Goa at 12:45 ಅಂದ್ರೆ ಏನು?
Reach Goa ಅಂದೆ ನಾನು. Reach Goa at 12:45.
Reach Goa, whatever. ಇದು Goa gone ಗೆ ನಾವು ಇದನ್ನ ಮಾಡೋದು.
ಅಲ್ಲಿಂದ ಫ್ಲೈಟ್ my lord, I had to go to Ujjain.
ಅದು ಹೇಳಿ ಪರವಾಗಿಲ್ಲ.
Flight at 12:45, we have to reach it, that's all.
ತೊಂದರೆ ಇಲ್ಲ. Whatever 8:30 please it would commence at 8:30. 15 ನಿಮಿಷಕ್ಕೆ ಏನಾಗಲ್ಲ ಮಾಡಿ. Preparation will begin early. Don't get agitated, madam. Yes, nobody is denying the audience here.
ಡೈಲಿ ಅವ್ರ ಹತ್ರನೇ ಎಲ್ಲ ಕೇಳ್ಕೊತೀನಿ.
ಹೌದು, ಇದನ್ನು ಕೇಳ್ಕೊಂಡ್ಬಿಡ್ಬೇಕಾಗಿತ್ತು.
ನಮ್ಮನ್ನ ಕೇಳಿದ್ರೆ ಹೇಳ್ಬಿಡ್ತೀನಿ.
However, it should. However, this interim order cannot become a position.
No, this interim order, I'm disposing it.
But
with the aforesaid observation, petition stands disposed. I make it clear that this is an order passed this is a one-off order passed in a one-off situation, which can never be treated as a precedent at any cost.
Please.
ಆಮೇಲೆ 8:30 ಯಾಕೆ 6 ಗಂಟೆಗೆ ಕೇಳ್ತಾರ ಬಿಟ್ರೆ ಅದು ಮಾಡಿ.
With lordships 93 my lords. Lordships were pleased to take your lordship said that 93 your lordships would take it up my lords at the end.
ಏನ್ ಅರ್ಜೆನ್ಸಿ ಸರ್?
Urgency my lords, the road is being widened right in front of the temple.
Respondent ಯಾರು?
Respondent state my lords. Road is being widened right in the front of temple.
ಸಡನ್ ಆಗಿ ಹೇಳ್ಬಿಟ್ರೆ ಅವರು ಕಷ್ಟ ಆಗುತ್ತೆ.
Well, main matter can be heard after vacation. Only interim protection is now my lords, the fair is being commenced from 27th. Lakhs of devotees would assemble. That would my lords create my lords and my lords
ವೈಂಡಿಂಗ್ ಮಾಡಿದ್ರೆ ಒಳ್ಳೇದೇ ಅಲ್ವಾ?
chariot is being pulled my lords, which the road widening will come in way my lords.
ಅಲ್ಲ ಈಗ
if
yes
We'll get instructions.
ಯಾವ್ದು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತಗೊಂಡಿದಾರ ಅವರು ಏನು?
from the day I have been filed
ಯಾವತ್ತಿರೋದು?
27th my lords.
27th.
But road they have already come and my lords.
I'll take it tomorrow at 2:30.
Please.
ಅದೊಂದು ನಾಳೆ ಬೆಳಗ್ಗೆ ಮೆನ್ಷನ್ ಮಾಡಿ.
Please.
ನಾನು 2:30 ಹಾಕಿರ್ತೀನಿ ಬಿಕಾಸ್ ಕ್ಲೋಸ್ ಆಗಿರುತ್ತೆ.
Please.
2:30. ಯಾರು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೋಬೇಕು?
Tomorrow, I will only take. Tomorrow, I will only take.
ಕೇಳ್ಕೊಂಡ್ಬಿಟ್ರೆ ಹೇಳಿ.
This commence the work my lords. What would happen at the elevate ಆದ್ರೆ
ನಾಳೆ ಕೊಡ್ತೀನಪ್ಪ.
Please.
2:30 ಗೆ.
Highly obliged.
Lordship, serial number 43, your lordship. Mandamus.
ಏನಾಗಿದೆ?
Monday.
ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಆಗಿದೆಯಾ?
ಹೌದು.
ಬರೀ ಮಂಡಮಸ್.
Yes.
Monday.
Lordship.
43.
Permission.
Number 2 ಎಲ್ಲ.
List number 2.
But I have lot of pending things to do. I will leave a complaint.
List number 2, serial number 3, fresh matter notice. I am seeking for interim.
Fresh matter. ಏನದು?
Consumer forum, my lords, the petitioner was a liquidator appointed to the respondent number 1 society. Now, my lords, after his
fresh matters 3 ಮಂಡೇಗೆ ಹಾಕಿ.
Please.
Fresh matter ಮಾತ್ರ.
Please.
My lords, on permission.
List number 2, serial number 21.
Third by judgment, my lord.
Interim order may be extended, my lordship.
Interim orders will extend, sir. Yes.
Lordship, serial
Please,
number
ma'am.
36, my lord. The accountants, my lord, of a municipality, my lord, they are serving more than 10 to 15 years. Lordship has granted a my lord, interim order, but similar order has been my lord, coordinate bench passed, my lord, with respect to
ಮತ್ತೆ
that at
ತಗೊಳ್ಳಿ ಸರ್.
Kalburgi.
ಇದು 3
Please,
ಫ್ರೆಶ್ ಅಂತ ಮಾತ್ರ ನಾನು ಹಾಕ್ತೆ ಅಷ್ಟೇ.
Please, my lord, because
ನೋ ಸರ್.
Sir, serial number 17.
My lordship, serial
ಟೈಮ್
number.
ಬಂದಾಗ ಮತ್ತೆ
The list to serial number 17.
ನೆಕ್ಸ್ಟ್
Covered by judgment, my lord.
My
Sir,
lordship,
list
one
to-
permission, my lordship. Serial number 34 is list number 2. Since 2022, her proposal for appointment is pending, assistant cook. 22 itself, she has been selected, but till today it is not approved, my lordship.
ಇಲ್ಲ, ದಟ್ ಕ್ಯಾನ್ಸಲ್ ಆಗಿದೆ ಸೆಲೆಕ್ಷನ್ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
No, there's,
No, that's what madam said, yes.
this is for the first time it is reached, my lordship.
ಯಾವ್ದ್ರಲ್ಲ ಇನ್ನೊಂದು ಕುಕ್ ಸರಿ.
Second list.
List number 2, serial number 34, my lordship.
Don't you move a memo. I'll get it posted.
Sir, list 2.
On Monday will, ಇಲ್ಲ ಎಲ್ಲ ಪೋಸ್ಟ್ ಮಾಡ್ಬೇಕಾಗುತ್ತಮ್ಮ. ಲಿಸ್ಟ್
Covered by judgment, my lord.
See? Yes. You move a memo.
Grateful.
Covered by judgment, my lord.
Yes.
List 2.
After vacation. ಎಲ್ಲ list 2 except these 3 after vacation. You move a memo.
ಅವಸರ ಮಾಡ್ತೀಯ ಅಂತ ನಾನೇ ಬರ್ತೀನಿ. ಅಂಕಿತ ನಾನೇ ಬರ್ತೀನಿ.
ಮೆಣಸಿನಕಾಯಿ ಗುಡಿ ಮುಂದೆ ರೋಡ್
ಅಲ್ಲ, ಅದು ಮ್ಯಾಟ್ರ್ ಪೆಂಡಿಂಗ್ ಐತಾ?
ಪೆಂಡಿಂಗ್ ಐತೆ.
ಇವತ್ತಿತ್ತ?
ಸೀರಿಯಲ್ ನಂಬರ್ 93.
ಇಲ್ಲ, ನಮ್ದಲ್ಲ ಅದು ಹನುಮರೆಡ್ಡಿ ಸರ್
ಓಕೆ. ಅವ್ರಿಗೆ ಹೇಳ್ತೀರಿ ನಾನು ನಾಳೆ
ಇಲ್ಲ, ನಾಳೆ
ಅದ್ರಾಗ ಏನಿಲ್ಲ, ಮೇನ್ ಮ್ಯಾಟರ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಆಗ್ಲಿ.
ಅವಾಗ ಇವತ್ತೊಂದು ಐತಿ.
27ರಿಂದ
ನಾನು ಬರೀ
ಹಿಂಗೆ ಎತ್ತರ ಮಾಡಿಬಿಟ್ರೆ ಪೂರ ಆಗೋದಿಲ್ಲ.